Section 101, Definitions. Except as otherwise provided in this title. As used in this title, the following terms and their variant forms mean the following. An anonymous work is a work on the copies or phonorecords of which no natural person is identified as author. An architectural work is the design of a building as embodied in any tangible medium of expression, including a building, architectural plans, or drawings. The work includes the overall form as well as the arrangement and composition of spaces and elements in the design, but does not include individual standard features. Audiovisual works are works that consist of a series of related images which are intrinsically intended to be shown by the use of machines or devices such as projectors, viewers, or electronic equipment, together with accompanying sounds, if any, regardless of the nature of the material objects such as films or tapes in which the works are embodied. The Berne Convention is the convention for the protection of literary and artistic works, signed at Bern, Switzerland, on September 9, 1886, and all acts, protocols, and revisions thereto. The best edition of a work is the edition published in the United States at any time before the date of deposit that the Library of Congress determines to be most suitable for its purposes. A person's children are that person's immediate offspring, whether legitimate or not, and any children legally adopted by that person. A collective work is a work, such as a periodical issue, anthology, or encyclopedia, in which a number of contributions constituting separate and independent works in themselves are assembled into a collective whole. A compilation is a work formed by the collection and assembling of pre-existing materials or of data that are selected, coordinated, or arranged in such a way that the resulting work as a whole constitutes an original work of authorship. The term compilation includes collective works. A computer program is a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. Copies are material objects other than phonorecords, in which a work is fixed by any method now known or later developed, and from which the work can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. The term copies includes the material object other than a phonorecord, in which the work is first fixed. Copyright owner, with respect to any one of the exclusive rights comprised in a copyright, refers to the owner of that particular right. A copyright royalty judge is a copyright royalty judge appointed under Section 802 of this title, and includes any individual serving as an interim copyright royalty judge under such section. A work is created when it is fixed in a copy or phonorecord for the first time, where a work is prepared over a period of time. The portion of it that has been fixed at any particular time constitutes the work as of that time. And where the work has been prepared in different versions, each version constitutes a separate work. A derivative work is a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. A work consisting of editorial revisions, annotations, elaborations, or other modifications which as a whole represent an original work of authorship is a derivative work. A device, machine, or process is one now known or later developed. A digital transmission is a transmission in whole or in part in a digital or other non-analog format. To display a work means to show a copy of it, either directly or by means of a film, slide, television image, or any other device or process, or, in the case of a motion picture or other audiovisual work, to show individual images non-sequentially. An establishment is a store, shop, or any similar place of business open to the general public for the primary purpose of selling goods or services in which the majority of the gross square feet of space that is non-residential is used for that purpose, and in which non-dramatic musical works are performed publicly. The term financial gain includes receipt or expectation of receipt of anything of value, including the receipt of other copyrighted works. A work is fixed in a tangible medium of expression when its embodiment in a copy or phonorecord, by or under the authority of the author, is sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than transitory duration. A work consisting of sounds, images, or both that are being transmitted is fixed for purposes of this title if a fixation of the work is being made simultaneously with its transmission. A food service or drinking establishment is a restaurant, inn, bar, tavern, or any other similar place of business in which the public or patrons assemble for the primary purpose of being served food or drink, in which the majority of the gross square feet of space that is non-residential is used for that purpose, and in which non-dramatic musical works are performed publicly. The Geneva Phonograms Convention is the convention for the protection of producers of phonograms against unauthorized duplication of their phonograms, concluded at Geneva, Switzerland on October 29, 1971. The gross square feet of space of an establishment means the entire interior space of that establishment, and any adjoining outdoor space used to serve patrons, whether on a seasonal basis or otherwise. The terms including and such as are illustrative and not limitative. An international agreement is: Paragraph 1, the Universal Copyright Convention. Paragraph 2, the Geneva Phonograms Convention. Paragraph 3, the Berne Convention. Paragraph 4, the WTO Agreement. Paragraph 5, the WIPO Copyright Treaty. Paragraph 6, the WIPO Performances and Phonograms Treaty, and Paragraph 7, any other copyright treaty to which the United States is a party. A joint work is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. Literary works are works other than audiovisual works expressed in words, numbers, or other verbal or numerical symbols or indicia, regardless of the nature of the material objects, such as books, periodicals, manuscripts, phonorecords, film, tapes, discs, or cards, in which they are embodied. The term motion picture exhibition facility means a movie theater, screening room, or other venue that is being used primarily for the exhibition of a copyrighted motion picture. If such exhibition is open to the public or is made to an assembled group of viewers outside of a normal circle of a family and its social acquaintances, motion pictures are audiovisual works consisting of a series of related images which, when shown in succession, impart an impression of motion, together with accompanying sounds, if any. To perform a work means to recite, render, play, dance, or act it, either directly or by means of any device or process, or, in the case of a motion picture or other audiovisual work, to show its images in any sequence or to make the sounds accompanying it audible. A performing rights society is an association, corporation, or other entity that licenses the public performance of non-dramatic musical works on behalf of copyright owners of such works, such as the American Society of Composers, Authors and Publishers ASCAP Broadcast Music, Inc., BMI, and CSAC, Inc. Phonorecords are material objects in which sounds, other than those accompanying a motion picture or other audiovisual work, are fixed by any method now known or later developed and from which the sounds can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. The term phonorecords includes the material object in which the sounds are first fixed. Pictorial, graphic, and sculptural works include two-dimensional and three-dimensional works of fine, graphic, and applied art, photographs, prints, and art reproductions, maps, globes, charts, diagrams, models, and technical drawings, including architectural plans. Such works shall include works of artistic craftsmanship insofar as their form but not their mechanical or utilitarian aspects are concerned. The design of a useful article as defined in this section shall be considered a pictorial graphic, or sculptural work only if and only to the extent that such design incorporates pictorial, graphic, or sculptural features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. For purposes of Section 513, a proprietor is an individual, corporation, partnership, or other entity, as the case may be, that owns an establishment or a food service or drinking establishment, except that no owner or operator of a radio or television station licensed by the Federal Communications Commission, cable system or satellite carrier, cable or satellite carrier service or programmer, provider of online services or network access, or the operator of facilities therefore, telecommunications company, or any other such audio or audio-visual service or programmer now known, or as may be developed in the future. Commercial subscription music service, or owner or operator of any other transmission service shall under any circumstances be deemed to be a proprietor. A pseudonymous work is a work on the copies or phonorecords of which the author is identified under a fictitious name. Publication is the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership, or by rental, lease, or lending. The offering to distribute copies or phonorecords to a group of persons for purposes of further distribution, public performance, or public display constitutes publication. A public performance or display of a work does not of itself constitute publication. To perform or display a work publicly means: Paragraph 1. To perform or display it at a place open to the public or at any place where a substantial number of persons outside of a normal circle of a family and its social acquaintances is gathered. Or, Paragraph 2. To transmit or otherwise communicate a performance or display of the work to a place specified by Clause 1 or to the public by means of any device or process, whether the members of the public capable of receiving the performance or display receive it in the same place or in separate places and at the same time or at different times. Registration, for purposes of Sections 205, subsection C, paragraph 2, 405, 406, 41 and subsection D, 411, 4112, and 506, subsection E, means a registration of a claim in the original or the renewed and extended term of copyright. Sound recordings are works that result from the fixation of a series of musical, spoken, or other sounds, but not including the sounds accompanying a motion picture or other audiovisual work, regardless of the nature of the material objects, such as discs, tapes, or other phonorecords in which they are embodied. State includes the District of Columbia and the Commonwealth of Puerto Rico, and any territories to which this title is made applicable by an act of Congress. A transfer of copyright ownership is an assignment, mortgage, exclusive license, or any other conveyance, alienation, or hypothecation of a copyright or of any of the exclusive rights comprised in a copyright, whether or not it is limited in time or place of effect, but not including a non-exclusive license. A transmission program is a body of material that, as an aggregate, has been produced for the sole purpose of transmission to the public in sequence and as a unit. To transmit a performance or display is to communicate it by any device or process whereby images or sounds are received beyond the place from which they are sent. A treaty party is a country or intergovernmental organization other than the United States that is a party to an international agreement. The United States, when used in a geographical sense, comprises the several states, the District of Columbia and the Commonwealth of Puerto Rico, and the organized territories under the jurisdiction of the United States government. For purposes of Section 411, a work is a United States work only if: Paragraph 1. In the case of a published work, the work is first published. Subparagraph A. In the United States. Subparagraph B. Simultaneously in the United States and another treaty party or parties, whose law grants a term of copyright protection that is the same as or longer than the term provided in the United States. Subparagraph C. Simultaneously in the United States and a foreign nation that is not a treaty party, or Subparagraph D. In a foreign nation that is not a treaty party and all of the authors of the work are nationals, domiciliaries, or habitual residents of, or in the case of an audiovisual work, legal entities with headquarters in the United States. Paragraph 2. In the case of an unpublished work, all the authors of the work are nationals, domiciliaries, or habitual residents of the United States, or, in the case of an unpublished audiovisual work, all the authors are legal entities with headquarters in the United States, or Paragraph 3. In the case of a pictorial, graphic, or sculptural work incorporated in a building or structure, the building or structure is located in the United States. A useful article is an article having an intrinsic utilitarian function that is not merely to portray the appearance of the article or to convey information. An article that is normally a part of a useful article is considered a useful article. The author's widow or widower is the author's surviving spouse under the law of the author's domicile at the time of his or her death, whether or not the spouse has later remarried. The WIPO Copyright Treaty is the WIPO Copyright Treaty concluded at Geneva, Switzerland on December 20, 1996. The WIPO Performances and Phonograms Treaty is the WIPO Performances and Phonograms Treaty concluded at Geneva, Switzerland on December 20, 1996. A work of visual art is: Paragraph 1. A painting, drawing, print, or sculpture existing in a single copy, in a limited edition of 200 copies or fewer that are signed and consecutively numbered by the author, or, in the case of a sculpture, in multiple cast carved, or fabricated sculptures of 200 or fewer that are consecutively numbered by the author and bear the signature or other identifying mark of the author, or Paragraph 2. A still photographic image produced for exhibition purposes only, existing in a single copy that is signed by the author, or in a limited edition of 200 copies or fewer that are signed and consecutively numbered by the author. A work of visual art does not include: Subparagraph A, Clause 1. Any poster, map, globe, chart, technical drawing, diagram, model, applied art, motion picture, or other audiovisual work, book, magazine, newspaper, periodical, database, electronic information service, electronic publication, or similar publication. Subsection 2. Any merchandising item or advertising, promotional, descriptive covering or packaging material or container. Subsection 3. Any portion or part of any item described in Clause 1 or 2. Subparagraph B. Any work made for hire, or Subparagraph C. Any work not subject to copyright protection under this title. A work of the United States government is a work prepared by an officer or employee of the United States government as part of that person's official duties. A work made for hire is: Paragraph 1. A work prepared by an employee within the scope of his or her employment, or Paragraph 2. A work specially ordered or commissioned for use as a contribution to a collective work, as a part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas, if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. For the purpose of the foregoing sentence, a supplementary work is a work prepared for publication as a secondary adjunct to a work by another author for the purpose of introducing, concluding, illustrating, explaining, revising, commenting upon, or assisting in the use of the other work, such as forewords, afterwords, pictorial illustrations, maps, charts, tables, editorial notes, musical arrangements, answer material for tests, bibliographies, appendixes, and indexes. And an instructional text is a literary, pictorial, or graphic work prepared for publication, and with the purpose of use in systematic instructional activities. In determining whether any work is eligible to be considered a work made for hire under Paragraph 2, neither the amendment contained in Section 101, subsection D of the Intellectual Property and Communications Omnibus Reform Act of 1999, as enacted by Section 1000, subsection A, Paragraph 9 of Public Law 106-113, nor the deletion of the words added by that amendment. Subparagraph A shall be considered or otherwise given any legal significance, or Subparagraph B shall be interpreted to indicate congressional approval or disapproval of, or acquiescence in, any judicial determination by the courts or the Copyright Office. Paragraph 2 shall be interpreted as if both Section 2, subsection Paragraph 1 of the Work Made for Hire and Copyright Corrections Act of 2000 and Section 1011, subsection D of the Intellectual Property and Communications Omnibus Reform Act of 1999, as enacted by Section 1000, subsection A, Paragraph 9 of Public Law 106-113, were never enacted, and without regard to any inaction or awareness by the Congress at any time of any judicial determinations. The terms WTO agreement and WTO member country have the meanings given those terms in paragraphs 9 and 10, respectively, of Section 2 of the Uruguay Round Agreements Act. Section 102, Subject matter of copyright, in general. Subsection A. Copyright protection subsists in accordance with this title in original works of authorship fixed in any tangible medium of expression now known or later developed from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Works of authorship include the following categories. Paragraph 1. Literary works. Paragraph 2. Musical works, including any accompanying words. Paragraph 3. Dramatic works, including any accompanying music. Paragraph 4. Pantomimes and choreographic works. Paragraph 5. Pictorial, graphic, and sculptural works. Paragraph 6. Motion pictures and other audiovisual works. Paragraph 7. Sound recordings. And Paragraph 8. Architectural works. Subsection B. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Section 103. Subject matter of copyright, compilations and derivative works. Subsection A. The subject matter of copyright as specified by Section 102 includes compilations and derivative works, but protection for a work employing pre-existing material in which copyright subsists does not extend to any part of the work in which such material has been used unlawfully. Subsection B. The copyright in a compilation or derivative work extends only to the material contributed by the author of such work as distinguished from the pre-existing material employed in the work, and does not imply any exclusive right in the pre-existing material. The copyright in such work is independent of, and does not affect or enlarge the scope, duration, ownership, or subsistence of any copyright protection in the pre-existing material. Section 104. Subject matter of copyright, national origin. Subsection A. Unpublished works. The works specified by Sections 102 and 103, while unpublished, are subject to protection under this title without regard to the nationality or domicile of the author. Subsection B. Published works. The works specified by Sections 102 and 103, when published, are subject to protection under this title if: Paragraph 1. On the date of first publication, one or more of the authors is a national or domiciliary of the United States, or is a national, domiciliary, or sovereign authority of a treaty party, or is a stateless person, wherever that person may be domiciled. Or, Paragraph 2. The work is first published in the United States or in a foreign nation that, on the date of first publication, is a treaty party. Or, Paragraph 3. The work is a sound recording that was first fixed in a treaty party. Or, Paragraph 4. The work is a pictorial, graphic, or sculptural work that is incorporated in a building or other structure, or an architectural work that is embodied in a building, and the building or structure is located in the United States or a treaty party. Or, Paragraph 5. The work is first published by the United Nations or any of its specialized agencies, or by the Organization of American States. Or, Paragraph 6. The work comes within the scope of a presidential proclamation. Whenever the president finds that a particular foreign nation extends to works by authors who are nationals or domiciliaries of the United States, or to works that are first published in the United States, copyright protection on substantially the same basis as that on which the foreign nation extends protection to works of its own nationals and domiciliaries and works first published in that nation. The President may, by proclamation, extend protection under this title to works of which one or more of the authors is, on the date of first publication, a national, domiciliary, or sovereign authority of that nation, or which was first published in that nation. The President may revise, suspend, or revoke any such proclamation or impose any conditions or limitations on protection under a proclamation. For purposes of Paragraph 2, a work that is published in the United States or a treaty party within 30 days after publication in a foreign nation that is not a treaty party shall be considered to be first published in the United States or such treaty party, as the case may be. Subsection C. Effect of Berne Convention. No right or interest in a work eligible for protection under this title may be claimed by virtue of, or in reliance upon, the provisions of the Berne Convention or the adherence of the United States thereto. Any rights in a work eligible for protection under this title that derive from this title, other federal or state statutes, or the common law, shall not be expanded or reduced by virtue of or in reliance upon the provisions of the Berne Convention, or the adherence of the United States thereto. Subsection D. Effect of phonograms treaties. Notwithstanding the provisions of subsection B, no works other than sound recordings shall be eligible for protection under this title solely by virtue of the adherence of the United States to the Geneva Phonograms Convention or the WIPO Performances and Phonograms Treaty. Section 104A. Copyright in restored works. Subsection A. Automatic protection and term. Paragraph 1. Term. Subparagraph A. Copyright subsists in accordance with this section in restored works and vests automatically on the date of restoration. Subparagraph B. Any work in which copyright is restored under this section shall subsist for the remainder of the term of copyright that the work would have otherwise been granted in the United States if the work never entered the public domain in the United States. Paragraph 2. Exception. Any work in which the copyright was ever owned or administered by the alien property custodian and in which the restored copyright would be owned by a government or instrumentality thereof is not a restored work. Subsection B. Ownership of restored copyright. A restored work vests initially in the author or initial right holder of the work as determined by the law of the source country of the work. Subsection C. Filing of notice of intent to enforce restored copyright against reliance parties on or after the date of restoration. Any person who owns a copyright in a restored work or an exclusive right therein may file with the Copyright Office a notice of intent to enforce that person's copyright or exclusive right, or may serve such a notice directly on a reliance party. Acceptance of a notice by the Copyright Office is effective as to any reliance parties, but shall not create a presumption of the validity of any of the facts stated therein. Service on a reliance party is effective as to that reliance party and any other reliance parties with actual knowledge of such service and of the contents of that notice. Subsection D. Remedies for infringement of restored copyrights. Paragraph 1. Enforcement of copyright in restored works in the absence of a reliance party. As against any party who is not a reliance party, the remedies provided in Chapter 5 of this title shall be available on or after the date of restoration of a restored copyright with respect to an act of infringement of the restored copyright that is commenced on or after the date of restoration. Paragraph 2. Enforcement of copyright in restored works as against reliance parties. As against a reliance party, except to the extent provided in paragraphs 3 and 4, the remedies provided in Chapter 5 of this title shall be available with respect to an act of infringement of a restored copyright on or after the date of restoration of the restored copyright if the requirements of either of the following subparagraphs are met. Subparagraph A, Clause 1. The owner of the restored copyright, or such owner's agent, or the owner of an exclusive right therein, or such owner's agent files with the Copyright Office, during the 24-month period beginning on the date of restoration, a notice of intent to enforce the restored copyright, and Subsection 2, Subclause 1. The act of infringement commenced after the end of the 12-month period beginning on the date of publication of the notice in the Federal Register. Subparagraph 2. The act of infringement commenced before the end of the 12-month period described in Subclause 1 and continued after the end of that 12-month period, in which case remedies shall be available only for infringement occurring after the end of that 12-month period, or Subparagraph 3. Copies or phonorecords of a work in which copyright has been restored under this section are made after publication of the notice of intent in the Federal Register. Subparagraph B, Clause 1. The owner of the restored copyright or such owner's agent, or the owner of an exclusive right therein, or such owner's agent, serves upon a reliance party a notice of intent to enforce a restored copyright, and Subsection 2, Subclause 1. The act of infringement commenced after the end of the 12-month period beginning on the date the notice of intent is received. Subparagraph 2. The act of infringement commenced before the end of the 12-month period described in Subclause 1 and continued after the end of that 12-month period, in which case remedies shall be available only for the infringement occurring after the end of that 12-month period, or Subparagraph 3. Copies or phonorecords of a work in which copyright has been restored under this section are made after receipt of the notice of intent. In the event that notice is provided under both subparagraphs A and B, the 12-month period referred to in such subparagraphs shall run from the earlier of publication or service of notice. Paragraph 3. Existing derivative works. Subparagraph A. In the case of a derivative work that is based upon a restored work and is created. Clause 1. Before the date of the enactment of the Uruguay Round Agreements Act, if the source country of the restored work is an eligible country on such date, or Clause 2. Before the date on which the source country of the restored work becomes an eligible country, if that country is not an eligible country on such date of enactment, a reliance party may continue to exploit that derivative work for the duration of the restored copyright if the reliance party pays to the owner of the restored copyright reasonable compensation for conduct, which would be subject to a remedy for infringement, but for the provisions of this paragraph. Subparagraph B. In the absence of an agreement between the parties, the amount of such compensation shall be determined by an action in United States District Court and shall reflect any harm to the actual or potential market for or value of the restored work from the reliance party's continued exploitation of the work, as well as compensation for the relative contributions of expression of the author of the restored work and the reliance party to the derivative work. Paragraph 4. Commencement of infringement for reliance parties. For purposes of Section 412, in the case of reliance parties, infringement shall be deemed to have commenced before registration when acts which would have constituted infringement had the restored work been subject to copyright were commenced before the date of restoration. Subsection E. Notices of intent to enforce a restored copyright. Paragraph 1. Notices of intent filed with the Copyright Office. AI. A notice of intent filed with the Copyright Office to enforce a restored copyright shall be signed by the owner of the restored copyright or the owner of an exclusive right therein, who files the notice under subsection D, paragraph 2, subparagraph A. Clause 1, hereafter in this paragraph referred to as the owner, or by the owner's agent, shall identify the title of the restored work, and shall include an English translation of the title and any other alternative titles known to the owner by which the restored work may be identified, and an address and telephone number at which the owner may be contacted. If the notice is signed by an agent, the agency relationship must have been constituted in a writing signed by the owner before the filing of the notice. The Copyright Office may specifically require in regulations other information to be included in the notice, but failure to provide such other information shall not invalidate the notice or be a basis for refusal to list the restored work in the Federal Register. Subsection 2. If a work in which copyright is restored has no formal title, it shall be described in the notice of intent in detail sufficient to identify it. Subsection 3. Minor errors or omissions may be corrected by further notice at any time after the notice of intent is filed. Notices of corrections for such minor errors or omissions shall be accepted after the period established in subsection D, paragraph 2, subparagraph A, clause 1. Notices shall be published in the Federal Register pursuant to subparagraph B. Subparagraph B, clause 1. The Register of Copyrights shall publish in the Federal Register, commencing not later than 4 months after the date of restoration for a particular nation, and every 4 months thereafter for a period of 2 years, lists identifying restored works and the ownership thereof, if a notice of intent to enforce a restored copyright has been filed. Subsection 2. Not less than one list containing all notices of intent to enforce shall be maintained in the Public Information Office of the Copyright Office and shall be available for public inspection and copying during regular business hours pursuant to sections 705 and 708. Subparagraph C. The Register of Copyrights is authorized to fix reasonable fees based on the costs of receipt, processing, recording, and publication of notices of intent to enforce a restored copyright and corrections thereto. Subparagraph D, Clause 1. Not later than 90 days before the date the agreement on trade-related aspects of intellectual property referred to in Section 101, subsection D, paragraph 15 of the Uruguay Round Agreements Act enters into force with respect to the United States, the Copyright Office shall issue and publish in the Federal Register regulations governing the filing under this subsection of notices of intent to enforce a restored copyright. Subsection 2. Such regulations shall permit owners of restored copyrights to file simultaneously for registration of the restored copyright. Paragraph 2. Notices of intent served on a reliance party. Subparagraph A. Notices of intent to enforce a restored copyright may be served on a reliance party at any time after the date of restoration of the restored copyright. Subparagraph B. Notices of intent to enforce a restored copyright served on a reliance party shall be signed by the owner or the owner's agent, shall identify the restored work and the work in which the restored work is used, if any, in detail sufficient to identify them, and shall include an English translation of the title, any other alternative titles known to the owner by which the work may be identified, the use or uses to which the owner objects, and an address and telephone number at which the reliance party may contact the owner. If the notice is signed by an agent, the agency relationship must have been constituted in writing and signed by the owner before service of the notice. Paragraph 3. Effect of material false statements. Any material false statement knowingly made with respect to any restored copyright identified in any notice of intent shall make void all claims and assertions made with respect to such restored copyright. Subsection F. Immunity from warranty and related liability. Paragraph 1. In general. Any person who warrants, promises, or guarantees that a work does not violate an exclusive right granted in Section 106 shall not be liable for legal, equitable, arbitral, or administrative relief if the warranty, promise, or guarantee is breached by virtue of the restoration of copyright under this section if such warranty, promise, or guarantee is made before January 1, 1995. Paragraph 2. Performances. No person shall be required to perform any act if such performance is made infringing by virtue of the restoration of copyright under the provisions of this section, if the obligation to perform was undertaken before January 1, 1995. Subsection G. Proclamation of copyright restoration. Whenever the President finds that a particular foreign nation extends to works by authors who are nationals or domiciliaries of the United States restored copyright protection on substantially the same basis as provided under this section, the President may, by proclamation, extend restored protection provided under this section to any work. Paragraph 1 of which one or more of the authors is, on the date of first publication, a national, domiciliary, or sovereign authority of that nation, or Paragraph 2, which was first published in that nation. The President may revise, suspend, or revoke any such proclamation or impose any conditions or limitations on protection under such a proclamation. Subsection H. Definitions. For purposes of this section and Section 109, Subsection A. Paragraph 1. The term date of adherence or proclamation means the earlier of the date on which a foreign nation which, as of the date the WTO agreement enters into force with respect to the United States, is not a nation adhering to the Berne Convention or a WTO member country, becomes Subparagraph A. A nation adhering to the Berne Convention. Subparagraph B. A WTO member country. Subparagraph C. A nation adhering to the WIPO Copyright Treaty. Subparagraph D. A nation adhering to the WIPO Performances and Phonograms Treaty, or Subparagraph E, subject to a presidential proclamation under subsection G. Paragraph 2. The date of restoration of a restored copyright is Subparagraph A, January 1st, 1996, if the source country of the restored work is a nation adhering to the Berne Convention or a WTO member country on such date. Or Subparagraph B, the date of adherence or proclamation in the case of any other source country of the restored work. Paragraph 3. The term eligible country means a nation other than the United States that Subparagraph A becomes a WTO member country after the date of the enactment of the Uruguay Round Agreements Act. Subparagraph B, on such date of enactment is, or after such date of enactment becomes, a nation adhering to the Berne Convention. Subparagraph C adheres to the WIPO Copyright Treaty. Subparagraph D adheres to the WIPO Performances and Phonograms Treaty, or Subparagraph E, after such date of enactment becomes subject to a proclamation under subsection G. Paragraph 4. The term reliance party means any person who, Subparagraph A, with respect to a particular work, engages in acts before the source country of that work becomes an eligible country, which would have violated Section 106 if the restored work had been subject to copyright protection, and who, after the source country becomes an eligible country, continues to engage in such acts. Subparagraph B, before the source country of a particular work becomes an eligible country, makes or acquires one or more copies or phonorecords of that work, or Subparagraph C, as the result of the sale or other disposition of a derivative work covered under subsection D. Paragraph 3, or significant assets of a person described in subparagraph A or B, is a successor, assignee, or licensee of that person. Paragraph 5. The term restored copyright means copyright in a restored work under this section. Paragraph 6. The term restored work means an original work of authorship that Subparagraph A is protected under subsection A. Subparagraph B is not in the public domain in its source country through expiration of term of protection. Subparagraph C is in the public domain in the United States due to Clause 1. Non-compliance with formalities imposed at any time by United States copyright law, including failure of renewal, lack of proper notice, or failure to comply with any manufacturing requirements. Clause 2. Lack of subject matter protection in the case of sound recordings fixed before February 15, 1972. Or Clause 3. Lack of national eligibility. Subparagraph D has at least one author or right holder who was, at the time the work was created, a national or domiciliary of an eligible country, and if published, was first published in an eligible country and not published in the United States during the 30-day period following publication in such eligible country. And Subparagraph E, if the source country for the work is an eligible country solely by virtue of its adherence to the WIPO Performances and Phonograms Treaty, is a sound recording. Paragraph 7. The term right holder means the person. Subparagraph A, who, with respect to a sound recording, first fixes a sound recording with authorization, or Subparagraph B, who has acquired rights from the person described in Subparagraph A by means of any conveyance or by operation of law. Paragraph 8. The source country of a restored work is Subparagraph A, a nation other than the United States. Subparagraph B, in the case of an unpublished work. Clause 1. The eligible country in which the author or right holder is a national or domiciliary, or if a restored work has more than one author or right holder, of which the majority of foreign authors or right holders are nationals or domiciliaries, or Clause 2. If the majority of authors or right holders are not foreign, the nation other than the United States, which has the most significant contacts with the work, and Subparagraph C. In the case of a published work, Clause 1. The eligible country in which the work is first published, or Clause 2. If the restored work is published on the same day in two or more eligible countries, the eligible country which has the most significant contacts with the work. Section 105. Subject matter of copyright. United States government works. Subsection A in general. Copyright protection under this title is not available for any work of the United States government, but the United States government is not precluded from receiving and holding copyrights transferred to it by assignment, bequest, or otherwise. Subsection B. Copyright protection of certain works. Subject to subsection C, the covered author of a covered work owns the copyright to that covered work. Subsection C, use by federal government. Paragraph 1, Secretary of Defense Authority. With respect to a covered author who produces a covered work in the course of employment at a covered institution described in subparagraph as A through K of subsection D, paragraph 2 and subparagraph L of such subsection, when the Coast Guard is operating as a service in the Navy, the Secretary of Defense may direct the covered author to provide the federal government with an irrevocable, royalty-free, worldwide, non-exclusive license to reproduce, distribute, perform, or display such covered work for purposes of the United States government. Paragraph 2. Secretary of the Department in which the Coast Guard is operating when it is not operating as a service in the Navy Authority. With respect to a covered author who produces a covered work in the course of employment at the covered institution described in subsection D, paragraph 2, subparagraph L, The Secretary of the department in which the Coast Guard is operating when it is not operating as a service in the Navy may direct the covered author to provide the federal government with an irrevocable, royalty-free, worldwide, non-exclusive license to reproduce, distribute, perform, or display such covered work for purposes of the United States government. Paragraph 3. Director of National Intelligence Authority. With respect to a covered author who produces a covered work in the course of employment at the covered institution described in subsection D, paragraph 2, subparagraph M, the Director of National Intelligence may direct the covered author to provide the federal government with an irrevocable, royalty-free, worldwide, non-exclusive license to reproduce, distribute, perform, or display such covered work for purposes of the United States government. Paragraph 4. Secretary of Transportation Authority. With respect to a covered author who produces a covered work in the course of employment at the covered institution described in subsection D, paragraph 2, subparagraph N, the Secretary of Transportation may direct the covered author to provide the federal government with an irrevocable, royalty-free, worldwide, non-exclusive license to reproduce, distribute, perform, or display such covered work for purposes of the United States government. Subsection D definitions. In this section, paragraph 1. Covered author. The term covered author means a civilian member of the faculty of a covered institution. Paragraph 2. Covered institution. The term covered institution means the following. Subparagraph A, National Defense University. Subparagraph B, United States Military Academy. Subparagraph C, Army War College. Subparagraph D, United States Army Command and General Staff College. Subparagraph E, United States Naval Academy. Subparagraph F, Naval War College. Subparagraph G, Naval Postgraduate School. Subparagraph H, Marine Corps University. Subparagraph I, United States Air Force Academy. Subparagraph J, Air University. Subparagraph K, Defense Language Institute. Subparagraph L, United States Coast Guard Academy. Subparagraph M, National Intelligence University. Subparagraph N, United States Merchant Marine Academy. Paragraph 3. Covered work. The term covered work means a literary work produced by a covered author in the course of employment at a covered institution for publication by a scholarly press or journal. Section 106. Exclusive rights in copyrighted works. Subject to sections 107 through 122, the owner of copyright under this title has the exclusive rights to do and to authorize any of the following. Paragraph 1. To reproduce the copyrighted work in copies or phonorecords. Paragraph 2. To prepare derivative works based upon the copyrighted work. Paragraph 3. To distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership or by rental, lease, or lending. Paragraph 4. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures and other audiovisual works, to perform the copyrighted work publicly. Paragraph 5. In the case of literary, musical, dramatic, and choreographic works, pantomimes and pictorial, graphic, or sculptural works, including the individual images of a motion picture or other audiovisual work, to display the copyrighted work publicly. And Paragraph 6. In the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. Section 106A. Rights of certain authors to attribution and integrity. Subsection A. Rights of attribution and integrity. Subject to Section 107 and independent of the exclusive rights provided in Section 106, the author of a work of visual art. Paragraph 1 shall have the right. Subparagraph A. To claim authorship of that work, and Subparagraph B. To prevent the use of his or her name as the author of any work of visual art which he or she did not create. Paragraph 2 shall have the right to prevent the use of his or her name as the author of the work of visual art in the event of a distortion, mutilation, or other modification of the work which would be prejudicial to his or her honor or reputation. And Paragraph 3, subject to the limitations set forth in Section 113, subsection D, shall have the right. Subparagraph A. To prevent any intentional distortion, mutilation, or other modification of that work which would be prejudicial to his or her honor or reputation. And any intentional distortion, mutilation, or modification of that work is a violation of that right. And Subparagraph B. To prevent any destruction of a work of recognized stature, and any intentional or grossly negligent destruction of that work is a violation of that right. Subsection B. Scope and exercise of rights. Only the author of a work of visual art has the rights conferred by subsection A in that work, whether or not the author is the copyright owner. The authors of a joint work of visual art are co-owners of the rights conferred by subsection A in that work. Subsection C. Exceptions. Paragraph 1. The modification of a work of visual art which is a result of the passage of time or the inherent nature of the materials is not a distortion, mutilation, or other modification described in subsection A, paragraph 3, subparagraph A. Paragraph 2. The modification of a work of visual art, which is the result of conservation, or of the public presentation, including lighting and placement, of the work is not a destruction, distortion, mutilation, or other modification described in subsection A. Paragraph 3, unless the modification is caused by gross negligence. Paragraph 3. The rights described in paragraphs 1 and 2 of subsection A shall not apply to any reproduction, depiction, portrayal, or other use of a work in, upon, or in any connection with any item described in subparagraph A or B of the definition of work of visual art in section 101, and any such reproduction, depiction, portrayal, or other use of a work is not a destruction, distortion, mutilation, or other modification described in paragraph 3 of subsection A. Subsection D. Duration of rights. Paragraph 1. With respect to works of visual art created on or after the effective date set forth in Section 610, subsection A of the Visual Artists' Rights Act of 1990, the rights conferred by subsection A shall endure for a term consisting of the life of the author. Paragraph 2. With respect to works of visual art created before the effective date set forth in Section 610, subsection A of the Visual Artists' Rights Act of 1990, but title to which has not, as of such effective date, been transferred from the author. The rights conferred by subsection A shall be coextensive with, and shall expire at the same time as, the rights conferred by section 106. Paragraph 3. In the case of a joint work prepared by two or more authors, the rights conferred by subsection A shall endure for a term consisting of the life of the last surviving author. Paragraph 4. All terms of the rights conferred by subsection A run to the end of the calendar year in which they would otherwise expire. Subsection E. Transfer and waiver. Paragraph 1. The rights conferred by subsection A may not be transferred, but those rights may be waived if the author expressly agrees to such waiver in a written instrument signed by the author. Such instrument shall specifically identify the work and uses of that work to which the waiver applies, and the waiver shall apply only to the work and uses so identified. In the case of a joint work prepared by two or more authors, a waiver of rights under this paragraph made by one such author waives such rights for all such authors. Paragraph 2. Ownership of the rights conferred by subsection A with respect to a work of visual art is distinct from ownership of any copy of that work, or of a copyright or any exclusive right under a copyright in that work. Transfer of ownership of any copy of a work of visual art, or of a copyright or any exclusive right under a copyright, shall not constitute a waiver of the rights conferred by subsection A, except as may otherwise be agreed by the author in a written instrument signed by the author. A waiver of the rights conferred by subsection A with respect to a work of visual art shall not constitute a transfer of ownership of any copy of that work, or of ownership of a copyright, or of any exclusive right under a copyright in that work. Section 107. Limitations on exclusive rights. Fair use. Notwithstanding the provisions of sections 106 and 106A, the fair use of a copyrighted work, including such use by reproduction in copies or phonorecords, or by any other means specified by that section, for purposes such as criticism, comment, news reporting, teaching including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include: Paragraph 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Paragraph 2. The nature of the copyrighted work. Paragraph 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And Paragraph 4. The effect of the use upon the potential market for or value of the copyrighted work. The fact that a work is unpublished shall not itself bar a finding of fair use, if such finding is made upon consideration of all the above factors. Section 108. Limitations on exclusive rights. Reproduction by libraries and archives. Subsection A. Except as otherwise provided in this title, and notwithstanding the provisions of Section 106, it is not an infringement of copyright for a library or archives, or any of its employees acting within the scope of their employment, to reproduce no more than one copy or phonorecord of a work, except as provided in subsections B and C, or to distribute such copy or phonorecord under the conditions specified by this section, if: Paragraph 1. The reproduction or distribution is made without any purpose of direct or indirect commercial advantage. Paragraph 2. The collections of the library or archives are I open to the public, or 2 available not only to researchers affiliated with the library or archives, or with the institution of which it is a part, but also to other persons doing research in a specialized field, and Paragraph 3. The reproduction or distribution of the work includes a notice of copyright that appears on the copy or phonorecord that is reproduced under the provisions of this section, or includes a legend stating that the work may be protected by copyright if no such notice can be found on the copy or phonorecord that is reproduced under the provisions of this section. Subsection B. The rights of reproduction and distribution under this section apply to 3 copies or phonorecords of an unpublished work duplicated solely for purposes of preservation and security, or for deposit for research use in another library or archives of the type described by Clause 2 of subsection A, if: Paragraph 1. The copy or phonorecord reproduced is currently in the collections of the library or archives, and Paragraph 2. Any such copy or phonorecord that is reproduced in digital format is not otherwise distributed in that format and is not made available to the public in that format outside the premises of the library or archives. Subsection C. The right of reproduction under this section applies to 3 copies or phonorecords of a published work, duplicated solely for the purpose of replacement of a copy or phonorecord that is damaged, deteriorating, lost, or stolen, or if the existing format in which the work is stored has become obsolete if Paragraph 1. The library or archives has, after a reasonable effort, determined that an unused replacement cannot be obtained at a fair price, and Paragraph 2. Any such copy or phonorecord that is reproduced in digital format is not made available to the public in that format outside the premises of the library or archives, in lawful possession of such copy. For purposes of this subsection, a format shall be considered obsolete if the machine or device necessary to render perceptible a work stored in that format is no longer manufactured or is no longer reasonably available in the commercial marketplace. Subsection D. The rights of reproduction and distribution under this section apply to a copy made from the collection of a library or archives where the user makes his or her request, or from that of another library or archives, of no more than one article or other contribution to a copyrighted collection or periodical issue, or to a copy or phonorecord of a small part of any other copyrighted work. If Paragraph 1. The copy or phonorecord becomes the property of the user, and the library or archives has had no notice that the copy or phonorecord would be used for any purpose other than private study, scholarship, or research. And Paragraph 2. The library or archives displays prominently, at the place where orders are accepted, and includes on its order form a warning of copyright in accordance with requirements that the Register of Copyrights shall prescribe by regulation. Subsection E. The rights of reproduction and distribution under this section apply to the entire work, or to a substantial part of it made from the collection of a library or archives where the user makes his or her request, or from that of another library or archives. If the library or archives has first determined, on the basis of a reasonable investigation, that a copy or phonorecord of the copyrighted work cannot be obtained at a fair price. If Paragraph 1. The copy or phonorecord becomes the property of the user, and the library or archives has had no notice that the copy or phonorecord would be used for any purpose other than private study, scholarship, or research. And Paragraph 2. The library or archives displays prominently, at the place where orders are accepted, and includes on its order form a warning of copyright in accordance with requirements that the Register of Copyrights shall prescribe by regulation. Subsection F. Nothing in this section. Paragraph 1. Shall be construed to impose liability for copyright infringement upon a library or archives or its employees for the unsupervised use of reproducing equipment located on its premises, provided that such equipment displays a notice that the making of a copy may be subject to the copyright law. Paragraph 2. Excuses a person who uses such reproducing equipment or who requests a copy or phonorecord under subsection D from liability for copyright infringement for any such act or for any later use of such copy or phonorecord, if it exceeds fair use as provided by section 107. Paragraph 3. Shall be construed to limit the reproduction and distribution by lending of a limited number of copies and excerpts by a library or archives of an audiovisual news program, subject to clauses 1, 2, and 3 of subsection A, or Paragraph 4. In any way affects the right of fair use as provided by section 107, or any contractual obligations assumed at any time by the library or archives when it obtained a copy or phonorecord of a work in its collections. Subsection G. The rights of reproduction and distribution under this section extend to the isolated and unrelated reproduction or distribution of a single copy or phonorecord of the same material on separate occasions, but do not extend to cases where the library or archives or its employee, Paragraph 1, is aware or has substantial reason to believe that it is engaging in the related or concerted reproduction or distribution of multiple copies or phonorecords of the same material, whether made on one occasion or over a period of time, and whether intended for aggregate use by one or more individuals or for separate use by the individual members of a group, or Paragraph 2. Engages in the systematic reproduction or distribution of single or multiple copies or phonorecords of material described in subsection D, provided that nothing in this clause prevents a library or archives from participating in interlibrary arrangements that do not have as their purpose or effect that the library or archives receiving such copies or phonorecords for distribution does so in such aggregate quantities as to substitute for a subscription to or purchase of such work. Subsection H, Paragraph 1. For purposes of this section, during the last 20 years of any term of copyright of a published work, a library or archives, including a non-profit educational institution that functions as such, may reproduce, distribute, display, or perform in facsimile or digital form a copy or phonorecord of such work or portions thereof for purposes of preservation, scholarship, or research if such library or archives has first determined on the basis of a reasonable investigation that none of the conditions set forth in subparagraphs A, B, and C of Paragraph 2 apply. Paragraph 2. No reproduction, distribution, display, or performance is authorized under this subsection if Subparagraph A. The work is subject to normal commercial exploitation. Subparagraph B, a copy or phonorecord of the work can be obtained at a reasonable price, or subparagraph C, the copyright owner or its agent provides notice pursuant to regulations promulgated by the Register of Copyrights that either of the conditions set forth in subparagraphs A and B applies. Paragraph 3. The exemption provided in this subsection does not apply to any subsequent uses by users other than such library or archives. Clause 1. The rights of reproduction and distribution under this section do not apply to a musical work, a pictorial, graphic, or sculptural work, or a motion picture or other audiovisual work other than an audiovisual work dealing with news, except that no such limitation shall apply with respect to rights granted by subsections B, C, and H, or with respect to pictorial or graphic works published as illustrations, diagrams, or similar adjuncts to works of which copies are reproduced or distributed in accordance with subsections D and E. Section 109. Limitations on exclusive rights, effect of transfer of particular copy or phonorecord. Subsection A. Notwithstanding the provisions of Section 106, Subsection 3, the owner of a particular copy or phonorecord lawfully made under this title, or any person authorized by such owner, is entitled, without the authority of the copyright owner, to sell or otherwise dispose of the possession of that copy or phonorecord. Notwithstanding the preceding sentence, copies or phonorecords of works subject to restored copyright under Section 104A that are manufactured before the date of restoration of copyright or, with respect to reliance parties, before publication or service of notice under Section 104A, subsection E, may be sold or otherwise disposed of without the authorization of the owner of the restored copyright for purposes of direct or indirect commercial advantage only during the 12-month period beginning on. Paragraph 1. The date of the publication in the Federal Register of the Notice of Intent filed with the Copyright Office under Section 104A, subsection D, Paragraph 2, Subparagraph A, or Paragraph 2. The date of the receipt of actual notice served under Section 104A, subsection D, Paragraph 2, Subparagraph B, whichever occurs first. Subsection B, Paragraph 1, Subparagraph A. Notwithstanding the provisions of Subsection A, unless authorized by the owners of copyright in the sound recording or the owner of copyright in a computer program, including any tape, disc, or other medium embodying such program. And in the case of a sound recording and the musical works embodied therein, neither the owner of a particular phonorecord nor any person in possession of a particular copy of a computer program, including any tape, disc, or other medium embodying such program may, for the purposes of direct or indirect commercial advantage, dispose of or authorize the disposal of the possession of that phonorecord or computer program, including any tape, disc, or other medium embodying such program by rental, lease, or lending, or by any other act or practice in the nature of rental, lease, or lending. Nothing in the preceding sentence shall apply to the rental, lease, or lending of a phonorecord for nonprofit purposes by a nonprofit library or nonprofit educational institution. The transfer of possession of a lawfully made copy of a computer program by a nonprofit educational institution to another nonprofit educational institution or to faculty, staff, and students does not constitute rental, lease, or lending for direct or indirect commercial purposes under this subsection. Subparagraph B. This subsection does not apply to Clause 1. A computer program which is embodied in a machine or product and which cannot be copied during the ordinary operation or use of the machine or product, or Clause 2. A computer program embodied in or used in conjunction with a limited-purpose computer that is designed for playing video games and may be designed for other purposes. Subparagraph C. Nothing in this subsection affects any provision of Chapter 9 of this title. Paragraph 2. Subparagraph A. Nothing in this subsection shall apply to the lending of a computer program for nonprofit purposes by a nonprofit library. If each copy of a computer program which is lent by such library has affixed to the packaging containing the program a warning of copyright in accordance with requirements that the Register of Copyrights shall prescribe by regulation. Subparagraph B. Not later than 3 years after the date of the enactment of the Computer Software Rental Amendments Act of 1990, and at such times thereafter as the Register of Copyrights considers appropriate, the Register of Copyrights, after consultation with representatives of copyright owners and librarians, shall submit to the Congress a report stating whether this paragraph has achieved its intended purpose of maintaining the integrity of the copyright system, while providing nonprofit libraries the capability to fulfill their function. Such report shall advise the Congress as to any information or recommendations that the Register of Copyrights considers necessary to carry out the purposes of this subsection. Paragraph 3. Nothing in this subsection shall affect any provision of the antitrust laws. For purposes of the preceding sentence, antitrust laws has the meaning given that term in the first section of the Clayton Act and includes Section 5 of the Federal Trade Commission Act, to the extent that section relates to unfair methods of competition. Paragraph 4. Any person who distributes a phonorecord or a copy of a computer program, including any tape, disc, or other medium embodying such program in violation of Paragraph 1 is an infringer of copyright under Section 501 of this title and is subject to the remedies set forth in Sections 502, 503, 504, and 505. Such violation shall not be a criminal offense under Section 506 or cause such person to be subject to the criminal penalties set forth in Section 2319 of Title 18. Subsection C. Notwithstanding the provisions of Section 106, Subsection 5, the owner of a particular copy lawfully made under this title, or any person authorized by such owner, is entitled, without the authority of the copyright owner, to display that copy publicly, either directly or by the projection of no more than one image at a time, to viewers present at the place where the copy is located. Subsection D. The privileges prescribed by subsections A and C do not, unless authorized by the copyright owner, extend to any person who has acquired possession of the copy or phonorecord from the copyright owner, by rental, lease, loan, or otherwise, without acquiring ownership of it. Subsection E. Notwithstanding the provisions of Sections 106, Subsection 4, and 106, Subsection 5, in the case of an electronic audiovisual game intended for use in coin-operated equipment, the owner of a particular copy of such a game lawfully made under this title is entitled, without the authority of the copyright owner of the game, to publicly perform or display that game in coin-operated equipment, except that this subsection shall not apply to any work of authorship embodied in the audiovisual game if the copyright owner of the electronic audiovisual game is not also the copyright owner of the work of authorship. Section 110. Limitations on exclusive rights, exemption of certain performances and displays. Notwithstanding the provisions of Section 106, the following are not infringements of copyright. Paragraph 1. Performance or display of a work by instructors or pupils in the course of face-to-face teaching activities of a nonprofit educational institution, in a classroom or similar place devoted to instruction, unless, in the case of a motion picture or other audiovisual work, the performance or the display of individual images is given by means of a copy that was not lawfully made under this title, and that the person responsible for the performance knew or had reason to believe was not lawfully made. Paragraph 2. Except with respect to a work produced or marketed primarily for performance or display as part of mediated instructional activities transmitted via digital networks, or a performance or display that is given by means of a copy or phonorecord that is not lawfully made and acquired under this title, and the transmitting government body or accredited nonprofit educational institution knew or had reason to believe was not lawfully made and acquired. The performance of a non-dramatic literary or musical work, or reasonable and limited portions of any other work, or display of a work in an amount comparable to that which is typically displayed in the course of a live classroom session, by or in the course of a transmission if. Subparagraph A. The performance or display is made by, at the direction of, or under the actual supervision of an instructor as an integral part of a class session offered as a regular part of the systematic mediated instructional activities of a governmental body or an accredited nonprofit educational institution. Subparagraph B. The performance or display is directly related and of material assistance to the teaching content of the transmission. Subparagraph C. The transmission is made solely for, and, to the extent technologically feasible, the reception of such transmission is limited to. Clause 1. Students officially enrolled in the course for which the transmission is made, or. Clause 2. Officers or employees of governmental bodies as a part of their official duties or employment, and. Subparagraph D. The transmitting body or institution. Clause 1. Institutes policies regarding copyright, provides informational materials to faculty, students, and relevant staff members that accurately describe and promote compliance with the laws of the United States relating to copyright, and provides notice to students that materials used in connection with the course may be subject to copyright protection, and Clause 2. In the case of digital transmissions, Subclause 1 applies technological measures that reasonably prevent Item AA. Retention of the work in accessible form by recipients of the transmission from the transmitting body or institution for longer than the class session. And Item BB. Unauthorized further dissemination of the work in accessible form by such recipients to others. And Subclause 2. Does not engage in conduct that could reasonably be expected to interfere with technological measures used by copyright owners to prevent such retention or unauthorized further dissemination. Paragraph 3. Performance of a non-dramatic literary or musical work, or of a dramatico-musical work of a religious nature, or display of a work in the course of services at a place of worship or other religious assembly. Paragraph 4. Performance of a non-dramatic literary or musical work otherwise than in a transmission to the public, without any purpose of direct or indirect commercial advantage and without payment of any fee or other compensation for the performance to any of its performers, promoters, or organizers if. Subparagraph A. There is no direct or indirect admission charge, or Subparagraph B. The proceeds, after deducting the reasonable costs of producing the performance, are used exclusively for educational, religious, or charitable purposes and not for private financial gain, except where the copyright owner has served notice of objection to the performance under the following conditions. Clause 1. The notice shall be in writing and signed by the copyright owner or such owner's duly authorized agent, and Clause 2. The notice shall be served on the person responsible for the performance at least 7 days before the date of the performance and shall state the reasons for the objection, and Clause 3, the notice shall comply, in form, content, and manner of service, with requirements that the Register of Copyrights shall prescribe by regulation. Paragraph 5, subparagraph A. Except as provided in subparagraph B, communication of a transmission embodying a performance or display of a work by the public reception of the transmission on a single receiving apparatus of a kind commonly used in private homes, unless Clause 1. A direct charge is made to see or hear the transmission, or Clause 2. The transmission thus received is further transmitted to the public. Subparagraph B. Communication by an establishment of a transmission or retransmission embodying a performance or display of a non-dramatic musical work intended to be received by the general public. Originated by a radio or television broadcast station licensed as such by the Federal Communications Commission, or if an audiovisual transmission by a cable system or satellite carrier, if Clause 1. In the case of an establishment other than a food service or drinking establishment, either the establishment in which the communication occurs has less than 2,000 gross square feet of space, excluding space used for customer parking and for no other purpose, or the establishment in which the communication occurs has 2,000 or more gross square feet of space, excluding space used for customer parking and for no other purpose, and Subclause 1. If the performance is by audio means only, the performance is communicated by means of a total of not more than 6 loudspeakers, of which not more than 4 loudspeakers are located in any one room or adjoining outdoor space, or Subclause 2. If the performance or display is by audiovisual means, any visual portion of the performance or display is communicated by means of a total of not more than 4 audiovisual devices, of which not more than 1 audiovisual device is located in any one room, and no such audiovisual device has a diagonal screen size greater than 55 inches, and any audio portion of the performance or display is communicated by means of a total of not more than 6 loudspeakers, of which not more than 4 loudspeakers are located in any one room or adjoining outdoor space. Clause 2. In the case of a food service or drinking establishment, either the establishment in which the communication occurs has less than 3,750 gross square feet of space, excluding space used for customer parking and for no other purpose, or the establishment in which the communication occurs has 3,750 gross square feet of space or more, excluding space used for customer parking and for no other purpose, and Subclause 1. If the performance is by audio means only, the performance is communicated by means of a total of not more than 6 loudspeakers, of which not more than 4 loudspeakers are located in any one room or adjoining outdoor space, or Subclause 2. If the performance or display is by audiovisual means, any visual portion of the performance or display is communicated by means of a total of not more than 4 audiovisual devices, of which not more than 1 audiovisual device is located in any one room, and no such audiovisual device has a diagonal screen size greater than 55 inches, and any audio portion of the performance or display is communicated by means of a total of not more than 6 loudspeakers, of which not more than 4 loudspeakers are located in any one room or adjoining outdoor space. Clause 3. No direct charge is made to see or hear the transmission or retransmission. Clause 4. The transmission or retransmission is not further transmitted beyond the establishment where it is received, and Clause 5. The transmission or retransmission is licensed by the copyright owner of the work so publicly performed or displayed. Paragraph 6. Performance of a non-dramatic musical work by a governmental body or a non-profit agricultural or horticultural organization in the course of an annual agricultural or horticultural fair or exhibition conducted by such body or organization. The exemption provided by this clause shall extend to any liability for copyright infringement that would otherwise be imposed on such body or organization under doctrines of vicarious liability or related infringement for a performance by a concessionaire, business establishment, or other person at such fair or exhibition, but shall not excuse any such person from liability for the performance. Paragraph 7. Performance of a non-dramatic musical work by a vending establishment open to the public at large without any direct or indirect admission charge, where the sole purpose of the performance is to promote the retail sale of copies or phonorecords of the work, or of the audiovisual or other devices utilized in such performance, and the performance is not transmitted beyond the place where the establishment is located and is within the immediate area where the sale is occurring. Paragraph 8. Performance of a non-dramatic literary work by or in the course of a transmission specifically designed for and primarily directed to blind or other handicapped persons who are unable to read normal printed material as a result of their handicap, or deaf or other handicapped persons who are unable to hear the aural signals accompanying a transmission of visual signals. If the performance is made without any purpose of direct or indirect commercial advantage and its transmission is made through the facilities of subsection I, a governmental body, or 2, a non-commercial educational broadcast station, as defined in Section 397 of Title 47, or 3, a radio subcarrier authorization, as defined in 47 CFR 73.293-73.295 and 73.593-73.595, or 4, a cable system, as defined in Section 111, subsection F. Paragraph 9. Performance on a single occasion of a dramatic literary work published at least 10 years before the date of the performance. by or in the course of a transmission specifically designed for and primarily directed to blind or other handicapped persons who are unable to read normal printed material as a result of their handicap. If the performance is made without any purpose of direct or indirect commercial advantage and its transmission is made through the facilities of a radio subcarrier authorization referred to in Clause 8, Subclause 3, provided that the provisions of this clause shall not be applicable to more than one performance of the same work by the same performers or under the auspices of the same organization. Paragraph 10. Notwithstanding paragraph 4, the following is not an infringement of copyright. Performance of a non-dramatic literary or musical work in the course of a social function which is organized and promoted by a non-profit veterans organization or a non-profit fraternal organization to which the general public is not invited, but not including the invitees of the organizations if the proceeds from the performance, after deducting the reasonable cost of producing the performance, are used exclusively for charitable purposes and not for financial gain. For purposes of this section, the social functions of any college or university fraternity or sorority shall not be included unless the social function is held solely to raise funds for a specific charitable purpose. And paragraph 11. The making imperceptible, by or at the direction of a member of a private household, of limited portions of audio or video content of a motion picture during a performance in or transmitted to that household for private home viewing, from an authorized copy of the motion picture or the creation or provision of a computer program or other technology that enables such making imperceptible and that is designed and marketed to be used at the direction of a member of a private household. For such making imperceptible, if no fixed copy of the altered version of the motion picture is created by such computer program or other technology. The exemptions provided under paragraph 5 shall not be taken into account in any administrative, judicial, or other governmental proceeding to set or adjust the royalties payable to copyright owners for the public performance or display of their works. Royalties payable to copyright owners for any public performance or display of their works other than such performances or displays as are exempted under paragraph 5 shall not be diminished in any respect as a result of such exemption. In paragraph 2, the term mediated instructional activities with respect to the performance or display of a work by digital transmission under this section refers to activities that use such work as an integral part of the class experience, controlled by or under the actual supervision of the instructor and analogous to the type of performance or display that would take place in a live classroom setting. The term does not refer to activities that use in one or more class sessions of a single course, such works as textbooks, course packs, or other material in any media. Copies or phonorecords of which are typically purchased or acquired by the students in higher education for their independent use and retention, or are typically purchased or acquired for elementary and secondary students for their possession and independent use. For purposes of paragraph 2, accreditation. Subparagraph A, with respect to an institution providing post-secondary education, shall be as determined by a regional or national accrediting agency recognized by the Council on Higher Education Accreditation or the United States Department of Education, and subparagraph B, with respect to an institution providing elementary or secondary education, shall be as recognized by the applicable state certification or licensing procedures. For purposes of paragraph 2, no governmental body or accredited nonprofit educational institution shall be liable for infringement by reason of the transient or temporary storage of material carried out through the automatic technical process of a digital transmission of the performance or display of that material as authorized under paragraph 2. No such material stored on the system or network controlled or operated by the transmitting body or institution under this paragraph shall be maintained on such system or network in a manner ordinarily accessible to anyone other than anticipated recipients. No such copy shall be maintained on the system or network in a manner ordinarily accessible to such anticipated recipients for a longer period than is reasonably necessary to facilitate the transmissions for which it was made. For purposes of paragraph 11, the term making imperceptible does not include the addition of audio or video content that is performed or displayed over or in place of existing content in a motion picture. Nothing in paragraph 11 shall be construed to imply further rights under section 106 of this title, or to have any effect on defenses or limitations on rights granted under any other section of this title, or under any other paragraph of this section. Section 111. Limitations on exclusive rights, secondary transmissions of broadcast programming by cable. Subsection A. Certain secondary transmissions exempted. The secondary transmission of a performance or display of a work embodied in a primary transmission is not an infringement of copyright if: Paragraph 1. The secondary transmission is not made by a cable system and consists entirely of the relaying, by the management of a hotel, apartment house, or similar establishment, of signals transmitted by a broadcast station licensed by the Federal Communications Commission within the local service area of such station to the private lodgings of guests or residents of such establishment, and no direct charge is made to see or hear the secondary transmission, or Paragraph 2. The secondary transmission is made solely for the purpose and under the conditions specified by paragraph 2 of section 110, or Paragraph 3. The secondary transmission is made by any carrier who has no direct or indirect control over the content or selection of the primary transmission, or over the particular recipients of the secondary transmission, and whose activities with respect to the secondary transmission consist solely of providing wires, cables, or other communications channels for the use of others, provided that the provisions of this paragraph extend only to the activities of said carrier with respect to secondary transmissions and do not exempt from liability the activities of others with respect to their own primary or secondary transmissions. Paragraph 4. The secondary transmission is made by a satellite carrier pursuant to a statutory license under Section 119 or Section 122. Paragraph 5. The secondary transmission is not made by a cable system but is made by a governmental body or other nonprofit organization without any purpose of direct or indirect commercial advantage, and without charge to the recipients of the secondary transmission other than assessments necessary to defray the actual and reasonable costs of maintaining and operating the secondary transmission service. Subsection B. Secondary transmission of primary transmission to controlled group. Notwithstanding the provisions of subsections A and C, the secondary transmission to the public of a performance or display of a work embodied in a primary transmission is actionable as an act of infringement under Section 501, and is fully subject to the remedies provided by Sections 502 through 506. If the primary transmission is not made for reception by the public at large but is controlled and limited to reception by particular members of the public, provided, however, that such secondary transmission is not actionable as an act of infringement if Paragraph 1. The primary transmission is made by a broadcast station licensed by the Federal Communications Commission, and Paragraph 2. The carriage of the signals comprising the secondary transmission is required under the rules, regulations, or authorizations of the Federal Communications Commission, and Paragraph 3. The signal of the primary transmitter is not altered or changed in any way by the secondary transmitter. Subsection C. Secondary transmissions by cable systems. Paragraph 1. Subject to the provisions of paragraphs 2, 3, and 4 of this subsection and Section 114, subsection D, secondary transmissions to the public by a cable system of a performance or display of a work embodied in a primary transmission made by a broadcast station licensed by the Federal Communications Commission or by an appropriate governmental authority of Canada or Mexico shall be subject to statutory licensing upon compliance with the requirements of subsection D, where the carriage of the signals comprising the secondary transmission is permissible under the rules, regulations, or authorizations of the Federal Communications Commission. Paragraph 2. Notwithstanding the provisions of Paragraph 1 of this subsection, the willful or repeated secondary transmission to the public by a cable system of a primary transmission made by a broadcast station licensed by the Federal Communications Commission or by an appropriate governmental authority of Canada or Mexico and embodying a performance or display of a work is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506 in the following cases. Subparagraph A, where the carriage of the signals comprising the secondary transmission is not permissible under the rules, regulations, or authorizations of the Federal Communications Commission, or Subparagraph B, where the cable system has not deposited the statement of account and royalty fee required by subsection D. Paragraph 3. Notwithstanding the provisions of Paragraph 1 of this subsection and subject to the provisions of subsection E of this section, the secondary transmission to the public by a cable system of a performance or display of a work embodied in a primary transmission made by a broadcast station licensed by the Federal Communications Commission or by an appropriate governmental authority of Canada or Mexico is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506 and Section 501 if the content of the particular program in which the performance or display is embodied, or any commercial advertising or station announcements transmitted by the primary transmitter during or immediately before or after the transmission of such program, is in any way willfully altered by the cable system through changes, deletions, or additions except for the alteration, deletion, or substitution of commercial advertisements performed by those engaged in TV commercial advertising market research, provided that the research company has obtained the prior consent of the advertiser who has purchased the original commercial advertisement, the TV station broadcasting that commercial advertisement, and the cable system performing the secondary transmission, and provided further that such commercial alteration, deletion, or substitution is not performed for the purpose of deriving income from the sale of that commercial time. Paragraph 4. Notwithstanding the provisions of Paragraph 1 of this subsection, the secondary transmission to the public by a cable system of a performance or display of a work embodied in a primary transmission made by a broadcast station licensed by an appropriate governmental authority of Canada or Mexico is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506 if A, with respect to Canadian signals, the community of the cable system is located more than 150 miles from the United States-Canadian border and is also located south of the 42nd parallel of latitude, or B, with respect to Mexican signals. The secondary transmission is made by a cable system which received the primary transmission by means other than direct interception of a free space radio wave emitted by such broadcast television station, unless prior to April 15, 1976, such cable system was actually carrying, or was specifically authorized to carry, the signal of such foreign station on the system pursuant to the rules, regulations, or authorizations of the Federal Communications Commission. Subsection D. Statutory license for secondary transmissions by cable systems. Paragraph 1. Statement of account and royalty fees. Subject to Paragraph 5, a cable system whose secondary transmissions have been subject to statutory licensing under subsection C shall, on a semi-annual basis, deposit with the Register of Copyrights, in accordance with requirements that the Register shall prescribe by regulation, the following. Subparagraph A. A statement of account covering the 6 months next preceding, specifying the number of channels on which the cable system made secondary transmissions to its subscribers, the names and locations of all primary transmitters whose transmissions were further transmitted by the cable system, the total number of subscribers, the gross amounts paid to the cable system for the basic service of providing secondary transmissions of primary broadcast transmitters, and such other data as the Register of Copyrights may from time to time prescribe by regulation. In determining the total number of subscribers and the gross amounts paid to the cable system for the basic service of providing secondary transmissions of primary broadcast transmitters, the system shall not include subscribers and amounts collected from subscribers receiving secondary transmissions pursuant to Section 119. Such statement shall also include a special statement of account covering any non-network TV programming that was carried by the cable system in whole or in part beyond the local service area of the primary transmitter, under rules, regulations, or authorizations of the Federal Communications Commission permitting the substitution or addition of signals under certain circumstances, together with logs showing the times, dates, stations, and programs involved in such substituted or added carriage. Subparagraph B. Except in the case of a cable system whose royalty fee is specified in subparagraph E or F, a total royalty fee payable to copyright owners pursuant to paragraph 3 for the period covered by the statement, computed on the basis of specified percentages of the gross receipts from subscribers to the cable service during such period for the basic service of providing secondary transmissions of primary broadcast transmitters, as follows. Clause 1. 1.064% of such gross receipts for the privilege of further transmitting, beyond the local service area of such primary transmitter, any non-network programming of a primary transmitter in whole or in part, such amount to be applied against the fee, if any, payable pursuant to clauses 2 through 4. Clause 2. 1.064% of such gross receipts for the first distant signal equivalent. Clause 3. 0.701% of such gross receipts for each of the second, third, and fourth distant signal equivalents, and Clause 4, 0.33% of such gross receipts for the fifth distant signal equivalent and each distant signal equivalent thereafter. Subparagraph C in computing amounts under clauses 2 through 4 of subparagraph B. Clause 1, any fraction of a distant signal equivalent shall be computed at its fractional value. Clause 2. In the case of any cable system located partly within and partly outside of the local service area of a primary transmitter, gross receipts shall be limited to those gross receipts derived from subscribers located outside of the local service area of such primary transmitter, and Clause 3. If a cable system provides a secondary transmission of a primary transmitter to some but not all communities served by that cable system. Subclause 1. The gross receipts and the distant signal equivalent values for such secondary transmission shall be derived solely on the basis of the subscribers in those communities, where the cable system provides such secondary transmission, and Subclause 2. The total royalty fee for the period paid by such system shall not be less than the royalty fee calculated under subparagraph B, Clause 1 multiplied by the gross receipts from all subscribers to the system. Subparagraph D. A cable system that, on a statement submitted before the date of the enactment of the Satellite TV Extension and Localism Act of 2010, computed its royalty fee consistent with the methodology under subparagraph at C, Clause 3, or that amends a statement filed before such date of enactment to compute the royalty fee due using such methodology shall not be subject to an action for infringement or eligible for any royalty refund or offset, arising out of its use of such methodology on such statement. Subparagraph E. If the actual gross receipts paid by subscribers to a cable system for the period covered by the statement for the basic service of providing secondary transmissions of primary broadcast transmitters are $263,800 or less. Clause 1. Gross receipts of the cable system for the purpose of this paragraph shall be computed by subtracting from such actual gross receipts the amount by which $263,800 exceeds such actual gross receipts, except that in no case shall a cable system's gross receipts be reduced to less than $10,400, and Clause 2. The royalty fee payable under this paragraph to copyright owners pursuant to paragraph 3 shall be 0.5% regardless of the number of distant signal equivalents, if any. Subparagraph F. If the actual gross receipts paid by subscribers to a cable system for the period covered by the statement for the basic service of providing secondary transmissions of primary broadcast transmitters are more than $260,800 but less than $527,600, the royalty fee payable under this paragraph to copyright owners pursuant to paragraph 3 shall be Clause 1. 0.5% of any gross receipts up to $263,800, regardless of the number of distant signal equivalents, if any, and Clause 2. 1% of any gross receipts in excess of $263,800, but less than $527,600, regardless of the number of distant signal equivalents, if any. Subparagraph G. A filing fee, as determined by the Register of Copyrights pursuant to Section 708, subsection A. Paragraph 2. Handling of fees. The Register of Copyrights shall receive all fees, including the filing fee specified in paragraph 1, subparagraph G, deposited under this section, and, after deducting the reasonable costs incurred by the Copyright Office under this section, shall deposit the balance in the Treasury of the United States in such manner as the Secretary of the Treasury directs. All funds held by the Secretary of the Treasury shall be invested in interest-bearing United States securities for later distribution with interest by the Librarian of Congress upon authorization by the copyright royalty judges. Paragraph 3. Distribution of royalty fees to copyright owners. The royalty fees thus deposited shall, in accordance with the procedures provided by paragraph 4, be distributed to those among the following copyright owners who claim that their works were the subject of secondary transmissions by cable systems during the relevant semi-annual period. Subparagraph A. Any such owner whose work was included in a secondary transmission made by a cable system of a non-network TV program in whole or in part beyond the local service area of the primary transmitter. Subparagraph B. Any such owner whose work was included in a secondary transmission identified in a special statement of account deposited under paragraph 1, subparagraph A. Subparagraph C. Any such owner whose work was included in non-network programming, consisting exclusively of aural signals carried by a cable system in whole or in part beyond the local service area of the primary transmitter of such programs. Paragraph 4. Procedures for royalty fee distribution. The royalty fees thus deposited shall be distributed in accordance with the following procedures. Subparagraph A. During the month of July in each year, every person claiming to be entitled to statutory license fees for secondary transmissions shall file a claim with the copyright royalty judges, in accordance with requirements that the copyright royalty judges shall prescribe by regulation. Notwithstanding any provisions of the antitrust laws, for purposes of this clause any claimants may agree among themselves as to the proportionate division of statutory licensing fees among them, may lump their claims together and file them jointly or as a single claim, or may designate a common agent to receive payment on their behalf. Subparagraph B. After the first day of August of each year, the copyright royalty judges shall determine whether there exists a controversy concerning the distribution of royalty fees. If the copyright royalty judges determine that no such controversy exists, the copyright royalty judges shall authorize the Librarian of Congress to proceed to distribute such fees to the copyright owners entitled to receive them, or to their designated agents, subject to the deduction of reasonable administrative costs under this section. If the copyright royalty judges find the existence of a controversy, the copyright royalty judges shall, pursuant to Chapter 8 of this title, conduct a proceeding to determine the distribution of royalty fees. Subparagraph C. During the pendency of any proceeding under this subsection, the copyright royalty judges shall have the discretion to authorize the Librarian of Congress to proceed to distribute any amounts that are not in controversy. Paragraph 5. 3.75% rate and syndicated exclusivity surcharge not applicable to multicast streams. The royalty rates specified in sections 256.2c and 256.2d of Title 37, Code of Federal Regulations, commonly referred to as the 3.75% rate, and the syndicated exclusivity surcharge, respectively, as in effect on the date of the enactment of the Satellite Television Extension and Localism Act of 2010, as such rates may be adjusted or such sections redesignated thereafter by the copyright royalty judges, shall not apply to the secondary transmission of a multicast stream. Paragraph 6. Verification of accounts and fee payments. The Register of Copyrights shall issue regulations to provide for the confidential verification by copyright owners whose works were embodied in the secondary transmissions of primary transmissions pursuant to this section of the information reported on the semi-annual statements of account filed under this subsection for accounting periods beginning on or after January 1st. 2010, in order that the auditor designated under subparagraph A is able to confirm the correctness of the calculations and royalty payments reported therein. The regulations shall, subparagraph A, establish procedures for the designation of a qualified independent auditor. Clause 1. With exclusive authority to request verification of such a statement of account on behalf of all copyright owners whose works were the subject of secondary transmissions of primary transmissions by the cable system that deposited the statement during the accounting period covered by this statement. And Clause 2, who is not an officer, employee, or agent of any such copyright owner for any purpose other than such audit. Subparagraph B, establish procedures for safeguarding all non-public financial and business information provided under this paragraph. Subparagraph C, Clause 1, require a consultation period for the independent auditor to review its conclusions with a designee of the cable system. Subsection 2, establish a mechanism for the cable system to remedy any errors identified in the auditor's report and to cure any underpayment identified. And Subsection 3, provide an opportunity to remedy any disputed facts or conclusions. Subparagraph D. Limit the frequency of requests for verification for a particular cable system and the number of audits that a multiple system operator can be required to undergo in a single year. And subparagraph E. Permit requests for verification of a statement of account to be made only within 3 years after the last day of the year in which the statement of account is filed. Paragraph 7. Acceptance of additional deposits. Any royalty fee payments received by the Copyright Office from cable systems for the secondary transmission of primary transmission that are in addition to the payments calculated and deposited in accordance with this subsection shall be deemed to have been deposited for the particular accounting period for which they are received and shall be distributed as specified under this subsection. Subsection E. Non-simultaneous secondary transmissions by cable system. Paragraph 1. Notwithstanding those provisions of the subsection F, paragraph 2 relating to non-simultaneous secondary transmissions by a cable system, any such transmissions are actionable as an act of infringement under section 501, and are fully subject to the remedies provided by sections 502 through 506 and section 510 unless, subparagraph A, the program on the videotape is transmitted no more than one time to the cable system's subscribers. Subparagraph B, the copyrighted program, episode, or motion picture videotape, including the commercials contained within such program, episode, or picture, is transmitted without deletion or editing. Subparagraph C, an owner or officer of the cable system, prevents the duplication of the videotape while in the possession of the system. Clause 2. Prevents unauthorized duplication while in the possession of the facility making the videotape for the system if the system owns or controls the facility, or takes reasonable precautions to prevent such duplication if it does not own or control the facility. Clause 3. Takes adequate precautions to prevent duplication while the tape is being transported, and 4. Subject to paragraph 2, erases or destroys or causes the erasure or destruction of the videotape. Subparagraph D. Within 45 days after the end of each calendar quarter, an owner or officer of the cable system executes an affidavit attesting to the steps and precautions taken to prevent duplication of the videotape, and 2. Subject to paragraph 2, to the erasure or destruction of all videotapes made or used during such quarter. Subparagraph E. Such owner or officer places or causes each such affidavit and affidavits received pursuant to paragraph 2, subparagraph C, to be placed in a file open to public inspection at such system's main office in the community where the transmission is made or in the nearest community where such system maintains an office. And subparagraph F. The non-simultaneous transmission is one that the cable system would be authorized to transmit under the rules, regulations, and authorizations of the Federal Communications Commission in effect at the time of the non-simultaneous transmission, if the transmission had been made simultaneously, except that this subparagraph shall not apply to inadvertent or accidental transmission. Paragraph 2. If a cable system transfers to any person a videotape of a program non-simultaneously transmitted by it, such transfer is actionable as an act of infringement under section 501 and is fully subject to the remedies provided by sections 502 through 506. Except that, pursuant to a written, non-profit contract providing for the equitable sharing of the costs of such videotape and its transfer, a videotape non-simultaneously transmitted by it, in accordance with paragraph 1, may be transferred by one cable system in Alaska to another system in Alaska, by one cable system in Hawaii permitted to make such non-simultaneous transmissions to another such cable system in Hawaii, or by one cable system in Guam, the Northern Mariana Islands, the Federated States of Micronesia, the Republic of Palau, or the Republic of the Marshall Islands, to another cable system in any of those 5 entities, if, subparagraph A, each such contract is available for public inspection in the offices of the cable systems involved, and a copy of such contract is filed within 30 days after such contract is entered into, with the Copyright Office, which office shall make each such contract available for public inspection. Subparagraph B, the cable system to which the videotape is transferred complies with paragraph 1, subparagraph A, B, C, I, 3 and 4, and D through F, and subparagraph C, such system provides a copy of the affidavit required to be made in accordance with paragraph 1, subparagraph D to each cable system making a previous non-simultaneous transmission of the same videotape. Paragraph 3. This subsection shall not be construed to supersede the exclusivity protection provisions of any existing agreement or any such agreement hereafter entered into between a cable system and a TV broadcast station in the area in which the cable system is located or a network with which such station is affiliated. Paragraph 4. As used in this subsection, the term videotape means the reproduction of the images and sounds of a program or programs broadcast by a TV broadcast station licensed by the Federal Communications Commission, regardless of the nature of the material objects, such as tapes or films, in which the reproduction is embodied. Subsection F. Definitions. As used in this section, the following terms mean the following. Paragraph 1. Primary transmission. A primary transmission is a transmission made to the public by a transmitting facility whose signals are being received and further transmitted by a secondary transmission service, regardless of where or when the performance or display was first transmitted. In the case of a TV broadcast station, the primary stream and any multicast streams transmitted by the station constitute primary transmissions. Paragraph 2. Secondary transmission. A secondary transmission is the further transmitting of a primary transmission simultaneously with the primary transmission or non-simultaneously with the primary transmission if by a cable system not located in whole or in part within the boundary of the 48 contiguous states, Hawaii or Puerto Rico provided, however, that a non-simultaneous further transmission by a cable system located in Hawaii of a primary transmission shall be deemed to be a secondary transmission if the carriage of the TV broadcast signal comprising such further transmission is permissible under the rules, regulations, or authorizations of the Federal Communications Commission. Paragraph 3. Cable system. A cable system is a facility located in any state, territory, trust territory, or possession of the United States that in whole or in part receives signals transmitted or programs broadcast by one or more television broadcast stations licensed by the Federal Communications Commission and makes secondary transmissions of such signals or programs by wires, cables, microwave, or other communications channels to subscribing members of the public who pay for such service. For purposes of determining the royalty fee under subsection D, paragraph 1, two or more cable systems in contiguous communities under common ownership or control or operating from one head end shall be considered as one system. Paragraph 4. Local service area of a primary transmitter. The local service area of a primary transmitter, in the case of both the primary stream and any multicast streams transmitted by a primary transmitter that is a TV broadcast station, comprises the area where such primary transmitter could have insisted upon its signal being retransmitted by a cable system pursuant to the rules, regulations, and authorizations of the Federal Communications Commission in effect on April 15, 1976, or such station's TV market as defined in Section 76.55E of Title 47, Code of Federal Regulations, as in effect on September 18, 1993, or any modifications to such television market made on or after September 18, 1993, pursuant to Section 76.55E or 76.59 of Title 47, Code of Federal Regulations, or within the noise-limited contour as defined in 73.622, subsection E, paragraph 1 of Title 47, Code of Federal Regulations, or in the case of a TV broadcast station licensed by an appropriate governmental authority of Canada or Mexico, the area in which it would be entitled to insist upon its signal being retransmitted if it were a television broadcast station subject to such rules, regulations, and authorizations. In the case of a low-power television station, as defined by the rules and regulations of the Federal Communications Commission, the local service area of a primary transmitter comprises the designated market area, as defined in Section 122, subsection J, paragraph 2, subparagraph C, that encompasses the community of license of such station and any community that is located outside such designated market area that is either wholly or partially within 35 miles of the transmitter site or, in the case of such a station located in a standard metropolitan statistical area which has one of the 50 largest populations of all standard metropolitan statistical areas based on the 1980 decennial census of population taken by the Secretary of Commerce, wholly or partially within 20 miles of such transmitter site. The local service area of a primary transmitter, in the case of a radio broadcast station, comprises the primary service area of such station pursuant to the rules and regulations of the Federal Communications Commission. Paragraph 5. Distant signal equivalent. Subparagraph A in general, except as provided under subparagraph B, a distant signal equivalent. Clause 1 is the value assigned to the secondary transmission of any non-network TV programming carried by a cable system in whole or in part beyond the local service area of the primary transmitter of such programming, and Clause 2 is computed by assigning a value of 1 to each primary stream and to each multicast stream, other than a simulcast, that is an independent station, and by assigning a value of 1/4 to each primary stream and to each multicast stream, other than a simulcast, that is a network station or a non-commercial educational station. Subparagraph B exceptions. The values for independent network and non-commercial educational stations specified in subparagraph A are subject to the following. Clause 1. Where the rules and regulations of the Federal Communications Commission require a cable system to omit the further transmission of a particular program, and such rules and regulations also permit the substitution of another program embodying a performance or display of a work in place of the omitted transmission, or where such rules and regulations in effect on the date of the enactment of the Copyright Act of 1976 permit a cable system, at its election, to effect such omission and substitution of a non-live program, or to carry additional programs not transmitted by primary transmitters within whose local service area the cable system is located, no value shall be assigned for the substituted or additional program. Clause 2. Where the rules, regulations, or authorizations of the Federal Communications Commission in effect on the date of the enactment of the Copyright Act of 1976 permit a cable system, at its election, to omit the further transmission of a particular program, and such rules, regulations, or authorizations also permit the substitution of another program, embodying a performance or display of a work in place of the omitted transmission. The value assigned for the substituted or additional program shall be, in the case of a live program, the value of one full distance signal equivalent multiplied by a fraction that has as its numerator the number of days in the year in which such substitution occurs, and as its denominator the number of days in the year. Clause 3. In the case of the secondary transmission of a primary transmitter that is a TV broadcast station pursuant to the late night or specialty programming rules of the Federal Communications Commission, or the secondary transmission of a primary transmitter that is a television broadcast station on a part-time basis where full-time carriage is not possible because the cable system lacks the activated channel capacity to retransmit on a full-time basis all signals that it is authorized to carry. The values for independent network and non-commercial educational stations set forth in subparagraph of A, as the case may be, shall be multiplied by a fraction that is equal to the ratio of the broadcast hours of such primary transmitter, retransmitted by the cable system to the total broadcast hours of the primary transmitter. Clause 4. No value shall be assigned for the secondary transmission of the primary stream or any multicast streams of a primary transmitter that is a TV broadcast station in any community that is within the local service area of the primary transmitter. Paragraph 6. Network station. Subparagraph A. Treatment of primary stream. The term network station shall be applied to a primary stream of a television broadcast station that is owned or operated by or affiliated with one or more of the TV networks in the United States, providing nationwide transmissions, and that transmits a substantial part of the programming supplied by such networks for a substantial part of the primary stream's typical broadcast day. Subparagraph B. Treatment of multicast streams. The term network station shall be applied to a multicast stream on which a television broadcast station transmits all or substantially all of the programming of an interconnected program service that Clause 1 is owned or operated by or affiliated with one or more of the television networks described in subparagraph A, and Clause 2 offers programming on a regular basis for 15 or more hours per week to at least 25 of the affiliated television licensees of the interconnected program service in 10 or more states. Paragraph 7. Independent station. The term independent station shall be applied to the primary stream or multicast stream of a TV broadcast station that is not a network station or a non-commercial educational station. Paragraph 8. Non-commercial educational station. The term non-commercial educational station shall be applied to the primary stream or a multicast stream of a TV broadcast station that is a non-commercial educational broadcast station as defined in Section 397 of the Communications Act of 1934, as in effect on the date of the enactment of the Satellite Television Extension and Localism Act of 2010. Paragraph 9. Primary stream. A primary stream is Subparagraph A, the single digital stream of programming that, before June 12, 2009, was substantially duplicating the programming transmitted by the television broadcast station as an analog signal, or Subparagraph B, if there is no stream described in subparagraph A, then the single digital stream of programming transmitted by the TV broadcast station for the longest period of time. Paragraph 10. Primary transmitter. A primary transmitter is a TV or radio broadcast station licensed by the Federal Communications Commission or by an appropriate governmental authority of Canada or Mexico that makes primary transmissions to the public. Paragraph 11. Multicast stream. A multicast stream is a digital stream of programming that is transmitted by a television broadcast station and is not the station's primary stream. Paragraph 12. Simulcast. A simulcast is a multicast stream of a TV broadcast station that duplicates the programming transmitted by the primary stream or another multicast stream of such station. Paragraph 13. Subscriber. Subscribe. Subparagraph A. Subscriber. The term subscriber means a person or entity that receives a secondary transmission service from a cable system and pays a fee for the service, directly or indirectly to the cable system. Subparagraph B. Subscribe. The term subscribe means to elect to become a subscriber. Section 112. Limitations on exclusive rights. Ephemeral recordings. Subsection A. Paragraph 1. Notwithstanding the provisions of Section 106, and except in the case of a motion picture or other audiovisual work, it is not an infringement of copyright for a transmitting organization entitled to transmit to the public a performance or display of a work under a license, including a statutory license under Section 114, subsection F, or transfer of the copyright, or under the limitations on exclusive rights and sound recordings specified by Section 114, subsection A, or for a transmitting organization that is a broadcast radio or television station licensed as such by the Federal Communications Commission and that makes a broadcast transmission of a performance of a sound recording in a digital format on a non-subscription basis. To make no more than one copy or phonorecord of a particular transmission program embodying the performance or display, if Subparagraph A. The copy or phonorecord is retained and used solely by the transmitting organization that made it, and no further copies or phonorecords are reproduced from it, and Subparagraph B. The copy or phonorecord is used solely for the transmitting organization's own transmissions within its local service area or for purposes of archival preservation or security, and Subparagraph C. Unless preserved exclusively for archival purposes, the copy or phonorecord is destroyed within 6 months from the date the transmission program was first transmitted to the public. Paragraph 2. In a case in which a transmitting organization entitled to make a copy or phonorecord under paragraph 1 in connection with the transmission to the public of a performance or display of a work is prevented from making such copy or phonorecord by reason of the application by the copyright owner of technical measures that prevent the reproduction of the work, the copyright owner shall make available to the transmitting organization the necessary means for permitting the making of such copy or phonorecord as permitted under that paragraph, if it is technologically feasible and economically reasonable for the copyright owner to do so. If the copyright owner fails to do so in a timely manner in light of the transmitting organization's reasonable business requirements, the transmitting organization shall not be liable for a violation of Section 1001, subsection A. Paragraph 1 of this title for engaging in such activities as are necessary to make such copies or phonorecords as permitted under paragraph 1 of this subsection. Subsection B. Notwithstanding the provisions of Section 106, it is not an infringement of copyright for a governmental body or other nonprofit organization entitled to transmit a performance or display of a work under Section 110, Substack 2, or under the limitations on exclusive rights in sound recording specified by Section 114, subsection A, to make no more than 30 copies or phonorecords of a particular transmission program embodying the performance or display if Paragraph 1. No further copies or phonorecords are reproduced from the copies or phonorecords made under this clause, and Paragraph 2. Except for one copy or phonorecord that may be preserved exclusively for archival purposes, the copies or phonorecords are destroyed within 7 years from the date the transmission program was first transmitted to the public. Subsection C. Notwithstanding the provisions of Section 106, it is not an infringement of copyright for a governmental body or other nonprofit organization to make for distribution no more than one copy or phonorecord for each transmitting organization specified in Clause 2 of this subsection of a particular transmission program embodying a performance of a non-dramatic musical work of a religious nature or of a sound recording of such a musical work if Paragraph 1. There is no direct or indirect charge for making or distributing any such copies or phonorecords, and Paragraph 2. None of such copies or phonorecords is used for any performance other than a single transmission to the public by a transmitting organization entitled to transmit to the public a performance of the work under a license or transfer of the copyright. And Paragraph 3. Except for one copy or phonorecord that may be preserved exclusively for archival purposes, the copies or phonorecords are all destroyed within 1 year from the date the transmission program was first transmitted to the public. Subsection D. Notwithstanding the provisions of Section 106, it is not an infringement of copyright for a governmental body or other nonprofit organization entitled to transmit a performance of a work under Section 110. Substack 8 to make no more than 10 copies or phonorecords embodying the performance, or to permit the use of any such copy or phonorecord by any governmental body or nonprofit organization entitled to transmit a performance of a work under Section 110. Substack 8 if Paragraph 1. Any such copy or phonorecord is retained and used solely by the organization that made it, or by a governmental body or nonprofit organization entitled to transmit a performance of a work under Section 110, subsection 8, and no further copies or phonorecords are reproduced from it. And Paragraph 2. Any such copy or phonorecord is used solely for transmissions authorized under Section 110, subsection 8, or for purposes of archival preservation or security. And Paragraph 3. The governmental body or nonprofit organization permitting any use of any such copy or phonorecord by any governmental body or nonprofit organization under this subsection does not make any charge for such use. Subsection E. Statutory license. Paragraph 1. A transmitting organization entitled to transmit to the public a performance of a sound recording under the limitation on exclusive rights specified by Section 114, subsection D, paragraph 1, subparagraph at C. Clause 4, or under a statutory license in accordance with Section 114, subsection F is entitled to a statutory license under the conditions specified by this subsection. To make no more than one phonorecord of the sound recording, unless the terms and conditions of the statutory license allow for more, if the following conditions are satisfied. Subparagraph A. The phonorecord is retained and used solely by the transmitting organization that made it, and no further phonorecords are reproduced from it. Subparagraph B. The phonorecord is used solely for the transmitting organization's own transmissions originating in the United States under a statutory license in accordance with Section 114, subsection F, or the limitation on exclusive rights specified by Section 114, substack D, paragraph 1, subparagraph C, clause 4. Subparagraph C. Unless preserved exclusively for purposes of archival preservation, the phonorecord is destroyed within 6 months from the date the sound recording was first transmitted to the public using the phonorecord. Subparagraph D. Phonorecords of the sound recording have been distributed to the public under the authority of the copyright owner, or the copyright owner authorizes the transmitting entity to transmit the sound recording, and the transmitting entity makes the phonorecord under this subsection from a phonorecord lawfully made and acquired under the authority of the copyright owner. Paragraph 2. Notwithstanding any provision of the antitrust laws, Any copyright owners of sound recordings and any transmitting organizations entitled to a statutory license under this subsection may negotiate and agree upon royalty rates and license terms and conditions for making phonorecords of such sound recordings under this section and the proportionate division of fees paid among copyright owners, and may designate common agents to negotiate, agree to, pay, or receive such royalty payments. Paragraph 3. Proceedings under Chapter 8 shall determine reasonable rates and terms of royalty payments for the activities specified by Paragraph 1 during the 5-year period beginning on January 1st of the second year following the year in which the proceedings are to be commenced, or such other period as the parties may agree. Such rates shall include a minimum fee for each type of service offered by transmitting organizations. Any copyright owners of sound recordings or any transmitting organizations entitled to a statutory license under this subsection may submit to the copyright royalty judges licenses covering such activities with respect to such sound recordings. The parties to each proceeding shall bear their own costs. Paragraph 4. The schedule of reasonable rates and terms determined by the copyright royalty judges shall, subject to Paragraph 5, be binding on all copyright owners of sound recordings and transmitting organizations entitled to a statutory license under this subsection during the 5-year period specified in Paragraph 3, or such other period as the parties may agree. Such rates shall include a minimum fee for each type of service offered by transmitting organizations. The copyright royalty judges shall establish rates that most clearly represent the fees that would have been negotiated in the marketplace between a willing buyer and a willing seller. In determining such rates and terms, the copyright royalty judges shall base their decision on economic, competitive, and programming information presented by the parties, including subparagraph A, whether use of the service may substitute for or may promote the sales of phonorecords or otherwise interferes with or enhances the copyright owner's traditional streams of revenue, and subparagraph B, the relative roles of the copyright owner and the transmitting organization in the copyrighted work and the service made available to the public with respect to relative creative contribution, technological contribution, capital investment, cost, and risk. In establishing such rates and terms, the copyright royalty judges may consider the rates and terms under voluntary license agreements described in paragraphs 2 and 3. The copyright royalty judges shall also establish requirements by which copyright owners may receive reasonable notice of the use of their sound recordings under this section, and under which records of such use shall be kept and made available by transmitting organizations entitled to obtain a statutory license under this subsection. Paragraph 5. License agreements voluntarily negotiated at any time between one or more copyright owners of sound recordings and one or more transmitting organizations entitled to obtain a statutory license under this subsection shall be given effect in lieu of any decision by the Librarian of Congress or determination by the copyright royalty judges. Paragraph 6. Subparagraph A. Any person who wishes to make a phonorecord of a sound recording under a statutory license in accordance with this subsection may do so without infringing the exclusive right of the copyright owner of the sound recording under Section 106, subsection 1. Clause 1. By complying with such notice requirements as the copyright royalty judges shall prescribe by regulation and by paying royalty fees in accordance with this subsection, or Clause 2. If such royalty fees have not been set, by agreeing to pay such royalty fees as shall be determined in accordance with this subsection. Subparagraph B. Any royalty payments in arrears shall be made on or before the 20th day of the month next succeeding the month in which the royalty fees are set. Paragraph 7. If a transmitting organization entitled to make a phonorecord under this subsection is prevented from making such phonorecord by reason of the application by the copyright owner of technical measures that prevent the reproduction of the sound recording, the copyright owner shall make available to the transmitting organization the necessary means for permitting the making of such phonorecord as permitted under this subsection, if it is technologically feasible and economically reasonable for the copyright owner to do so. If the copyright owner fails to do so in a timely manner in light of the transmitting organization's reasonable business requirements, the transmitting organization shall not be liable for a violation of Section 1001, subsection A, paragraph 1 of this title for engaging in such activities as are necessary to make such phonorecords as permitted under this subsection. Paragraph 8. Nothing in this subsection annuls, limits, impairs, or otherwise affects in any way the existence or value of any of the exclusive rights of the copyright owners in a sound recording, except as otherwise provided in this subsection, or in a musical work, including the exclusive rights to reproduce and distribute a sound recording or musical work, including by means of a digital phonorecord delivery under Sections 106, subsection 1, 106, subsection 3, and 115, and the right to perform publicly a sound recording or musical work, including by means of a digital audio transmission under Sections 106, subsection 4, and 106, subsection 6. Subsection F, paragraph 1. Notwithstanding the provisions of Section 106, and without limiting the application of subsection B, it is not an infringement of copyright for a governmental body or other nonprofit educational institution entitled under Section 110. Subchapter 2 to transmit a performance or display to make copies or phonorecords of a work that is in digital form and, solely to the extent permitted in paragraph 2, of a work that is in analog form, embodying the performance or display to be used for making transmissions authorized under Section 110, subsection 2, if Subparagraph A. Such copies or phonorecords are retained and used solely by the body or institution that made them, and no further copies or phonorecords are reproduced from them, except as authorized under Section 110, subsection 2 and Subparagraph B. Such copies or phonorecords are used solely for transmissions authorized under Section 110, subsection 2. Paragraph 2. This subsection does not authorize the conversion of print or other analog versions of works into digital formats except that such conversion is permitted hereunder. Only with respect to the amount of such works authorized to be performed or displayed under Section 110, subsection 2, if Subparagraph A. No digital version of the work is available to the institution, or Subparagraph B. The digital version of the work that is available to the institution is subject to technological protection measures that prevent its use for Section 110, subsection 2. Subsection G. The transmission program embodied in a copy or phonorecord made under this section is not subject to protection as a derivative work under this title, except with the express consent of the owners of copyright in the pre-existing works employed in the program. Section 113. Scope of exclusive rights in pictorial, graphic, and sculptural works. Subsection A. Subject to the provisions of subsections B and C of this section, the exclusive right to reproduce a copyrighted pictorial, graphic, or sculptural work in copies under Section 106 includes the right to reproduce the work in or on any kind of article, whether useful or otherwise. Subsection B. This title does not afford to the owner of copyright in a work that portrays a useful article as such any greater or lesser rights with respect to the making, distribution, or display of the useful article so portrayed than those afforded to such works under the law, whether Title 17 or the common law or statutes of a state, in effect on December 31, 1977, as held applicable and construed by a court in an action brought under this title. Subsection C. In the case of a work lawfully reproduced in useful articles that have been offered for sale or other distribution to the public, copyright does not include any right to prevent the making, distribution, or display of pictures or photographs of such articles in connection with advertisements or commentaries related to the distribution or display of such articles, or in connection with news reports. Subsection D, paragraph 1. In a case in which, subparagraph A, a work of visual art has been incorporated in or made part of a building in such a way that removing the work from the building will cause the destruction, distortion, mutilation, or other modification of the work as described in Section 106A, subsection A, paragraph 3, and subparagraph B. The author consented to the installation of the work in the building either before the effective date set forth in Section 610, subsection A of the Visual Artists' Rights Act of 1990, or in a written instrument executed on or after such effective date that is signed by the owner of the building and the author, and that specifies that installation of the work may subject the work to destruction, distortion, mutilation, or other modification by reason of its removal, then the rights conferred by paragraphs 2 and 3 of Section 106A, subsection A shall not apply. Paragraph 2. If the owner of a building wishes to remove a work of visual art which is a part of such building, and which can be removed from the building without the destruction, distortion, mutilation, or other modification of the work, as described in Section 106A, subchapter A, paragraph 3, the author's rights under paragraphs 2 and 3 of Section 106A, subsection A shall apply unless. Subparagraph A. The owner has made a diligent good faith attempt without success to notify the author of the owner's intended action affecting the work of visual art, or subparagraph B, the owner did provide such notice in writing and the person so notified failed, within 90 days after receiving such notice, either to remove the work or to pay for its removal. For purposes of subparagraph A, an owner shall be presumed to have made a diligent, good faith attempt to send notice if the owner sent such notice by registered mail to the author at the most recent address of the author that was recorded with the Register of Copyrights pursuant to paragraph 3. If the work is removed at the expense of the author, title to that copy of the work shall be deemed to be in the author. Paragraph 3. The Register of Copyrights shall establish a system of records whereby any author of a work of visual art that has been incorporated in or made part of a building may record his or her identity and address with the Copyright Office. The Register shall also establish procedures under which any such author may update the information so recorded, and procedures under which owners of buildings may record with the Copyright Office evidence of their efforts to comply with this subsection. Section 114. Scope of exclusive rights in sound recordings. Subsection A. The exclusive rights of the owner of copyright in a sound recording are limited to the rights specified by clauses 1, 2, 3, and 6 of Section 106, and do not include any right of performance under Section 106, subsection 4. Subsection B. The exclusive right of the owner of copyright in a sound recording under Clause 1 of Section 106 is limited to the right to duplicate the sound recording in the form of phono records or copies that directly or indirectly recapture the actual sounds fixed in the recording. The exclusive right of the owner of copyright in a sound recording under Clause 2 of Section 106 is limited to the right to prepare a derivative work in which the actual sounds fixed in the sound recording are rearranged, remixed, or otherwise altered in sequence or quality. The exclusive rights of the owner of copyright in a sound recording under clauses 1 and 2 of section 106 do not extend to the making or duplication of another sound recording that consists entirely of an independent fixation of other sounds, even though such sounds imitate or simulate those in the copyrighted sound recording. The exclusive rights of the owner of copyright in a sound recording under clauses 1, 2, and 3 of section 106 do not apply to sound recordings included in educational television and radio programs, as defined in section 397 of Title 47, distributed or transmitted by or through public broadcasting entities, as defined by section 118, subsection F, provided that copies or phonorecords of said programs are not commercially distributed by or through public broadcasting entities to the general public. Subsection C. This section does not limit or impair the exclusive right to perform publicly, by means of a phonorecord, any of the works specified by section 106, subsection 4. Subsection D. Limitations on exclusive right, notwithstanding the provisions of section 106, subsection 6. Paragraph 1. Exempt transmissions and retransmissions. The performance of a sound recording publicly by means of a digital audio transmission, other than as a part of an interactive service, is not an infringement of section 106, subsection 6, if the performance is part of Subparagraph A, a non-subscription broadcast transmission. Subparagraph B, a retransmission of a non-subscription broadcast transmission, provided that, in the case of a retransmission of a radio station's broadcast transmission, Clause 1. The radio station's broadcast transmission is not willfully or repeatedly retransmitted more than a radius of 150 miles from the site of the radio broadcast transmitter. However, Subclause 1. The 150-mile limitation under this clause shall not apply when a non-subscription broadcast transmission by a radio station licensed by the Federal Communications Commission is retransmitted on a non-subscription basis by a terrestrial broadcast station, terrestrial translator, or terrestrial repeater licensed by the Federal Communications Commission, and Subclause 2. In the case of a subscription retransmission of a non-subscription broadcast retransmission covered by Subclause 1, the 150-mile radius shall be measured from the transmitter site of such broadcast retransmitter. Clause 2. The retransmission is of radio station broadcast transmissions that are Subclause 1. Obtained by the retransmitter over the air. Subclause 2. Not electronically processed by the retransmitter to deliver separate and discrete signals, and Subclause 3. Retransmitted only within the local communities served by the retransmitter. Clause 3. The radio station's broadcast transmission was being retransmitted to cable systems as defined in Section 111, subsection F, by a satellite carrier on January 1, 1995, and that retransmission was being retransmitted by cable systems as a separate and discrete signal, and the satellite carrier obtains the radio station's broadcast transmission in an analog format, provided that the broadcast transmission being retransmitted may embody the programming of no more than one radio station, or Clause 4. The radio station's broadcast transmission is made by a non-commercial educational broadcast station funded on or after January 1, 1995, under Section 396, subsection K of the Communications Act of 1934, Title 47, United States Code, Section 396, subsection K, consists solely of non-commercial educational and cultural radio programs, and the retransmission, whether or not simultaneous, is a non-subscription terrestrial broadcast retransmission, or Subparagraph C, a transmission that comes within any of the following categories. Clause 1. A prior or simultaneous transmission incidental to an exempt transmission, such as a feed received by and then retransmitted by an exempt transmitter, provided that such incidental transmissions do not include any subscription transmission directly for reception by members of the public. Clause 2. A transmission within a business establishment confined to its premises or the immediately surrounding vicinity. Clause 3. A retransmission by any retransmitter, including a multi-channel video programming distributor as defined in Section 602, subsection 12 of the Communications Act of 1934, Title 47, United States Code, Section 522, subsection 12, of a transmission by a transmitter licensed to publicly perform the sound recording as a part of that transmission, if the retransmission is simultaneous with the licensed transmission and authorized by the transmitter, or Clause 4. A transmission to a business establishment for use in the ordinary course of its business, provided that the business recipient does not retransmit the transmission outside of its premises or the immediately surrounding vicinity, and that the transmission does not exceed the sound recording performance complement. Nothing in this clause shall limit the scope of the exemption in Clause 2. Paragraph 2. Statutory licensing of certain transmissions. The performance of a sound recording publicly by means of a subscription digital audio transmission not exempt under Paragraph 1, an eligible non-subscription transmission, or a transmission not exempt under Paragraph 1 that is made by a pre-existing satellite digital audio radio service, shall be subject to statutory licensing in accordance with subsection F if Subparagraph A, Clause 1. The transmission is not part of an interactive service. Subsection 2. Except in the case of a transmission to a business establishment, the transmitting entity does not automatically and intentionally cause any device receiving the transmission to switch from one program channel to another. And Subsection 3. Except as provided in Section 1002, subsection E, the transmission of the sound recording is accompanied, if technically feasible, by the information encoded in that sound recording, if any, by or under the authority of the copyright owner of that sound recording that identifies the title of the sound recording, the featured recording artist who performs on the sound recording, and related information, including information concerning the underlying musical work and its writer. Subparagraph B. In the case of a subscription transmission not exempt under paragraph 1 that is made by a pre-existing subscription service in the same transmission medium used by such service on July 31, 1998, or in the case of a transmission not exempt under paragraph 1 that is made by a pre-existing satellite digital audio radio service. Clause 1. The transmission does not exceed the sound recording performance complement, and Clause 2. The transmitting entity does not cause to be published by means of an advance program schedule or prior announcement the titles of the specific sound recordings or phonorecords embodying such sound recordings to be transmitted, and subparagraph C. In the case of an eligible non-subscription transmission or a subscription transmission not exempt under paragraph 1 that is made by a new subscription service or by a pre-existing subscription service other than in the same transmission medium used by such service on July 31st. 1998, Clause 1. The transmission does not exceed the sound recording performance complement, except that this requirement shall not apply in the case of a retransmission of a broadcast transmission. If the retransmission is made by a transmitting entity that does not have the right or ability to control the programming of the broadcast station making the broadcast transmission, unless Subclause 1. The broadcast station makes broadcast transmissions. Item AA in digital format that regularly exceed the sound recording performance complement, or Item BB in analog format, a substantial portion of which on a weekly basis exceed the sound recording performance complement, and Subclause 2. The sound recording copyright owner or its representative has notified the transmitting entity in writing that broadcast transmissions of the copyright owner's sound recordings exceed the sound recording performance complement as provided in this clause. Clause 2. The transmitting entity does not cause to be published or induce or facilitate the publication, by means of an advance program schedule or prior announcement, the titles of the specific sound recordings to be transmitted, the phonorecords embodying such sound recordings, or, other than for illustrative purposes, the names of the featured recording artists, except that this clause does not disqualify a transmitting entity that makes a prior announcement that a particular artist will be featured within an unspecified future time period. And in the case of a retransmission of a broadcast transmission by a transmitting entity that does not have the right or ability to control the programming of the broadcast transmission, the requirement of this clause shall not apply to a prior oral announcement by the broadcast station or to an advance program schedule published, induced, or facilitated by the broadcast station, if the transmitting entity does not have actual knowledge and has not received written notice from the copyright owner or its representative that the broadcast station publishes or induces or facilitates the publication of such advance program schedule, or if such advance program schedule is a schedule of classical music programming published by the broadcast station in the same manner as published by that broadcast station on or before September 30th, 1998. Clause 3. The transmission. Subclause 1 is not part of an archived program of less than 5 hours duration. Subclause 2 is not part of an archived program of 5 hours or greater in duration that is made available for a period exceeding 2 weeks. Subclause 3 is not part of a continuous program which is of less than 3 hours duration, or Subclause 4 is not part of an identifiable program in which performances of sound recordings are rendered in a predetermined order other than an archived or continuous program that is transmitted at Item AA more than 3 times in any 2-week period that have been publicly announced in advance in the case of a program of less than 1 hour in duration, or Item BB more than 4 times in any 2-week period that have been publicly announced in advance in the case of a program of 1 hour or more in duration, except that the requirement of this subclause shall not apply in the case of a retransmission of a broadcast transmission by a transmitting entity that does not have the right or ability to control the programming of the broadcast transmission, unless the transmitting entity is given notice in writing by the copyright owner of the sound recording that the broadcast station makes broadcast transmissions that regularly violate such requirement. Clause 4. The transmitting entity does not knowingly perform the sound recording as part of a service that offers transmissions of visual images contemporaneously with transmissions of sound recordings in a manner that is likely to cause confusion, to cause mistake, or to deceive as to the affiliation, connection, or association of the copyright owner or featured recording artist with the transmitting entity or a particular product or service advertised by the transmitting entity, or as to the origin, sponsorship, or approval by the copyright owner or featured recording artist of the activities of the transmitting entity other than the performance of the sound recording itself. Clause 5. The transmitting entity cooperates to prevent, to the extent feasible without imposing substantial costs or burdens, a transmission recipient or any other person or entity from automatically scanning the transmitting entity's transmissions alone or together with transmissions by other transmitting entities in order to select a particular sound recording to be transmitted to the transmission recipient, except that the requirement of this clause shall not apply to a satellite digital audio service that is in operation or that is licensed by the Federal Communications Commission on or before July 31st, 1998. Clause 6. The transmitting entity takes no affirmative steps to cause or induce the making of a phonorecord by the transmission recipient, and if the technology used by the transmitting entity enables the transmitting entity to limit the making by the transmission recipient of phonorecords of the transmission directly in a digital format, the transmitting entity sets such technology to limit such making of phonorecords to the extent permitted by such technology. Clause 7. Phonorecords of the sound recording have been distributed to the public under the authority of the copyright owner, or the copyright owner authorizes the transmitting entity to transmit the sound recording, and the transmitting entity makes the transmission from a phonorecord lawfully made under the authority of the copyright owner. Except that the requirement of this clause shall not apply to a retransmission of a broadcast transmission by a transmitting entity that does not have the right or ability to control the programming of the broadcast transmission, unless the transmitting entity is given notice in writing by the copyright owner of the sound recording that the broadcast station makes broadcast transmissions that regularly violate such requirement. Clause 8. The transmitting entity accommodates and does not interfere with the transmission of technical measures that are widely used by sound recording copyright owners to identify or protect copyrighted works, and that are technically feasible of being transmitted by the transmitting entity without imposing substantial costs on the transmitting entity or resulting in perceptible oral or visual degradation of the digital signal. Except that the requirement of this clause shall not apply to a satellite digital audio service that is in operation or that is licensed under the authority of the Federal Communications Commission on or before July 31st, 1998. To the extent that such service has designed, developed, or made commitments to procure equipment or technology that is not compatible with such technical measures before such technical measures are widely adopted by sound recording copyright owners. And Clause 9. The transmitting entity identifies in textual data the sound recording during, but not before, the time it is performed, including the title of the sound recording, the title of the phonorecord embodying such sound recording, if any, and the featured recording artists, in a manner to permit it to be displayed to the transmission recipient by the device or technology intended for receiving the service provided by the transmitting entity. Except that the obligation in this clause shall not take effect until 1 year after the date of the enactment of the Digital Millennium Copyright Act, and shall not apply in the case of a retransmission of a broadcast transmission by a transmitting entity that does not have the right or ability to control the programming of the broadcast transmission, or in the case in which devices or technology intended for receiving the service provided by the transmitting entity that have the capability to display such textual data are not common in the marketplace. Paragraph 3. Licenses for transmissions by interactive services. Subparagraph A. No interactive service shall be granted an exclusive license under Section 106, subsection 6 for the performance of a sound recording publicly by means of digital audio transmission for a period in excess of 12 months, except that with respect to an exclusive license granted to an interactive service by a licensor that holds the copyright to 1,000 or fewer sound recordings, the period of such license shall not exceed 24 months, provided, however, that the grantee of such exclusive license shall be ineligible to receive another exclusive license for the performance of that sound recording for a period of 13 months from the expiration of the prior exclusive license. Subparagraph B. The limitations set forth in subparagraph A of this paragraph shall not apply if: Clause 1. The licensor has granted and there remain in effect licenses under Section 106, subsection 6 for the public performance of sound recordings by means of digital audio transmission by at least 5 different interactive services, provided, however, that each such license must be for a minimum of 10% of the copyrighted sound recordings owned by the licensor that have been licensed to interactive services, but in no event less than 50 sound recordings, or Clause 2. The exclusive license is granted to perform publicly up to 45 seconds of a sound recording, and the sole purpose of the performance is to promote the distribution or performance of that sound recording. Subparagraph C. Notwithstanding the grant of an exclusive or non-exclusive license of the right of public performance under Section 106, subsection 6, an interactive service may not publicly perform a sound recording unless a license has been granted for the public performance of any copyrighted musical work contained in the sound recording, provided that such license to publicly perform the copyrighted musical work may be granted either by a performing rights society representing the copyright owner or by the copyright owner. Subparagraph D. The performance of a sound recording by means of a retransmission of a digital audio transmission is not an infringement of Section 106, subsection 6 if: Clause 1. The retransmission is of a transmission by an interactive service licensed to publicly perform the sound recording to a particular member of the public as part of that transmission, and Clause 2. The retransmission is simultaneous with the licensed transmission, authorized by the transmitter, and limited to that particular member of the public intended by the interactive service to be the recipient of the transmission. Subparagraph E. For the purposes of this paragraph, Clause 1. A licensor shall include the licensing entity and any other entity under any material degree of common ownership, management, or control that owns copyrights in sound recordings, and Clause 2. A performing rights society is an association or corporation that licenses the public performance of non-dramatic musical works on behalf of the copyright owner, such as the American Society of Composers, Authors, and Publishers, Broadcast Music, Inc., and SESAC, Inc. Paragraph 4. Rights not otherwise limited. Subparagraph A. Except as expressly provided in this section does not limit or impair the exclusive right to perform a sound recording publicly by means of a digital audio transmission under Section 106, subsection 6. Subparagraph B. Nothing in this section annuls or limits in any way. Clause 1. The exclusive right to publicly perform a musical work, including by means of a digital audio transmission, under Section 106, subsection 4. Clause 2. The exclusive rights in a sound recording or the musical work embodied therein under Sections 106, subsection 1, 106, subsection 2, and 106, subsection 3, or Clause 3. Any other rights under any other clause of Section 106 or remedies available under this title, as such rights or remedies exist either before or after the date of enactment of the Digital Performance Right and Sound Recordings Act of 1995. Subparagraph C. Any limitations in this section on the exclusive right under Section 106, subsection 6 apply only to the exclusive right under Section 106, subsection 6, and not to any other exclusive rights under Section 106. Nothing in this section shall be construed to annul, limit, impair, or otherwise affect in any way the ability of the owner of a copyright in a sound recording to exercise the rights under Sections 106, subsection 2, and 106, subsection 2, and 106, subsection 3, or to obtain the remedies available under this title pursuant to such rights, as such rights and remedies exist either before or after the date of enactment of the Digital Performance Right and Sound Recordings Act of 1995. Subsection E. Authority for negotiation. Paragraph 1. Notwithstanding any provision of the antitrust laws in negotiating statutory licenses in accordance with subsection F, any copyright owners of sound recordings and any entities performing sound recordings affected by this section may negotiate and agree upon the royalty rates and license terms and conditions for the performance of such sound recordings and the proportionate division of fees paid among copyright owners, and may designate common agents on a non-exclusive basis to negotiate, agree to, pay, or receive payments. Paragraph 2. For licenses granted under Section 106, subsection 6, other than statutory licenses, such as for performances by interactive services or performances that exceed the sound recording performance complement. Subparagraph A. Copyright owners of sound recordings affected by this section may designate common agents to act on their behalf to grant licenses and receive and remit royalty payments, provided that each copyright owner shall establish the royalty rates and material license terms and conditions unilaterally, that is, not in agreement, combination, or concert with other copyright owners of sound recordings. And subparagraph B. Entities performing sound recordings affected by this section may designate common agents to act on their behalf to obtain licenses and collect and pay royalty fees, provided that each entity performing sound recordings shall determine the royalty rates and material license terms and conditions unilaterally, that is, not in agreement, combination, or concert with other entities performing sound recording. Subsection F. Licenses for certain non-exempt transmissions. Paragraph 1, subparagraph A. Proceedings under Chapter 8 shall determine reasonable rates and terms of royalty payments for transmissions subject to statutory licensing under subsection D. Paragraph 2. During the 5-year period beginning on January 1st of the second year following the year in which the proceedings are to be commenced pursuant to subparagraph A or B of Section 804, subsection B, paragraph 3, as the case may be, or such other period as the parties may agree, the parties to each proceeding shall bear their own costs. Subparagraph B. The schedule of reasonable rates and terms determined by the copyright royalty judges shall, subject to paragraph 2, be binding on all copyright owners of sound recordings and entities performing sound recordings affected by this paragraph during the 5-year period specified in subparagraph A, or such other period as the parties may agree. Such rates and terms shall distinguish among the different types of services then in operation and shall include a minimum fee for each such type of service. Such differences to be based on criteria including the quantity and nature of the use of sound recordings and the degree to which use of the service may substitute for or may promote the purchase of phono records by consumers. The copyright royalty judges shall establish rates and terms that most clearly represent the rates and terms that would have been negotiated in the marketplace between a willing buyer and a willing seller. In determining such rates and terms, the copyright royalty judges, Clause 1, shall base their decision on economic, competitive, and programming information presented by the parties, including Subclause 1. Whether use of the service may substitute for or may promote the sales of phono records or otherwise may interfere with or may enhance the sound recording copyright owner's other streams of revenue from the copyright owner's sound recordings. And Subclause 2. The relative roles of the copyright owner and the transmitting entity in the copyrighted work and the service made available to the public with respect to relative creative contribution, technological contribution, capital investment, cost and risk. And Clause 2 may consider the rates and terms for comparable types of audio transmission services and comparable circumstances under voluntary license agreements. Subparagraph C. The procedures under subparagraphs A and B shall also be initiated pursuant to a petition filed by any sound recording copyright owner or any transmitting entity indicating that a new type of service on which sound recordings are performed is or is about to become operational. for the purpose of determining reasonable terms and rates of royalty payments with respect to such new type of service for the period, beginning with the inception of such new type of service and ending on the date on which the royalty rates and terms for eligible non-subscription services and new subscription services, or pre-existing subscription services and pre-existing satellite digital audio radio services, as the case may be, most recently determined under subparagraph A or B in Chapter 8 expire, or such other period as the parties may agree. Paragraph 2. License agreements voluntarily negotiated at any time between one or more copyright owners of sound recordings and one or more entities performing sound recordings shall be given effect in lieu of any decision by the Librarian of Congress, or determination by the copyright royalty judges. Paragraph 3. Subparagraph A. The copyright royalty judges shall also establish requirements by which copyright owners may receive reasonable notice of the use of their sound recordings under this section, and under which records of such use shall be kept and made available by entities performing sound recordings. The notice and record-keeping rules in effect on the day before the effective date of the Copyright Royalty and Distribution Reform Act of 2004 shall remain in effect unless and until new regulations are promulgated by the copyright royalty judges. If new regulations are promulgated under this subparagraph, the copyright royalty judges shall take into account the substance and effect of the rules in effect on the day before the effective date of the Copyright Royalty and Distribution Reform Act of 2004, and shall, to the extent practicable, avoid significant disruption of the functions of any designated agent authorized to collect and distribute royalty fees. Subparagraph B. Any person who wishes to perform a sound recording publicly by means of a transmission eligible for statutory licensing under this subsection may do so without infringing the exclusive right of the copyright owner of the sound recording. Clause 1. By complying with such notice requirements as the copyright royalty judges shall prescribe by regulation and by paying royalty fees in accordance with this subsection, or Clause 2. If such royalty fees have not been set, by agreeing to pay such royalty fees as shall be determined in accordance with this subsection. Subparagraph C. Any royalty payments in arrears shall be made on or before the 20th day of the month next succeeding the month in which the royalty fees are set. Paragraph 4. Subparagraph A. Notwithstanding Section 112, subsection E, and the other provisions of this subsection, the receiving agent may enter into agreements for the reproduction and performance of sound recordings under Section 112. Substact E and this section by any one or more commercial webcasters or non-commercial webcasters for a period of not more than 11 years beginning on January 1, 2005, that, once published in the Federal Register pursuant to subparagraph B, shall be binding on all copyright owners of sound recordings and other persons entitled to payment under this section in lieu of any determination by the copyright royalty judges. Any such agreement for commercial webcasters may include provisions for payment of royalties on the basis of a percentage of revenue or expenses, or both, and include a minimum fee. Any such agreement may include other terms and conditions, including requirements by which copyright owners may receive notice of the use of their sound recordings and under which records of such use shall be kept and made available by commercial webcasters or non-commercial webcasters. The receiving agent shall be under no obligation to negotiate any such agreement. The receiving agent shall have no obligation to any copyright owner of sound recordings or any other person entitled to payment under this section in negotiating any such agreement, and no liability to any copyright owner of sound recordings or any other person entitled to payment under this section for having entered into such agreement. Subparagraph B. The Copyright Office shall cause to be published in the Federal Register any agreement entered into pursuant to subparagraph A. Such publication shall include a statement containing the substance of subparagraph C. Such agreements shall not be included in the Code of Federal Regulations. Thereafter, the terms of such agreement shall be available as an option to any commercial webcaster or non-commercial webcaster meeting the eligibility conditions of such agreement. Subparagraph C. Neither subparagraph A nor any provisions of any agreement entered into pursuant to subparagraph A, including any rate structure, fees, terms, conditions, or notice and record-keeping requirements set forth therein, shall be admissible as evidence or otherwise taken into account in any administrative, judicial, or other government proceeding involving the setting or adjustment of the royalties payable for the public performance or reproduction, in ephemeral phonorecords or copies of sound recordings, the determination of terms or conditions related thereto, or the establishment of notice or record-keeping requirements by the copyright royalty judges under paragraph 3 or section 112, subsection E, paragraph 4. It is the intent of Congress that any royalty rates, rate structure, definitions, terms, conditions, or notice and record-keeping requirements included in such agreements shall be considered as a compromise motivated by the unique business, economic, and political circumstances of webcasters, copyright owners, and performers, rather than as matters that would have been negotiated in the marketplace between a willing buyer and a willing seller, or otherwise meet the objectives set forth in section 801, subsection B. This subparagraph shall not apply to the extent that the receiving agent and a webcaster that is party to an agreement entered into pursuant to subparagraph A expressly authorize the submission of the agreement in a proceeding under this subsection. Subparagraph D. Nothing in the Webcaster Settlement Act of 2008, the Webcaster Settlement Act of 2009, or any agreement entered into pursuant to subparagraph A shall be taken into account by the United States Court of Appeals for the District of Columbia Circuit in its review of the determination by the copyright royalty judges of May 1, 2007, of rates and terms for the digital performance of sound recordings and ephemeral recordings pursuant to sections 112 and 114. Subparagraph E as used in this paragraph. Clause 1. The term non-commercial webcaster means a webcaster that. Subclause 1 is exempt from taxation under Section 501 of the Internal Revenue Code of 1986, Title 26 United States Code, Section 501. Subclause 2 has applied in good faith to the Internal Revenue Service for exemption from taxation under Section 501 of the Internal Revenue Code and has a commercially reasonable expectation that such exemption shall be granted, or Subclause 3 is operated by a state or possession or any governmental entity or subordinate thereof, or by the United States or District of Columbia for exclusively public purposes. Clause 2. The term receiving agent shall have the meaning given that term in Section 261.2 of Title 37, Code of Federal Regulations, as published in the Federal Register on July 8, 2002, and Clause 3. The term webcaster means a person or entity that has obtained a compulsory license under Section 112 or 114 and the implementing regulations therefore. Subparagraph F. The authority to make settlements pursuant to subparagraph A shall expire at 11:59 p.m. Eastern Time on the 30th day after the date of the enactment of the Webcaster Settlement Act of 2009. Subsection G. Proceeds from licensing of transmissions. Paragraph 1. Except in the case of a transmission licensed under a statutory license in accordance with subsection F of this section. Subparagraph A. A featured recording artist who performs on a sound recording that has been licensed for a transmission shall be entitled to receive payments from the copyright owner of the sound recording in accordance with the terms of the artist's contract. And subparagraph B. A non-featured recording artist who performs on a sound recording that has been licensed for a transmission shall be entitled to receive payments from the copyright owner of the sound recording in accordance with the terms of the non-featured recording artist's applicable contract or other applicable agreement. Paragraph 2. Except as provided for in paragraph 6, a nonprofit collective designated by the copyright royalty judges to distribute receipts from the licensing of transmissions in accordance with subsection F shall distribute such receipts as follows. Subparagraph A. 50% of the receipts shall be paid to the copyright owner of the exclusive right under section 106, subsection 6 of this title to publicly perform a sound recording by means of a digital audio transmission. Subparagraph B. 2.5% of the receipts shall be deposited in an escrow account managed by an independent administrator jointly appointed by copyright owners of sound recordings and the American Federation of Musicians or any successor entity to be distributed to non-featured musicians, whether or not members of the American Federation of Musicians, who have performed on sound recordings. Subparagraph C. 2.5% of the receipts shall be deposited in an escrow account managed by an independent administrator jointly appointed by copyright owners of sound recordings and the American Federation of Television and Radio Artists, or any successor entity, to be distributed to non-featured vocalists, whether or not members of the American Federation of Television and Radio Artists, who have performed on sound recordings. Subparagraph D. 45% of the receipts shall be paid on a per sound recording basis to the recording artist or artists featured on such sound recording, or the persons conveying rights in the artist's performance in the sound recordings. Paragraph 3. A nonprofit collective designated by the copyright royalty judges to distribute receipts from the licensing of transmissions in accordance with subsection F may deduct from any of its receipts. Prior to the distribution of such receipts to any person or entity entitled thereto other than copyright owners and performers who have elected to receive royalties from another designated nonprofit collective and have notified such nonprofit collective in writing of such election, the reasonable costs of such collective incurred after November 1, 1995 in Subparagraph A. The administration of the collection, distribution, and calculation of the royalties. Subparagraph B. The settlement of disputes relating to the collection and calculation of the royalties. And Subparagraph C. The licensing and enforcement of rights with respect to the making of ephemeral recordings and performances subject to licensing under Section 112 in this section, including those incurred in participating in negotiations or arbitration proceedings under Section 112 and this section, except that all costs incurred relating to the Section 112 ephemeral recordings right may only be deducted from the royalties received pursuant to Section 112. Paragraph 4. Notwithstanding Paragraph 3, any nonprofit collective designated to distribute receipts from the licensing of transmissions in accordance with subsection F may deduct from any of its receipts, prior to the distribution of such receipts, the reasonable costs identified in Paragraph 3 of such collective incurred after November 1, 1995. With respect to such copyright owners and performers who have entered with such collective a contractual relationship that specifies that such costs may be deducted from such royalty receipts. Paragraph 5. Letter of Direction. Subparagraph A. In general. A nonprofit collective designated by the copyright royalty judges to distribute receipts from the licensing of transmissions in accordance with subsection F shall adopt and reasonably implement a policy that provides, in circumstances determined by the collective to be appropriate, for acceptance of instructions from a payee identified under subparagraph A or D of paragraph 2 to distribute to a producer, mixer, or sound engineer who is part of the creative process that created a sound recording, a portion of the payments to which the payee would otherwise be entitled from the licensing of transmissions of the sound recording. In this section, such instructions shall be referred to as a letter of direction. Subparagraph B, acceptance of letter. To the extent that a collective described in subparagraph A accepts a letter of direction under that subparagraph, the person entitled to payment pursuant to the letter of direction shall, during the period in which the letter of direction is in effect and carried out by the collective, be treated for all purposes as the owner of the right to receive such payment, and the payee providing the letter of direction to the collective shall be treated as having no interest in such payment. Subparagraph C, authority of collective. This paragraph shall not be construed in such a manner so that the collective is not authorized to accept or act upon payment instructions in circumstances other than those to which this paragraph applies. Paragraph 6, sound recordings fixed before November 1st, 1995. Subparagraph A, payment absent letter of direction. A nonprofit collective designated by the copyright royalty judges to distribute receipts from the licensing of transmissions in accordance with subsection F in this paragraph referred to as the collective shall adopt and reasonably implement a policy that provides, in circumstances determined by the collective to be appropriate, for the deduction of 2% of all the receipts that are collected from the licensing of transmissions of a sound recording fixed before November 1st, 1995, but which is withdrawn from the amount otherwise payable under paragraph 2, subparagraph D, to the recording artist or artists featured on the sound recording, or the persons conveying rights in the artist's performance in the sound recording, and the distribution of such amount to one or more persons described in subparagraph B of this paragraph, after deduction of costs described in paragraph 3 or 4, as applicable, if each of the following requirements is met. Clause 1. Certification of attempt to obtain a letter of direction. The person described in subparagraph B, who is to receive the distribution, has certified to the collective, under penalty of perjury, that, subclause 1, for a period of not less than 120 days, that person made reasonable efforts to contact the artist payee for such sound recording to request and obtain a letter of direction instructing the collective to pay to that person a portion of the royalties payable to the featured recording artist or artist, and subclause 2. During the period beginning on the date on which that person began the reasonable efforts described in subclause 1 and ending on the date of that person's certification to the collective, the artist payee did not affirm or deny in writing the request for a letter of direction. Clause 2. Collective attempt to contact artist. After receipt of the certification described in Clause 1, and for a period of not less than 120 days before the first distribution by the collective to the person described in subparagraph B, the collective attempts, in a reasonable manner, as determined by the collective, to notify the artist payee of the certification made by the person described in subparagraph B. Clause 3. No objection received. The artist payee does not, as of the date that was 10 business days before the date on which the first distribution is made, submit to the collective in writing an objection to the distribution. Subparagraph B. Eligibility for payment. A person shall be eligible for payment under subparagraph A if the person. Clause 1 is a producer, mixer, or sound engineer of the sound recording. Clause 2. Has entered into a written contract with a record company involved in the creation or lawful exploitation of the sound recording, or with the recording artist or artists featured on the sound recording, or the persons conveying rights in the artist's performance in the sound recording, under which the person seeking payment is entitled to participate in royalty payments that are based on the exploitation of the sound recording and are payable from royalties otherwise payable to the recording artist or artists featured on the sound recording, or the persons conveying rights in the artist's performance in the sound recording. Clause 3. Made a creative contribution to the creation of the sound recording, and Clause 4. Submits to the collective. Subclause 1. A written certification stating, under penalty of perjury, that the person meets the requirements in clauses 1 through 3, and Subclause 2. A true copy of the contract described in Clause 2. Subparagraph C. Multiple certifications. Subject to subparagraph D. In a case in which more than one person described in subparagraph B has met the requirements for a distribution under subparagraph A with respect to a sound recording as of the date that is 10 business days before the date on which the distribution is made, the collective shall divide the 2% distribution equally among all such persons. Subparagraph D. Objection to payment. Not later than 10 business days after the date on which the collective receives from the artist's payee a written objection to a distribution made pursuant to subparagraph A, the collective shall cease making any further payment relating to such distribution. In any case in which the collective has made one or more distributions pursuant to subparagraph A to a person described in subparagraph B before the date that is 10 business days after the date on which the collective receives from the artist payee an objection to such distribution, the objection shall not affect that person's entitlement to any distribution made before the collective ceases such distribution under the subparagraph. Subparagraph E. Ownership of the right to receive payments. To the extent that the collective determines that a distribution will be made under subparagraph A to a person described in subparagraph B, such person shall, during the period covered by such distribution, be treated for all purposes as the owner of the right to receive such payments, and the artist payee to whom such payments would otherwise be payable shall be treated as having no interest in such payments. Subparagraph F. Artist payee defined. In this paragraph, the term artist payee means a person, other than a person described in subparagraph B, who owns the right to receive all or part of the receipts payable under paragraph 2, subparagraph D, with respect to a sound recording. In a case in which there are multiple artist payees with respect to a sound recording, an objection by one such payee shall apply only to that payee's share of the receipts payable under paragraph 2, subparagraph D, and shall not preclude payment under subparagraph A from the share of an artist payee that does not so object. Paragraph 7. Preemption of state property laws. The holding and distribution of receipts under Section 112 in this section by a nonprofit collective designated by the copyright royalty judges in accordance with this subsection and regulations adopted by the copyright royalty judges, or by an independent administrator pursuant to subparagraphs B and C of Section 114, subsection G, paragraph 2, shall supersede and preempt any state law, including common law concerning escheatment or abandoned property, or any analogous provision that might otherwise apply. Subsection H. Licensing to affiliates. Paragraph 1. If the copyright owner of a sound recording licenses an affiliated entity the right to publicly perform a sound recording by means of a digital audio transmission under Section 106, subsection 6, the copyright owner shall make the licensed sound recording available under Section 106, subsection 6, on no less favorable terms and conditions to all bona fide entities that offer similar services, except that, if there are material differences in the scope of the requested license with respect to the type of service, the particular sound recordings licensed, the frequency of use, the number of subscribers served, or the duration, then the copyright owner may establish different terms and conditions for such other services. Paragraph 2. The limitations set forth in paragraph 1 of this subsection shall not apply in the case where the copyright owner of a sound recording licenses. Subparagraph A, an interactive service, or subparagraph B, an entity to perform publicly up to 45 seconds of the sound recording, and the sole purpose of the performance is to promote the distribution or performance of that sound recording. I repealed Public Law 115-264, Title I, Section 103, Subsection B, October 11, 2018, 132, Statutes at Large 3724. Subsection J. Definitions. As used in this section, the following terms have the following meanings. Paragraph 1. An affiliated entity is an entity engaging in digital audio transmissions covered by Section 106, Subsection 6, other than an interactive service, in which the licensor has any direct or indirect partnership or any ownership interest amounting to 5% or more of the outstanding voting or non-voting stock. Paragraph 2. An archived program is a predetermined program that is available repeatedly on the demand of the transmission recipient, and that is performed in the same order from the beginning, except that an archived program shall not include a recorded event or broadcast transmission that makes no more than an incidental use of sound recordings. As long as such recorded event or broadcast transmission does not contain an entire sound recording or feature a particular sound recording. Paragraph 3. A broadcast transmission is a transmission made by a terrestrial broadcast station licensed as such by the Federal Communications Commission. Paragraph 4. A continuous program is a predetermined program that is continuously performed in the same order, and that is accessed at a point in the program that is beyond the control of the transmission recipient. Paragraph 5. A digital audio transmission is a digital transmission as defined in Section 101 that embodies the transmission of a sound recording. This term does not include the transmission of any audiovisual work. Paragraph 6. An eligible non-subscription transmission is a non-interactive non-subscription digital audio transmission not exempt under subsection D, paragraph 1, that is made as part of a service that provides audio programming consisting in whole or in part of performances of sound recordings, including retransmissions of broadcast transmissions, if the primary purpose of the service is to provide to the public such audio or other entertainment programming, and the primary purpose of the service is not to sell, advertise, or promote particular products or services other than sound recordings, live concerts, or other music-related events. Paragraph 7. An interactive service is one that enables a member of the public to receive a transmission of a program specially created for the recipient, or on request, a transmission of a particular sound recording, whether or not as part of a program, which is selected by or on behalf of the recipient. The ability of individuals to request that particular sound recordings be performed for reception by the public at large, or in the case of a subscription service by all subscribers of the service, does not make a service interactive. If the programming on each channel of the service does not substantially consist of sound recordings that are performed within 1 hour of the request or at a time designated by either the transmitting entity or the individual making such request. If an entity offers both interactive and non-interactive services, either concurrently or at different times, the non-interactive component shall not be treated as part of an interactive service. Paragraph 8. A new subscription service is a service that performs sound recordings by means of non-interactive subscription digital audio transmissions, and that is not a pre-existing subscription service or a pre-existing satellite digital audio radio service. Paragraph 9. A non-subscription transmission is any transmission that is not a subscription transmission. Paragraph 10. A pre-existing satellite digital audio radio service is a subscription satellite digital audio radio service provided pursuant to a satellite digital audio radio service license issued by the Federal Communications Commission on or before July 31st, 1998, and any renewal of such license to the extent of the scope of the original license, and may include a limited number of sample channels representative of the subscription service that are made available on a non-subscription basis in order to promote the subscription service. Paragraph 11. A pre-existing subscription service is a service that performs sound recordings by means of non-interactive audio-only subscription digital audio transmissions, which was in existence and was making such transmissions to the public for a fee on or before July 31st, 1998, and may include a limited number of sample channels representative of the subscription service that are made available on a non-subscription basis in order to promote the subscription service. Paragraph 12. A retransmission is a further transmission of an initial transmission and includes any further retransmission of the same transmission. Except as provided in this section, a transmission qualifies as a retransmission only if it is simultaneous with the initial transmission. Nothing in this definition shall be construed to exempt a transmission that fails to satisfy a separate element required to qualify for an exemption under Section 114, subsection D, paragraph 1. Paragraph 13. The sound recording performance complement is the transmission during any 3-hour period, on a particular channel used by a transmitting entity, of no more than. Subparagraph A. 3 different selections of sound recordings from any one phonorecord lawfully distributed for public performance or sale in the United States, if no more than 2 such selections are transmitted consecutively, or. Subparagraph B. 4 different selections of sound recordings. Clause 1. By the same featured recording artist, or. Clause 2. From any set or compilation of phonorecords lawfully distributed together as a unit for public performance or sale in the United States, if no more than 3 such selections are transmitted consecutively, provided that the transmission of selections in excess of the numerical limits provided for in clauses A and B from multiple phonorecords shall nonetheless qualify as a sound recording performance complement if the programming of the multiple phonorecords was not willfully intended to avoid the numerical limitations prescribed in such clauses. Paragraph 14. A subscription transmission is a transmission that is controlled and limited to particular recipients, and for which consideration is required to be paid or otherwise given by or on behalf of the recipient to receive the transmission or a package of transmissions, including the transmission. Paragraph 15. A transmission is either an initial transmission or a retransmission. Section 115. Scope of exclusive rights in non-dramatic musical works. Compulsory license for making and distributing phonorecords. In the case of non-dramatic musical works, the exclusive rights provided by clauses 1 and 3 of Section 106 to make and to distribute phonorecords of such works are subject to compulsory licensing under the conditions specified by this section. Subsection A. Availability and scope of compulsory license in general. Paragraph 1. Eligibility for compulsory license. Subparagraph A. Conditions for compulsory license. A person may, by complying with the provisions of this section, obtain a compulsory license to make and distribute phonorecords of a non-dramatic musical work, including by means of digital phonorecord delivery. A person may obtain a compulsory license only if the primary purpose in making phonorecords of the musical work is to distribute them to the public for private use, including by means of digital phonorecord delivery, and Clause 1. Phonorecords of such musical work have previously been distributed to the public in the United States under the authority of the copyright owner of the work, including by means of digital phonorecord delivery, or Clause 2. In the case of a digital music provider seeking to make and distribute digital phonorecord deliveries of a sound recording embodying a musical work under a compulsory license for which Clause 1 does not apply. Subclause 1. The first fixation of such sound recording was made under the authority of the musical work copyright owner, and the sound recording copyright owner has the authority of the musical work copyright owner to make and distribute digital phonorecord deliveries embodying such work to the public in the United States. And Subclause 2. The sound recording copyright owner, or the authorized distributor of the sound recording copyright owner, has authorized the digital music provider to make and distribute digital phonorecord deliveries of the sound recording to the public in the United States. Subparagraph B. Duplication of sound recording. A person may not obtain a compulsory license for the use of the work in the making of phonorecords duplicating a sound recording fixed by another, including by means of digital phonorecord delivery, unless Clause 1. Such sound recording was fixed lawfully, and Clause 2. The making of the phonorecords was authorized by the owner of the copyright in the sound recording, or, if the sound recording was fixed before February 15, 1972, by any person who fixed the sound recording pursuant to an express license from the owner of the copyright in the musical work, or pursuant to a valid compulsory license for use of such work in a sound recording. Paragraph 2. Musical arrangement. A compulsory license includes the privilege of making a musical arrangement of the work to the extent necessary to conform it to the style or manner of interpretation of the performance involved. But the arrangement shall not change the basic melody or fundamental character of the work, and shall not be subject to protection as a derivative work under this title, except with the express consent of the copyright owner. Subsection B. Procedures to obtain a compulsory license. Paragraph 1. Phonorecords other than digital phonorecord deliveries. A person who seeks to obtain a compulsory license under subsection A to make and distribute phonorecords of a musical work other than by means of digital phonorecord delivery shall, before or not later than 30 calendar days after making, and before distributing any phonorecord of the work, serve notice of intention to do so on the copyright owner. If the registration or other public records of the Copyright Office do not identify the copyright owner and include an address at which notice can be served, it shall be sufficient to file the notice of intention with the Copyright Office. The notice shall comply in form, content, and manner of service, with requirements that the Register of Copyrights shall prescribe by regulation. Paragraph 2. Digital phonorecord deliveries. A person who seeks to obtain a compulsory license under subsection A to make and distribute phonorecords of a musical work by means of digital phonorecord delivery. Subparagraph A. Prior to the license availability date shall, before or not later than 30 calendar days after first making any such digital phonorecord delivery, serve a notice of intention to do so on the copyright owner, but may not file the notice with the Copyright Office, even if the public records of the office do not identify the owner or the owner's address, and such notice shall comply, in form, content, and manner of service, with requirements that the Register of Copyrights shall prescribe by regulation, or subparagraph B, on or after the license availability date shall, before making any such digital phonorecord delivery, follow the procedure described in subsection D, paragraph 2, except as provided in paragraph 3. Paragraph 3. Record company individual download licenses. Notwithstanding paragraph 2, subparagraph B, a record company may, on or after the license availability date, obtain an individual download license in accordance with the notice requirements described in paragraph 2. Subparagraph A, except for the requirement that notice occur prior to the license availability date. A record company that obtains an individual download license as permitted under this paragraph shall provide statements of account and pay royalties as provided in subsection C, paragraph 2, subparagraph I. Paragraph 4. Failure to obtain license. Subparagraph A. Phonorecords other than digital phonorecord deliveries. In the case of phonorecords made and distributed other than by means of digital phonorecord delivery, the failure to serve or file the notice of intention required by paragraph 1 forecloses the possibility of a compulsory license under paragraph 1. In the absence of a voluntary license, the failure to obtain a compulsory license renders the making and distribution of phonorecords actionable as acts of infringement under section 501 and subject to the remedies provided by sections 502 through 506. Subparagraph B. Digital phonorecord deliveries. Clause 1. In general, in the case of phonorecords made and distributed by means of digital phonorecord delivery. Subclause 1. The failure to serve the notice of intention required by paragraph 2, subparagraph A or paragraph 3, as applicable, forecloses the possibility of a compulsory license under such paragraph. Subclause 2. The failure to comply with paragraph 2, subparagraph B forecloses the possibility of a blanket license for a period of 3 years after the last calendar day on which the notice of license was required to be submitted to the Mechanical Licensing Collective under such paragraph. Clause 2. Effective failure. In either case described in subclause 1 or 2 of clause 1, in the absence of a voluntary license, the failure to obtain a compulsory license renders the making and distribution of phonorecords by means of digital phonorecord delivery actionable as acts of infringement under section 501 and subject to the remedies provided by sections 502 through 5006. Subsection C. General conditions applicable to compulsory license. Paragraph 1. Royalty payable under compulsory license. Subparagraph A. Identification requirement. To be entitled to receive royalties under a compulsory license obtained under subsection B, paragraph 1, the copyright owner must be identified in the registration or other public records of the Copyright Office. The owner is entitled to royalties for phonorecords made and distributed after being so identified, but is not entitled to recover for any phonorecords previously made and distributed. Subparagraph B. Royalty for phonorecords other than digital phonorecord deliveries, except as provided by subparagraph A, for every phonorecord made and distributed under a compulsory license under subsection A other than by means of digital phonorecord delivery. With respect to each work embodied in the phonorecord, the royalty shall be the royalty prescribed under subparagraphs D through F, paragraph 2, subparagraph A, and chapter 8. For purposes of this subparagraph, a phonorecord is considered distributed if the person exercising the compulsory license has voluntarily and permanently parted with its possession. Subparagraph C. Royalty for digital phonorecord deliveries. For every digital phonorecord delivery of a musical work made under a compulsory license under this section, the royalty payable shall be the royalty prescribed under subparagraphs D through F, paragraph 2, subparagraph A, and chapter 8. Subparagraph D. Authority to negotiate. Notwithstanding any provision of the antitrust laws, any copyright owners of non-dramatic musical works and any persons entitled to obtain a compulsory license under subsection A may negotiate and agree upon the terms and rates of royalty payments under this section and the proportionate division of fees paid among copyright owners, and may designate common agents on a non-exclusive basis to negotiate, agree to, pay, or receive such royalty payments. Such authority to negotiate the terms and rates of royalty payments includes, but is not limited to, the authority to negotiate the year during which the royalty rates prescribed under this subparagraphs E and F, paragraph 2, subparagraph A, and chapter 8 shall next be determined. Subparagraph E, determination of reasonable rates and terms. Proceedings under chapter 8 shall determine reasonable rates and terms of royalty payments for the activities specified by this section during the period beginning with the effective date of such rates and terms, but not earlier than January 1st of the second year following the year in which the petition requesting the proceeding is filed, and ending on the effective date of successor rates and terms, or such other period as the parties may agree. Any copyright owners of non-dramatic musical works and any persons entitled to obtain a compulsory license under subsection A may submit to the copyright royalty judges licenses covering such activities. The parties to each proceeding shall bear their own costs. Subparagraph F, schedule of reasonable rates. The schedule of reasonable rates in terms determined by the copyright royalty judges shall, subject to paragraph 2, subparagraph A, be binding on all copyright owners of non-dramatic musical works and persons entitled to obtain a compulsory license under subsection A during the period specified in subparagraph E. Such other period as may be determined pursuant to subparagraphs D and E, or such other period as the parties may agree. The copyright royalty judges shall establish rates and terms that most clearly represent the rates and terms that would have been negotiated in the marketplace between a willing buyer and a willing seller. In determining such rates and terms for digital phonorecord deliveries, the copyright royalty judges shall base their decision on economic, competitive, and programming information presented by the parties, including Clause 1, whether use of the compulsory licensee's service may substitute for or may promote the sales of phonorecords or otherwise may interfere with or may enhance the musical work copyright owner's other streams of revenue from its musical works, and Clause 2. The relative roles of the copyright owner and the compulsory licensee in the copyrighted work and the service made available to the public with respect to the relative creative contribution, technological contribution, capital investment, cost, and risk. Paragraph 2. Additional terms and conditions. Subparagraph A. Voluntary licenses and contractual royalty rates. Clause 1. In general. License agreements voluntarily negotiated at any time between one or more copyright owners of non-dramatic musical works and one or more persons entitled to obtain a compulsory license under subsection A shall be given effect in lieu of any determination by the copyright royalty judges. Subject to Clause 2, the royalty rates determined pursuant to subparagraphs E and F of paragraph 1 shall be given effect as to digital phonorecord deliveries in lieu of any contrary royalty rates specified in a contract pursuant to which a recording artist who is the author of a non-dramatic musical work grants a license under that person's exclusive rights in the musical work under paragraphs 1 and 3 of section 106, or commits another person to grant a license in that musical work under paragraphs 1 and 3 of section 106, to a person desiring to fix in a tangible medium of expression a sound recording embodying the musical work. Clause 2. Applicability. The second sentence of Clause 1 shall not apply to Subclause 1. A contract entered into on or before June 22, 1995, and not modified thereafter for the purpose of reducing the royalty rates determined pursuant to subparagraphs E and F of paragraph 1, or of increasing the number of musical works within the scope of the contract covered by the reduced rates, except if a contract entered into on or before June 22, 1995, is modified thereafter for the purpose of increasing the number of musical works within the scope of the contract. Any contrary royalty rates specified in the contract shall be given effect in lieu of royalty rates determined pursuant to subparagraphs E and F of paragraph 1 for the number of musical works within the scope of the contract as of June 22, 1995. And Subclause 2. A contract entered into after the date that the sound recording is fixed in a tangible medium of expression substantially in a form intended for commercial release, if at the time the contract is entered into, the recording artist retains the right to grant licenses as to the musical work under paragraphs 1 and 3 of section 106. Subparagraph B. Sound recording information. Except as provided in section 1002, subsection E, a digital phonorecord delivery licensed under this paragraph shall be accompanied by the information encoded in the sound recording, if any, by or under the authority of the copyright owner of that sound recording that identifies the title of the sound recording, the featured recording artist who performs on the sound recording, and related information, including information concerning the underlying musical work and its writer. Subparagraph C. Infringement remedies. Clause 1. In general. A digital phonorecord delivery of a sound recording is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506, unless Subclause 1. The digital phonorecord delivery has been authorized by the sound recording copyright owner, and Subclause 2. The entity making the digital phonorecord delivery has obtained a compulsory license under subsection A, or has otherwise been authorized by the musical work copyright owner, or by a record company pursuant to an individual download license, to make and distribute phonorecords of each musical work embodied in the sound recording by means of digital phonorecord delivery. Clause 2. Other remedies. Any cause of action under this subparagraph shall be in addition to those available to the owner of the copyright in the non-dramatic musical work under subparagraph J in section 106, Subsector 4, and the owner of the copyright in the sound recording under Section 106, subsection 6. Subparagraph D. Liability of sound recording owners. The liability of the copyright owner of a sound recording for infringement of the copyright in a non-dramatic musical work embodied in the sound recording shall be determined in accordance with applicable law, except that the owner of a copyright in a sound recording shall not be liable for a digital phonorecord delivery by a third party if the owner of the copyright in the sound recording does not license the distribution of a phonorecord of the non-dramatic musical work. Subparagraph E. Recording devices and media. Nothing in Section 1008 shall be construed to prevent the exercise of the rights and remedies allowed by this paragraph, subparagraph J, and Chapter 5 in the event of a digital phonorecord delivery, except that no action alleging infringement of copyright may be brought under this title against a manufacturer, importer, or distributor of a digital audio recording device, a digital audio recording medium, an analog recording device, or an analog recording medium, or against a consumer based on the actions described in such section. Subparagraph F. Preservation of rights. Nothing in this section annuls or limits. Clause 1. The exclusive right to publicly perform a sound recording or the musical work embodied therein, including by means of a digital transmission, under paragraphs 4 and 6 of Section 106. Clause 2. Except for compulsory licensing under the conditions specified by this section, the exclusive rights to reproduce and distribute the sound recording and the musical work embodied therein under paragraphs 1 and 3 of Section 106, including by means of a digital phonorecord delivery, or Clause 3. Any other rights under any other provision of Section 106 or remedies available under this title, as such rights or remedies exist before, on, or after the date of enactment of the Digital Performance Right in Sound Recordings Act of 1995. Subparagraph G. Exempt transmissions and retransmissions. The provisions of this section concerning digital phonorecord deliveries shall not apply to any exempt transmissions or retransmissions under Section 114, subsection D, paragraph 1. The exemptions created in Section 114, subsection D, Paragraph 1 do not expand or reduce the rights of copyright owners under paragraphs 1 through 5 of Section 106 with respect to such transmissions and retransmissions. Subparagraph H. Distribution by rental, lease, or lending. A compulsory license obtained under subsection B, paragraph 1 to make and distribute phonorecords includes the right of the maker of such a phonorecord to distribute or authorize distribution of such phonorecord, other than by means of a digital phonorecord delivery, by rental, lease, or lending, or by acts or practices in the nature of rental, lease, or lending. With respect to each non-dramatic musical work embodied in the phonorecord, the royalty shall be a proportion of the revenue received by the compulsory licensee from every such act of distribution of the phonorecord under this clause equal to the proportion of the revenue received by the compulsory licensee from distribution of the phonorecord under subsection A. Paragraph 1, subparagraph A, clause 2, subclause 2, that is payable by a compulsory licensee under that clause and under Chapter 8. The Register of Copyrights shall issue regulations to carry out the purpose of this subparagraph. Subparagraph I. Payment of royalties and statements of account. Except as provided in paragraphs 4, subparagraph A, clause 1 and 10b of subsection D, royalty payments shall be made on or before the 20th day of each month and shall include all royalties for the month next preceding. Each monthly payment shall be made under oath and shall comply with requirements that the Register of Copyrights shall prescribe by regulation. The Register shall also prescribe regulations under which detailed cumulative annual statements of account, certified by a certified public accountant, shall be filed for every compulsory license under subsection A. The regulations covering both the monthly and the annual statements of account shall prescribe the form, content, and manner of certification with respect to the number of records made and the number of records distributed. Subparagraph J. Notice of default and termination of compulsory license. In the case of a license obtained under paragraph 1, 2a, or 3 of subsection B, if the copyright owner does not receive the monthly payment and the monthly and annual statements of account when due, the owner may give written notice to the licensee that, unless the default is remedied not later than 30 days after the date on which the notice is sent, the compulsory license will be automatically terminated. Such termination renders either the making or the distribution, or both, of all phonorecords for which the royalty has not been paid, actionable as acts of infringement under Section 501 and fully subject to the remedies provided by Sections 502 through 506. In the case of a license obtained under subsection B, paragraph 2, subparagraph B, license authority under the compulsory license may be terminated as provided in subsection D, paragraph 4, subparagraph E. Subsection D, blanket license for digital uses, mechanical licensing collective, and digital licensee coordinator. Paragraph 1, blanket license for digital uses. Subparagraph A, in general, a digital music provider that qualifies for a compulsory license under subsection A may, by complying with the terms and conditions of this subsection, obtain a blanket license from copyright owners through the Mechanical Licensing Collective to make and distribute digital phonorecord deliveries of musical works through one or more covered activities. Subparagraph B, included activities. A blanket license. Clause 1 covers all musical works or shares of such works available for compulsory licensing under this section for purposes of engaging in covered activities, except as provided in subparagraph C. Clause 2 includes the making and distribution of server, intermediate, archival, and incidental reproductions of musical works that are reasonable and necessary for the digital music provider to engage in covered activities licensed under this subsection, solely for the purpose of engaging in such covered activities. And Clause 3 does not cover or include any rights or uses other than those described in Clauses 1 and 2. Subparagraph C. Other licenses. A voluntary license for covered activities entered into by or under the authority of one or more copyright owners and one or more digital music providers, or authority to make and distribute permanent downloads of a musical work obtained by a digital music provider from a sound recording copyright owner pursuant to an individual download license, shall be given effect in lieu of a blanket license under this subsection with respect to the musical works or shares thereof covered by such voluntary license or individual download authority, and the following conditions apply. Clause 1. Where a voluntary license or individual download license applies, the license authority provided under the blanket license shall exclude any musical works or shares thereof, subject to the voluntary license or individual download license. Clause 2. An entity engaged in covered activities under a voluntary license or authority obtained pursuant to an individual download license that is a significant non-blanket licensee shall comply with paragraph 6, subparagraph A. Clause 3. The rates and terms of any voluntary license shall be subject to the second sentence of Clause 1 and Clause 2 of subsection C, paragraph 2, subparagraph A, and paragraph 9, subparagraph C, as applicable. Subparagraph D. Protection against infringement actions. A digital music provider that obtains and complies with the terms of a valid blanket license under this subsection shall not be subject to an action for infringement of the exclusive rights provided by paragraphs 1 and 3 of section 106 under this title arising from use of a musical work, or share thereof, to engage in covered activities authorized by such license, subject to paragraph 4, subparagraph E. Subparagraph E. Other requirements and conditions apply, except as expressly provided in this subsection. Each requirement, limitation, condition, privilege, right, and remedy otherwise applicable to compulsory licenses under this section shall apply to compulsory blanket licenses under this subsection. Paragraph 2. Availability of blanket license. Subparagraph A. Procedure for obtaining license. A digital music provider may obtain a blanket license by submitting a notice of license to the Mechanical Licensing Collective that specifies the particular covered activities in which the digital music provider seeks to engage, as follows. Clause 1. The notice of license shall comply in form and substance with requirements that the Register of Copyrights shall establish by regulation. Clause 2. Unless rejected in writing by the Mechanical Licensing Collective not later than 30 calendar days after the date on which the Mechanical Licensing Collective receives the notice, the blanket license shall be effective as of the date on which the notice of license was sent by the digital music provider, as shown by a physical or electronic record. Clause 3. A notice of license may only be rejected by the Mechanical Licensing Collective if Subclause 1. The digital music provider or notice of license does not meet the requirements of this section or applicable regulations, in which case the requirements at issue shall be specified with reasonable particularity in the notice of rejection. Or Subclause 2. The digital music provider has had a blanket license terminated by the Mechanical Licensing Collective during the 3-year period preceding the date on which the Mechanical Licensing Collective receives the notice pursuant to paragraph 4, subparagraph E. Clause 4. If a notice of license is rejected under Clause 3, Subclause 1, the digital music provider shall have 30 calendar days after receipt of the notice of rejection to cure any deficiency and submit an amended notice of license to the Mechanical Licensing Collective. If the deficiency has been cured, the Mechanical Licensing Collective shall so confirm in writing, and the license shall be effective as of the date that the original notice of license was provided by the digital music provider. Clause 5. A digital music provider that believes a notice of license was improperly rejected by the Mechanical Licensing Collective may seek review of such rejection in an appropriate district court of the United States. The district court shall determine the matter de novo based on the record before the Mechanical Licensing Collective and any additional evidence presented by the parties. Subparagraph B. Blanket license effective date. Blanket licenses shall be made available by the Mechanical Licensing Collective on and after the license availability date. No such license shall be effective prior to the license availability date. Paragraph 3. Mechanical Licensing Collective. Subparagraph A. In general, the Mechanical Licensing Collective shall be a single entity that, Clause 1, is a non-profit entity, not owned by any other entity that is created by copyright owners to carry out responsibilities under this subsection. Clause 2, is endorsed by and enjoys substantial support from musical work copyright owners that together represent the greatest percentage of the licensor market for uses of such works and covered activities as measured over the preceding 3 full calendar years. Clause 3, is able to demonstrate to the Register of Copyrights that the entity has or will have prior to the license availability date the administrative and technological capabilities to perform the required functions of the Mechanical Licensing Collective under this subsection, and that is governed by a board of directors in accordance with subparagraph D, subclause 1, and Clause 4 has been designated by the Register of Copyrights with the approval of the Librarian of Congress pursuant to Section 702 in accordance with subparagraph B. Subparagraph B, designation of mechanical licensing collective. Clause 1, initial designation. Not later than 270 days after the enactment date, the Register of Copyrights shall initially designate the mechanical licensing collective as follows. Subclause 1. Not later than 90 calendar days after the enactment date, the Register shall publish notice in the Federal Register soliciting information to assist in identifying the appropriate entity to serve as the mechanical licensing collective, including the name and affiliation of each member of the Board of Directors described under subparagraph D, Clause 1, and each committee established pursuant to Clauses 3, 4, and V of subparagraph D. Subclause 2. After reviewing the information requested under Subclause 1 and making a designation, the Register shall publish notice in the Federal Register setting forth. Item AA, the identity of and contact information for the mechanical licensing collective, and Item BB, the reasons for the designation. Clause 2, periodic review of designation. Following the initial designation of the mechanical licensing collective, the Register shall, every 5 years, beginning with the 5th full calendar year to commence after the initial designation, publish notice in the Federal Register in the month of January soliciting information concerning whether the existing designation should be continued, or a different entity meeting the criteria described in Clauses 1 through 3 of subparagraph A shall be designated. Following publication of such notice, the Register shall, Subclause 1, after reviewing the information submitted and conducting additional proceedings as appropriate, publish notice in the Federal Register of a continuing designation or new designation of the mechanical licensing collective as the case may be, and the reasons for such a designation, with any new designation to be effective as of the first day of a month that is not less than 6 months, and not longer than 9 months after the date on which the Register publishes the notice, as specified by the Register. And Subclause 2. If a new entity is designated as the mechanical licensing collective, adopt regulations to govern the transfer of licenses, funds, records, data, and administrative responsibilities from the existing mechanical licensing collective to the new entity. Clause 3. Closest alternative designation. If the Register is unable to identify an entity that fulfills each of the qualifications set forth in Clauses 1 through 3 of subparagraph A, the Register shall designate the entity that most nearly fulfills such qualifications for purposes of carrying out the responsibilities of the mechanical licensing collective. Subparagraph C, authorities and functions. Clause 1, in general, the mechanical licensing collective is authorized to perform the following functions, subject to more particular requirements, as described in this subsection. Subclause 1, offer and administer blanket licenses, including receipt of notices of license and reports of usage from digital music providers. Subclause 2, collect and distribute royalties from digital music providers for covered activities. Subclause 3, engage in efforts to identify musical works and shares of such works embodied in particular sound recordings, and to identify and locate the copyright owners of such musical works and shares of such works. Subclause 4, maintain the musical works database and other information relevant to the administration of licensing activities under this section. Subclause 5, administer a process by which copyright owners can claim ownership of musical works and shares of such works, and a process by which royalties for works for which the owner is not identified or located are equitably distributed to known copyright owners. Subclause 6, administer collections of the administrative assessment from digital music providers and significant non-blanket licensees, including receipt of notices of non-blanket activity. Subclause 7, invest in relevant resources and arrange for services of outside vendors and others to support the activities of the mechanical licensing collective. Subclause 8, engage in legal and other efforts to enforce rights and obligations under this subsection, including by filing bankruptcy proofs of claims for amounts owed under licenses and acting in coordination with the digital licensee coordinator. Subclause 9, initiate and participate in proceedings before the copyright royalty judges to establish the administrative assessment under this subsection. Subclause 10, initiate and participate in proceedings before the Copyright Office with respect to activities under this subsection. Subclause 11, gather and provide documentation for use in proceedings before the copyright royalty judges to set rates and terms under this section. Subclause 12, maintain records of the activities of the mechanical licensing collective and engage in and respond to audits described in this subsection. Subclause 13, engage in such other activities as may be necessary or appropriate to fulfill the responsibilities of the mechanical licensing collective under this subsection. Clause 2, restrictions concerning licensing and administrative activities with respect to the administration of licenses except as provided in Clauses 1 and 3 and subparagraph E. Clause 5, the mechanical licensing collective may only, Subclause 1, issue blanket licenses pursuant to subsection D, paragraph 1, and Subclause 2, administer blanket licenses for reproduction or distribution rights in musical works for covered activities, including collecting and distributing royalties pursuant to blanket licenses. Clause 3, additional administrative activities. Subject to paragraph 11, subparagraph C, the Mechanical Licensing Collective may also administer, including by collecting and distributing royalties, voluntary licenses issued by, or individual download licenses obtained from, copyright owners only for reproduction or distribution rights in musical works for covered activities, for which the Mechanical Licensing Collective shall charge reasonable fees for such services. Clause 4. Restriction on lobbying. The Mechanical Licensing Collective may not engage in government lobbying activities, but may engage in the activities described in subclauses 9x and LX of Clause 1. Subparagraph D. Governance. Clause 1. Board of Directors. The Mechanical Licensing Collective shall have a board of directors consisting of 14 voting members and 3 non-voting members, as follows. Subclause 110 voting members shall be representatives of music publishers. Item AA, to which songwriters have assigned exclusive rights of reproduction and distribution of musical works with respect to covered activities, and Item B, none of which may be owned by or under common control with any other board member. Subclause 2, 4 voting members shall be professional songwriters who have retained and exercised exclusive rights of reproduction and distribution with respect to covered activities with respect to musical works they have authored. Subclause 3. 1 non-voting member shall be a representative of the nonprofit trade association of music publishers that represents the greatest percentage of the licensor market for uses of musical works in covered activities, as measured for the 3-year period preceding the date on which the member is appointed. Subclause 4. 1 non-voting member shall be a representative of the digital licensee coordinator, provided that a digital licensee coordinator has been designated pursuant to paragraph 5, subparagraph B. Otherwise, the non-voting member shall be the nonprofit trade association of digital licensees that represents the greatest percentage of the licensee market for uses of musical works in covered activities, as measured over the preceding 3 full calendar years. Subclause 5. 1 non-voting member shall be a representative of a nationally recognized nonprofit trade association whose primary mission is advocacy on behalf of songwriters in the United States. Clause 2. Bylaws. Subclause 1. Establishment. Not later than 1 year after the date on which the Mechanical Licensing Collective is initially designated by the Register of Copyrights under subparagraph B, Clause 1. The collective shall establish bylaws to determine issues relating to the governance of the collective, including, but not limited to, Item AA, the length of the term for each member of the Board of Directors. Item B, the staggering of the terms of the members of the Board of Directors. Item C, a process for filling a seat on the Board of Directors that is vacated before the end of the term with respect to that seat. Item D, a process for electing a member to the Board of Directors, and Item E, a management structure for daily operation of the collective. Subclause 2, public availability. The Mechanical Licensing Collective shall make the bylaws established under Subclause 1 available to the public. Clause 3, board meetings. The Board of Directors shall meet not less frequently than biannually and discuss matters pertinent to the operations of the Mechanical Licensing Collective, including the Mechanical Licensing Collective budget. Clause 4, Operations Advisory Committee. The Board of Directors of the Mechanical Licensing Collective shall establish an Operations Advisory Committee consisting of not fewer than 6 members to make recommendations to the Board of Directors concerning the operations of the Mechanical Licensing Collective, including the efficient investment in and deployment of information technology and data resources. Such committee shall have an equal number of members of the committee who are Subclause 1, musical work, copyright owners who are appointed by the Board of Directors of the Mechanical Licensing Collective, and Subclause 2, representatives of digital music providers who are appointed by the Digital Licensee Coordinator. Clause 5, Unclaimed Royalties Oversight Committee. The Board of Directors of the Mechanical Licensing Collective shall establish and appoint an Unclaimed Royalties Oversight Committee consisting of 10 members, 5 of which shall be musical work, copyright owners, and 5 of which shall be professional songwriters whose works are used in covered activities. Clause 6, Dispute Resolution Committee. The Board of Directors of the Mechanical Licensing Collective shall establish and appoint a Dispute Resolution Committee that shall Subclause 1, consist of not fewer than 6 members, and Subclause 2, include an equal number of representatives of musical work, copyright owners, and professional songwriters. Clause 7, Mechanical Licensing Collective Annual Report. Subclause 1, in general, not later than June 30 of each year commencing after the license availability date, the Mechanical Licensing Collective shall post, and make available online for a period of not less than 3 years, an annual report that sets forth information regarding Item AA, the operational and licensing practices of the collective. Item B, how royalties are collected and distributed. Item C, budgeting and expenditures. Item D, the collective total costs for the preceding calendar year. Item E, the projected annual Mechanical Licensing Collective budget. Item F, aggregated royalty receipts and payments. Item G, expenses that are more than 10% of the annual Mechanical Licensing Collective budget, and Item H, the efforts of the collective to locate and identify copyright owners of unmatched musical works and shares of works. Subclause 2. Submission. On the date on which the Mechanical Licensing Collective posts each report required under Subclause 1, the collective shall provide a copy of the report to the Register of Copyrights. Clause 8. Independent officers. An individual serving as an officer of the Mechanical Licensing Collective may not at the same time also be an employee or agent of any member of the Board of Directors of the collective or any entity represented by a member of the Board of Directors, as described in Clause 1. Clause 9. Oversight and accountability. Subclause 1. In general, the Mechanical Licensing Collective shall, Item AA, ensure that the policies and practices of the collective are transparent and accountable. Item BB, identify a point of contact for publisher inquiries and complaints with timely redress, and Item CC, establish an anti-commingling policy for funds not collected under this section and royalties collected under this section. Subclause 2. Audits. Item AA, in general. Beginning in the fourth full calendar year that begins after the initial designation of the Mechanical Licensing Collective by the Register of Copyrights under subparagraph B, Clause 1, and in every fifth calendar year thereafter. The collective shall retain a qualified auditor that shall, Subitem AA, examine the books, records, and operations of the collective. Subitem BB, prepare a report for the Board of Directors of the collective with respect to the matters described in Item BB, and Subitem CC, not later than December 31st of the year in which the qualified auditor is retained, deliver the report described in Subitem BB to the Board of Directors of the collective. Item BB, matters addressed. Each report prepared under Item AA shall address the implementation and efficacy of procedures of the Mechanical Licensing Collective. Subitem AA, for the receipt, handling, and distribution of royalty funds, including any amounts held as unclaimed royalties. Subitem BB, to guard against fraud, abuse, waste, and the unreasonable use of funds, and Subitem CC, to protect the confidentiality of financial, proprietary, and other sensitive information. Item CC, public availability. With respect to each report prepared under Item AA, the Mechanical Licensing Collective shall, Subitem AA, submit the report to the Register of Copyrights, and Subitem BB, make the report available to the public. Subparagraph E, Musical Works Database. Clause 1. Establishment and maintenance of database. The Mechanical Licensing Collective shall establish and maintain a database containing information relating to musical works and shares of such works, and, to the extent known, the identity and location of the copyright owners of such works and shares thereof, and the sound recordings in which the musical works are embodied. In furtherance of maintaining such database, the Mechanical Licensing Collective shall engage in efforts to identify the musical works embodied in particular sound recordings, as well as to identify and locate the copyright owners of such works and shares thereof, and update such data as appropriate. Clause 2. Matched works. With respect to musical works and shares thereof that have been matched to copyright owners, the Musical Works Database shall include Subclause 1. The title of the musical work. Subclause 2. The copyright owner of the work or share thereof, and the ownership percentage of that owner. Subclause 3. Contact information for such copyright owner. Subclause 4. To the extent reasonably available to the Mechanical Licensing Collective. Item AA. The International Standard Musical Work Code for the work, and Item BB. Identifying information for sound recordings in which the musical work is embodied, including the name of the sound recording featured artist, sound recording copyright owner producer, International Standard Recording Code, and other information commonly used to assist in associating sound recordings with musical works, and Subclause 5. Such other information as the Register of Copyrights may prescribe by regulation. Clause 3. Unmatched works. With respect to unmatched musical works and shares of works in the database, the Musical Works Database shall include Subclause 1. To the extent reasonably available to the Mechanical Licensing Collective. Item AA. The title of the musical work. Item BB. The ownership percentage for which an owner has not been identified. Item CC. If a copyright owner has been identified but not located, the identity of such owner and the ownership percentage of that owner. Item D. Identifying information for sound recordings in which the work is embodied, including sound recording name, featured artist, sound recording copyright owner, producer, International Standard Recording Code, and other information commonly used to assist in associating sound recordings with musical works, and Item EE. Any additional information reported to the Mechanical Licensing Collective that may assist in identifying the work, and Subclause 2. Such other information relating to the identity and ownership of musical works and shares of such works as the Register of Copyrights may prescribe by regulation. Clause 4. Sound recording information. Each musical work copyright owner with any musical work listed in the Musical Works Database shall engage in commercially reasonable efforts to deliver to the Mechanical Licensing Collective, including for use in the Musical Works Database. To the extent such information is not then available in the database, information regarding the names of the sound recordings in which that copyright owner's musical works or shares thereof are embodied, to the extent practicable. Clause 5. Accessibility of database. The Musical Works database shall be made available to members of the public in a searchable online format, free of charge. The Mechanical Licensing Collective shall make such database available in a bulk, machine-readable format through a widely available software application to the following entities. Subclause 1. Digital music providers operating under the authority of valid notices of license free of charge. Subclause 2. Significant non-blanket licensees in compliance with their obligations under paragraph 6, free of charge. Subclause 3. Authorized vendors of the entities described in subclauses 1 and 2, free of charge. Subclause 4. The register of copyrights, free of charge, but the register shall not treat such database or any information therein as a government record. Subclause 5. Any other person or entity for a fee not to exceed the marginal cost to the Mechanical Licensing Collective of providing the database to such person or entity. Clause 6. Additional requirements. The Register of Copyrights shall establish requirements by regulations to ensure the usability, interoperability, and usage restrictions of the Musical Works database. Subparagraph F. Notices of license and non-blanket activity. Clause 1. Notices of licenses. The Mechanical Licensing Collective shall receive, review, and confirm or reject notices of license from digital music providers as provided in paragraph 2, subparagraph A. The collective shall maintain a current publicly accessible list of blanket licenses that includes contact information for the licensees and the effective dates of such licenses. Clause 2. Notices of non-blanket activity. The Mechanical Licensing Collective shall receive notices of non-blanket activity from significant non-blanket licensees as provided in paragraph 6, subparagraph A. The collective shall maintain a current, publicly accessible list of notices of non-blanket activity that includes contact information for significant non-blanket licensees and the dates of receipt of such notices. Subparagraph G. Collection and distribution of royalties. Clause 1 in general. Upon receiving reports of usage and payments of royalties from digital music providers for covered activities, the Mechanical Licensing Collective shall, subclause 1, engage in efforts to Item AA. Identify the musical works embodied in sound recordings reflected in such reports, and the copyright owners of such musical works and shares thereof. Item B. Confirm uses of musical works subject to voluntary licenses and individual download licenses, and the corresponding pro rata amounts to be deducted from royalties that would otherwise be due under the blanket license, and Item C. Confirm proper payment of royalties due. Subclause 2. Distribute royalties to copyright owners in accordance with the usage and other information contained in such reports, as well as the ownership and other information contained in the records of the collective. And Subclause 3. Deposit into an interest-bearing account, as provided in subparagraph H. Clause 2. Royalties that cannot be distributed due to Item AA. An inability to identify or locate a copyright owner of a musical work or share thereof, or Item B. A pending dispute before the Dispute Resolution Committee of the Mechanical Licensing Collective. Clause 2. Other collection efforts. Any royalties recovered by the Mechanical Licensing Collective as a result of efforts to enforce rights or obligations under a blanket license, including through a bankruptcy proceeding or other legal action, shall be distributed to copyright owners based on available usage information and in accordance with the procedures described in subclauses 1 and 2 of Clause 1. On a pro rata basis in proportion to the overall percentage recovery of the total royalties owed, with any pro rata share of royalties that cannot be distributed deposited in an interest-bearing account as provided in subparagraph H. Clause 2. Subparagraph H. Holding of accrued royalties. Clause 1. Holding period. The Mechanical Licensing Collective shall hold accrued royalties associated with particular musical works and shares of works that remain unmatched for a period of not less than 3 years after the date on which the funds were received by the Mechanical Licensing Collective, or not less than 3 years after the date on which the funds were accrued by a digital music provider that subsequently transferred such funds to the Mechanical Licensing Collective pursuant to paragraph 10, subparagraph B, whichever period expires sooner. Clause 2. Interest-bearing account. Accrued royalties for unmatched works and shares thereof shall be maintained by the Mechanical Licensing Collective in an interest-bearing account that earns monthly interest. Subclause 1. At the federal short-term rate, and Subclause 2. That accrues for the benefit of copyright owners entitled to payment of such accrued royalties. Subparagraph I. Musical works claiming process. When a copyright owner of an unmatched work or share of a work has been identified and located in accordance with the procedures of the Mechanical Licensing Collective, the collective shall Clause 1. Update the musical works database and the other records of the collective accordingly, and Clause 2. Provided that accrued royalties for the musical work or share thereof have not yet been included in a distribution pursuant to subparagraph J, Clause 1. Pay such accrued royalties and a proportionate amount of accrued interest associated with that work or share thereof to the copyright owner, accompanied by a cumulative statement of account reflecting usage of such work and accrued royalties based on information provided by digital music providers to the Mechanical Licensing Collective. Subparagraph J. Distribution of unclaimed accrued royalties. Clause 1. Distribution procedures. After the expiration of the prescribed holding period for accrued royalties provided in subparagraph H, Clause 1, the Mechanical Licensing Collective shall distribute such accrued royalties, along with a proportionate share of accrued interest, to copyright owners identified in the records of the collective, subject to the following requirements, and in accordance with the policies and procedures established under Clause 2. Subclause 1. The first such distribution shall occur on or after January 1st of the second full calendar year to commence after the license availability date, with not less than one such distribution to take place during each calendar year thereafter. Subclause 2. Copyright owners' payment shares for unclaimed accrued royalties for particular reporting periods shall be determined in a transparent and equitable manner based on data indicating the relative market shares of such copyright owners as reflected in reports of usage provided by digital music providers for covered activities for the periods in question, including, in addition to usage data provided to the Mechanical Licensing Collective, usage data provided to copyright owners under voluntary licenses and individual download licenses for covered activities, to the extent such information is available to the Mechanical Licensing Collective, in furtherance of the determination of equitable market shares under this subparagraph. Item AA. The Mechanical Licensing Collective may require copyright owners seeking distributions of unclaimed accrued royalties to provide or direct the provision of information concerning the usage of musical works under voluntary licenses and individual download licenses for covered activities, and Item BB. The Mechanical Licensing Collective shall take appropriate steps to safeguard the confidentiality and security of usage, financial, and other sensitive data used to compute market shares in accordance with the confidentiality provisions prescribed by the Register of Copyrights under paragraph 12, subparagraph C. Clause 2. Establishment of distribution policies. The Unclaimed Royalties Oversight Committee established under subparagraph D, Clause 5, shall establish policies and procedures for the distribution of unclaimed accrued royalties and accrued interest in accordance with this subparagraph, including the provision of usage data to copyright owners to allocate payments and credits to songwriters pursuant to Clause 4, subject to the approval of the Board of Directors of the Mechanical Licensing Collective. Clause 3. Public notice of unclaimed accrued royalties. The Mechanical Licensing Collective shall. Subclause 1. Maintain a publicly accessible online facility with contact information for the collective that lists unmatched musical works and shares of works, through which a copyright owner may assert an ownership claim with respect to such a work and a share of such a work. Subclause 2. Engage in diligent, good faith efforts to publicize throughout the music industry. Item AA. The existence of the collective and the ability to claim unclaimed accrued royalties for unmatched musical works and shares of such works held by the collective. Item BB. The procedures by which copyright owners may identify themselves and provide contact, ownership, and other relevant information to the collective in order to receive payments of accrued royalties. Item CC. Any transfer of accrued royalties for musical works under paragraph 10, subparagraph B, not later than 180 days after the date on which the transfer is received, and Item D. Any pending distribution of unclaimed accrued royalties and accrued interest, not less than 90 days before the date on which the distribution is made, and Subclause 3. As appropriate, participate in music industry conferences and events for the purpose of publicizing the matters described in Subclause 2. Clause 4. Songwriter payments. Copyright owners that receive a distribution of unclaimed accrued royalties and accrued interest shall pay or credit a portion to songwriters, or the authorized agents of songwriters, on whose behalf the copyright owners license or administer musical works for covered activities, in accordance with applicable contractual terms, but notwithstanding any agreement to the contrary. Subclause 1. Such payments and credits to songwriters shall be allocated in proportion to reported usage of individual musical works by digital music providers during the reporting periods covered by the distribution from the Mechanical Licensing Collective, and Subclause 2. In no case shall the payment or credit to an individual songwriter be less than 50% of the payment received by the copyright owner, attributable to usage of musical works or shares of works of that songwriter. Subparagraph K. Dispute resolution. The Dispute Resolution Committee established under subparagraph D, Clause 6, shall establish policies and procedures. Clause 1. For copyright owners to address in a timely and equitable manner disputes relating to ownership interests in musical works licensed under this section and allocation and distribution of royalties by the Mechanical Licensing Collective, subject to the approval of the Board of Directors of the Mechanical Licensing Collective. Clause 2. That shall include a mechanism to hold disputed funds in accordance with the requirements described in subparagraph H. Clause 2. Pending resolution of the dispute. And Clause 3. Except as provided in paragraph 11, subparagraph D, that shall not affect any legal or equitable rights or remedies available to any copyright owner or songwriter concerning ownership of and entitlement to royalties for a musical work. Subparagraph L. Verification of payments by Mechanical Licensing Collective. Clause 1. Verification process. A copyright owner entitled to receive payments of royalties for covered activities from the Mechanical Licensing Collective may, individually or with other copyright owners, Conduct an audit of the Mechanical Licensing Collective to verify the accuracy of royalty payments by the Mechanical Licensing Collective to such copyright owner as follows. Subclause 1. A copyright owner may audit the Mechanical Licensing Collective only once in a year for any or all of the 3 calendar years preceding the year in which the audit is commenced, and may not audit records for any calendar year more than once. Subclause 2. The audit shall be conducted by a qualified auditor who shall perform the audit during the ordinary course of business by examining the books, records, and data of the Mechanical Licensing Collective, according to generally accepted auditing standards and subject to applicable confidentiality requirements prescribed by the Register of Copyrights under paragraph 12, subparagraph C. Subclause 3. The Mechanical Licensing Collective shall make such books, records, and data available to the qualified auditor and respond to reasonable requests for relevant information, and shall use commercially reasonable efforts to facilitate access to relevant information maintained by third parties. Subclause 4. To commence the audit, any copyright owner shall file with the Copyright Office a notice of intent to conduct an audit of the Mechanical Licensing Collective, identifying the period of time to be audited, and shall simultaneously deliver a copy of such notice to the Mechanical Licensing Collective. The Register of Copyrights shall cause the notice of audit to be published in the Federal Register not later than 45 calendar days after the date on which the notice is received. Subclause 5. The qualified auditor shall determine the accuracy of royalty payments, including whether an underpayment or overpayment of royalties was made by the Mechanical Licensing Collective to each auditing copyright owner, except that, before providing a final audit report to any such copyright owner, the qualified auditor shall provide a tentative draft of the report to the Mechanical Licensing Collective and allow the Mechanical Licensing Collective a reasonable opportunity to respond to the findings, including by clarifying issues and correcting factual errors. Subclause 6. The auditing copyright owner or owners shall bear the cost of the audit. In case of an underpayment to any copyright owner, the Mechanical Licensing Collective shall pay the amounts of any such underpayment to such auditing copyright owner, as appropriate. In case of an overpayment by the Mechanical Licensing Collective, the Mechanical Licensing Collective may debit the account of the auditing copyright owner or owners for such overpaid amounts, or such owner or owners shall refund overpaid amounts to the Mechanical Licensing Collective as appropriate. Clause 2. Alternative verification procedures. Nothing in this subparagraph shall preclude a copyright owner and the Mechanical Licensing Collective from agreeing to audit procedures different from those described in this subparagraph, except that a notice of the audit shall be provided to and published by the Copyright Office as described in Clause 1, Subclause 4. Subparagraph M. Records of Mechanical Licensing Collective. Clause 1. Records maintenance. The Mechanical Licensing Collective shall ensure that all material records of the operations of the Mechanical Licensing Collective, including those relating to notices of license, the administration of the claims process of the Mechanical Licensing Collective, reports of usage, royalty payments, receipt and maintenance of accrued royalties, royalty distribution processes, and legal matters, are preserved and maintained in a secure and reliable manner, with appropriate commercially reasonable safeguards against unauthorized access, copying, and disclosure, and subject to the confidentiality requirements prescribed by the Register of Copyrights under paragraph 12, subparagraph C, for a period of not less than 7 years after the date of creation or receipt, whichever occurs later. Clause 2. Records access. The Mechanical Licensing Collective shall provide prompt access to electronic and other records pertaining to the administration of a copyright owner's musical works upon reasonable written request of the owner or the authorized representative of the owner. Paragraph 4. Terms and conditions of blanket license. A blanket license is subject to, and conditioned upon, the following requirements. Subparagraph A. Royalty reporting and payments. Clause 1. Monthly reports and payment. A digital music provider shall report and pay royalties to the Mechanical Licensing Collective under the blanket license on a monthly basis in accordance with Clause 2 in subsection C, paragraph 2, subparagraph I, except that the monthly reporting shall be due on the date that is 45 calendar days, rather than 20 calendar days after the end of the monthly reporting period. Clause 2. Data to be reported. In reporting usage of musical works to the Mechanical Licensing Collective, a digital music provider shall provide usage data for musical works used under the blanket license and usage data for musical works used in covered activities under voluntary licenses and individual download licenses. In the report of usage, the digital music provider shall: Subclause 1. With respect to each sound recording embodying a musical work. Item AA. Provide identifying information for the sound recording, including sound recording name, featured artist, and, to the extent acquired by the digital music provider in connection with its use of sound recordings of musical works, to engage in covered activities, including pursuant to subparagraph B, sound recording, copyright owner, producer, International Standard Recording Code, and other information commonly used in the industry to identify sound recordings and match them to the musical works the sound recordings embody. Item BB. To the extent acquired by the digital music provider in the metadata provided by sound recording copyright owners or other licensors of sound recordings in connection with the use of sound recordings of musical works to engage in covered activities, including pursuant to subparagraph B, provide information concerning authorship and ownership of the applicable rights in the musical work embodied in the sound recording, including each songwriter publisher name and respective ownership share in the International Standard Musical Work Code. And Item C, provide the number of digital phono record deliveries of the sound recording, including limited downloads and interactive streams. Subclause 2, identify and provide contact information for all musical work, copyright owners for works embodied in sound recordings, as to which a voluntary license, rather than the blanket license, is in effect with respect to the uses being reported. And Subclause 3, provide such other information as the Register of Copyrights shall require by regulation. Clause 3, format and maintenance of reports. Reports of usage provided by digital music providers to the Mechanical Licensing Collective shall be in a machine-readable format that is compatible with the information technology systems of the Mechanical Licensing Collective and meets the requirements of regulations adopted by the Register of Copyrights. The Register shall also adopt regulations setting forth requirements under which records of use shall be maintained and made available to the Mechanical Licensing Collective by digital music providers engaged in covered activities under a blanket license. Clause 4, adoption of regulations. The Register of Copyrights shall adopt regulations. Subclause 1, setting forth requirements under which records of use shall be maintained and made available to the Mechanical Licensing Collective by digital music providers engaged in covered activities under a blanket license. And Subclause 2, regarding adjustments to reports of usage by digital music providers, including mechanisms to account for overpayment and underpayment of royalties in prior periods. Subparagraph B, collection of sound recording information. A digital music provider shall engage in good faith, commercially reasonable efforts to obtain from sound recording, copyright owners and other licensors of sound recordings made available through the service of such digital music provider information concerning. Clause 1, sound recording copyright owners, producers, international standard recording codes, and other information commonly used in the industry to identify sound recordings and match them to the musical works the sound recordings embody. And Clause 2, the authorship and ownership of musical works, including songwriters, publisher names, ownership shares, and international standard musical work codes. Subparagraph C, payment of administrative assessment. A digital music provider and any significant non-blanket licensee shall pay the administrative assessment established under paragraph 7, subparagraph D, in accordance with this subsection and applicable regulations. Subparagraph D, verification of payments by digital music providers. Clause 1, verification process. The Mechanical Licensing Collective may conduct an audit of a digital music provider operating under the blanket license to verify the accuracy of royalty payments by the digital music provider to the Mechanical Licensing Collective as follows. Subclause 1. The Mechanical Licensing Collective may commence an audit of a digital music provider not more frequently than once in any 3 calendar year period, to cover a verification period of not more than the 3 full calendar years preceding the date of commencement of the audit, and such audit may not audit records for any such 3-year verification period more than once. Subclause 2. The audit shall be conducted by a qualified auditor who shall perform the audit during the ordinary course of business by examining the books, records, and data of the digital music provider according to generally accepted auditing standards and subject to applicable confidentiality requirements prescribed by the Register of Copyrights under paragraph 12, subparagraph C. Subclause 3. The digital music provider shall make such books, records, and data available to the qualified auditor and respond to reasonable requests for relevant information, and shall use commercially reasonable efforts to provide access to relevant information maintained with respect to a digital music provider by third parties. Subclause 4. To commence the audit, the Mechanical Licensing Collective shall file with the Copyright Office a notice of intent to conduct an audit of the digital music provider, identifying the period of time to be audited, and shall simultaneously deliver a copy of such notice to the digital music provider. The Register of Copyrights shall cause the notice of audit to be published in the Federal Register not later than 45 calendar days after the date on which notice is received. Subclause 5. The qualified auditor shall determine the accuracy of royalty payments, including whether an underpayment or overpayment of royalties was made by the digital music provider to the Mechanical Licensing Collective, except that, before providing a final audit report to the Mechanical Licensing Collective, the qualified auditor shall provide a tentative draft of the report to the digital music provider and allow the digital music provider a reasonable opportunity to respond to the findings, including by clarifying issues and correcting factual errors. Subclause 6. The Mechanical Licensing Collective shall pay the cost of the audit, unless the qualified auditor determines that there was an underpayment by the digital music provider of not less than 10%. In which case, the digital music provider shall bear the reasonable costs of the audit, in addition to paying the amount of any underpayment to the Mechanical Licensing Collective. In case of an overpayment by the digital music provider, the Mechanical Licensing Collective shall provide a credit to the account of the digital music provider. Subclause 7. A digital music provider may not assert Section 507 or any other federal or state statute of limitations, doctrine of laches or estoppel, or similar provision as a defense to a legal action arising from an audit under this subparagraph if such legal action is commenced not more than 6 years after the commencement of the audit. That is the basis for such action. Clause 2. Alternative verification procedures. Nothing in this subparagraph shall preclude the Mechanical Licensing Collective and a digital music provider from agreeing to audit procedures different from those described in this subparagraph, except that a notice of the audit shall be provided to and published by the Copyright Office as described in Clause 1, Subclause 4. Subparagraph E. Default under blanket license. Clause 1. Conditions of default. A digital music provider shall be in default under a blanket license if the digital music provider. Subclause 1. Fails to provide one or more monthly reports of usage to the Mechanical Licensing Collective when due. Subclause 2. Fails to make a monthly royalty or late fee payment to the Mechanical Licensing Collective when due, in all or material part. Subclause 3. Provides one or more monthly reports of usage to the Mechanical Licensing Collective that, on the whole, is or are materially deficient as a result of inaccurate, missing, or unreadable data, where the correct data was available to the digital music provider and required to be reported under this section and applicable regulations. Subclause 4 fails to pay the administrative assessment as required under this subsection and applicable regulations. Or Subclause 5, after being provided written notice by the Mechanical Licensing Collective, refuses to comply with any other material term or condition of the blanket license under this section for a period of not less than 60 calendar days. Clause 2. Notice of default and termination. In case of a default by a digital music provider, the Mechanical Licensing Collective may proceed to terminate the blanket license of the digital music provider as follows. Subclause 1. The Mechanical Licensing Collective shall provide written notice to the digital music provider describing with reasonable particularity the default and advising that unless such default is cured not later than 60 calendar days after the date of the notice, the blanket license will automatically terminate at the end of that period. Subclause 2. If the digital music provider fails to remedy the default before the end of the 60-day period described in Subclause 1, the license shall terminate without any further action on the part of the Mechanical Licensing Collective. Such termination renders the making of all digital phonorecord deliveries of all musical works and shares thereof, covered by the blanket license for which the royalty or administrative assessment has not been paid, actionable as acts of infringement under Section 501 and subject to the remedies provided by Sections 502 through 506. Clause 3. Notice to copyright owners. The Mechanical Licensing Collective shall provide written notice of any termination under this subparagraph to copyright owners of affected works. Clause 4. Review by Federal District Court. A digital music provider that believes a blanket license was improperly terminated by the Mechanical Licensing Collective may seek review of such termination in an appropriate District Court of the United States. The District Court shall determine the matter de novo based on the record before the Mechanical Licensing Collective and any additional supporting evidence presented by the parties. Paragraph 5. Digital Licensee Coordinator. Subparagraph A. In general, the Digital Licensee Coordinator shall be a single entity that Clause 1 is a non-profit, not owned by any other entity, that is created to carry out responsibilities under this subsection. Clause 2 is endorsed by and enjoys substantial support from digital music providers and significant non-blanket licensees that together represent the greatest percentage of the licensee market for uses of musical works and covered activities, as measured over the preceding 3 calendar years. Clause 3 is able to demonstrate that it has or will have, prior to the license availability date, the administrative capabilities to perform the required functions of the Digital Licensee Coordinator under this subsection. And Clause 4 has been designated by the Register of Copyrights with the approval of the Librarian of Congress pursuant to Section 702 in accordance with subparagraph B. Subparagraph B. Designation of Digital Licensee Coordinator. Clause 1. Initial designation. The Register of Copyrights shall initially designate the Digital Licensee Coordinator not later than 270 days after the enactment date, in accordance with the same procedure described for designation of the Mechanical Licensing Collective in paragraph 3. Subparagraph B. Clause 1. Clause 2. Periodic review of designation. Following the initial designation of the Digital Licensee Coordinator, the Register of Copyrights shall, every 5 years, beginning with the 5th full calendar year to commence after the initial designation, determine whether the existing designation should be continued, or a different entity meeting the criteria described in clauses 1 through 3 of subparagraph A should be designated, in accordance with the same procedure described for the Mechanical Licensing Collective in paragraph 3, subparagraph B, clause 2. Clause 3. Inability to designate. If the Register of Copyrights is unable to identify an entity that fulfills each of the qualifications described in clauses 1 through 3 of subparagraph A to serve as the Digital Licensee Coordinator, the Register may decline to designate a Digital Licensee Coordinator. The determination of the Register not to designate a Digital Licensee Coordinator shall not negate or otherwise affect any provision of this subsection except to the limited extent that a provision references the Digital Licensee Coordinator. In such case, the reference to the Digital Licensee Coordinator shall be without effect unless and until a new Digital Licensee Coordinator is designated. Subparagraph C. Authorities and functions. Clause 1. In general, the Digital Licensee Coordinator is authorized to perform the following functions, subject to more particular requirements as described in this subsection. Subclause 1. Establish a governance structure, criteria for membership, and any dues to be paid by its members. Subclause 2. Engage in efforts to enforce notice and payment obligations with respect to the administrative assessment, including by receiving information from and coordinating with the Mechanical Licensing Collective. Subclause 3. Initiate and participate in proceedings before the copyright royalty judges to establish the administrative assessment under this subsection. Subclause 4. Initiate and participate in proceedings before the Copyright Office with respect to activities under this subsection. Subclause 5. Gather and provide documentation for use in proceedings before the copyright royalty judges to set rates and terms under this section. Subclause 6. Maintain records of its activities. Subclause 7. Assist in publicizing the existence of the Mechanical Licensing Collective and the ability of copyright owners to claim royalties for unmatched musical works and shares of works through the collective. Subclause 8. Engage in such other activities as may be necessary or appropriate to fulfill its responsibilities under this subsection. Clause 2. Restriction on lobbying. The digital licensee coordinator may not engage in government lobbying activities, but may engage in the activities described in subclauses 3, 4, and V of Clause 1. Clause 3. Assistance with publicity for unclaimed royalties. The digital licensee coordinator shall make reasonable, good faith efforts to assist the Mechanical Licensing Collective in the efforts of the collective to locate and identify copyright owners of unmatched musical works and shares of such works by encouraging digital music providers to publicize the existence of the collective and the ability of copyright owners to claim unclaimed accrued royalties, including by Subclause 1. Posting contact information for the collective at reasonably prominent locations on digital music provider websites and applications, and Subclause 2. Conducting in-person outreach activities with songwriters. Paragraph 6. Requirements for significant non-blanket licensees. Subparagraph A in general. Clause 1. Notice of activity. Not later than 45 calendar days after the license availability date, or 45 calendar days after the end of the first full calendar month in which an entity initially qualifies as a significant non-blanket licensee, whichever occurs later, a significant non-blanket licensee shall submit a notice of non-blanket activity to the Mechanical Licensing Collective. The notice of non-blanket activity shall comply in form and substance with requirements that the Register of Copyrights shall establish by regulation, and a copy shall be made available to the digital licensee coordinator. Clause 2. Reporting and payment obligations. The notice of non-blanket activity submitted to the Mechanical Licensing Collective shall be accompanied by a report of usage that contains the information described in paragraph 4, subparagraph A, clause 2, as well as any payment of the administrative assessment required under this subsection and applicable regulations. Thereafter, subject to clause 3, a significant non-blanket licensee shall continue to provide monthly reports of usage accompanied by any required payment of the administrative assessment to the Mechanical Licensing Collective. Such reports and payments shall be submitted not later than 45 calendar days after the end of the calendar month being reported. Clause 3. Discontinuation of obligations. An entity that has submitted a notice of non-blanket activity to the Mechanical Licensing Collective that has ceased to qualify as a significant non-blanket licensee may so notify the collective in writing. In such case, as of the calendar month in which such notice is provided, such entity shall no longer be required to provide reports of usage or pay the administrative assessment, but if such entity later qualifies as a significant non-blanket licensee, such entity shall again be required to comply with clauses 1 and 2. Subparagraph B. Reporting by Mechanical Licensing Collective to Digital Licensee Coordinator. Clause 1. Monthly reports of non-compliant licensees. The Mechanical Licensing Collective shall provide monthly reports to the Digital Licensee Coordinator setting forth any significant non-blanket licensees of which the collective is aware that have failed to comply with subparagraph A. Clause 2. Treatment of confidential information. The Mechanical Licensing Collective and Digital Licensee Coordinator shall take appropriate steps to safeguard the confidentiality and security of financial and other sensitive data shared under this subparagraph, in accordance with the confidentiality requirements prescribed by the Register of Copyrights under paragraph 12, subparagraph C. Subparagraph C. Legal enforcement efforts. Clause 1. Federal court action. Should the Mechanical Licensing Collective or Digital Licensee Coordinator become aware that a significant non-blanket licensee has failed to comply with subparagraph A, either may commence an action in an appropriate district court of the United States for damages and injunctive relief. If the significant non-blanket licensee is found liable, the court shall, absent a finding of excusable neglect, award damages in an amount equal to 3 times the total amount of the unpaid administrative assessment and, notwithstanding anything to the contrary in Section 505, reasonable attorney's fees and costs, as well as such other relief as the court determines appropriate. In all other cases, the court shall award relief as appropriate. Any recovery of damages shall be payable to the Mechanical Licensing Collective as an offset to the collective total costs. Clause 2. Statute of limitations for enforcement action. Any action described in this subparagraph shall be commenced within the time period described in Section 507, subsection B. Clause 3. Other rights and remedies preserved. The ability of the mechanical licensing collective or digital licensee coordinator to bring an action under this subparagraph shall in no way alter, limit, or negate any other right or remedy that may be available to any party at law or in equity. Paragraph 7. Funding of mechanical licensing collective. Subparagraph A in general. The collective total cost shall be funded by Clause 1. An administrative assessment, as such assessment is established by the copyright royalty judges pursuant to subparagraph D from time to time, to be paid by Subclause 1. Digital music providers that are engaged in all or in part in covered activities pursuant to a blanket license, and Subclause 2. Significant non-blanket licensees, and Clause 2. Voluntary contributions from digital music providers and significant non-blanket licensees as may be agreed with copyright owners. Subparagraph B. Voluntary contributions. Clause 1. Agreements concerning contributions. Except as provided in Clause 2, voluntary contributions by digital music providers and significant non-blanket licensees shall be determined by private negotiation and agreement, and the following conditions apply. Subclause 1. The date and amount of each voluntary contribution to the Mechanical Licensing Collective shall be documented in a writing signed by an authorized agent of the Mechanical Licensing Collective and the contributing party. Subclause 2. Such agreement shall be made available as required in proceedings before the copyright royalty judges to establish or adjust the administrative assessment in accordance with applicable statutory and regulatory provisions and rulings of the copyright royalty judges. Clause 2. Treatment of contributions. Each voluntary contribution described in Clause 1 shall be treated for purposes of an administrative assessment proceeding as an offset to the collective total costs that would otherwise be recovered through the administrative assessment. Any allocation or reallocation of voluntary contributions between or among individual digital music providers or significant non-blanket licensees shall be a matter of private negotiation and agreement among such parties and outside the scope of the administrative assessment proceeding. Subparagraph C. Interim application of accrued royalties. In the event that the administrative assessment, together with any funding from voluntary contributions as provided in subparagraphs A and B, is inadequate to cover current collective total costs, the collective, with approval of its board of directors, may apply unclaimed accrued royalties on an interim basis to defray such costs, subject to future reimbursement of such royalties from future collections of the assessment. Subparagraph D. Determination of administrative assessment. Clause 1. Administrative assessment to cover collective total costs. The administrative assessment shall be used solely and exclusively to fund the collective total cost. Clause 2. Separate proceeding before copyright royalty judges. The amount and terms of the administrative assessment shall be determined and established in a separate and independent proceeding before the copyright royalty judges, according to the procedures described in Clauses 3 and 4. The administrative assessment determined in such proceeding shall, Subclause 1, be wholly independent of royalty rates and terms applicable to digital music providers, which shall not be taken into consideration in any manner in establishing the administrative assessment. Subclause 2, be established by the copyright royalty judges in an amount that is calculated to defray the reasonable collective total costs. Subclause 3, be assessed based on usage of musical works by digital music providers and significant non-blanket licensees in covered activities under both compulsory and non-blanket licenses. Subclause 4, may be in the form of a percentage of royalties payable under this section for usage of musical works in covered activities, regardless of whether a different rate applies under a voluntary license, or any other usage-based metric reasonably calculated to equitably allocate the collective total costs across digital music providers and significant non-blanket licensees engaged in covered activities, and shall include as a component a minimum fee for all digital music providers and significant non-blanket licensees, and Subclause 5, take into consideration anticipated future collective total costs and collections of the administrative assessment, including, as applicable, Item AA. Any portion of past actual collective total costs of the Mechanical Licensing Collective not funded by previous collections of the administrative assessment or voluntary contributions because such collections or contributions together were insufficient to fund such costs. Item B. Any past collections of the administrative assessment and voluntary contributions that exceeded past actual collective total costs, resulting in a surplus, and Item C. The amount of any voluntary contributions by digital music providers or significant non-blanket licensees in relevant periods, described in subparagraphs A and B of paragraph 7. Clause 3. Initial administrative assessment. The procedure for establishing the initial administrative assessment shall be as follows. Subclause 1. Not later than 270 days after the enactment date, the copyright royalty judges shall commence a proceeding to establish the initial administrative assessment by publishing a notice in the Federal Register seeking petitions to participate. Subclause 2. The Mechanical Licensing Collective and Digital Licensee Coordinator shall participate in the proceeding described in Subclause 1, along with any interested copyright owners, digital music providers, or significant non-blanket licensees that have notified the copyright royalty judges of their desire to participate. Subclause 3. The copyright royalty judges shall establish a schedule for submission by the parties of information that may be relevant to establishing the administrative assessment. including actual and anticipated collective total costs of the Mechanical Licensing Collective, actual and anticipated collections from digital music providers and significant non-blanket licensees, and documentation of voluntary contributions, as well as a schedule for further proceedings which shall include a hearing as the copyright royalty judges determine appropriate. Subclause 4. The initial administrative assessment shall be determined, and such determination shall be published in the Federal Register by the copyright royalty judges not later than 1 year after commencement of the proceeding described in this clause. The determination shall be supported by a written record. The initial administrative assessment shall be effective as of the license availability date and shall continue in effect unless and until an adjusted administrative assessment is established pursuant to an adjustment proceeding under Clause 4. Clause 4. Adjustment of administrative assessment. The administrative assessment may be adjusted by the copyright royalty judges periodically in accordance with the following procedures. Subclause 1. Not earlier than 1 year after the most recent publication of a determination of the administrative assessment by the copyright royalty judges, the Mechanical Licensing Collective, the Digital Licensee Coordinator, or one or more interested copyright owners. Digital music providers or significant non-blanket licensees may file a petition with the copyright royalty judges in the month of May to commence a proceeding to adjust the administrative assessment. Subclause 2. Notice of the commencement of such proceedings shall be published in the Federal Register in the month of June following the filing of any petition, with a schedule of requested information and additional proceedings as described in Clause 3. Subclause 3. The Mechanical Licensing Collective and Digital Licensee Coordinator shall participate in such proceeding, along with any interested copyright owners, digital music providers, or significant non-blanket licensees that have notified the copyright royalty judges of their desire to participate. Subclause 3. The determination of the adjusted administrative assessment, which shall be supported by a written record, shall be published in the Federal Register during June of the calendar year following the commencement of the proceeding. The adjusted administrative assessment shall take effect January 1st of the year following such publication. Clause 5. Adoption of voluntary agreements. In lieu of reaching their own determination based on evaluation of relevant data, the copyright royalty judges shall approve and adopt a negotiated agreement to establish the amount and terms of the administrative assessment that has been agreed to by the Mechanical Licensing Collective and the Digital Licensee Coordinator, or if none has been designated. Interested digital music providers and significant non-blanket licensees representing more than half of the market for uses of musical works and covered activities. Except that the copyright royalty judges shall have the discretion to reject any such agreement for good cause shown. An administrative assessment adopted under this clause shall apply to all digital music providers and significant non-blanket licensees engaged in covered activities during the period the administrative assessment is in effect. Clause 6. Continuing authority to amend. The copyright royalty judges shall retain continuing authority to amend a determination of an administrative assessment to correct technical or clerical errors or modify the terms of implementation for good cause, with any such amendment to be published in the Federal Register. Clause 7. Appeal of administrative assessment. The determination of an administrative assessment by the copyright royalty judges shall be appealable, not later than 30 calendar days after publication in the Federal Register, to the Court of Appeals for the District of Columbia Circuit by any party that fully participated in the proceeding. The administrative assessment as established by the copyright royalty judges shall remain in effect pending the final outcome of any such appeal, and the Mechanical Licensing Collective, Digital Licensee Coordinator, digital music providers, and significant non-blanket licensees shall implement appropriate financial or other measures not later than 90 days after any modification of the assessment to reflect and account for such outcome. Clause 8. Regulations. The copyright royalty judges may adopt regulations to govern the conduct of proceedings under this paragraph. Paragraph 8. Establishment of rates and terms under blanket license. Subparagraph A. Restrictions on rate-setting participation. Neither the Mechanical Licensing Collective nor the Digital Licensee Coordinator shall be a party to a proceeding described in subsection C, paragraph 1, subparagraph E, except that the Mechanical Licensing Collective or the Digital Licensee Coordinator may gather and provide financial and other information for the use of a party to such a proceeding and comply with requests for information as required under applicable statutory and regulatory provisions and rulings of the copyright royalty judges. Subparagraph B. Application of late fees. In any proceeding described in subparagraph A in which the copyright royalty judges establish a late fee for late payment of royalties for uses of musical works under this section, such fee shall apply to covered activities under blanket licenses as follows. Clause 1. Late fees for past due royalty payments shall accrue from the due date for payment until payment is received by the Mechanical Licensing Collective. Clause 2. The availability of late fees shall in no way prevent a copyright owner or the Mechanical Licensing Collective from asserting any other rights or remedies to which such copyright owner or the Mechanical Licensing Collective may be entitled under this title. Subparagraph C. Interim rate agreements in general. For any covered activity for which no rate or terms have been established by the copyright royalty judges, the Mechanical Licensing Collective and any digital music provider may agree to an interim rate and terms for such activity under the blanket license, and any such rate and terms Clause 1 shall be treated as non-precedential and not cited or relied upon in any rate-setting proceeding before the copyright royalty judges or any other tribunal. And Clause 2 shall automatically expire upon the establishment of a rate and terms for such covered activity by the copyright royalty judges under subsection C, paragraph 1, subparagraph E. Subparagraph D, adjustments for interim rates. The rate and terms established by the copyright royalty judges for a covered activity to which an interim rate and terms have been agreed under subparagraph C shall supersede the interim rate and terms and apply retroactively to the inception of the activity under the blanket license. In such case, not later than 90 days after the effective date of the rate and terms established by the copyright royalty judges. Clause 1. If the rate established by the copyright royalty judges exceeds the interim rate, the digital music provider shall pay to the Mechanical Licensing Collective the amount of any underpayment of royalties due. Or, Clause 2. If the interim rate exceeds the rate established by the copyright royalty judges, the Mechanical Licensing Collective shall credit the account of the digital music provider for the amount of any overpayment of royalties due. Paragraph 9. Transition to blanket licenses. Subparagraph A. Substitution of blanket license. On the license availability date, a blanket license shall, without any interruption in license authority enjoyed by such digital music provider, be automatically substituted for and supersede any existing compulsory license previously obtained under this section by the digital music provider from a copyright owner to engage in one or more covered activities with respect to a musical work, except that such substitution shall not apply to any authority obtained from a record company pursuant to a compulsory license to make and distribute permanent downloads, unless and until such record company terminates such authority in writing to take effect at the end of a monthly reporting period, with a copy to the Mechanical Licensing Collective. Subparagraph B. Expiration of existing licenses. Except to the extent provided in subparagraph A, on and after the license availability date, licenses other than individual download licenses obtained under this section for covered activities prior to the license availability date shall no longer continue in effect. Subparagraph C. Treatment of voluntary licenses. A voluntary license for a covered activity in effect on the license availability date will remain in effect unless and until the voluntary license expires according to the terms of the voluntary license, or the parties agree to amend or terminate the voluntary license. In a case where a voluntary license for a covered activity entered into before the license availability date incorporates the terms of this section by reference, the terms so incorporated but not the rates shall be those in effect immediately prior to the license availability date, and those terms shall continue to apply unless and until such voluntary license is terminated or amended, or the parties enter into a new voluntary license. Subparagraph D. Further acceptance of notices for covered activities by Copyright Office on and after the enactment date. Clause 1. The Copyright Office shall no longer accept notices of intention with respect to covered activities, and Clause 2. Notices of intention filed before the enactment date will no longer be effective or provide license authority with respect to covered activities, except that, before the license availability date, there shall be no liability under Section 501 for the reproduction or distribution of a musical work or share thereof in covered activities if a valid notice of intention was filed for such work or share before the enactment date. Paragraph 10. Prior unlicensed uses. Subparagraph A. Limitation on liability in general. A copyright owner that commences an action under Section 501 on or after January 1, 2018, against a digital music provider for the infringement of the exclusive rights provided by paragraph 1 or 3 of Section 106 arising from the unauthorized reproduction or distribution of a musical work by such digital music provider in the course of engaging in covered activities prior to the license availability date, shall, as the copyright owner's sole and exclusive remedy against the digital music provider, be eligible to recover the royalty prescribed under subsection C, paragraph 1, subparagraph C in Chapter 8, from the digital music provider, provided that such digital music provider can demonstrate compliance with the requirements of subparagraph B as applicable. In all other cases, the limitation on liability under this subparagraph shall not apply. Subparagraph B. Requirements for limitation on liability. The following requirements shall apply on the enactment date and through the end of the period that expires 90 days after the license availability date to digital music providers seeking to avail themselves of the limitation on liability described in subparagraph A. Clause 1. Not later than 30 calendar days after first making a particular sound recording of a musical work available through its service via one or more covered activities, or 30 calendar days after the enactment date, whichever occurs later, a digital music provider shall engage in good faith, commercially reasonable efforts to identify and locate each copyright owner of such musical work or share thereof. Such required matching efforts shall include the following. Subclause 1. Good faith. Commercially reasonable efforts to obtain from the owner of the corresponding sound recording made available through the digital music provider's service the following information. Item AA. Sound recording name, featured artist, sound recording copyright owner, producer, International Standard Recording Code, and other information commonly used in the industry to identify sound recordings and match them to the musical works they embody. Item B. Any available musical work ownership information, including each songwriter and publisher name, percentage ownership share, and International Standard Musical Work Code. Subclause 2. employment of one or more bulk electronic matching processes that are available to the digital music provider through a third-party vendor on commercially reasonable terms. Except that a digital music provider may rely on its own bulk electronic matching process if that process has capabilities comparable to or better than those available from a third-party vendor on commercially reasonable terms. Clause 2. The required matching efforts shall be repeated by the digital music provider not less than once per month, for so long as the copyright owner remains unidentified or has not been located. Clause 3. If the required matching efforts are successful in identifying and locating a copyright owner of a musical work, or share thereof, by the end of the calendar month in which the digital music provider first makes use of the work, the digital music provider shall provide statements of account and pay royalties to such copyright owner in accordance with this section and applicable regulations. Clause 4. If the copyright owner is not identified or located by the end of the calendar month in which the digital music provider first makes use of the work, the digital music provider shall accrue and hold royalties calculated under the applicable statutory rate in accordance with usage of the work, from initial use of the work until the accrued royalties can be paid to the copyright owner or are required to be transferred to the Mechanical Licensing Collective as follows. Subclause 1. Accrued royalties shall be maintained by the digital music provider in accordance with generally accepted accounting principles. Subclause 2. If a copyright owner of an unmatched musical work or share thereof is identified and located by or to the digital music provider before the license availability date, the digital music provider shall: Item AA. Not later than 45 calendar days after the end of the calendar month during which the copyright owner was identified and located, pay the copyright owner all accrued royalties. Such payment to be accompanied by a cumulative statement of account that includes all of the information that would have been provided to the copyright owner had the digital music provider been providing monthly statements of account to the copyright owner from initial use of the work in accordance with this section and applicable regulations, including the requisite certification under subsection C, paragraph 2, subparagraph I. Item B. Beginning with the accounting period following the calendar month in which the copyright owner was identified and located, and for all other accounting periods prior to the license availability date. Provide monthly statements of account and pay royalties to the copyright owner as required under this section and applicable regulations. And Item C. Beginning with the monthly royalty reporting period commencing on the license availability date, report usage and pay royalties for such musical work or share thereof for such reporting period and reporting periods thereafter to the Mechanical Licensing Collective as required under this subsection and applicable regulations. Subclause 3. If a copyright owner of an unmatched musical work or share thereof is not identified and located by the license availability date, the digital music provider shall: Item AA. Not later than 45 calendar days after the license availability date, transfer all accrued royalties to the Mechanical Licensing Collective. Such payment to be accompanied by a cumulative statement of account that includes all of the information that would have been provided to the copyright owner had the digital music provider been serving monthly statements of account on the copyright owner from initial use of the work in accordance with this section and applicable regulation, including the requisite certification under subsection C, paragraph 2, subparagraph I, and accompanied by an additional certification by a duly authorized officer of the digital music provider that the digital music provider has fulfilled the requirements of clauses 1 and 2 of subparagraph B, but has not been successful in locating or identifying the copyright owner. And Item B. Beginning with the monthly royalty reporting period commencing on the license availability date, report usage and pay royalties for such musical work or share thereof for such period and reporting periods thereafter to the Mechanical Licensing Collective as required under this subsection and applicable regulations. Clause 5. A digital music provider that complies with the requirements of this subparagraph with respect to unmatched musical works or shares of works shall not be liable for or accrue late fees for late payments of royalties for such works until such time as the digital music provider is required to begin paying monthly royalties to the copyright owner or the Mechanical Licensing Collective, as applicable. Subparagraph C. Adjusted statute of limitations. Notwithstanding anything to the contrary in section 507, subsection B, with respect to any claim of infringement of the exclusive rights provided by paragraphs 1 and 3 of section 106 against a digital music provider arising from the unauthorized reproduction or distribution of a musical work by such digital music provider in the course of engaging in covered activities that accrued not more than 3 years prior to the license availability date. Such action may be commenced not later than the later of Clause 1, 3 years after the date on which the claim accrued, or Clause 2, 2 years after the license availability date. Subparagraph D. Other rights and remedies preserved. Except as expressly provided in this paragraph, nothing in this paragraph shall be construed to alter, limit, or negate any right or remedy of a copyright owner with respect to unauthorized use of a musical work. Paragraph 11. Legal protections for licensing activities. Subparagraph A. Exemption for compulsory license activities. The antitrust exemption described in subsection C, paragraph 1, subparagraph D shall apply to negotiations and agreements between and among copyright owners and persons entitled to obtain a compulsory license for covered activities. and common agents acting on behalf of such copyright owners or persons, including with respect to the administrative assessment established under this subsection. Subparagraph B, limitation on common agent exemption. Notwithstanding the antitrust exemption provided in subsection C, paragraph 1, subparagraph D and subparagraph A of this paragraph, except for the administrative assessment referenced in such subparagraph A, and except as provided in paragraph 8. Subparagraph C, neither the mechanical licensing collective nor the digital licensee coordinator shall serve as a common agent with respect to the establishment of royalty rates or terms under this section. Subparagraph C, antitrust exemption for administrative activities. Notwithstanding any provision of the antitrust laws, copyright owners and persons entitled to obtain a compulsory license under this section may designate the mechanical licensing collective to administer voluntary licenses for the reproduction or distribution of musical works in covered activities on behalf of such copyright owners and persons. Subject to the following conditions. Clause 1. Each copyright owner shall establish the royalty rates and material terms of any such voluntary license individually and not in agreement, combination, or concert with any other copyright owner. Clause 2. Each person entitled to obtain a compulsory license under this section shall establish the royalty rates and material terms of any such voluntary license individually and not in agreement, combination, or concert with any other digital music provider. Clause 3. The mechanical licensing collective shall maintain the confidentiality of the voluntary licenses in accordance with the confidentiality provisions prescribed by the Register of Copyrights under paragraph 12, subparagraph C. Subparagraph D. Liability for good faith activities. The mechanical licensing collective shall not be liable to any person or entity based on a claim arising from its good faith administration of policies and procedures adopted and implemented to carry out the responsibilities described in subparagraphs J and K of paragraph 3, except to the extent of correcting an underpayment or overpayment of royalties as provided in paragraph 3, subparagraph L, clause 1, subclause 6. But the collective may participate in a legal proceeding as a stakeholder party if the collective is holding funds that are the subject of a dispute between copyright owners. For purposes of this subparagraph, the term good faith administration means administration in a manner that is not grossly negligent. Subparagraph E, preemption of state property laws. The holding and distribution of funds by the mechanical licensing collective in accordance with this subsection shall supersede and preempt any state law, including common law concerning escheatment or abandoned property, or any analogous provision that might otherwise apply. Subparagraph F, rule of construction. Except as expressly provided in this subsection, nothing in this subsection shall negate or limit the ability of any person to pursue an action in federal court against the mechanical licensing collective or any other person based upon a claim arising under this title or other applicable law. Paragraph 12, regulations. Subparagraph A, adoption by Register of Copyrights and copyright royalty judges. The Register of Copyrights may conduct such proceedings and adopt such regulations as may be necessary or appropriate to effectuate the provisions of this subsection, except for regulations concerning proceedings before the copyright royalty judges to establish the administrative assessment, which shall be adopted by the copyright royalty judges. Subparagraph B, judicial review of regulations. Except as provided in paragraph 7, subparagraph D, clause 7, regulations adopted under this subsection shall be subject to judicial review pursuant to Chapter 7 of Title 5. Subparagraph C, protection of confidential information. The Register of Copyrights shall adopt regulations to provide for the appropriate procedures to ensure that confidential, private, proprietary, or privileged information contained in the records of the mechanical licensing collective and digital licensee coordinator is not improperly disclosed or used, including through any disclosure or use by the board of directors or personnel of either entity, and specifically including the Unclaimed Royalties Oversight Committee and the Dispute Resolution Committee of the Mechanical Licensing Collective. Paragraph 13, savings clauses. Subparagraph A, limitation on activities and rights covered. This subsection applies solely to uses of musical works subject to licensing under this section. The blanket license shall not be construed to extend or apply to activities other than covered activities or to rights other than the exclusive rights of reproduction and distribution licensed under this section, or serve or act as the basis to extend or expand the compulsory license under this section to activities and rights not covered by this section on the day before the enactment date. Subparagraph B, rights of public performance not affected. The rights, protections, and immunities granted under this subsection, the data concerning musical works collected and made available under this subsection, and the definitions under subsection E shall not extend to limit or otherwise affect any right of public performance in a musical work. Subsection E, definitions, as used in this section. Paragraph 1, accrued interest. The term accrued interest means interest accrued on accrued royalties as described in subsection D, paragraph 3, subparagraph H, clause 2. Paragraph 2, accrued royalties. The term accrued royalties means royalties accrued for the reproduction or distribution of a musical work or share thereof in a covered activity, calculated in accordance with the applicable royalty rate under this section. Paragraph 3, administrative assessment. The term administrative assessment means the fee established pursuant to subsection D, paragraph 7, subparagraph D. Paragraph 4, audit. The term audit means a royalty compliance examination to verify the accuracy of royalty payments or the conduct of such an examination as applicable. Paragraph 5. Blanket license. The term blanket license means a compulsory license described in subsection D, paragraph 1, subparagraph A to engage in covered activities. Paragraph 6. Collective total costs. The term collective total costs. Subparagraph A means the total costs of establishing, maintaining, and operating the mechanical licensing collective to fulfill its statutory functions, including Clause 1. Startup costs. Clause 2. Financing, legal, audit, and insurance costs. Clause 3. Investments in information technology, infrastructure, and other long-term resources. Clause 4. Outside vendor costs. Clause 5. Costs of licensing, royalty administration, and enforcement of rights. Clause 6. Costs of bad debt. And Clause 7. Costs of automated and manual efforts to identify and locate copyright owners of musical works, and shares of such musical works, and match sound recordings to the musical works. The sound recordings embody, and subparagraph B does not include any added costs incurred by the mechanical licensing collective to provide services under voluntary licenses. Paragraph 7. Covered activity. The term covered activity means the activity of making a digital phono record delivery of a musical work, including in the form of a permanent download, limited download, or interactive stream, where such activity qualifies for a compulsory license under this section. Paragraph 8. Digital music provider. The term digital music provider means a person or persons operating under the authority of that person, that with respect to a service engaged in covered activities. Subparagraph A has a direct contractual subscription or other economic relationship with end users of the service, or, if no such relationship with end users exists, exercises direct control over the provision of the service to end user. Subparagraph B is able to fully report on any revenues and consideration generated by the service, and subparagraph C is able to fully report on usage of sound recordings of musical works by the service or procure such reporting. Paragraph 9. Digital Licensee Coordinator. The term digital licensee coordinator means the entity most recently designated pursuant to subsection D, paragraph 5. Paragraph 10. Digital phono record delivery. The term digital phono record delivery means each individual delivery of a phono record by digital transmission of a sound recording that results in a specifically identifiable reproduction by or for any transmission recipient of a phono record of that sound recording, regardless of whether the digital transmission is also a public performance of the sound recording or any musical work embodied therein and includes a permanent download, a limited download, or an interactive stream. A digital phono record delivery does not result from a real-time, non-interactive subscription transmission of a sound recording where no reproduction of the sound recording or the musical work embodied therein is made from the inception of the transmission through to its receipt by the transmission recipient in order to make the sound recording audible. A digital phono record delivery does not include the digital transmission of sounds accompanying a motion picture or other audiovisual work, as defined in Section 101. Paragraph 11. Enactment date. The term enactment date means the date of the enactment of the Musical Works Modernization Act. Paragraph 12. Individual download license. The term individual download license means a compulsory license obtained by a record company to make and distribute, or authorize the making and distribution of, permanent downloads embodying a specific individual musical work. Paragraph 13. Interactive stream. The term interactive stream means a digital transmission of a sound recording of a musical work in the form of a stream, where the performance of the sound recording by means of such transmission is not exempt under Section 114, subsection D. Paragraph 1, and does not in itself, or as a result of a program in which it is included, qualify for statutory licensing under Section 114, subsection D, paragraph 2. An interactive stream is a digital phono record delivery. Paragraph 14. Interested. The term interested, as applied to a party seeking to participate in a proceeding under subsection D, paragraph 7, subparagraph D, is a party as to which the copyright royalty judges have not determined that the party lacks a significant interest in such proceeding. Paragraph 15. License availability date. The term license availability date means January 1st following the expiration of the 2-year period beginning on the enactment date. Paragraph 16. Limited download. The term limited download means a digital transmission of a sound recording of a musical work in the form of a download, where such sound recording is accessible for listening only for a limited amount of time or specified number of times. Paragraph 17. Matched. The term matched, as applied to a musical work or share thereof, means that the copyright owner of such work or share thereof has been identified and located. Paragraph 18. Mechanical Licensing Collective. The term Mechanical Licensing Collective means the entity most recently designated as such by the Register of Copyrights under subsection D, paragraph 3. Paragraph 19. Mechanical Licensing Collective Budget. The term Mechanical Licensing Collective Budget means a statement of the financial position of the Mechanical Licensing Collective for a fiscal year or quarter thereof based on estimates of expenditures during the period and proposals for financing those expenditures, including a calculation of the collective total costs. Paragraph 20. Musical Works Database. The term Musical Works Database means the database described in subsection D. Paragraph 3, subparagraph E. Paragraph 21. Nonprofit. The term nonprofit means a nonprofit created or organized in a state. Paragraph 22. Notice of license. The term notice of license means a notice from a digital music provider provided under subsection D, paragraph 2, subparagraph A for purposes of obtaining a blanket license. Paragraph 23. Notice of non-blanket activity. The term notice of non-blanket activity means a notice from a significant non-blanket licensee provided under subsection D, paragraph 6. Subparagraph A for purposes of notifying the mechanical licensing collective that the licensee has been engaging in covered activities. Paragraph 24. Permanent download. The term permanent download means a digital transmission of a sound recording of a musical work in the form of a download, where such sound recording is accessible for listening without restriction as to the amount of time or number of times it may be accessed. Paragraph 25. Qualified auditor. The term qualified auditor means an independent certified public accountant with experience performing music royalty audits. Paragraph 26. Record company. The term record company means an entity that invests in, produces, and markets sound recordings of musical works and distributes such sound recordings for remuneration through multiple sales channels, including a corporate affiliate of such an entity engaged in distribution of sound recordings. Paragraph 27. Report of usage. The term report of usage means a report reflecting an entity's usage of musical works in covered activities described in subsection D, paragraph 4, subparagraph A. Paragraph 28. Required matching efforts. The term required matching efforts means efforts to identify and locate copyright owners of musical works as described in subsection D, paragraph 10, subparagraph B, clause 1. Paragraph 29. Service. The term service as used in relation to covered activities means any site, facility, or offering by or through which sound recordings of musical works are digitally transmitted to members of the public. Paragraph 30. Share. The term share as applied to a musical work means a fractional ownership interest in such work. Paragraph 31. Significant non-blanket licensee. The term significant non-blanket licensee. Subparagraph A. Means an entity, including a group of entities under common ownership or control that, acting under the authority of one or more voluntary licenses or individual download licenses, offers a service engaged in covered activities, and such entity or group of entities, Clause 1, is not currently operating under a blanket license and is not obligated to provide reports of usage reflecting covered activities under subsection D, paragraph 4, subparagraph A. Clause 2 has a direct contractual subscription or other economic relationship with end users of the service, or, if no such relationship with end users exists, exercises direct control over the provision of the service to end users, and Clause 3, either Subclause 1, on any day in a calendar month makes more than 5,000 different sound recordings of musical works available through such service, or Subclause 2 derives revenue or other consideration in connection with such covered activities greater than $50,000 in a calendar month, or total revenue or other consideration greater than $500,000 during the preceding 12 calendar months, and Subparagraph B does not include Clause 1. An entity whose covered activity consists solely of free-to-the-user streams of segments of sound recordings of musical works that do not exceed 90 seconds in length, are offered only to facilitate a licensed use of musical works that is not a covered activity, and have no revenue directly attributable to such streams constituting the covered activity, or Clause 2, a public broadcasting entity as defined in Section 118, subsection F. Paragraph 32. Songwriter. The term songwriter means the author of all or part of a musical work, including a composer or lyricist. Paragraph 33. State. The term state means each state of the United States, the District of Columbia, and each territory or possession of the United States. Paragraph 34. Unclaimed accrued royalties. The term unclaimed accrued royalties means accrued royalties eligible for distribution under subsection D, paragraph 3, subparagraph J. Paragraph 35. Unmatched. The term unmatched, as applied to a musical work or share thereof, means that the copyright owner of such work, or share thereof, has not been identified or located. Paragraph 36. Voluntary license. The term voluntary license means a license for use of a musical work or share thereof other than a compulsory license obtained under this section. Section 116. Negotiated licenses for public performances by means of coin-operated phono record players. Subsection A. Applicability of section. This section applies to any non-dramatic musical work embodied in a phono record. Subsection B. Negotiated licenses. Paragraph 1. Authority for negotiations. Any owners of copyright in works to which this section applies, and any operators of coin-operated phono record players may negotiate and agree upon the terms and rates of royalty payments for the performance of such works and the proportionate division of fees paid among copyright owners, and may designate common agents to negotiate, agree to, pay, or receive such royalty payments. Paragraph 2, Chapter 8 proceeding. Parties not subject to such a negotiation may have the terms and rates and the division of fees described in paragraph 1 determined in a proceeding in accordance with the provisions of Chapter 8. Subsection C, license agreements superior to determinations by copyright royalty judges. License agreements between one or more copyright owners and one or more operators of coin-operated phonorecord players, which are negotiated in accordance with subsection B, shall be given effect in lieu of any otherwise applicable determination by the copyright royalty judges. Subsection D, definitions. As used in this section, the following terms mean the following. Paragraph 1. A coin-operated phonorecord player is a machine or device that, subparagraph A, is employed solely for the performance of non-dramatic musical works by means of phonorecords upon being activated by the insertion of coins, currency, tokens, or other monetary units or their equivalent. Subparagraph B is located in an establishment making no direct or indirect charge for admission. Subparagraph C is accompanied by a list which is comprised of the titles of all the musical works available for performance on it, and is affixed to the phonorecord player or posted in the establishment in a prominent position where it can be readily examined by the public. And subparagraph D affords a choice of works available for performance and permits the choice to be made by the patrons of the establishment in which it is located. Paragraph 2. An operator is any person who, alone or jointly with others. Subparagraph A owns a coin-operated phonorecord player. Subparagraph B has the power to make a coin-operated phonorecord player available for placement in an establishment for purposes of public performance, or subparagraph C has the power to exercise primary control over the selection of the musical works made available for public performance on a coin-operated phonorecord player. Section 116A, renumbered Section 116. Section 117, limitations on exclusive rights, computer programs. Subsection A, making of additional copy or adaptation by owner of copy. Notwithstanding the provisions of Section 106, it is not an infringement for the owner of a copy of a computer program to make or authorize the making of another copy or adaptation of that computer program provided. Paragraph 1. That such a new copy or adaptation is created as an essential step in the utilization of the computer program in conjunction with a machine and that it is used in no other manner, or Paragraph 2. That such new copy or adaptation is for archival purposes only, and that all archival copies are destroyed in the event that continued possession of the computer program should cease to be rightful. Subsection B, lease, sale, or other transfer of additional copy or adaptation. Any exact copies prepared in accordance with the provisions of this section may be leased, sold, or otherwise transferred, along with the copy from which such copies were prepared only as part of the lease, sale, or other transfer of all rights in the program. Adaptations so prepared may be transferred only with the authorization of the copyright owner. Subsection C, machine maintenance or repair. Notwithstanding the provisions of Section 106, it is not an infringement for the owner or lessee of a machine to make or authorize the making of a copy of a computer program if such copy is made solely by virtue of the activation of a machine that lawfully contains an authorized copy of the computer program, for purposes only of maintenance or repair of that machine if, Paragraph 1. Such new copy is used in no other manner and is destroyed immediately after the maintenance or repair is completed, and Paragraph 2. With respect to any computer program or part thereof that is not necessary for that machine to be activated, such program or part thereof is not accessed or used other than to make such a new copy by virtue of the activation of the machine. Subsection D, definitions for purposes of this section. Paragraph 1. The maintenance of a machine is the servicing of the machine in order to make it work in accordance with its original specifications and any changes to those specifications authorized for that machine. And Paragraph 2. The repair of a machine is the restoring of the machine to the state of working in accordance with its original specifications and any changes to those specifications authorized for that machine. Section 118. Scope of exclusive rights, use of certain works in connection with non-commercial broadcasting. Subsection A. The exclusive rights provided by Section 106 shall, with respect to the works specified by subsection B and the activities specified by subsection D, be subject to the conditions and limitations prescribed by this section. Subsection B. Notwithstanding any provision of the antitrust laws, any owners of copyright in published non-dramatic musical works and published pictorial, graphic, and sculptural works and any public broadcasting entities, respectively, may negotiate and agree upon the terms and rates of royalty payments and the proportionate division of fees paid among various copyright owners, and may designate common agents to negotiate, agree to, pay, or receive payments. Paragraph 1. Any owner of copyright in a work specified in this subsection or any public broadcasting entity may submit to the copyright royalty judges proposed licenses covering such activities with respect to such works. Paragraph 2. License agreements voluntarily negotiated at any time between one or more copyright owners and one or more public broadcasting entities shall be given effect in lieu of any determination by the Librarian of Congress or the copyright royalty judges, if copies of such agreements are filed with the copyright royalty judges within 30 days of execution in accordance with regulations that the copyright royalty judges shall issue. Paragraph 3. Voluntary negotiation proceedings initiated pursuant to a petition filed under Section 804. Substag A, for the purpose of determining a schedule of terms and rates of royalty payments by public broadcasting entities to owners of copyright in works specified by this subsection, and the proportionate division of fees paid among various copyright owners shall cover the 5-year period beginning on January 1st of the second year following the year in which the petition is filed. The parties to each negotiation proceeding shall bear their own costs. Paragraph 4. In the absence of license agreements negotiated under paragraph 2 or 3, the copyright royalty judges shall, pursuant to Chapter 8, conduct a proceeding to determine and publish in the Federal Register a schedule of rates and terms which, subject to paragraph 2, shall be binding on all owners of copyright in works specified by this subsection and public broadcasting entities, regardless of whether such copyright owners have submitted proposals to the copyright royalty judges. In establishing such rates and terms, the copyright royalty judges may consider the rates for comparable circumstances under voluntary license agreements negotiated as provided in paragraph 2 or 3. The copyright royalty judges shall also establish requirements by which copyright owners may receive reasonable notice of the use of their works under this section, and under which records of such use shall be kept by public broadcasting entities. Subsection C. Subject to the terms of any voluntary license agreements that have been negotiated as provided by subsection B, paragraph 2 or 3, a public broadcasting entity may, upon compliance with the provisions of this section, including the rates and terms established by the copyright royalty judges under subsection B, paragraph 4, engage in the following activities with respect to published non-dramatic musical works and published pictorial, graphic, and sculptural works. Paragraph 1. Performance or display of a work by or in the course of a transmission made by a non-commercial educational broadcast station referred to in subsection F, and paragraph 2. Production of a transmission program, reproduction of copies or phonorecords of such a transmission program, and distribution of such copies or phonorecords where such production, reproduction, or distribution is made by a non-profit institution or organization solely for the purpose of transmission specified in paragraph 1, and paragraph 3. The making of reproductions by a governmental body or a non-profit institution of a transmission program simultaneously with its transmission as specified in paragraph 1. And the performance or display of the contents of such program under the conditions specified by paragraph 1 of section 110, but only if the reproductions are used for performances or displays for a period of no more than 7 days from the date of the transmission specified in paragraph 1 and are destroyed before or at the end of such period. No person supplying, in accordance with paragraph 2, a reproduction of a transmission program to governmental bodies or nonprofit institutions under this paragraph shall have any liability as a result of failure of such body or institution to destroy such reproduction, provided that it shall have notified such body or institution of the requirement for such destruction pursuant to this paragraph, and provided further, that if such body or institution itself fails to destroy such reproduction, it shall be deemed to have infringed. Subsection D, except as expressly provided in this subsection, this section shall have no applicability to works other than those specified in subsection B. Owners of copyright in non-dramatic literary works and public broadcasting entities may, during the course of voluntary negotiations, agree among themselves, respectively, as to the terms and rates of royalty payments without liability under the antitrust laws. Any such terms and rates of royalty payments shall be effective upon filing with the copyright royalty judges, in accordance with regulations that the copyright royalty judges shall prescribe as provided in section 803, subsection B, paragraph 6. Subsection E. Nothing in this section shall be construed to permit, beyond the limits of fair use as provided by section 107, the unauthorized dramatization of a non-dramatic musical work, the production of a transmission program drawn to any substantial extent from a published compilation of pictorial, graphic, or sculptural works, or the unauthorized use of any portion of an audiovisual work. Subsection F. As used in this section, the term public broadcasting entity means a non-commercial educational broadcast station as defined in section 397 of Title 47, and any non-profit institution or organization engaged in the activities described in paragraph 2 of subsection C. Section 119. Limitations on exclusive rights. Secondary transmissions of distant television programming by satellite. Subsection A. Secondary transmissions by satellite carriers. Paragraph 1. Non-network stations. Subject to the provisions of paragraphs 3, 4, and 6 of this subsection and section 114, subsection D. Secondary transmissions of a performance or display of a work embodied in a primary transmission made by a non-network station shall be subject to statutory licensing under this section if the secondary transmission is made by a satellite carrier to the public for private home viewing or for viewing in a commercial establishment. With regard to secondary transmissions, the satellite carrier is in compliance with the rules, regulations, or authorizations of the Federal Communications Commission governing the carriage of television broadcast station signals, and the carrier makes a direct or indirect charge for each retransmission service to each subscriber receiving the secondary transmission, or to a distributor that has contracted with the carrier for direct or indirect delivery of the secondary transmission to the public for private home viewing, or for viewing in a commercial establishment. Paragraph 2. Network stations. Subparagraph A in general. subject to the provisions of subparagraph B of this paragraph and paragraphs 3, 4, 5, and 6 of this subsection and section 114, subsection D. Secondary transmissions of a performance or display of a work embodied in a primary transmission made by a network station shall be subject to statutory licensing under this section if the secondary transmission is made by a satellite carrier to the public for private home viewing. With regard to secondary transmissions, the satellite carrier is in compliance with the rules, regulations, or authorizations of the Federal Communications Commission governing the carriage of television broadcast station signals. The carrier makes a direct or indirect charge for such retransmission service to each subscriber receiving the secondary transmission, and the carrier provides local in-to-local service to all DMAs. Failure to reach an agreement with a network station to retransmit the signals of the station shall not be construed to affect compliance with providing local in-to-local service to all DMAs if the satellite carrier has the capability to retransmit such signals when an agreement is reached. Subparagraph B, secondary transmissions to unserved households, Clause 1 in general. The statutory license provided for in subparagraph A shall be limited to secondary transmissions of the signals of no more than 2 network stations in a single day for each TV network to persons who reside in unserved households. Clause 2, short markets. In the case of secondary transmissions to households located in short markets, subject to Clause 1, the statutory license shall be further limited to secondary transmissions of only those primary transmissions of network stations that embody the programming of networks not offered on the primary stream or the multicast stream transmitted by any network station in that market. Subparagraph C, submission of subscriber lists to network. Clause 1, initial lists. A satellite carrier that makes secondary transmissions of a primary transmission made by a network station pursuant to subparagraph A shall, not later than 90 days after commencing such secondary transmissions, submit to the network that owns or is affiliated with the network station a list identifying by name and address, including street or rural route number, city, state, and 9-digit zip code, all subscribers to which the satellite carrier makes secondary transmissions of that primary transmission to subscribers in unserved households. Clause 2, monthly lists. After the submission of the initial lists under Clause 1, the satellite carrier shall, not later than the 15th of each month, submit to the network a list, aggregated by designated market area, identifying by name and address, including street or rural route number, city, state, and 9-digit zip code, any persons who have been added or dropped as subscribers under Clause 1 since the last submission under this subparagraph. Clause 3, use of subscriber information. Subscriber information submitted by a satellite carrier under this subparagraph may be used only for purposes of monitoring compliance by the satellite carrier with this subsection. Clause 4, applicability. The submission requirements of this subparagraph shall apply to a satellite carrier only if the network to which the submissions are to be made places on file with the Register of Copyrights a document identifying the name and address of the person to whom such submissions are to be made. The Register shall maintain for public inspection a file of all such documents. Paragraph 3. Noncompliance with reporting and payment requirements. Notwithstanding the provisions of paragraphs 1 and 2, the willful or repeated secondary transmission to the public by a satellite carrier of a primary transmission made by a non-network station or a network station and embodying a performance or display of a work is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506, where the satellite carrier has not deposited the statement of account and royalty fee required by subsection B, or has failed to make the submissions to networks required by paragraph 2, subparagraph of C. Paragraph 4. Willful alterations. Notwithstanding the provisions of paragraphs 1 and 2, the secondary transmission to the public by a satellite carrier of a performance or display of a work embodied in a primary transmission made by a non-network station or a network station is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506 and Section 510 if the content of the particular program in which the performance or display is embodied, or any commercial advertising or station announcement transmitted by the primary transmitter during or immediately before or after the transmission of such program is in any way willfully altered by the satellite carrier through changes, deletions, or additions, or is combined with programming from any other broadcast signal. Paragraph 5. Violation of territorial restrictions on statutory license for network stations. Subparagraph A. Individual violations. The willful or repeated secondary transmission by a satellite carrier of a primary transmission made by a network station and embodying a performance or display of a work to a subscriber who is not eligible to receive the transmission under this section is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506, except that Clause 1. No damages shall be awarded for such act of infringement if the satellite carrier took corrective action by promptly withdrawing service from the ineligible subscriber, and Clause 2. Any statutory damages shall not exceed $250 for such subscriber for each month during which the violation occurred. Subparagraph B. Pattern of violations. If a satellite carrier engages in a willful or repeated pattern or practice of delivering a primary transmission made by a network station and embodying a performance or display of a work to subscribers who are not eligible to receive the transmission under this section, then in addition to the remedies set forth in subparagraph A, Clause 1, if the pattern or practice has been carried out on a substantially nationwide basis, the court shall order a permanent injunction barring the secondary transmission by the satellite carrier for private home viewing of the primary transmissions of any primary network station affiliated with the same network, and the court may order statutory damages of not to exceed $2,500,000 for each 3-month period during which the pattern or practice was carried out, and Clause 2. If the pattern or practice has been carried out on a local or regional basis, the court shall order a permanent injunction barring the secondary transmission for private home viewing in that locality or region by the satellite carrier of the primary transmissions of any primary network station affiliated with the same network. And the court may order statutory damages of not to exceed $2,500,000 for each 6-month period during which the pattern or practice was carried out. Subparagraph C, previous subscribers excluded. Subparagraphs A and B do not apply to secondary transmissions by a satellite carrier to persons who subscribe to receive such secondary transmissions from the satellite carrier or a distributor before November 16, 1988. Subparagraph D, burden of proof. In any action brought under this paragraph, the satellite carrier shall have the burden of proving that its secondary transmission of a primary transmission by a network station is to a subscriber who is eligible to receive the secondary transmission under this section. The court shall direct 1/2 of any statutory damages ordered under Clause 1 to be deposited with the Register of Copyrights for distribution to copyright owners pursuant to subsection B. The copyright royalty judges shall issue regulations establishing procedures for distributing such funds on a proportional basis to copyright owners whose works were included in the secondary transmissions that were the subject of the statutory damages. Paragraph 6. Discrimination by a satellite carrier. Notwithstanding the provisions of paragraph 1, the willful or repeated secondary transmission to the public by a satellite carrier of a performance or display of a work embodied in a primary transmission made by a non-network station or a network station is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506 if the satellite carrier unlawfully discriminates against a distributor. Paragraph 7. Geographic limitation on secondary transmissions. The statutory license created by this section shall apply only to secondary transmissions to households located in the United States. Paragraph 8. Service to recreational vehicles and commercial trucks. Subparagraph A. Exemption. Clause 1 in general. For purposes of this subsection, and subject to clauses 2 and 3, the term unserved household shall include Subclause 1, recreational vehicles as defined in regulations of the Secretary of Housing and Urban Development under Section 3282.8 of Title 24, Code of Federal Regulations, and Subclause 2, commercial trucks that qualify as commercial motor vehicles under regulations of the Secretary of Transportation under Section 383.5 of Title 49, Code of Federal Regulations. Clause 2, limitation. Clause I shall apply only to a recreational vehicle or commercial truck if any satellite carrier that proposes to make a secondary transmission of a network station to the operator of such a recreational vehicle or commercial truck complies with the documentation requirements under subparagraph B. And Clause 3, exclusion. For purposes of this subparagraph, the terms recreational vehicle and commercial truck shall not include any fixed dwelling, whether a mobile home or otherwise. Subparagraph B, documentation requirements. A recreational vehicle or commercial truck shall be deemed to be an unserved household beginning 10 days after the relevant satellite carrier provides to the network that owns or is affiliated with a network station that will be secondarily transmitted to the recreational vehicle or commercial truck the following documents. Clause 1, declaration. A signed declaration by the operator of the recreational vehicle or commercial truck that the satellite dish is permanently attached to the recreational vehicle or commercial truck and will not be used to receive satellite programming at any fixed dwelling. Clause 2, registration. In the case of a recreational vehicle, a copy of the current state vehicle registration for the recreational vehicle. Clause 3, registration and license. In the case of a commercial truck, a copy of Subclause 1, the current state vehicle registration for the truck, and Subclause 2, a copy of a valid current commercial driver's license as defined in regulations of the Secretary of Transportation under Section 383 of Title 49, Code of Federal Regulations, issued to the operator. Subparagraph C, updated documentation requirements. If a satellite carrier wishes to continue to make secondary transmissions to a recreational vehicle or commercial truck for more than a 2-year period, that carrier shall provide each network, upon request, with updated documentation in the form described under subparagraph B during the 90 days before expiration of that 2-year period. Paragraph 9. Statutory license contingent on compliance with FCC rules and remedial steps. Notwithstanding any other provision of this section, the willful or repeated secondary transmission to the public by a satellite carrier of a primary transmission embodying a performance or display of a work made by a broadcast station licensed by the Federal Communications Commission is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506 if, at the time of such transmission, the satellite carrier is not in compliance with the rules, regulations, and authorizations of the Federal Communications Commission concerning the carriage of television broadcast station signals. Paragraph 10. Restricted transmission of out-of-state distant network signals into certain markets. Subparagraph A. Out-of-state network affiliates. Notwithstanding any other provision of this title, the statutory license in this subsection and subsection B shall not apply to any secondary transmission of the primary transmission of a network station located outside of the state of Alaska, to any subscriber in that state to whom the secondary transmission of the primary transmission of a TV station located in that state is made available by the satellite carrier pursuant to Section 122. Subparagraph B. Exception. The limitation in subparagraph A shall not apply to the secondary transmission of the primary transmission of a digital signal of a network station located outside of the state of Alaska if at the time that the secondary transmission is made, no TV station licensed to a community in the state and affiliated with the same network makes primary transmissions of a digital signal. Subsection B. Deposit of statements and fees, verification procedures. Paragraph 1. Deposits with the Register of Copyrights. A satellite carrier whose secondary transmissions are subject to statutory licensing under subsection A shall, on a semi-annual basis, deposit with the Register of Copyrights in accordance with requirements that the Register shall prescribe by regulation. Subparagraph A. A statement of account covering the preceding 6-month period, specifying the names and locations of all non-network stations and network stations whose signals were retransmitted at any time during that period to subscribers as described in subsections A. Paragraph 1 and A2, the total number of subscribers that received such retransmissions, and such other data as the Register of Copyrights may from time to time prescribe by regulation. Subparagraph B. A royalty fee payable to copyright owners pursuant to paragraph 4 for that 6-month period, computed by multiplying the total number of subscribers receiving each secondary transmission of a primary stream, or multicast stream of each non-network station or network station during each calendar year, month by the appropriate rate in effect under this subsection. And subparagraph C, a filing fee, as determined by the Register of Copyrights pursuant to section 708, subsection A. Paragraph 2, verification of accounts and fee payments. The Register of Copyrights shall issue regulations to permit interested parties to verify and audit the statements of account and royalty fees submitted by satellite carriers under this subsection. Paragraph 3, investment of fees. The Register of Copyrights shall receive all fees, including the filing fee specified in paragraph 1, subparagraph C, deposited under this section, and, after deducting the reasonable costs incurred by the Copyright Office under this section, other than the costs deducted under paragraph 5, shall deposit the balance in the Treasury of the United States in such manner as the Secretary of the Treasury directs. All funds held by the Secretary of the Treasury shall be invested in interest-bearing securities of the United States for later distribution with interest by the Librarian of Congress as provided by this title. Paragraph 4. Persons to whom fees are distributed. The royalty fees deposited under paragraph 3 shall, in accordance with the procedures provided by paragraph 5, be distributed to those copyright owners whose works were included in a secondary transmission made by a satellite carrier during the applicable 6-month accounting period, and who file a claim with the copyright royalty judges under paragraph 5. Paragraph 5. Procedures for distribution. The royalty fees deposited under paragraph 3 shall be distributed in accordance with the following procedures. Subparagraph A. Filing of claims for fees. During the month of July in each year, each person claiming to be entitled to statutory license fees for secondary transmissions shall file a claim with the copyright royalty judges, in accordance with requirements that the copyright royalty judges shall prescribe by regulation. For purposes of this paragraph, any claimants may agree among themselves as to the proportionate division of statutory license fees among them, may lump their claims together and file them jointly or as a single claim, or may designate a common agent to receive payment on their behalf. Subparagraph B. Determination of controversy. Distributions. After the first day of August of each year, the copyright royalty judges shall determine whether there exists a controversy concerning the distribution of royalty fees. If the copyright royalty judges determine that no such controversy exists, the copyright royalty judges shall authorize the Librarian of Congress to proceed to distribute such fees to the copyright owners entitled to receive them, or to their designated agents, subject to the deduction of reasonable administrative costs under this section. If the copyright royalty judges find the existence of a controversy, the copyright royalty judges shall, pursuant to Chapter 8 of this title, conduct a proceeding to determine the distribution of royalty fees. Subparagraph C. Withholding of fees during controversy. During the pendency of any proceeding under this subsection, the copyright royalty judges shall have the discretion to authorize the Librarian of Congress to proceed to distribute any amounts that are not in controversy. Subsection C. Adjustment of royalty fees. Paragraph 1. Applicability and determination of royalty fees for signals. Subparagraph A. Initial fee. The appropriate fee for purposes of determining the royalty fee under subsection B, paragraph 1, subparagraph B, for the secondary transmission of the primary transmissions of network stations and non-network stations shall be the appropriate fee set forth in Part 258 of Title 37, Code of Federal Regulations, as in effect on July 1, 2009, as modified under this paragraph. Subparagraph B. Fee set by voluntary negotiation. On or before June 1, 2010, the copyright royalty judges shall cause to be published in the Federal Register of the initiation of voluntary negotiation proceedings for the purpose of determining the royalty fee to be paid by satellite carriers for the secondary transmission of the primary transmissions of network stations and non-network stations. Under subsection B, paragraph 1, subparagraph B. Subparagraph C, negotiations, satellite carriers, distributors, and copyright owners entitled to royalty fees under this section shall negotiate in good faith in an effort to reach a voluntary agreement or agreements for the payment of royalty fees. Any such satellite carriers, distributors, and copyright owners may at any time negotiate and agree to the royalty fee and may designate common agents to negotiate, agree to, or pay such fees. If the parties fail to identify common agents, the copyright royalty judges shall do so. After requesting recommendations from the parties to the negotiation proceeding, the parties to each negotiation proceeding shall bear the costs thereof. Subparagraph D. Agreements binding on parties. Filing of agreements, public notice. Clause 1. Voluntary agreements. Filing. Voluntary agreements negotiated at any time in accordance with this paragraph shall be binding upon all satellite carriers, distributors, and copyright owners that are parties thereto. Copies of such agreements shall be filed with the Copyright Office within 30 days after execution in accordance with regulations that the Register of Copyrights shall prescribe. Clause 2. Procedure for adoption of fees. Subclause 1. Publication of notice. Within 10 days after publication in the Federal Register of a notice of the initiation of voluntary negotiation proceedings, parties who have reached a voluntary agreement may request that the royalty fees in that agreement be applied to all satellite carriers, distributors, and copyright owners without convening a proceeding under subparagraph F. Subclause 2. Public notice of fees. Upon receiving a request under Subclause 1, the copyright royalty judges shall immediately provide public notice of the royalty fees from the voluntary agreement and afford parties an opportunity to state that they object to those fees. Subclause 3. Adoption of fees. The copyright royalty judges shall adopt the royalty fees from the voluntary agreement for all satellite carriers, distributors, and copyright owners without convening the proceeding under subparagraph F, unless a party with an intent to participate in that proceeding and a significant interest in the outcome of that proceeding objects under Subclause 2. Subparagraph E. Period agreement is in effect. The obligation to pay the royalty fees established under a voluntary agreement which has been filed with the copyright royalty judges in accordance with this paragraph shall become effective on the date specified in the agreement and shall remain in effect in accordance with the terms of the agreement until the subscriber for which the royalty is payable is no longer eligible to receive a secondary transmission pursuant to the license under this section. Subparagraph F. Fee set by copyright royalty judges proceeding. Clause 1. Notice of initiation of the proceeding. On or before September 1, 2010. The copyright royalty judges shall cause notice to be published in the Federal Register of the initiation of a proceeding for the purpose of determining the royalty fees to be paid for the secondary transmission of the primary transmissions of network stations and non-network stations under subsection B. Paragraph 1, subparagraph B, by satellite carriers and distributors. Subclause 1. In the absence of a voluntary agreement filed in accordance with subparagraph D that establishes royalty fees to be paid by all satellite carriers and distributors, or Subclause 2. If an objection to the fees from a voluntary agreement submitted for adoption by the copyright royalty judges to apply to all satellite carriers, distributors, and copyright owners is received under subparagraph D from a party with an intent to participate in the proceeding and a significant interest in the outcome of that proceeding, such proceeding shall be conducted under Chapter 8. Clause 2. Establishment of royalty fees. In determining royalty fees under this subparagraph, the copyright royalty judges shall establish fees for the secondary transmissions of the primary transmissions of network stations and non-network stations that most clearly represent the fair market value of secondary transmission. Except that the copyright royalty judges shall adjust royalty fees to account for the obligations of the parties under any applicable voluntary agreement filed with the copyright royalty judges in accordance with subparagraph D. In determining the fair market value, the judges shall base their decision on economic, competitive, and programming information presented by the parties, including Subclause 1. The competitive environment in which such programming is distributed, the cost of similar signals in similar private and compulsory license marketplaces, and any special features and conditions of the retransmission marketplace. Subclause 2. The economic impact of such fees on copyright owners and satellite carriers, and Subclause 3. The impact on the continued availability of secondary transmissions to the public. Clause 3. Effective date for decision of copyright royalty judges. The obligation to pay the royalty fees established under a determination that is made by the copyright royalty judges in a proceeding under this paragraph shall be effective as of January 1, 2010. Clause 4. Persons subject to royalty fees. The royalty fees referred to in Clause 3 shall be binding on all satellite carriers, distributors, and copyright owners who are not party to a voluntary agreement filed with the Copyright Office under subparagraph D. Paragraph 2. Annual royalty fee adjustment. Effective January 1st of each year, the royalty fee payable under subsection B, paragraph 1, Subparagraph B, for the secondary transmission of the primary transmissions of network stations and non-network stations, shall be adjusted by the copyright royalty judges to reflect any changes occurring in the cost of living, as determined by the most recent Consumer Price Index, for all consumers and for all items, published by the Secretary of Labor before December 1st of the preceding year. Notification of the adjusted fees shall be published in the Federal Register at least 25 days before January 1. Subsection D, definitions, as used in this section. Paragraph 1, distributor. The term distributor means an entity that contracts to distribute secondary transmissions from a satellite carrier, and either as a single channel or in a package with other programming. Provides the secondary transmission either directly to individual subscribers or indirectly through other program distribution entities in accordance with the provisions of this section. Paragraph 2. Network station. The term network station means, subparagraph A, a TV station licensed by the Federal Communications Commission, including any translator station or terrestrial satellite station that rebroadcasts all or substantially all of the programming broadcast by a network station, that is owned or operated by or affiliated with one or more of the television networks in the United States that offer an interconnected program service on a regular basis for 15 or more hours per week to at least 25 of its affiliated television licensees in 10 or more states, or subparagraph B, a non-commercial educational broadcast station as defined in Section 397 of the Communications Act of 1934, except that the term does not include the signal of the Alaska Rural Communications Service or any successor entity to that service. Paragraph 3, primary network station. The term primary network station means a network station that broadcasts or rebroadcasts the basic programming service of a particular national network. Paragraph 4, primary transmission. The term primary transmission has the meaning given that term in Section 111, subsection F of this title. Paragraph 5. Private home viewing. The term private home viewing means the viewing for private use in a household by means of satellite reception equipment that is operated by an individual in that household, and that serves only such household, of a secondary transmission delivered by a satellite carrier of a primary transmission of a TV station licensed by the Federal Communications Commission. Paragraph 6. Satellite carrier. The term satellite carrier means an entity that uses the facilities of a satellite or satellite service licensed by the Federal Communications Commission and operates in the fixed satellite service under Part 25 of Title 47, Code of Federal Regulations, or the direct broadcast satellite service under Part 100 of Title 47, Code of Federal Regulations, to establish and operate a channel of communications for point-to-multipoint distribution of television station signals, and that owns or leases a capacity or service on a satellite in order to provide such point-to-multipoint distribution, except to the extent that such entity provides such distribution pursuant to tariff under the Communications Act of 1934, other than for private home viewing pursuant to this section. Paragraph 7. Secondary transmission. The term secondary transmission has the meaning given that term in Section 111, subsection F of this title. Paragraph 8. Subscriber, subscribe. Subparagraph A. Subscriber. The term subscriber means a person or entity that receives a secondary transmission service from a satellite carrier and pays a fee for the service, directly or indirectly, to the satellite carrier or to a distributor. Subparagraph B. Subscribe. The term subscribe means to elect to become a subscriber. Paragraph 9. Non-network station. The term non-network station means a TV station other than a network station licensed by the Federal Communications Commission that is secondarily transmitted by a satellite carrier. Paragraph 10. Unserved household. The term unserved household, with respect to a particular television network, means a household that subparagraph A is a subscriber to whom subsection A paragraph 8 applies, or subparagraph B is a subscriber located in a short market. Paragraph 11. Local market. The term local market has the meaning given such term under Section 122, subsection J. Paragraph 12. Commercial establishment. The term commercial establishment, subparagraph A, means an establishment used for commercial purposes, such as a bar, restaurant, private office, fitness club, oil rig, retail store, bank or other financial institution, supermarket, automobile or boat dealership, or any other establishment with a common business area, and subparagraph B does not include a multi-unit permanent or temporary dwelling where private home viewing occurs, such as a hotel, dormitory, hospital, apartment, condominium, or prison. Paragraph 13. Multicast stream. The term multicast stream means a digital stream containing programming and program-related material affiliated with a television network other than the primary stream. Paragraph 14. Primary stream. The term primary stream means subparagraph A, the single digital stream of programming as to which a television broadcast station has the right to mandatory carriage with a satellite carrier under the rules of the Federal Communications Commission, in effect on July 1, 2009, or subparagraph B, if there is no stream described in subparagraph A, then either Clause 1. The single digital stream of programming associated with the network last transmitted by the station as an analog signal, or Clause 2. If there is no stream described in Clause 1, then the single digital stream of programming affiliated with the network that, as of July 1st, 2009, had been offered by the TV broadcast station for the longest period of time. Paragraph 15. Local interlocal service to all DMAs. The term local interlocal service to all DMAs has the meaning given such term in subsection F, paragraph 7. Paragraph 16. Short market. The term short market means a local market in which programming of one or more of the four most widely viewed TV networks nationwide is not offered on either the primary stream or multicast stream transmitted by any network station in that market, or is temporarily or permanently unavailable as a result of an act of God or other force majeure event beyond the control of the carrier. Subsection E. Expedited consideration by Justice Department of voluntary agreements to provide satellite secondary transmissions to local markets. Paragraph 1. In general. In a case in which no satellite carrier makes available to subscribers located in a local market, as defined in Section 122, subsection J, paragraph 2, the secondary transmission into that market of a primary transmission of one or more television broadcast stations licensed by the Federal Communications Commission, and two or more satellite carriers request a business review letter in accordance with Section 50.6 of Title 28, Code of Federal Regulations as in effect on July 7, 2004. In order to assess the legality under the antitrust laws of proposed business conduct to make or carry out an agreement to provide such secondary transmission into such local market. The appropriate official of the Department of Justice shall respond to the request no later than 90 days after the date on which the request is received. Paragraph 2. Definition. For purposes of this subsection, the term antitrust laws, subparagraph A, has the meaning given that term in subsection A of the first section of the Clayton Act, Title 15, United States Code, Section 12, subsection A, except that such term includes Section 5 of the Federal Trade Commission Act, Title 15, United States Code, Section 45, to the extent such Section 5 applies to unfair methods of competition, and subparagraph B includes any state law similar to the laws referred to in paragraph 1. Subsection F, certain waivers granted to providers of local interlocal service to all DMAs. Paragraph 1, injunction waiver. A court that issued an injunction pursuant to subsection A, paragraph 5, subparagraph B before the date of the enactment of this subsection shall waive such injunction if the court recognizes the entity against which the injunction was issued as a qualified carrier. Paragraph 2, limited temporary waiver. Subparagraph A in general. Upon a request made by a satellite carrier, a court that issued an injunction against such carrier under subsection A, paragraph 5, subparagraph B before the date of the enactment of this subsection shall waive such injunction with respect to the statutory license provided under subsection A. Paragraph 2 to the extent necessary to allow such carrier to make secondary transmissions of primary transmissions made by a network station to unserved households located in short markets in which such carrier was not providing local service pursuant to the license under Section 122 as of December 31st, 2009. Subparagraph B. Expiration of temporary waiver. A temporary waiver of an injunction under subparagraph A shall expire after the end of the 120-day period beginning on the date such temporary waiver is issued, unless extended for good cause by the court making the temporary waiver. Subparagraph C. Failure to provide local interlocal service to all DMAs. Clause 1. Failure to act reasonably and in good faith. If the court issuing a temporary waiver under such failure. Subclause 1 is actionable as an act of infringement under Section 501, and the court may, in its discretion, impose the remedies provided for in Sections 502 through 506, and subsection A, paragraph 6, subparagraph B of this section, and subclause 2 shall result in the termination of the waiver issued under subparagraph A. Clause 2, failure to provide local interlocal service. If the court issuing a temporary waiver under subparagraph A determines that the satellite carrier that made the request for such waiver has failed to provide local interlocal service to all DMAs, but determines that the carrier acted reasonably and in good faith, the court may, in its discretion, impose financial penalties that reflect Subclause 1, the degree of control the carrier had over the circumstances that resulted in the failure. Subclause 2, the quality of the carrier's efforts to remedy the failure, and Subclause 3, the severity and duration of any service interruption. Subparagraph D, single temporary waiver available. An entity may only receive one temporary waiver under this paragraph. Subparagraph E, short market defined. For purposes of this paragraph, The term short market means a local market in which programming of one or more of the four most widely viewed TV networks nationwide as measured on the date of the enactment of this subsection is not offered on the primary stream transmitted by any local television broadcast station. Paragraph 3. Establishment of qualified carrier recognition. Subparagraph A. Statement of eligibility. An entity seeking to be recognized as a qualified carrier under this subsection shall file a statement of eligibility with the court that imposed the injunction. A statement of eligibility must include: Clause 1. An affidavit that the entity is providing local in-to-local service to all DMAs. Clause 2. A motion for a waiver of the injunction. Clause 3. A motion that the court appoint a special master under Rule 53 of the Federal Rules of Civil Procedure. Clause 4. An agreement by the carrier to pay all expenses incurred by the special master under paragraph 4, subparagraph B, Clause 2, and Clause 5. A certification issued pursuant to Section 342, subsection A of Communications Act of 1934. Subparagraph B. Grant of recognition as a qualified carrier. Upon receipt of a statement of eligibility, the court shall recognize the entity as a qualified carrier and issue the waiver under paragraph 1. Upon motion pursuant to subparagraph A, Clause 3, the court shall appoint a special master to conduct the examination and provide a report to the court as provided in paragraph 4, subparagraph B. Subparagraph C. Voluntary termination. At any time, an entity recognized as a qualified carrier may file a statement of voluntary termination with the court certifying that it no longer wishes to be recognized as a qualified carrier. Upon receipt of such statement, the court shall reinstate the injunction waived under paragraph 1. Subparagraph D. Loss of recognition prevents future recognition. No entity may be recognized as a qualified carrier if such entity had previously been recognized as a qualified carrier and subsequently lost such recognition or voluntarily terminated such recognition under subparagraph C. Paragraph 4. Qualified carrier obligations and compliance. Subparagraph A. Continuing obligations. Clause 1. In general, an entity recognized as a qualified carrier shall continue to provide local interlocal service to all DMAs. Clause 2. Cooperation with compliance examination. An entity recognized as a qualified carrier shall fully cooperate with the special master appointed by the court under paragraph 3, subparagraph B in an examination set forth in subparagraph B. Subparagraph B. Qualified carrier compliance examination. Clause 1. Examination and report. A special master appointed by the court under paragraph 3, subparagraph B shall conduct an examination of and file a report on the qualified carrier's compliance with the royalty payment and household eligibility requirements of the license under this section. The report shall address the qualified carrier's conduct during the period beginning on the date on which the qualified carrier is recognized as such under paragraph 3, subparagraph B, and ending on April 30, 2012. Clause 2. Records of qualified carrier. Beginning on the date that is 1 year after the date on which the qualified carrier is recognized as such under paragraph 3, subparagraph B, but not later than December 1, 2011, the qualified carrier shall provide the special master with all records that the special master considers to be directly pertinent to the following requirements under this section. Subclause 1. Proper calculation and payment of royalties under the statutory license under this section. Subclause 2. Provision of service under this license to eligible subscribers only. Clause 3. Submission of report. The special master shall file the report required by Clause 1 not later than July 24, 2012, with the court referred to in paragraph 1 that issued the injunction, and the court shall transmit a copy of the report to the Register of Copyrights. The Committees on the Judiciary and on Energy and Commerce of the House of Representatives, and the Committees on the Judiciary and on Commerce, Science, and Transportation of the Senate. Clause 4. Evidence of infringement. The special master shall include in the report a statement of whether the examination by the special master indicated that there is substantial evidence that a copyright holder could bring a successful action under this section against the qualified carrier for infringement. Clause 5. Subsequent examination. If the special master's report includes a statement that its examination indicated the existence of substantial evidence that a copyright holder could bring a successful action under this section against the qualified carrier for infringement, the special master shall, not later than 6 months after the report under Clause 1 is filed, initiate another examination of the qualified carrier's compliance with the royalty payment and household eligibility requirements of the license under this section since the last report was filed under Clause 3. The special master shall file a report on the results of the examination conducted under this clause with the court referred to in paragraph 1 that issued the injunction, and the court shall transmit a copy to the Register of Copyrights. The Committees on the Judiciary and on Energy and Commerce of the House of Representatives, and the Committees on the Judiciary and on Commerce, Science, and Transportation of the Senate. The report shall include a statement described in Clause 4. Clause 6. Compliance. Upon motion filed by an aggrieved copyright owner, the court recognizing an entity as a qualified carrier shall terminate such designation upon finding that the entity has failed to cooperate with an examination required by this subparagraph. Clause 7. Oversight. During the period of time that the Special Master is conducting an examination under this subparagraph, the Comptroller General shall monitor the degree to which the entity seeking to be recognized or recognized as a qualified carrier under paragraph 3 is complying with the Special Master's examination. The qualified carrier shall make available to the Comptroller General all records and individuals that the Comptroller General considers necessary to meet the Comptroller General's obligations under this clause. The Comptroller General shall report the results of the monitoring required by this clause to the Committees on the Judiciary and on Energy and Commerce of the House of Representatives and the Committees on the Judiciary and on Commerce, Science, and Transportation of the Senate at intervals of not less than 6 months during such period. Subparagraph C. Affirmation. A qualified carrier shall file an affidavit with the District Court and the Register of Copyrights 30 months after such status was granted, stating that, to the best of the affiant's knowledge, it is in compliance with the requirements for a qualified carrier. The qualified carrier shall attach to its affidavit copies of all reports or orders issued by the Court, the Special Master, and the Comptroller General. Subparagraph D. Compliance determination. Upon the motion of an aggrieved television broadcast station, the court recognizing an entity as a qualified carrier may make a determination of whether the entity is providing local-into-local service to all DMAs. Subparagraph E. Pleading requirement. In any motion brought under subparagraph D, the party making such motion shall specify one or more designated market areas, as such term is defined in section 122, subsection J, paragraph 2. Subparagraph C, for which the failure to provide service is being alleged, and for each such designated market area shall plead with particularity the circumstances of the alleged failure. Subparagraph F, burden of proof. In any proceeding to make a determination under subparagraph D, and with respect to a designated market area for which failure to provide service is alleged, the entity recognized as a qualified carrier shall have the burden of proving that the entity provided local-into-local service with a good quality satellite signal to at least 90% of the households in such designated market area, based on the most recent census data released by the United States Census Bureau at the time and place alleged. Paragraph 5. Failure to provide service. Subparagraph A. Penalties. If the court recognizing an entity as a qualified carrier finds that such entity has willfully failed to provide local-into-local service to all DMAs, such finding shall result in the loss of recognition of the entity as a qualified carrier and the termination of the waiver provided under paragraph 1, and the court may, in its discretion. Clause 1. Treat such failure as an act of infringement under section 501 and subject such infringement to the remedies provided for in sections 502 through 506 and subsection A, paragraph 6, subparagraph B of this section. And Clause 2. Impose a fine of not less than $250,000 and not more than $5 million. Subparagraph B. Exception for non-willful violation. If the court determines that the failure to provide local-into-local service to all DMAs is non-willful, the court may in its discretion impose financial penalties for non-compliance that reflect. Clause 1. The degree of control the entity had over the circumstances that resulted in the failure. Clause 2. The quality of the entity's efforts to remedy the failure and restore service, and Clause 3. The severity and duration of any service interruption. Paragraph 6. Penalties for violations of license. A court that finds, under subsection A, paragraph 6, subparagraph A, that an entity recognized as a qualified carrier has willfully made a secondary transmission of a primary transmission made by a network station and embodying a performance or display of a work to a subscriber who is not eligible to receive the transmission, under this section shall reinstate the injunction waived under paragraph 1. And the court may order statutory damages of not more than $2,500,000. Paragraph 7. Local-into-local service to all DMAs defined. For purposes of this subsection, subparagraph A, in general, an entity provides local-into-local service to all DMAs if the entity provides local service in all designated market areas, as such term is defined in section 122, subsection J, paragraph 2, subparagraph C, pursuant to the license under section 122, except for designated market areas where the entity is temporarily or permanently unable to provide local service as a result of an act of God or other force majeure event beyond the control of the entity. Subparagraph B, household coverage. For purposes of subparagraph A, an entity that makes available local-into-local service with a good quality satellite signal to at least 90% of the households in a designated market area based on the most recent census data released by the United States Census Bureau shall be considered to be providing local service to such designated market area. Subparagraph C, good quality satellite signal defined. The term good quality satellite signal has the meaning given such term under section 342, subsection E, paragraph 2 of Communications, Act of 1934. Section 120. Scope of exclusive rights in architectural works. Subsection A, pictorial representations permitted. The copyright in an architectural work that has been constructed does not include the right to prevent the making, distributing, or public display of pictures, paintings, photographs, or other pictorial representations of the work if the building in which the work is embodied is located in or ordinarily visible from a public place. Subsection B, alterations to and destruction of buildings. Notwithstanding the provisions of Section 106, subsection 2, the owners of a building embodying an architectural work may, without the consent of the author or copyright owner of the architectural work, make or authorize the making of alterations to such building and destroy or authorize the destruction of such building. Section 121. Limitations on exclusive rights, reproduction for blind or other people with disabilities. Subsection A. Notwithstanding the provisions of Section 106, it is not an infringement of copyright for an authorized entity to reproduce or to distribute in the United States copies or phonorecords of a previously published literary work or of a previously published musical work that has been fixed in the form of text or notation, if such copies or phonorecords are reproduced or distributed in accessible formats exclusively for use by eligible persons. Subsection B, paragraph 1. Copies or phonorecords to which this section applies shall: Subparagraph A, not be reproduced or distributed in the United States in a format other than an accessible format exclusively for use by eligible persons. Subparagraph B. Bear notice that any further reproduction or distribution in a format other than an accessible format is an infringement, and subparagraph C. Include a copyright notice identifying the copyright owner and the date of the original publication. Paragraph 2. The provisions of this subsection shall not apply to standardized, secure, or norm reference tests and related testing material, or to computer programs, except the portions thereof that are in conventional human language, including descriptions of pictorial works, and displayed to users in the ordinary course of using the computer programs. Subsection C. Notwithstanding the provisions of Section 106, it is not an infringement of copyright for a publisher of print instructional materials for use in elementary or secondary schools to create and distribute to the National Instructional Materials Access Center copies of the electronic files described in Sections 612 electronic files described in Section 612. Substig A, paragraph 23, subparagraph C, 613, subsection A, paragraph 6, and section 674. Substig E of the Individuals with Disabilities Education Act that contain the contents of print instructional materials using the National Instructional Material Accessibility Standard as defined in section 674, subsection E, paragraph 3 of that act. If Paragraph 1. The inclusion of the contents of such print instructional materials is required by any state educational agency or local educational agency. Paragraph 2. The publisher had the right to publish such print instructional materials in print formats, and Paragraph 3. Such copies are used solely for reproduction or distribution of the contents of such print instructional materials in accessible formats. Subsection D. For purposes of this section, the term Paragraph 1. Accessible format means an alternative manner or form that gives an eligible person access to the work when the copy or phonorecord in the accessible format is used exclusively by the eligible person to permit him or her to have access as feasibly and comfortably as a person without such disability as described in Paragraph 3. Paragraph 2. Authorized entity means a nonprofit organization or a governmental agency that has a primary mission to provide specialized services relating to training, education, or adaptive reading or information access needs of blind or other persons with disabilities. Paragraph 3. Eligible person means an individual who, regardless of any other disability. Subparagraph A is blind. Subparagraph B. Has a visual impairment or perceptual or reading disability that cannot be improved to give visual function substantially equivalent to that of a person who has no such impairment or disability, and so is unable to read printed works to substantially the same degree as a person without an impairment or disability. Or subparagraph C is otherwise unable, through physical disability, to hold or manipulate a book or to focus or move the eyes to the extent that would be normally acceptable for reading. And Paragraph 4. Print instructional materials has the meaning given under Section 674, subsection E, paragraph 3, subparagraph C of the Individuals with Disabilities Education Act. Section 121A, Limitations on Exclusive Rights, Reproduction for Blind or Other People with Disabilities in Marrakesh Treaty Countries. Subsection A. Notwithstanding the provisions of Sections 106 and 602, it is not an infringement of copyright for an authorized entity acting pursuant to this section to export copies or phonorecords of a previously published literary work or of a previously published musical work that has been fixed in the form of text or notation in accessible formats to another country, when the exportation is made either to Paragraph 1. An authorized entity located in a country that is a party to the Marrakesh Treaty, or Paragraph 2. An eligible person in a country that is a party to the Marrakesh Treaty, if prior to the exportation of such copies or phonorecords, the authorized entity engaged in the exportation did not know or have reasonable grounds to know that the copies or phonorecords would be used other than by eligible persons. Subsection B. Notwithstanding the provisions of Sections 106 and 602, it is not an infringement of copyright for an authorized entity or an eligible person or someone acting on behalf of an eligible person acting pursuant to this section to import copies or phonorecords of a previously published literary work or of a previously published musical work that has been fixed in the form of text or notation in accessible formats. Subsection C. In conducting activities under subsection A or B, an authorized entity shall establish and follow its own practices in keeping with its particular circumstances. 2. Paragraph 1. Establish that the persons the authorized entity serves are eligible persons. Paragraph 2. Limit to eligible persons and authorized entities the distribution of accessible format copies by the authorized entity. Paragraph 3. Discourage the reproduction and distribution of unauthorized copies. Paragraph 4. Maintain due care in, and records of, the handling of copies of works by the authorized entity, while respecting the privacy of eligible persons on an equal basis with others. And Paragraph 5. Facilitate effective cross-border exchange of accessible format copies by making publicly available. Subparagraph A. The titles of works for which the authorized entity has accessible format copies or phonorecords, and the specific accessible formats in which they are available. And Subparagraph B. Information on the policies, practices, and authorized entity partners of the authorized entity for the cross-border exchange of accessible format copies. Subsection D. Nothing in this section shall be construed to establish. Paragraph 1. A cause of action under this title, or Paragraph 2. A basis for regulation by any federal agency. Subsection E. Nothing in this section shall be construed to limit the ability to engage in any activity otherwise permitted under this title. Subsection F. For purposes of this section. Paragraph 1. The terms accessible format, authorized entity, and eligible person have the meanings given those terms in Section 121. And Paragraph 2. The term Marrakesh Treaty means the Marrakesh Treaty to facilitate access to published works by visually impaired persons and persons with print disabilities concluded at Marrakesh, Morocco on June 28, 2013. Section 122. Limitations on exclusive rights, secondary transmissions of local TV programming by satellite. Subsection A. Secondary transmissions into local markets. Paragraph 1. Secondary transmissions of television broadcast stations within a local market. A secondary transmission of a performance or display of a work embodied in a primary transmission of a television broadcast station into the station's local market shall be subject to statutory licensing under this section if Subparagraph A. The secondary transmission is made by a satellite carrier to the public. Subparagraph B. With regard to secondary transmissions, the satellite carrier is in compliance with the rules, regulations, or authorizations of the Federal Communications Commission governing the carriage of TV broadcast station signals. And Subparagraph C. The satellite carrier makes a direct or indirect charge for this secondary transmission too. Clause 1. Each subscriber receiving the secondary transmission, or Clause 2. A distributor that has contracted with the satellite carrier for direct or indirect delivery of the secondary transmission to the public. Paragraph 2. Significantly viewed stations. Subparagraph A. In general. A secondary transmission of a performance or display of a work embodied in a primary transmission of a television broadcast station to subscribers who receive secondary transmissions of primary transmissions under Paragraph 1 shall be subject to statutory licensing under this paragraph if the secondary transmission is of the primary transmission of a network station or a non-network station to a subscriber who resides outside the station's local market, but within a community in which the signal has been determined by the Federal Communications Commission to be significantly viewed in such community. Pursuant to the rules, regulations, and authorizations of the Federal Communications Commission, in effect on April 15, 1976, applicable to determining with respect to a cable system whether signals are significantly viewed in a community. Subparagraph B. Waiver. A subscriber who is denied the secondary transmission of the primary transmission of a network station or a non-network station under subparagraph A may request a waiver from such denial by submitting a request through the subscriber's satellite carrier to the network station or non-network station in the local market affiliated with the same network or non-network where the subscriber is located. The network station or non-network station shall accept or reject the subscriber's request for a waiver within 30 days after receipt of the request. If the network station or non-network station fails to accept or reject the subscriber's request for a waiver within that 30-day period, that network station or non-network station shall be deemed to agree to the waiver request. Paragraph 3. Secondary transmission of low-power programming. Subparagraph A. In general. Subject to subparagraphs B and C. A secondary transmission of a performance or display of a work embodied in a primary transmission of a TV broadcast station to subscribers who receive secondary transmissions of primary transmissions under Paragraph 1 shall be subject to statutory licensing under this paragraph if the secondary transmission is of the primary transmission of a television broadcast station that is licensed as a low-power television station to a subscriber who resides within the same designated market area as the station that originates the transmission. Subparagraph B. No applicability to repeaters and translators. Secondary transmissions provided for in subparagraph A shall not apply to any low-powered TV station that retransmits the programs and signals of another TV station for more than 2 hours each day. Subparagraph C. No impact on other secondary transmissions obligations. A satellite carrier that makes secondary transmissions of a primary transmission of a low-power television station under a statutory license provided under this section is not required, by reason of such secondary transmission, to make any other secondary transmissions. Paragraph 4. Special exceptions. A secondary transmission of a performance or display of a work embodied in a primary transmission of a TV broadcast station to subscribers who receive secondary transmissions of primary transmissions under paragraph 1 shall, if the secondary transmission is made by a satellite carrier that complies with the requirements of paragraph 1, be subject to statutory licensing under this paragraph as follows. Subparagraph A, states with single full power network station. In a state in which there is licensed by the Federal Communications Commission a single full power station that was a network station on January 1, 1995. The statutory license provided for in this paragraph shall apply to the secondary transmission by a satellite carrier of the primary transmission of that station to any subscriber in a community that is located within that state and that is not within the first 50 television markets as listed in the regulations of the Commission, is in effect on such date, 47 CFR 76.51. Subparagraph B, states with all network stations and non-network stations in same local market. In a state in which all network stations and non-network stations licensed by the Federal Communications Commission within that state as of January 1, 1995, are assigned to the same local market and that local market does not encompass all counties of that state. The statutory license provided under this paragraph shall apply to the secondary transmission by a satellite carrier of the primary transmissions of such station to all subscribers in the state who reside in a local market that is within the first 50 major television markets as listed in the regulations of the Commission as in effect on such date. Section 76.51 of Title 47. Code of Federal Regulations. Subparagraph C. Additional stations. In the case of that state in which are located 4 counties that, Clause 1, on January 1, 2004, were in local markets principally comprised of counties in another state, and Clause 2 had a combined total of 41,340 TV households, according to the U.S. TV household estimates by Nielsen Media Research for 2004. The statutory license provided under this paragraph shall apply to secondary transmissions by a satellite carrier to subscribers in any such county of the primary transmissions of any network station located in that state, if the satellite carrier was making such secondary transmissions to any subscribers in that county on January 1, 2004. Subparagraph D. Certain additional stations. If 2 adjacent counties in a single state are in a local market comprised principally of counties located in another state, the statutory license provided for in this paragraph shall apply to the secondary transmission by a satellite carrier to subscribers in those 2 counties of the primary transmissions of any network station located in the capital of the state in which such 2 counties are located. If, Clause 1, the 2 counties are located in a local market that is in the top 100 markets for the year 2003, according to Nielsen Media Research, and Clause 2, the total number of television households in the 2 counties combined did not exceed 10,000 for the year 2003, according to Nielsen Media Research. Subparagraph E. Networks of non-commercial educational broadcast stations. In the case of a system of 3 or more non-commercial educational broadcast stations licensed to a single state public agency or political, educational, or special purpose subdivision of a state, the statutory license provided for in this paragraph shall apply to the secondary transmission of the primary transmission of such system to any subscriber in any county or county equivalent within such state. If such subscriber is located in a designated market area that is not otherwise eligible to receive the secondary transmission of the primary transmission of a non-commercial educational broadcast station located within the state pursuant to paragraph 1. Paragraph 5. Applicability of royalty rates and procedures. The royalty rates and procedures under Section 119, subsection B shall apply to the secondary transmissions to which the statutory license under paragraph 4 applies. Subsection B. Reporting requirement. Paragraph 1. Initial lists. A satellite carrier that makes secondary transmissions of a primary transmission made by a network station under subsection A shall, within 90 days after commencing such secondary transmissions, submit to the network that owns or is affiliated with the network station. Subparagraph A list identifying by name in alphabetical order and street address, including county and 9-digit zip code, all subscribers to which the satellite carrier makes secondary transmissions of that primary transmission under subsection A, and Subparagraph B, a separate list aggregated by designated market area, by name and address, including street or rural route number, city, state, and 9-digit zip code, which shall indicate those subscribers being served pursuant to paragraph 2 of subsection A. Paragraph 2. Subsequent lists. After the list is submitted under paragraph 1, the satellite carrier shall, on the 15th of each month, submit to the network. Subparagraph A list identifying by name in alphabetical order and street address, including county and 9-digit zip code, any subscribers who have been added or dropped as subscribers since the last submission under this subsection, and Subparagraph B. A separate list, aggregated by designated market area, by name and street address, including street or rural route number, city, state, and 9-digit zip code, identifying those subscribers whose service pursuant to paragraph 2 of subsection A has been added or dropped since the last submission under this subsection. Paragraph 3. Use of subscriber information. Subscriber information submitted by a satellite carrier under this subsection may be used only for the purposes of monitoring compliance by the satellite carrier with this section. Paragraph 4. Requirements of networks. The submission requirements of this subsection shall apply to a satellite carrier only if the network to which the submissions are to be made places on file with the Register of Copyrights a document identifying the name and address of the person to whom such submissions are to be made. The Register of Copyrights shall maintain for public inspection a file of all such documents. Subsection C. No royalty fee required for certain secondary transmission. A satellite carrier whose secondary transmissions are subject to statutory licensing under paragraphs 1, 2, and 3 of subsection A shall have no royalty obligation for such secondary transmissions. Subsection D. Noncompliance with reporting and regulatory requirements. Notwithstanding subsection A, the willful or repeated secondary transmission to the public by a satellite carrier into the local market of a television broadcast station of a primary transmission embodying a performance or display of a work made by that TV broadcast station is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided under Sections 502 through 506 if the satellite carrier has not complied with the reporting requirements of subsection B or with the rules, regulations, and authorizations of the Federal Communications Commission concerning the carriage of television broadcast signals. Subsection E. Willful alterations. Notwithstanding subsection A, the secondary transmission to the public by a satellite carrier into the local market of a television broadcast station of a performance or display of a work embodied in a primary transmission made by that television broadcast station is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506 and Section 501 if the content of the particular program in which the performance or display is embodied, or any commercial advertising or station announcement transmitted by the primary transmitter during or immediately before or after the transmission of such program is in any way willfully altered by the satellite carrier through changes, deletions, or additions, or is combined with programming from any other broadcast signal. Subsection F. Violation of territorial restrictions on statutory license for TV broadcast stations. Paragraph 1. Individual violations. The willful or repeated secondary transmission to the public by a satellite carrier of a primary transmission embodying a performance or display of a work made by a television broadcast station to a subscriber who does not reside in that station's local market and is not subject to statutory licensing under Section 119, subject to statutory licensing by reason of paragraph 2, subparagraph A, 3, or 4 of subsection A, or subject to a private licensing agreement, is actionable as an act of infringement under Section 501 and is fully subject to the remedies provided by Sections 502 through 506, except that subparagraph A. No damages shall be awarded for such act of infringement if the satellite carrier took corrective action by promptly withdrawing service from the ineligible subscriber, and subparagraph B. Any statutory damages shall not exceed $250 for such subscriber for each month during which the violation occurred. Paragraph 2. Pattern of violations. If a satellite carrier engages in a willful or repeated pattern or practice of secondarily transmitting to the public a primary transmission embodying a performance or display of a work made by a TV broadcast station to subscribers who do not reside in that station's local market and are not subject to statutory licensing under Section 119, subject to statutory licensing by reason of paragraph 2, subparagraph A, 3, or 4 of subsection A, or subject to a private licensing agreement, then in addition to the remedies under paragraph 1. Subparagraph A. If the pattern or practice has been carried out on a substantially nationwide basis, the court, Clause 1, shall order a permanent injunction barring the secondary transmission by the satellite carrier of the primary transmissions of that TV broadcast station. And if such TV broadcast station is a network station, all other TV broadcast stations affiliated with such network and, Clause 2, may order statutory damages not exceeding $2,500,000 for each 6-month period during which the pattern or practice was carried out, and subparagraph B, if the pattern or practice has been carried out on a local or regional basis with respect to more than one TV broadcast station, the court, Clause 1, shall order a permanent injunction barring the secondary transmission in that locality or region by the satellite carrier of the primary transmissions of any TV broadcast station, and Clause 2, may order statutory damages not exceeding $2,500,000 for each 6-month period during which the pattern or practice was carried out. Subsection G, burden of proof. In any action brought under subsection F, the satellite carrier shall have the burden of proving that its secondary transmission of a primary transmission by a TV broadcast station is made only to subscribers located within that station's local market or subscribers being served in compliance with Section 119. Paragraph 2, subparagraph A, 3, or 4 of subsection A, or a private licensing agreement. Subsection H, geographic limitations on secondary transmissions. The statutory license created by this section shall apply to secondary transmissions to locations in the United States. Subsection I, exclusivity with respect to secondary transmissions of broadcast stations by satellite to members of the public. No provision of Section 111 or any other law, other than this section and Section 119, shall be construed to contain any authorization, exemption, or license through which secondary transmissions by satellite carriers of programming contained in a primary transmission made by a television broadcast station may be made without obtaining the consent of the copyright owner. Subsection J. Definitions. In this section, paragraph 1. Distributor. The term distributor means an entity that contracts to distribute secondary transmissions from a satellite carrier and, either as a single channel or in a package with other programming, provides the secondary transmission either directly to individual subscribers or indirectly through other program distribution entities. Paragraph 2. Local market. Subparagraph A. In general, the term local market, in the case of both commercial and non-commercial television broadcast stations, means the designated market area in which a station is located, and Clause 1. In the case of a commercial television broadcast station, all commercial television broadcast stations licensed to a community within the same designated market area are within the same local market. And Clause 2. In the case of a non-commercial educational TV broadcast station, the market includes any station that is licensed to a community within the same designated market area as the non-commercial educational TV broadcast station. Subparagraph B. County of license. In addition to the area described in subparagraph a station's local market includes the county in which the station's community of license is located. Subparagraph C. Designated market area. For purposes of subparagraph A, the term designated market area means a designated market area as determined by Nielsen Media Research and published in the 1999-2000 Nielsen Station Index Directory and Nielsen Station Index United States Television Household Estimates, or any successor publication. Subparagraph D. Certain areas outside of any designated market area. Any census area, borough, or other area in the state of Alaska that is outside of a designated market area, as determined by Nielsen Media Research, shall be deemed to be part of one of the local markets in the state of Alaska. A satellite carrier may determine which local market in the state of Alaska will be deemed to be the relevant local market in connection with each subscriber in such census area, borough, or other area. Subparagraph E. Market determinations. The local market of a commercial television broadcast station may be modified by the Federal Communications Commission in accordance with Section 338, subsection L of the Communications Act of 1934, Title 47, United States Code, Section 338. Paragraph 3. Low-power TV station. The term low-power TV station means a low-powered TV station as defined in Section 74.701, subsection F of Title 47, Code of Federal Regulations, as in effect on June 1, 2004. For purposes of this paragraph, the term low-power TV station includes a low-power TV station that has been accorded primary status as a Class A TV licensee under Section 73.6001, subsection A of Title 47, Code of Federal Regulations. Paragraph 4. Network station, non-network station, satellite carrier, secondary transmission. The terms network station, non-network station, satellite carrier, and secondary transmission have the meanings given such terms under Section 119, subsection D. Paragraph 5. Non-commercial educational broadcast station. The term non-commercial educational broadcast station means a TV broadcast station that is a non-commercial educational broadcast station as defined in Section 397 of the Communications Act of 1934, as in effect on the date of the enactment of the Satellite Television Extension and Localism Act of 2010. Paragraph 6. Subscriber. The term subscriber means a person or entity that receives a secondary transmission service from a satellite carrier and pays a fee for the service, directly or indirectly, to the satellite carrier or to a distributor. Paragraph 7. Television broadcast station. The term TV broadcast station, subparagraph A, means an over-the-air commercial or non-commercial television broadcast station licensed by the Federal Communications Commission under Subpart E of Part 73 of Title 47, Code of Federal Regulations, except that such term does not include a low-power or translator television station, and subparagraph B includes a TV broadcast station licensed by an appropriate governmental authority of Canada or Mexico if the station broadcasts primarily in the English language and is a network station as defined in Section 119, subsection D, paragraph 2, subparagraph A. Section 201. Ownership of copyright. Subsection A. Initial ownership. Copyright in a work protected under this title vests initially in the author or authors of the work. The authors of a joint work are co-owners of copyright in the work. Subsection B. Works made for hire. In the case of a work made for hire, the employer or other person for whom the work was prepared is considered the author for purposes of this title, and, unless the parties have expressly agreed otherwise in a written instrument signed by them, owns all of the rights comprised in the copyright. Subsection C. Contributions to collective works. Copyright in each separate contribution to a collective work is distinct from copyright in the collective work as a whole, and vests initially in the author of the contribution, in the absence of an express transfer of the copyright or of any rights under it. The owner of copyright in the collective work is presumed to have acquired only the privilege of reproducing and distributing the contribution as part of that particular collective work, any revision of that collective work, and any later collective work in the same series. Subsection D. Transfer of ownership. Paragraph 1. The ownership of a copyright may be transferred in whole or in part by any means of conveyance or by operation of law, and may be bequeathed by will or pass as personal property by the applicable laws of intestate succession. Paragraph 2. Any of the exclusive rights comprised in a copyright, including any subdivision of any of the rights specified by Section 106, may be transferred as provided by Clause 1 and owned separately. The owner of any particular exclusive right is entitled, to the extent of that right, to all of the protection and remedies accorded to the copyright owner by this title. Subsection E. Involuntary transfer. When an individual author's ownership of a copyright or of any of the exclusive rights under a copyright has not previously been transferred voluntarily by that individual author, no action by any governmental body or other official or organization purporting to seize, expropriate, transfer, or exercise rights of ownership with respect to the copyright, or any of the exclusive rights under a copyright, shall be given effect under this title except as provided under Title 11. Section 22. Ownership of copyright as distinct from ownership of material object. Ownership of a copyright or of any of the exclusive rights under a copyright is distinct from ownership of any material object in which the work is embodied. Transfer of ownership of any material object, including the copy or phonorecord in which the work is first fixed, does not of itself convey any rights in the copyrighted work embodied in the object, nor, in the absence of an agreement, does transfer of ownership of a copyright or of any exclusive rights under a copyright convey property rights in any material object. Section 213. Termination of transfers and licenses granted by the author. Subsection A. Conditions for termination. In the case of any work other than a work made for hire, the exclusive or non-exclusive grant of a transfer or license of copyright or of any right under a copyright, executed by the author on or after January 1, 1978, otherwise than by will, is subject to termination under the following conditions. Paragraph 1. In the case of a grant executed by one author, termination of the grant may be effected by that author, or if the author is dead, by the person or persons who, under Clause 2 of this subsection, own and are entitled to exercise a total of more than one-half of that author's termination interest. In the case of a grant executed by two or more authors of a joint work, termination of the grant may be effected by a majority of the authors who executed it, if any of such authors is dead. The termination interest of any such author may be exercised as a unit by the person or persons who, under Clause 2 of this subsection, own and are entitled to exercise a total of more than one-half of that author's interest. Paragraph 2. Where an author is dead, his or her termination interest is owned and may be exercised as follows. Subparagraph A. The widow or widower owns the author's entire termination interest unless there are any surviving children or grandchildren of the author, in which case the widow or widower owns one-half of the author's interest. Subparagraph B. The author's surviving children and the surviving children of any dead child of the author own the author's entire termination interest unless there is a widow or widower, in which case the ownership of one-half of the author's interest is divided among them. Subparagraph C. The rights of the author's children and grandchildren are in all cases divided among them and exercised on a per stirps basis according to the number of such author's children represented. The share of the children of a dead child in a termination interest can be exercised only by the action of a majority of them. Subparagraph D. In the event that the author's widow or widower, children and grandchildren are not living, the author's executor, administrator, personal representative, or trustee shall own the author's entire termination interest. Paragraph 3. Termination of the grant may be effected at any time during a period of 5 years, beginning at the end of 35 years from the date of execution of the grant, or if the grant covers the right of publication of the work. The period begins at the end of 35 years from the date of publication of the work under the grant, or at the end of 40 years from the date of execution of the grant, whichever term ends earlier. Paragraph 4. The termination shall be effected by serving an advance notice in writing, signed by the number and proportion of owners of termination interests required under Clauses 1 and 2 of this subsection, or by their duly authorized agents, upon the grantee or the grantee's successor in title. Subparagraph A. The notice shall state the effective date of the termination, which shall fall within the 5-year period specified by Clause 3 of this subsection, and the notice shall be served not less than 2 or more than 10 years before that date. A copy of the notice shall be recorded in the Copyright Office before the effective date of termination, as a condition to its taking effect. Subparagraph B. The notice shall comply in form, content, and manner of service with requirements that the Register of Copyrights shall prescribe by regulation. Paragraph 5. Termination of the grant may be effected notwithstanding any agreement to the contrary, including an agreement to make a will or to make any future grant. Subsection B. Effective termination. Upon the effective date of termination, all rights under this title that were covered by the terminated grants revert to the author, authors, and other persons owning termination interests under Clauses 1 and 2 of subsection A, including those owners who did not join in signing the notice of termination under Clause 4 of subsection A, but with the following limitations. Paragraph 1. A derivative work prepared under authority of the grant before its termination may continue to be utilized under the terms of the grant after its termination, but this privilege does not extend to the preparation after the termination of other derivative works based upon the copyrighted work covered by the terminated grant. Paragraph 2. The future rights that will revert upon termination of the grant become vested on the date the notice of termination has been served as provided by Clause 4 of subsection A. The rights vest in the author, authors, and other persons named in and in the proportionate shares provided by Clauses 1 and 2 of subsection A. Paragraph 3. Subject to the provisions of Clause 4 of this subsection, a further grant, or agreement to make a further grant, of any right covered by a terminated grant is valid only if it is signed by the same number and proportion of the owners, in whom the right has vested under Clause 2 of this subsection, as are required to terminate the grant under Clauses 1 and 2 of subsection A. Such further grant or agreement is effective with respect to all of the persons in whom the right it covers has vested under Clause 2 of this subsection, including those who did not join in signing it. If any person dies after rights under a terminated grant have vested in him or her, that person's legal representatives, legatees, or heirs at law represent him or her for purposes of this clause. Paragraph 4. A further grant or agreement to make a further grant of any right covered by a terminated grant is valid only if it is made after the effective date of the termination. As an exception, however, an agreement for such a further grant may be made between the persons provided by Clause 3 of this subsection and the original grantee, or such grantee's successor in title, after the notice of termination has been served as provided by Clause 4 of subsection A. Paragraph 5. Termination of a grant under this section affects only those rights covered by the grants that arise under this title, and in no way affects rights arising under any other federal, state, or foreign laws. Paragraph 6. Unless and until termination is effected under this section, the grant, if it does not provide otherwise, continues in effect for the term of copyright provided by this title. Section 204. Execution of transfers of copyright ownership. Subsection A. A transfer of copyright ownership other than by operation of law is not valid unless an instrument of conveyance or a note or memorandum of the transfer is in writing and signed by the owner of the rights conveyed or such owner's duly authorized agent. Subsection B. A certificate of acknowledgement is not required for the validity of a transfer, but is prima facie evidence of the execution of the transfer if. Paragraph 1. In the case of a transfer executed in the United States, the certificate is issued by a person authorized to administer oaths within the United States, or Paragraph 2. In the case of a transfer executed in a foreign country, the certificate is issued by a diplomatic or consular officer of the United States, or by a person authorized to administer oaths whose authority is proved by a certificate of such an officer. Section 205. Recordation of transfers and other documents. Subsection A. Conditions for recordation. Any transfer of copyright ownership or other document pertaining to a copyright may be recorded in the Copyright Office if the document filed for recordation bears the actual signature of the person who executed it, or if it is accompanied by a sworn or official certification that it is a true copy of the original signed document. A sworn or official certification may be submitted to the Copyright Office electronically, pursuant to regulations established by the Register of Copyrights. Subsection B. Certificate of Recordation. The Register of Copyrights shall, upon receipt of a document as provided by subsection A and of the fee provided by section 708, record the document and return it with his certificate of recordation. Subsection C. Recordation as constructive notice. Recordation of a document in the Copyright Office gives all persons constructive notice of the facts stated in the recorded document, but only if, Paragraph 1, the document or material attached to it specifically identifies the work to which it pertains so that, after the document is indexed by the Register of Copyrights, it would be revealed by a reasonable search under the title or registration number of the work. And Paragraph 2. Registration has been made for the work. Subsection D. Priority between conflicting transfers. As between two conflicting transfers, the one executed first prevails if it is recorded, in the manner required to give constructive notice under subsection C, within 1 month after its execution in the United States, or within 2 months after its execution outside the United States, or at any time before recordation in such manner of the later transfer. Otherwise, the later transfer prevails if recorded first in such manner, and if taken in good faith, for valuable consideration, or on the basis of a binding promise to pay royalties, and without notice of the earlier transfer. Subsection E. Priority between conflicting transfer of ownership and non-exclusive license. A non-exclusive license, whether recorded or not, prevails over a conflicting transfer of copyright ownership if the license is evidenced by a written instrument signed by the owner of the rights licensed or such owner's duly authorized agent, and if, Paragraph 1, the license was taken before execution of the transfer, or Paragraph 2, the license was taken in good faith before recordation of the transfer and without notice of it. Section 301. Preemption with respect to other laws. Subsection A. On and after January 1st, 1978, all legal or equitable rights that are equivalent to any of the exclusive rights within the general scope of copyright as specified by Section 106 in works of authorship that are fixed in a tangible medium of expression and come within the subject matter of copyright as specified by Sections 102 and 103, whether created before or after that date and whether published or unpublished, are governed exclusively by this title. Thereafter, no person is entitled to any such right or equivalent right in any such work under the common law or statutes of any state. Subsection B. Nothing in this title annuls or limits any rights or remedies under the common law or statutes of any state with respect to. Paragraph 1. Subject matter that does not come within the subject matter of copyright is specified by sections 102 and 103, including works of authorship not fixed in any tangible medium of expression. Or, paragraph 2. Any cause of action arising from undertakings commenced before January 1st, 1978. Paragraph 3. Activities violating legal or equitable rights that are not equivalent to any of the exclusive rights within the general scope of copyright as specified by Section 106. Or, paragraph 4. State and local landmarks, historic preservation, zoning, or building codes relating to architectural works protected under Section 102, subsection A, paragraph 8. Subsection C, notwithstanding the provisions of Section 303, and in accordance with Chapter 14, no sound recording fixed before February 15, 1972, shall be subject to copyright under this title. With respect to sound recordings fixed before February 15, 1972, the preemptive provisions of subsection A shall apply to activities that are commenced on and after the date of enactment of the Classics Protection and Access Act. Nothing in this subsection may be construed to affirm or negate the preemption of rights and remedies pertaining to any cause of action arising from the non-subscription broadcast transmission of sound recordings under the common law or statutes of any state for activities that do not qualify as covered activities under Chapter 14 undertaken during the period between the date of enactment of the Classics Protection and Access Act and the date on which the term of prohibition on unauthorized acts under Section 141. Substact A, paragraph 2 expires for such sound recordings. Any potential preemption of rights and remedies related to such activities undertaken during that period shall apply in all respects as it did the day before the date of enactment of the Classics Protection and Access Act. Subsection D. Nothing in this title annuls or limits any rights or remedies under any other federal statute. Subsection E. The scope of federal preemption under this section is not affected by the adherence of the United States to the Berne Convention or the satisfaction of obligations of the United States thereunder. Subsection F. Paragraph 1. On or after the effective date set forth in Section 610, subsection A of the Visual Artists' Rights Act of 1990. All legal or equitable rights that are equivalent to any of the rights conferred by Section 106A with respect to works of visual art, to which the rights conferred by Section 106A apply, are governed exclusively by Section 106A and Section 113, Substack D, and the provisions of this title relating to such sections. Thereafter, no person is entitled to any such right or equivalent right in any work of visual art under the common law or statutes of any state. Paragraph 2. Nothing in paragraph 1 annuls or limits any rights or remedies under the common law or statutes of any state with respect to. Subparagraph A. Any cause of action from undertakings commenced before the effective date set forth in Section 610, subsection A of the Visual Artists' Rights Act of 1990. Subparagraph B. Activities violating legal or equitable rights that are not equivalent to any of the rights conferred by Section 106A with respect to works of visual art. Or subparagraph C. Activities violating legal or equitable rights which extend beyond the life of the author. Section 302. Duration of copyright. Works created on or after January 1st, 1978. Subsection A. In general, copyright in a work created on or after January 1st, 1978, subsists from its creation and, except as provided by the following subsections, endures for a term consisting of the life of the author and 70 years after the author's death. Subsection B. Joint works. In the case of a joint work prepared by two or more authors who did not work for hire, the copyright endures for a term consisting of the life of the last surviving author and 70 years after such last surviving author's death. Subsection C. Anonymous works, pseudonymous works, and works made for hire. In the case of an anonymous work, a pseudonymous work, or a work made for hire, the copyright endures for a term of 95 years from the year of its first publication, or a term of 120 years from the year of its creation, whichever expires first. If, before the end of such term, the identity of one or more of the authors of an anonymous or pseudonymous work is revealed in the records of a registration made for that work under subsections A or D of Section 408, or in the records provided by this subsection, the copyright in the work endures for the term specified by subsection A or B, based on the life of the author or authors whose identity has been revealed. Any person having an interest in the copyright in an anonymous or pseudonymous work may at any time record in records to be maintained by the Copyright Office for that purpose a statement identifying one or more authors of the work. The statement shall also identify the person filing it, the nature of that person's interest, the source of the information recorded, and the particular work affected, and shall comply in form and content with requirements that the Register of Copyrights shall prescribe by regulation. Subsection D. Records relating to death of authors. Any person having an interest in a copyright may at any time record in the Copyright Office a statement of the date of death of the author of the copyrighted work, or a statement that the author is still living on a particular date. The statement shall identify the person filing it, the nature of that person's interest, and the source of the information recorded, and shall comply in form and content with requirements that the Register of Copyrights shall prescribe by regulation. The Register shall maintain current records of information relating to the death of authors of copyrighted works based on such recorded statements and, to the extent the Register considers practicable, on data contained in any of the records of the Copyright Office or in other reference sources. Subsection E. Presumption as to author's death. After a period of 95 years from the year of first publication of a work, or a period of 120 years from the year of its creation, whichever expires first, any person who obtains from the Copyright Office a certified report that the records provided by subsection D disclose nothing to indicate that the author of the work is living or died less than 70 years before, is entitled to the benefits of a presumption that the author has been dead for at least 70 years. Reliance in good faith upon this presumption shall be a complete defense to any action for infringement under this title. Section 303. Duration of copyright. Works created, but not published or copyrighted before January 1, 1978. Subsection A. Copyright in a work created before January 1, 1978, but not theretofore in the public domain or copyrighted, subsists from January 1, 1978, and endures for the term provided by Section 302. In no case, however, shall the term of copyright in such a work expire before December 31, 2002, and if the work is published on or before December 31, 2002, the term of copyright shall not expire before December 31, 2047. Subsection B. The distribution before January 1, 1978, of a phonorecord shall not for any purpose constitute a publication of any musical work, dramatic work, or literary work embodied therein. Section 304. Duration of copyright. Subsisting copyrights. Subsection A. Copyrights in their first term on January 1, 1978. 1A. Any copyright, the first term of which is subsisting on January 1, 1978, shall endure for 28 years from the date it was originally secured. Subparagraph B. In the case of Clause 1. Any posthumous work or of any periodical, cyclopedic, or other composite work upon which the copyright was originally secured by the proprietor thereof. Or Clause 2. Any work copyrighted by a corporate body, otherwise than as assignee or licensee of the individual author, or by an employer for whom such work is made for hire. The proprietor of such copyright shall be entitled to a renewal and extension of the copyright in such work for the further term of 67 years. Subparagraph C. In the case of any other copyrighted work, including a contribution by an individual author to a periodical or to a cyclopedic or other composite work. Clause 1. The author of such work, if the author is still living. Clause 2. The widow, widower, or children of the author, if the author is not living. Clause 3. The author's executors, if such author, widow, widower, or children are not living. Or Clause 4. The author's next of kin, in the absence of a will of the author, shall be entitled to a renewal and extension of the copyright in such work for a further term of 67 years. Paragraph 2. Subparagraph A. At the expiration of the original term of copyright in a work specified in paragraph 1b of this subsection, the copyright shall endure for a renewed and extended further term of 67 years, which. Clause 1. If an application to register a claim to such further term has been made to the Copyright Office within 1 year before the expiration of the original term of copyright, and the claim is registered, shall vest, upon the beginning of such further term, in the proprietor of the copyright who is entitled to claim the renewal of copyright at the time the application is made. Or Clause 2. If no such application is made or the claim pursuant to such application is not registered, shall vest upon the beginning of such further term, in the person or entity that was the proprietor of the copyright as of the last day of the original term of copyright. Subparagraph B. At the expiration of the original term of copyright in a work specified in paragraph 1c of this subsection, the copyright shall endure for a renewed and extended further term of 67 years, which. Clause 1. If an application to register a claim to such further term has been made to the Copyright Office within 1 year before the expiration of the original term of copyright, and the claim is registered, shall vest, upon the beginning of such further term, in any person who is entitled under paragraph 1c to the renewal and extension of the copyright at the time the application is made. Or Clause 2. If no such application is made or the claim pursuant to such application is not registered, shall vest upon the beginning of such further term, in any person entitled under paragraph 1c, as of the last day of the original term of copyright, to the renewal and extension of the copyright. Paragraph 3, subparagraph A. An application to register a claim to the renewed and extended term of copyright in a work may be made to the Copyright Office. Clause 1. Within 1 year before the expiration of the original term of copyright by any person entitled under paragraph 1b or c to such further term of 67 years, and Clause 2. At any time during the renewed and extended term by any person in whom such further term vested, under paragraph 2a or b, or by any successor or assign of such person, if the application is made in the name of such person. Subparagraph B. Such an application is not a condition of the renewal and extension of the copyright in a work for a further term of 67 years. Paragraph 4. Subparagraph A. If an application to register a claim to the renewed and extended term of copyright in a work is not made within 1 year before the expiration of the original term of copyright in a work, or if the claim pursuant to such application is not registered, Then a derivative work prepared under authority of a grant of a transfer or license of the copyright that is made before the expiration of the original term of copyright may continue to be used under the terms of the grant during the renewed and extended term of copyright without infringing the copyright, except that such use does not extend to the preparation during such renewed and extended term of other derivative works based upon the copyrighted work covered by such grant. Subparagraph B. If an application to register a claim to the renewed and extended term of copyright in a work is made within 1 year before its expiration, and the claim is registered, the certificate of such registration shall constitute prima facie evidence as to the validity of the copyright during its renewed and extended term and of the facts stated in the certificate. The evidentiary weight to be accorded the certificates of a registration of a renewed and extended term of copyright made after the end of that 1-year period shall be within the discretion of the court. Subsection B. Copyrights in their renewal term at the time of the effective date of the Sonny Bono Copyright Term Extension Act. Any copyright still in its renewal term at the time that the Sonny Bono Copyright Term Extension Act becomes effective shall have a copyright term of 95 years from the date copyright was originally secured. Subsection C. Termination of transfers and licenses covering extended renewal term. In the case of any copyright subsisting in either its first or renewal term on January 1, 1978, other than a copyright in a work made for hire, the exclusive or non-exclusive grant of a transfer or license of the renewal copyright or any right under it, executed before January 1, 1978, by any of the persons designated by subsection A1C of this section, otherwise than by will, is subject to termination under the following conditions. Paragraph 1. In the case of a grant executed by a person or persons other than the author, termination of the grant may be effected by the surviving person or persons who executed it. In the case of a grant executed by one or more of the authors of the work, termination of the grant may be effected, to the extent of a particular author's share in the ownership of the renewal copyright, by the author who executed it, or, if such author is dead, by the person or persons who, under Clause 2 of this subsection, own and are entitled to exercise a total of more than one-half of that author's termination interest. Paragraph 2. Where an author is dead, his or her termination interest is owned and may be exercised as follows. Subparagraph A. The widow or widower owns the author's entire termination interest unless there are any surviving children or grandchildren of the author, in which case the widow or widower owns one-half of the author's interest. Subparagraph B. The author's surviving children and the surviving children of any dead child of the author own the author's entire termination interest unless there is a widow or widower, in which case the ownership of one-half of the author's interest is divided among them. Subparagraph C. The rights of the author's children and grandchildren are in all cases divided among them and exercised on a per stirpes basis according to the number of such author's children represented. The share of the children of a dead child in a termination interest can be exercised only by the action of a majority of them. Subparagraph D. In the event that the author's widow or widower, children and grandchildren are not living, the author's executor, administrator, personal representative, or trustee shall own the author's entire termination interest. Paragraph 3. Termination of the grant may be effected at any time during a period of 5 years beginning at the end of 56 years from the date copyright was originally secured, or beginning on January 1, 1978, whichever is later. Paragraph 4. The termination shall be effected by serving an advance notice in writing upon the grantee or the grantee's successor in title. In the case of a grant executed by a person or persons other than the author, the notice shall be signed by all of those entitled to terminate the grant under Clause 1 of this subsection, or by their duly authorized agents. In the case of a grant executed by one or more of the authors of the work, the notice as to any one author's share shall be signed by that author or his or her duly authorized agent, or, if that author is dead, by the number and proportion of the owners of his or her termination interest required under Clauses 1 and 2 of this subsection, or by their duly authorized agents. Subparagraph A. The notice shall state the effective date of the termination, which shall fall within the 5-year period specified by Clause 3 of this subsection, or, in the case of a termination under subsection D, within the 5-year period specified by subsection D2, and the notice shall be served not less than 2 or more than 10 years before that date. A copy of the notice shall be recorded in the Copyright Office before the effective date of termination as a condition to its taking effect. Subparagraph B. The notice shall comply, in form, content, and manner of service, with requirements that the Register of Copyrights shall prescribe by regulation. Paragraph 5. Termination of the grant may be effected notwithstanding any agreement to the contrary, including an agreement to make a will or to make any future grant. Paragraph 6. In the case of a grant executed by a person or persons other than the author, all rights under this title that were covered by the terminated grant revert, upon the effective date of termination, to all of those entitled to terminate the grant under Clause 1 of this subsection. In the case of a grant executed by one or more of the authors of the work, all of a particular author's rights under this title that were covered by the terminated grant revert, upon the effective date of termination, to that author, or if that author is dead, to the persons owning his or her termination interest under Clause 2 of this subsection, including those owners who did not join in signing the notice of termination under Clause 4 of this subsection. In all cases, the reversion of rights is subject to the following limitations. Subparagraph A. A derivative work prepared under authority of the grant before its termination may continue to be utilized under the terms of the grant after its termination. But this privilege does not extend to the preparation after the termination of other derivative works based upon the copyrighted work covered by the terminated grant. Subparagraph B. The future rights that will revert upon termination of the grant become vested on the date the notice of termination has been served as provided by Clause 4 of this subsection. Subparagraph C. Where the author's rights revert to two or more persons under Clause 2 of this subsection, they shall vest in those persons in the proportionate shares provided by that clause. In such a case, and subject to the provisions of subclause D of this clause, a further grant or agreement to make a further grant of a particular author's share with respect to any right covered by a terminated grant is valid only if it is signed by the same number and proportion of the owners, in whom the right has vested under this clause, as are required to terminate the grant under Clause 2 of this subsection. Such further grant or agreement is effective with respect to all of the persons in whom the right it covers has vested under this subclause, including those who did not join in signing it. If any person dies after rights under a terminated grant have vested in him or her, that person's legal representatives, legatees, or heirs at law represent him or her for purposes of this subclause. Subparagraph D. A further grant or agreement to make a further grant of any right covered by a terminated grant is valid only if it is made after the effective date of the termination. As an exception, however, an agreement for such a further grant may be made between the author or any of the persons provided by the first sentence of Clause 6 of this subsection, or between the persons provided by subclause C of this clause, and the original grantee or such grantee's successor in title after the notice of termination has been served as provided by Clause 4 of this subsection. Subparagraph E. Termination of a grant under this subsection affects only those rights covered by the grant that arise under this title, and in no way affects rights arising under any other federal, state, or foreign laws. Subparagraph F. Unless and until termination is effected under this subsection, the grant, if it does not provide otherwise, continues in effect for the remainder of the extended renewal term. Subsection D. Termination rights provided in subsection C, which have expired on or before the effective date of the Sonny Bono Copyright Term Extension Act. In the case of any copyright other than a work made for hire, subsisting in its renewal term on the effective date of the Sonny Bono Copyright Term Extension Act, for which the termination right provided in subsection C has expired by such date, where the author or owner of the termination right has not previously exercised such termination right, the exclusive or non-exclusive grant of a transfer or license of the renewal copyright, or any right under it, executed before January 1, 1978, by any of the persons designated in subsection A1C of this section, other than by will, is subject to termination under the following conditions. Paragraph 1. The conditions specified in subsections C1, 2, 4, 5, and 6 of this section apply to terminations of the last 20 years of copyright term as provided by the amendments made by the Sonny Bono Copyright Term Extension Act. Paragraph 2. Termination of the grant may be effected at any time during a period of 5 years beginning at the end of 75 years from the date copyright was originally secured. Section 305. Duration of copyright, terminal date. All terms of copyright provided by sections 302 through 304 run to the end of the calendar year in which they would otherwise expire. Section 401. Notice of copyright, visually perceptible copies. Subsection A. General provisions. Whenever a work protected under this title is published in the United States or elsewhere by authority of the copyright owner, a notice of copyright as provided by this section may be placed on publicly distributed copies from which the work can be visually perceived, either directly or with the aid of a machine or device. Subsection B. Form of notice. If a notice appears on the copies, it shall consist of the following three elements. Paragraph 1. The symbol ISTA, the letter C in a circle, or the word copyright or the abbreviation COPAR. And paragraph 2. The year of first publication of the work. In the case of compilations or derivative works incorporating previously published material, the year date of first publication of the compilation or derivative work is sufficient. The year date may be omitted where a pictorial, graphic, or sculptural work with accompanying text matter, if any, is reproduced in or on greeting cards, postcards, stationery, jewelry, dolls, toys, or any useful articles, and paragraph 3. The name of the owner of copyright in the work, or an abbreviation by which the name can be recognized, or a generally known alternative designation of the owner. Subsection C. Position of notice. The notice shall be affixed to the copies in such manner and location as to give reasonable notice of the claim of copyright. The Register of Copyrights shall prescribe by regulation, as examples, specific methods of affixation and positions of the notice on various types of works that will satisfy this requirement, but these specifications shall not be considered exhaustive. Subsection D. Evidentiary weight of notice. If a notice of copyright in the form and position specified by this section appears on the published copy or copies to which a defendant in a copyright infringement suit had access, then no weight shall be given to such a defendant's interposition of a defense based on innocent infringement in mitigation of actual or statutory damages, except as provided in the last sentence of Section 504, subsection C, paragraph 2. Section 402, Notice of Copyright, Phonorecords of Sound Recordings. Subsection A, General Provisions. Whenever a sound recording protected under this title is published in the United States or elsewhere by authority of the copyright owner, a notice of copyright as provided by this section may be placed on publicly distributed phonorecords of the sound recording. Subsection B, Form of Notice. If a notice appears on the phonorecords, it shall consist of the following three elements. Paragraph 1, the symbol P, the letter P in a circle, and Paragraph 2, the year of first publication of the sound recording, and Paragraph 3, the name of the owner of copyright in the sound recording, or an abbreviation by which the name can be recognized, or a generally known alternative designation of the owner. If the producer of the sound recording is named on the phonorecord labels or containers, and if no other name appears in conjunction with the notice, the producer's name shall be considered a part of the notice. Subsection C, Position of Notice. The notice shall be placed on the surface of the phonorecord, or on the phonorecord label or container, in such manner and location as to give reasonable notice of the claim of copyright. Subsection D, Evidentiary Weight of Notice. If a notice of copyright in the form and position specified by this section appears on the published phonorecord or phonorecords to which a defendant in a copyright infringement suit had access, then no weight shall be given to such a defendant's interposition of a defense based on innocent infringement in mitigation of actual or statutory damages, except as provided in the last sentence of Section 504, subsection C, paragraph 2. Section 403, Notice of Copyright, Publications incorporating United States government works. Sections 401D and 402D shall not apply to a work published in copies or phonorecords consisting predominantly of one or more works of the United States government, unless the notice of copyright appearing on the published copies or phonorecords to which a defendant in the copyright infringement suit had access includes a statement identifying, either affirmatively or negatively, those portions of the copies or phonorecords embodying any work or works protected under this title. Section 404, Notice of Copyright, Contributions to Collective Works. Subsection A, a separate contribution to a collective work may bear its own notice of copyright, as provided by sections 401 through 403. However, a single notice applicable to the collective work as a whole is sufficient to invoke the provisions of section 401, subsection D, or 402D. As applicable with respect to the separate contributions it contains, not including advertisements inserted on behalf of persons other than the owner of copyright in the collective work, regardless of the ownership of copyright in the contributions and whether or not they have been previously published. Subsection B, with respect to copies and phonorecords publicly distributed by authority of the copyright owner before the effective date of the Berne Convention Implementation Act of 1988, where the person named in a single notice applicable to a collective work as a whole is not the owner of copyright in a separate contribution that does not bear its own notice. The case is governed by the provisions of Section 406, subsection A. Section 405, Notice of Copyright, Omission of notice on certain copies and phonorecords. Subsection A, Effective omission on copyright. With respect to copies and phonorecords publicly distributed by authority of the copyright owner before the effective date of the Berne Convention Implementation Act of 1988, the omission of the copyright notice described in sections 401 through 403 from copies or phonorecords publicly distributed by authority of the copyright owner does not invalidate the copyright in a work if, paragraph 1, the notice has been omitted from no more than a relatively small number of copies or phonorecords distributed to the public, or, paragraph 2, registration for the work has been made before or is made within 5 years after the publication without notice, and a reasonable effort is made to add notice to all copies or phonorecords that are distributed to the public in the United States after the omission has been discovered, or, paragraph 3, the notice has been omitted in violation of an express requirement in writing that, as a condition of the copyright owner's authorization of the public distribution of copies or phonorecords, they bear the prescribed notice. Subsection B, Effective omission on innocent infringers. Any person who innocently infringes a copyright in reliance upon an authorized copy or phonorecord from which the copyright notice has been omitted and which was publicly distributed by authority of the copyright owner before the effective date of the Berne Convention Implementation Act of 1988, incurs no liability for actual or statutory damages under Section 504 for any infringing acts committed before receiving actual notice that registration for the work has been made under Section 408. If such person proves that he or she was misled by the omission of notice, in a suit for infringement in such a case, the court may allow or disallow recovery of any of the infringer's profits attributable to the infringement, and may enjoin the continuation of the infringing undertaking or may require, as a condition for permitting the continuation of the infringing undertaking, that the infringer pay the copyright owner a reasonable license fee in an amount and on terms fixed by the court. Subsection C, Removal of notice. Protection under this title is not affected by the removal, destruction, or obliteration of the notice without the authorization of the copyright owner from any publicly distributed copies or phonorecords. Section 406, Notice of Copyright. Error in name or date on certain copies and phonorecords. Subsection A, Error in name. With respect to copies and phonorecords publicly distributed by authority of the copyright owner before the effective date of the Berne Convention Implementation Act of 1988, where the person named in the copyright notice on copies or phonorecords publicly distributed by authority of the copyright owner is not the owner of copyright, the validity and ownership of the copyright are not affected. In such a case, however, any person who innocently begins an undertaking that infringes the copyright has a complete defense to any action for such infringement if such person proves that he or she was misled by the notice and began the undertaking in good faith under a purported transfer or license from the person named therein, unless before the undertaking was begun. Paragraph 1. Registration for the work had been made in the name of the owner of copyright, or Paragraph 2. A document executed by the person named in the notice and showing the ownership of the copyright had been recorded. The person named in the notice is liable to account to the copyright owner for all receipts from transfers or licenses purportedly made under the copyright by the person named in the notice. Subsection B. Error in date. When the year date in the notice on copies or phonorecords distributed before the effective date of the Berne Convention Implementation Act of 1988 by authority of the copyright owner is earlier than the year in which publication first occurred. Any period computed from the year of first publication under Section 302 is to be computed from the year in the notice. Where the year date is more than 1 year later than the year in which publication first occurred, the work is considered to have been published without any notice and is governed by the provisions of Section 405. Subsection C. Omission of name or date. Where copies or phonorecords publicly distributed before the effective date of the Berne Convention Implementation Act of 1988 by authority of the copyright owner contain no name or no date that could reasonably be considered a part of the notice. The work is considered to have been published without any notice and is governed by the provisions of Section 405 as in effect on the day before the effective date of the Berne Convention Implementation Act of 1988. Section 407. Deposit of copies or phonorecords for Library of Congress. Subsection A. Except as provided by subsection C and subject to the provisions of subsection E, the owner of copyright or of the exclusive right of publication in a work published in the United States shall deposit within 3 months after the date of such publication. Paragraph 1. 2 complete copies of the best edition, or Paragraph 2. If the work is a sound recording, 2 complete phonorecords of the best edition, together with any printed or other visually perceptible material published with such phonorecords. Neither the deposit requirements of this subsection nor the acquisition provisions of subsection E are conditions of copyright protection. Subsection B. The required copies or phonorecords shall be deposited in the Copyright Office for the use or disposition of the Library of Congress. The Register of Copyrights shall, when requested by the depositor and upon payment of the fee prescribed by Section 708, issue a receipt for the deposit. Subsection C. The Register of Copyrights may by regulation exempt any categories of material from the deposit requirements of this section, or require deposit of only 1 copy or phonorecord with respect to any categories. Such regulations shall provide either for complete exemption from the deposit requirements of this section, or for alternative forms of deposit aimed at providing a satisfactory archival record of a work without imposing practical or financial hardships on the depositor, where the individual author is the owner of copyright in a pictorial, graphic, or sculptural work and less than 5 copies of the work have been published, or 2, the work has been published in a limited edition consisting of numbered copies, the monetary value of which would make the mandatory deposit of 2 copies of the best edition of the work burdensome, unfair, or unreasonable. Subsection D. At any time after publication of a work is provided by subsection A, the Register of Copyrights may make written demand for the required deposit on any of the persons obligated to make the deposit under subsection A. Unless deposit is made within 3 months after the demand is received, the person or persons on whom the demand was made are liable. Paragraph 1. To a fine of not more than $250 for each work, and Paragraph 2. To pay into a specially designated fund in the Library of Congress the total retail price of the copies or phonorecords demanded, or, if no retail price has been fixed, the reasonable cost to the Library of Congress of acquiring them. And Paragraph 3. To pay a fine of $2,500 in addition to any fine or liability imposed under Clauses 1 and 2, if such person willfully or repeatedly fails or refuses to comply with such a demand. Subsection E. With respect to transmission programs that have been fixed and transmitted to the public in the United States but have not been published, the Register of Copyrights shall, after consulting with the Librarian of Congress and other interested organizations and officials, establish regulations governing the acquisition, through deposit or otherwise, of copies or phonorecords of such programs for the collections of the Library of Congress. Paragraph 1. The Librarian of Congress shall be permitted, under the standards and conditions set forth in such regulations, to make a fixation of a transmission program directly from a transmission to the public, and to reproduce 1 copy or phonorecord from such fixation for archival purposes. Paragraph 2. Such regulations shall also provide standards and procedures by which the Register of Copyrights may make written demand, upon the owner of the right of transmission in the United States, for the deposit of a copy or phonorecord of a specific transmission program, Such deposit may, at the option of the owner of the right of transmission in the United States, be accomplished by gift, by loan for purposes of reproduction, or by sale at a price not to exceed the cost of reproducing and supplying the copy or phonorecord. The regulations established under this clause shall provide reasonable periods of not less than 3 months for compliance with a demand, and shall allow for extensions of such periods and adjustments in the scope of the demand or the methods for fulfilling it, as reasonably warranted by the circumstances. Willful failure or refusal to comply with the conditions prescribed by such regulations shall subject the owner of the right of transmission in the United States to liability for an amount not to exceed the cost of reproducing and supplying the copy or phonorecord in question, to be paid into a specially designated fund in the Library of Congress. Paragraph 3. Nothing in this subsection shall be construed to require the making or retention, for purposes of deposit, of any copy or phonorecord of an unpublished transmission program, the transmission of which occurs before the receipt of a specific written demand as provided by Clause 2. Paragraph 4. No activity undertaken in compliance with regulations prescribed under Clauses 1 or 2 of this subsection shall result in liability if intended solely to assist in the acquisition of copies or phonorecords under this subsection. Section 408. Copyright registration in general. Subsection A. Registration permissive. At any time during the subsistence of the first term of copyright in any published or unpublished work in which the copyright was secured before January 1, 1978, and during the subsistence of any copyright secured on or after that date, the owner of copyright or of any exclusive right in the work may obtain registration of the copyright claim by delivering to the Copyright Office the deposit specified by this section, together with the application and fee specified by Sections 409 and 708. Such registration is not a condition of copyright protection. Subsection B. Deposit for copyright registration. Except as provided by subsection C, the material deposited for registration shall include: Paragraph 1. In the case of an unpublished work, 1 complete copy or phonorecord. Paragraph 2. In the case of a published work, 2 complete copies or phonorecords of the best edition. Paragraph 3. In the case of a work first published outside the United States, 1 complete copy or phonorecord as so published. Paragraph 4. In the case of a contribution to a collective work, 1 complete copy or phonorecord of the best edition of the collective work. Copies or phonorecords deposited for the Library of Congress under Section 407 may be used to satisfy the deposit provisions of this section if they are accompanied by the prescribed application and fee, and by any additional identifying material that the Register may by regulation require. The Register shall also prescribe regulations establishing requirements under which copies or phonorecords acquired for the Library of Congress under subsection E of Section 407, otherwise than by deposit, may be used to satisfy the deposit provisions of this section. Subsection C. Administrative classification and optional deposit. Paragraph 1. The Register of Copyrights is authorized to specify by regulation the administrative classes into which works are to be placed for purposes of deposit and registration, and the nature of the copies or phonorecords to be deposited in the various classes specified. The regulations may require or permit, for particular classes, the deposit of identifying material instead of copies or phonorecords, the deposit of only 1 copy or phonorecord where 2 would normally be required, or a single registration for a group of related works. This administrative classification of works has no significance with respect to the subject matter of copyright or the exclusive rights provided by this title. Paragraph 2. Without prejudice to the general authority provided under Clause 1, the Register of Copyrights shall establish regulations specifically permitting a single registration for a group of works by the same individual author. All first published as contributions to periodicals, including newspapers, within a 12-month period on the basis of a single deposit, application, and registration fee under the following conditions. Subparagraph A. If the deposit consists of 1 copy of the entire issue of the periodical, or of the entire section in the case of a newspaper in which each contribution was first published, and Subparagraph B. If the application identifies each work separately, including the periodical containing it and its date of first publication. Paragraph 3. As an alternative to separate renewal registrations under subsection A of Section 304, a single renewal registration may be made for a group of works by the same individual author, all first published as contributions to periodicals, including newspapers, upon the filing of a single application and fee under all of the following conditions. Subparagraph A. The renewal claimant or claimants, and the basis of claim or claims under Section 304, subsection A, is the same for each of the works, and Subparagraph B. The works were all copyrighted upon their first publication, either through separate copyright notice and registration, or by virtue of a general copyright notice in the periodical issue as a whole. And Subparagraph C. The renewal application and fee are received not more than 28 or less than 27 years after the 31st day of December of the calendar year in which all of the works were first published. And Subparagraph D. The renewal application identifies each work separately, including the periodical containing it and its date of first publication. Subsection D. Corrections and amplification. The register may also establish by regulation formal procedures for the filing of an application for supplementary registration to correct an error in a copyright registration or to amplify the information given in a registration. Such application shall be accompanied by the fee provided by Section 708 and shall clearly identify the registration to be corrected or amplified. The information contained in a supplementary registration augments, but does not supersede that contained in the earlier registration. Subsection E, published edition of previously registered work. Registration for the first published edition of a work previously registered in unpublished form may be made even though the work as published is substantially the same as the unpublished version. Subsection F, pre-registration of works being prepared for commercial distribution. Paragraph 1. Rulemaking. Not later than 180 days after the date of enactment of this subsection, the Register of Copyrights shall issue regulations to establish procedures for pre-registration of a work that is being prepared for commercial distribution and has not been published. Paragraph 2. Class of works. The regulations established under Paragraph 1 shall permit pre-registration for any work that is in a class of works that the Register determines has had a history of infringement prior to authorized commercial distribution. Paragraph 3. Application for registration. Not later than 3 months after the first publication of a work pre-registered under this subsection, the applicant shall submit to the Copyright Office. Subparagraph A. An application for registration of the work. Subparagraph B. A deposit, and Subparagraph C. The applicable fee. Paragraph 4. Effect of untimely application. An action under this chapter for infringement of a work pre-registered under this subsection, in a case in which the infringement commenced no later than 2 months after the first publication of the work, shall be dismissed if the items described in Paragraph 3 are not submitted to the Copyright Office in proper form within the earlier of. Subparagraph A. 3 months after the first publication of the work, or Subparagraph B. 1 month after the copyright owner has learned of the infringement. Section 409. Application for copyright registration. The application for copyright registration shall be made on a form prescribed by the Register of Copyrights and shall include: Paragraph 1. The name and address of the copyright claimant. Paragraph 2. In the case of a work other than an anonymous or pseudonymous work, the name and nationality or domicile of the author or authors, and, if one or more of the authors is dead, the dates of their deaths. Paragraph 3. If the work is anonymous or pseudonymous, the nationality or domicile of the author or authors. Paragraph 4. In the case of a work made for hire, a statement to this effect. Paragraph 5. If the copyright claimant is not the author, a brief statement of how the claimant obtained ownership of the copyright. Paragraph 6. The title of the work, together with any previous or alternative titles under which the work can be identified. Paragraph 7. The year in which creation of the work was completed. Paragraph 8. If the work has been published, the date and nation of its first publication. Paragraph 9. In the case of a compilation or derivative work, an identification of any pre-existing work or works that it is based on or incorporates, and a brief, general statement of the additional material covered by the copyright claim being registered, and Paragraph 10. Any other information regarded by the Register of Copyrights as bearing upon the preparation or identification of the work or the existence, ownership, or duration of the copyright. If an application is submitted for the renewed and extended term provided for in Section 304, subsection A, Paragraph 3, subparagraph A, and an original term registration has not been made, the Register may request information with respect to the existence, ownership, or duration of the copyright for the original term. Section 410, Registration of Claim and Issuance of Certificate. Subsection A. When, after examination, the Register of Copyrights determines that, in accordance with the provisions of this title, the material deposited constitutes copyrightable subject matter and that the other legal and formal requirements of this title have been met, the Register shall register the claim and issue to the applicant a certificate of registration under the seal of the Copyright Office. The certificate shall contain the information given in the application, together with the number and effective date of the registration. Subsection B. In any case in which the Register of Copyrights determines that, in accordance with the provisions of this title, the material deposited does not constitute copyrightable subject matter, or that the claim is invalid for any other reason, the Register shall refuse registration and shall notify the applicant in writing of the reasons for such refusal. Subsection C. In any judicial proceedings, the certificate of a registration made before or within 5 years after first publication of the work shall constitute prima facie evidence of the validity of the copyright and of the facts stated in the certificate. The evidentiary weight to be accorded the certificate of a registration made thereafter shall be within the discretion of the court. Subsection D. The effective date of a copyright registration is the day on which an application, deposit, and fee which are later determined by the Register of Copyrights or by a court of competent jurisdiction to be acceptable for registration have all been received in the Copyright Office. Section 411, Registration and Civil Infringement Actions. Subsection A. Except for an action brought for a violation of the rights of the author under Section 106A, subsection A, and subject to the provisions of subsection B, No civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. In any case, however, where the deposit, application, and fee required for registration have been delivered to the Copyright Office in proper form and registration has been refused, the applicant is entitled to institute a civil action for infringement if notice thereof, with a copy of the complaint, is served on the Register of Copyrights. The Register may, at his or her option, become a party to the action with respect to the issue of registrability of the copyright claim by entering an appearance within 60 days after such service, but the Register's failure to become a party shall not deprive the court of jurisdiction to determine that issue. Subsection B, Paragraph 1. A certificate of registration satisfies the requirements of this section and Section 412, regardless of whether the certificate contains any inaccurate information, unless Subparagraph A, the inaccurate information was included on the application for copyright registration with knowledge that it was inaccurate, and Subparagraph B, the inaccuracy of the information, if known, would have caused the Register of Copyrights to refuse registration. Paragraph 2. In any case in which inaccurate information described under Paragraph 1 is alleged, the court shall request the Register of Copyrights to advise the court whether the inaccurate information, if known, would have caused the Register of Copyrights to refuse registration. Paragraph 3. Nothing in this subsection shall affect any rights, obligations, or requirements of a person related to information contained in a registration certificate, except for the institution of and remedies in infringement actions under this section and Section 412. Subsection C. In the case of a work consisting of sounds, images, or both, the first fixation of which is made simultaneously with its transmission, the copyright owner may, either before or after such fixation takes place, institute an action for infringement under Section 501, fully subject to the remedies provided by Sections 502 through 505 and Section 510, if, in accordance with requirements that the Register of Copyrights shall prescribe by regulation, the copyright owner. Paragraph 1. Serves notice upon the infringer, not less than 48 hours before such fixation, identifying the work and the specific time and source of its first transmission, and declaring an intention to secure copyright in the work, and Paragraph 2 makes registration for the work if required by subsection A within 3 months after its first transmission. Section 412. Registration as prerequisite to certain remedies for infringement. In any action under this title other than an action brought for a violation of the rights of the author under Section 106A, subsection A, an action for infringement of the copyright of a work that has been pre-registered under Section 408. Substacta F before the commencement of the infringement, and that has an effective date of registration not later than the earlier of 3 months after the first publication of the work or 1 month after the copyright owner has learned of the infringement. Or an action instituted under Section 411, subsection C, no award of statutory damages or of attorney's fees, as provided by Sections 504 and 505, shall be made for. Paragraph 1. Any infringement of copyright in an unpublished work commenced before the effective date of its registration, or Paragraph 2. Any infringement of copyright commenced after first publication of the work and before the effective date of its registration, unless such registration is made within 3 months after the first publication of the work. Section 501. Infringement of copyright. Subsection A. Anyone who violates any of the exclusive rights of the copyright owner as provided by Sections 106 through 122, or of the author as provided in Section 106A, subsection A, or who imports copies or phonorecords into the United States in violation of Section 602, is an infringer of the copyright or right of the author, as the case may be. For purposes of this chapter, other than Section 506, any reference to copyright shall be deemed to include the rights conferred by Section 106A, subsection A. As used in this subsection, the term anyone includes any state, any instrumentality of a state, and any officer or employee of a state or instrumentality of a state acting in his or her official capacity. Any state and any such instrumentality, officer, or employee shall be subject to the provisions of this title in the same manner and to the same extent as any non-governmental entity. Subsection B, the legal or beneficial owner of an exclusive right under a copyright is entitled, subject to the requirements of Section 411, to institute an action for any infringement of that particular right committed while he or she is the owner of it. The court may require such owner to serve written notice of the action with a copy of the complaint upon any person shown by the records of the Copyright Office or otherwise to have or claim an interest in the copyright, and shall require that such notice be served upon any person whose interest is likely to be affected by a decision in the case. The court may require the joinder, and shall permit the intervention, of any person having or claiming an interest in the copyright. Subsection C. For any secondary transmission by a cable system that embodies a performance or a display of a work which is actionable as an act of infringement under subsection C of Section 111. A TV broadcast station holding a copyright or other license to transmit or perform the same version of that work shall, for purposes of subsection B of this section, be treated as a legal or beneficial owner if such secondary transmission occurs within the local service area of that TV station. Subsection D. For any secondary transmission by a cable system that is actionable as an act of infringement pursuant to Section 111, Subsection C, Paragraph 3, the following shall also have standing to sue. Subsection I. The primary transmitter whose transmission has been altered by the cable system, and 2. Any broadcast station within whose local service area the secondary transmission occurs. Subsection E. With respect to any secondary transmission that is made by a satellite carrier of a performance or display of a work embodied in a primary transmission, and is actionable as an act of infringement under Section 119, Subsection A, Paragraph 3. A network station holding a copyright or other license to transmit or perform the same version of that work shall, for purposes of subsection B of this section, be treated as a legal or beneficial owner if such secondary transmission occurs within the local service area of that station. Subsection F, Paragraph 1. With respect to any secondary transmission that is made by a satellite carrier of a performance or display of a work embodied in a primary transmission and is actionable as an act of infringement under Section 122. A television broadcast station holding a copyright or other license to transmit or perform the same version of that work shall, for purposes of subsection B of this section, be treated as a legal or beneficial owner if such secondary transmission occurs within the local market of that station. Paragraph 2. A TV broadcast station may file a civil action against any satellite carrier that has refused to carry TV broadcast signals, as required under Section 122, Subsection A, Paragraph 2, to enforce that television broadcast station's rights under Section 338, Subsection A of the Communications Act of 1934. Section 502. Remedies for infringement, injunctions. Subsection A. Any court having jurisdiction of a civil action arising under this title may, subject to the provisions of Section 1498 of Title 28, grant temporary and final injunctions on such terms as it may deem reasonable to prevent or restrain infringement of a copyright. Subsection B. Any such injunction may be served anywhere in the United States on the person enjoined. It shall be operative throughout the United States and shall be enforceable by proceedings in contempt or otherwise by any United States court having jurisdiction of that person. The clerk of the court granting the injunction shall, when requested by any other court in which enforcement of the injunction is sought, transmit promptly to the other court a certified copy of all the papers in the case on file in such clerk's office. Section 503. Remedies for infringement, impounding and disposition of infringing articles. Subsection A, Paragraph 1. At any time while an action under this title is pending, the court may order the impounding on such terms as it may deem reasonable. Subparagraph A, of all copies or phonorecords claimed to have been made or used in violation of the exclusive right of the copyright owner. Subparagraph B, of all plates, molds, matrices, masters, tapes, film negatives, or other articles by means of which such copies or phonorecords may be reproduced, and Subparagraph C, of records documenting the manufacture, sale, or receipt of things involved in any such violation, provided that any record seized under this subparagraph shall be taken into the custody of the court. Paragraph 2. For impoundments of records ordered under Paragraph 1C, the court shall enter an appropriate protective order with respect to discovery and use of any records or information that has been impounded. The protective orders shall provide for appropriate procedures to ensure that confidential, private, proprietary, or privileged information contained in such records is not improperly disclosed or used. Paragraph 3. The relevant provisions of paragraphs 2 through 11 of Section 34, subsection D of the Trademark Act, Title 15, United States Code, Section 1116, subsection D. Paragraph 2 through 11 shall extend to any impoundment of records ordered under Paragraph 1C that is based upon an ex parte application, notwithstanding the provisions of Rule 65 of the Federal Rules of Civil Procedure. Any references in paragraphs 2 through 11 of Section 34, subsection D of the Trademark Act to Section 32 of such act shall be read as references to Section 501 of this title, and references to use of a counterfeit mark in connection with the sale, offering for sale, or distribution of goods or services shall be read as references to infringement of a copyright. Subsection B. As part of a final judgment or decree, the court may order the destruction or other reasonable disposition of all copies or phonorecords found to have been made or used in violation of the copyright owner's exclusive rights, and of all plates, molds, matrices, masters, tapes, film negatives, or other articles by means of which such copies or phonorecords may be reproduced. Section 504. Remedies for infringement, damages, and profits. Subsection A in general. Except as otherwise provided by this title, an infringer of copyright is liable for either. Paragraph 1. The copyright owner's actual damages and any additional profits of the infringer, as provided by subsection B, or Paragraph 2. Statutory damages, as provided by subsection C. Subsection B. Actual damages and profits. The copyright owner is entitled to recover the actual damages suffered by him or her as a result of the infringement, and any profits of the infringer that are attributable to the infringement and are not taken into account in computing the actual damages. In establishing the infringer's profits, the copyright owner is required to present proof only of the infringer's gross revenue, and the infringer is required to prove his or her deductible expenses and the elements of profit attributable to factors other than the copyrighted work. Subsection C. Statutory damages. Paragraph 1. Except as provided by Clause 2 of this subsection, the copyright owner may elect, at any time before final judgment is rendered, to recover, instead of actual damages and profits, an award of statutory damages for all infringements involved in the action. With respect to any one work for which any one infringer is liable individually, or for which any two or more infringers are liable jointly and severally, in a sum of not less than $750 or more than $30,000, as the court considers just. For the purposes of this subsection, all the parts of a compilation or derivative work constitute one work. Paragraph 2. In a case where the copyright owner sustains the burden of proving, and the court finds, that infringement was committed willfully, the court in its discretion may increase the award of statutory damages to a sum of not more than $150,000. In a case where the infringer sustains the burden of proving, and the court finds that such infringer was not aware, and had no reason to believe that his or her acts constituted an infringement of copyright, the court in its discretion may reduce the award of statutory damages to a sum of not less than $200. The court shall remit statutory damages in any case where an infringer believed and had reasonable grounds for believing that his or her use of the copyrighted work was a fair use under Section 107, if the infringer was, subsection I, an employee or agent of a nonprofit educational institution, library, or archives acting within the scope of his or her employment who, or such institution, library, or archives itself, which infringed by reproducing the work in copies or phonorecords. Or 2, a public broadcasting entity which, or a person who, as a regular part of the nonprofit activities of a public broadcasting entity as defined in Section 118. Substact F, infringed by performing a published non-dramatic literary work or by reproducing a transmission program embodying a performance of such a work. Paragraph 3, subparagraph A. In a case of infringement, it shall be a rebuttable presumption that the infringement was committed willfully for purposes of determining relief if the violator, or a person acting in concert with the violator, knowingly provided or knowingly caused to be provided materially false contact information to a domain name registrar, domain name registry, or other domain name registration authority in registering, maintaining, or renewing a domain name used in connection with the infringement. Subparagraph B. Nothing in this paragraph limits what may be considered willful infringement under this subsection. Subparagraph C. For purposes of this paragraph, the term domain name has the meaning given that term in Section 45 of the Act entitled, An Act to Provide for the Registration and Protection of Trademarks Used in Commerce, to carry out the provisions of certain international conventions and for other purposes approved July 5, 1946, commonly referred to as the Trademark Act of 1946. Title 15, United States Code, Section 1127. Subsection D. Additional damages in certain cases. In any case in which the court finds that a defendant proprietor of an establishment who claims as a defense that its activities were exempt under Section 110, Substag 5 did not have reasonable grounds to believe that its use of a copyrighted work was exempt under such section, the plaintiff shall be entitled to, in addition to an additional award of 2 times the amount of the license fee that the proprietor of the establishment concerned should have paid the plaintiff for such use during the preceding period of up to 3 years. Section 505. Remedies for infringement, costs and attorney's fees. In any civil action under this title, the court in its discretion may allow the recovery of full costs by or against any party other than the United States or an officer thereof. Except as otherwise provided by this title, the court may also award a reasonable attorney's fee to the prevailing party as part of the costs. Section 506. Criminal offenses. Subsection A. Criminal infringement. Paragraph 1. In general, any person who willfully infringes a copyright shall be punished as provided under Section 2319 of Title 18 if the infringement was committed. Subparagraph A. For purposes of commercial advantage or private financial gain. Subparagraph B. By the reproduction or distribution, including by electronic means, during any 180-day period, of one or more copies or phonorecords of one or more copyrighted works, which have a total retail value of more than $1,000, or, subparagraph C. By the distribution of a work being prepared for commercial distribution, by making it available on a computer network accessible to members of the public, if such person knew or should have known that the work was intended for commercial distribution. Paragraph 2. Evidence. For purposes of this subsection, evidence of reproduction or distribution of a copyrighted work, by itself, shall not be sufficient to establish willful infringement of a copyright. Paragraph 3. Definition. In this subsection, the term work being prepared for commercial distribution means: subparagraph A, a computer program, a musical work, a motion picture or other audiovisual work, or a sound recording if, at the time of unauthorized distribution, Clause 1. The copyright owner has a reasonable expectation of commercial distribution, and Clause 2. The copies or phonorecords of the work have not been commercially distributed, or subparagraph B, a motion picture, if, at the time of unauthorized distribution, the motion picture. Clause 1 has been made available for viewing in a motion picture exhibition facility, and Clause 2 has not been made available in copies for sale to the general public in the United States in a format intended to permit viewing outside a motion picture exhibition facility. Subsection B, forfeiture, destruction, and restitution. Forfeiture, destruction, and restitution relating to this section shall be subject to Section 2323 of Title 18, to the extent provided in that section, in addition to any other similar remedies provided by law. Subsection C, fraudulent copyright notice. Any person who with fraudulent intent places on any article a notice of copyright or words of the same purport that such person knows to be false, or who with fraudulent intent publicly distributes or imports for public distribution any article bearing such notice or words that such person knows to be false, shall be fined not more than $2,500. Subsection D, fraudulent removal of copyright notice. Any person who with fraudulent intent removes or alters any notice of copyright appearing on a copy of a copyrighted work shall be fined not more than $2,500. Subsection E, false representation. Any person who knowingly makes a false representation of a material fact in the application for copyright registration provided for by Section 409, or in any written statement filed in connection with the application, shall be fined not more than $2,500. Subsection F, rights of attribution and integrity. Nothing in this section applies to infringement of the rights conferred by Section 106A, subsection A. Section 507, limitations on actions. Subsection A, criminal proceedings, except as expressly provided otherwise in this title. No criminal proceeding shall be maintained under the provisions of this title, unless it is commenced within 5 years after the cause of action arose. Subsection B, civil actions. No civil action shall be maintained under the provisions of this title, unless it is commenced within 3 years after the claim accrued. Section 508, notification of filing and determination of actions. Subsection A, within 1 month after the filing of any action under this title, the clerks of the courts of the United States shall send written notification to the Register of Copyrights setting forth, as far as is shown by the papers filed in the court, the names and addresses of the parties in the title, author, and registration number of each work involved in the action. If any other copyrighted work is later included in the action by amendment, answer, or other pleading, the clerk shall also send a notification concerning it to the register within 1 month after the pleading is filed. Subsection B, within 1 month after any final order or judgment is issued in the case, the clerk of the court shall notify the register of it, sending with the notification a copy of the order or judgment together with the written opinion, if any, of the court. Subsection C, upon receiving the notification specified in this section, the register shall make them a part of the public records of the Copyright Office. Section 509, repealed. Public Law 110-403, Title II, Section 201, Subsection B, Paragraph 1, October 13, 2008. 122 Statutes at Large for 2260. Section 510, remedies for alteration of programming by cable systems. Subsection A, in any action filed pursuant to Section 111, Subsection C, Paragraph 3, the following remedies shall be available. Paragraph 1. Where an action is brought by a party identified in subsections B or C of Section 501, the remedies provided by Sections 502 through 505, and the remedy provided by subsection B of this section, and Paragraph 2. When an action is brought by a party identified in subsection D of Section 501, the remedies provided by Sections 502 and 505, together with any actual damages suffered by such party as a result of the infringement, and the remedy provided by subsection B of this section. Subsection B. In any action filed pursuant to Section 111, Subsection C, Paragraph 3, the court may decree that, for a period not to exceed 30 days, the cable system shall be deprived of the benefit of a statutory license for one or more distant signals carried by such cable system. Section 511, liability of states, instrumentalities of states, and state officials for infringement of copyright. Subsection A, in general. Any state, any instrumentality of a state, and any officer or employee of a state or instrumentality of a state acting in his or her official capacity shall not be immune, under the 11th Amendment of the Constitution of the United States, or under any other doctrine of sovereign immunity, from suit in federal court by any person, including any governmental or non-governmental entity, for a violation of any of the exclusive rights of a copyright owner provided by Sections 106 through 122, for importing copies of phonorecords in violation of Section 602, or for any other violation under this title. Subsection B, remedies. In a suit described in subsection A for a violation described in that subsection, remedies, including remedies both at law and in equity, are available for the violation to the same extent as such remedies are available for such a violation in a suit against any public or private entity other than a state, instrumentality of a state, or officer or employee of a state acting in his or her official capacity. Such remedies include impounding and disposition of infringing articles under Section 503, actual damages and profits and statutory damages under Section 504, costs and attorney's fees under Section 505, and the remedies provided in Section 510. Section 512, Limitations on liability relating to material online. Subsection A, Transitory Digital Network Communications. A service provider shall not be liable for monetary relief, or, except as provided in subsection J, for injunctive or other equitable relief, for infringement of copyright by reason of the provider's transmitting, routing, or providing connections for material through a system or network controlled or operated by or for the service provider, or by reason of the intermediate and transient storage of that material in the course of such transmitting, routing, or providing connections if. Paragraph 1. The transmission of the material was initiated by or at the direction of a person other than the service provider. Paragraph 2. The transmission, routing, provision of connections or storage is carried out through an automatic technical process without selection of the material by the service provider. Paragraph 3. The service provider does not select the recipients of the material except as an automatic response to the request of another person. Paragraph 4. No copy of the material made by the service provider in the course of such intermediate or transient storage is maintained on the system or network in a manner ordinarily accessible to anyone other than anticipated recipients, and no such copy is maintained on the system or network in a manner ordinarily accessible to such anticipated recipients for a longer period than is reasonably necessary for the transmission, routing, or provision of connections. And Paragraph 5. The material is transmitted through the system or network without modification of its content. Subsection B, System Caching. Paragraph 1. Limitation on liability. A service provider shall not be liable for monetary relief, or, except as provided in subsection J, for injunctive or other equitable relief, for infringement of copyright by reason of the intermediate and temporary storage of material on a system or network controlled or operated by or for the service provider in a case in which Subparagraph A. The material is made available online by a person other than the service provider. Subparagraph B. The material is transmitted from the person described in subparagraph A through the system or network to a person other than the person described in subparagraph A at the direction of that other person. And Subparagraph C. The storage is carried out through an automatic technical process for the purpose of making the material available to users of the system or network who, after the material is transmitted as described in subparagraph B, request access to the material from the person described in subparagraph A if the conditions set forth in paragraph 2 are met. Paragraph 2. Conditions. The conditions referred to in paragraph 1 are that Subparagraph A. The material described in paragraph 1 is transmitted to the subsequent users described in paragraph 1C without modification to its content from the manner in which the material was transmitted from the person described in paragraph 1A. Subparagraph B. The service provider described in paragraph 1 complies with rules concerning the refreshing, reloading, or other updating of the material when specified by the person making the material available online in accordance with a generally accepted industry standard data communications protocol for the system or network through which that person makes the material available, except that this subparagraph applies only if those rules are not used by the person described in paragraph 1A to prevent or unreasonably impair the intermediate storage to which this subsection applies. Subparagraph C. The service provider does not interfere with the ability of technology associated with the material to return to the person described in paragraph 1 the information that would have been available to that person if the material had been obtained by the subsequent users described in paragraph 1C directly from that person, except that this subparagraph applies only if that technology. Clause 1 does not significantly interfere with the performance of the provider's system or network or with the intermediate storage of the material. Clause 2 is consistent with generally accepted industry standard communications protocols, and Clause 3 does not extract information from the provider's system or network other than the information that would have been available to the person described in paragraph 1A if the subsequent users had gained access to the material directly from that person. Subparagraph D. If the person described in paragraph 1A has in effect a condition that a person must meet prior to having access to the material, such as a condition based on payment of a fee or provision of a password or other information, the service provider permits access to the stored material in significant part only to users of its system or network that have met those conditions and only in accordance with those conditions. And Subparagraph E. If the person described in paragraph 1A makes that material available online without the authorization of the copyright owner of the material, the service provider responds expeditiously to remove or disable access to the material that is claimed to be infringing upon notification of claimed infringement as described in subsection C3, except that this subparagraph applies only if Clause 1. The material has previously been removed from the originating site or access to it has been disabled, or a court has ordered that the material be removed from the originating site or that access to the material on the originating site be disabled, and Clause 2. The party giving the notification includes in the notification a statement confirming that the material has been removed from the originating site or access to it has been disabled, or that a court has ordered that the material be removed from the originating site, or that access to the material on the originating site be disabled. Subsection C, information residing on systems or networks at direction of users. Paragraph 1, in general. A service provider shall not be liable for monetary relief, or except as provided in subsection J for injunctive or other equitable relief, for infringement of copyright by reason of the storage at the direction of a user of material that resides on a system or network controlled or operated by or for the service provider, if the service provider. Subparagraph A, Clause 1, does not have actual knowledge that the material or an activity using the material on the system or network is infringing. Subsection 2, in the absence of such actual knowledge is not aware of facts or circumstances from which infringing activity is apparent, or Subsection 3, upon obtaining such knowledge or awareness acts expeditiously to remove or disable access to the material. Subparagraph B does not receive a financial benefit directly attributable to the infringing activity in a case in which the service provider has the right and ability to control such activity, and Subparagraph C, upon notification of claimed infringement as described in paragraph 3, responds expeditiously to remove or disable access to the material that is claimed to be infringing or to be the subject of infringing activity. Paragraph 2. Designated agent. The limitations on liability established in this subsection apply to a service provider only if the service provider has designated an agent to receive notifications of claimed infringement described in paragraph 3 by making available through its service, including on its website in a location accessible to the public, and by providing to the Copyright Office substantially the following information. Subparagraph A, the name, address, phone number, and electronic mail address of the agent. Subparagraph B, other contact information which the Register of Copyrights may deem appropriate. The Register of Copyrights shall maintain a current directory of agents available to the public for inspection, including through the Internet, and may require payment of a fee by service providers to cover the costs of maintaining the directory. Paragraph 3, elements of notification. Subparagraph A, to be effective under this subsection, a notification of claimed infringement must be a written communication provided to the designated agent of a service provider that includes substantially the following. Clause 1, a physical or electronic signature of a person authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. Clause 2, identification of the copyrighted work claimed to have been infringed, or if multiple copyrighted works at a single online site are covered by a single notification, a representative list of such works at that site. Clause 3, identification of the material that is claimed to be infringing or to be the subject of infringing activity and that is to be removed or access to which is to be disabled, and information reasonably sufficient to permit the service provider to locate the material. Clause 4. Information reasonably sufficient to permit the service provider to contact the complaining party, such as an address, telephone number, and, if available, an electronic mail address at which the complaining party may be contacted. Clause 5. A statement that the complaining party has a good faith belief that use of the material in the manner complained of is not authorized by the copyright owner, its agent, or the law. Clause 6. A statement that the information in the notification is accurate and under penalty of perjury, that the complaining party is authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. Subparagraph B, Clause 1. Subject to Clause 2, a notification from a copyright owner or from a person authorized to act on behalf of the copyright owner that fails to comply substantially with the provisions of subparagraph A shall not be considered under paragraph 1, A, in determining whether a service provider has actual knowledge or is aware of facts or circumstances from which infringing activity is apparent. Subsection 2. In a case in which the notification that is provided to the service provider's designated agent fails to comply substantially with all the provisions of subparagraph A, but substantially complies with clauses 2, 3, and 4 of subparagraph A. Clause of this I of this of subparagraph applies only if the service provider promptly attempts to contact the person making the notification or takes other reasonable steps to assist in the receipt of notification that substantially complies with all the provisions of subparagraph A. Subsection D, information location tools. A service provider shall not be liable for monetary relief, or, except as provided in subsection J, for injunctive or other equitable relief, for infringement of copyright by reason of the provider referring or linking users to an online location containing infringing material or infringing activity by using information location tools, including a directory, index, reference pointer, or hypertext link if the service provider. Paragraph 1. Subparagraph A does not have actual knowledge that the material or activity is infringing. Subparagraph B, in the absence of such actual knowledge, is not aware of facts or circumstances from which infringing activity is apparent, or subparagraph C, upon obtaining such knowledge or awareness, acts expeditiously to remove or disable access to the material. Paragraph 2. Does not receive a financial benefit directly attributable to the infringing activity, in a case in which the service provider has the right and ability to control such activity, and Paragraph 3. upon notification of claimed infringement as described in subsection C3, responds expeditiously to remove or disable access to the material that is claimed to be infringing or to be the subject of infringing activity, except that, for purposes of this paragraph, the information described in subsection C3A3 shall be identification of the reference or link to material or activity claimed to be infringing, that is to be removed, or access to which is to be disabled, and information reasonably sufficient to permit the service provider to locate that reference or link. Subsection E, limitation on liability of nonprofit educational institutions, paragraph 1. When a public or other nonprofit institution of higher education is a service provider, and when a faculty member or graduate student who is an employee of such institution is performing a teaching or research function, for the purposes of subsections A and B, such faculty member or graduate student shall be considered to be a person other than the institution. And for the purposes of subsections C and D, such faculty members or graduate students' knowledge or awareness of his or her infringing activities shall not be attributed to the institution, if subparagraph A. Such faculty members or graduate students' infringing activities do not involve the provision of online access to instructional materials that are or were required or recommended within the preceding 3-year period for a course taught at the institution by such faculty member or graduate student. Subparagraph B. The institution has not, within the preceding 3-year period, received more than 2 notifications described in subsection C3 of claimed infringement by such faculty member or graduate student, and such notifications of claimed infringement were not actionable under subsection F, and subparagraph C, the institution provides to all users of its system or network informational materials that accurately describe and promote compliance with the laws of the United States relating to copyright. Paragraph 2. For the purposes of this subsection, the limitations on injunctive relief contained in subsections J2 and J3, but not those in J1, shall apply. Subsection F, misrepresentations. Any person who knowingly materially misrepresents under this section, paragraph 1, that material or activity is infringing, or paragraph 2, that material or activity was removed or disabled by mistake or misidentification, shall be liable for any damages, including costs and attorney's fees incurred by the alleged infringer, by any copyright owner or copyright owner's authorized licensee, or by a service provider who is injured by such misrepresentation, as the result of the service provider relying upon such misrepresentation in removing or disabling access to the material or activity claimed to be infringing, or in replacing the removed material or ceasing to disable access to it. Subsection G, replacement of removed or disabled material and limitation on other liability. Paragraph 1. No liability for taking down generally. Subject to paragraph 2, a service provider shall not be liable to any person for any claim based on the service provider's good faith disabling of access to or removal of material or activity claimed to be infringing, or based on facts or circumstances from which infringing activity is apparent, regardless of whether the material or activity is ultimately determined to be infringing. Paragraph 2. Exception. Paragraph 1 shall not apply with respect to material residing at the direction of a subscriber of the service provider on a system or network controlled or operated by or for the service provider that is removed, or to which access is disabled by the service provider, pursuant to a notice provided under subsection C1C, unless the service provider. Subparagraph A takes reasonable steps promptly to notify the subscriber that it has removed or disabled access to the material. Subparagraph B, upon receipt of a counter notification described in paragraph 3, promptly provides the person who provided the notification under subsection C1C with a copy of the counter notification, and informs that person that it will replace the removed material or cease disabling access to it in 10 business days, and subparagraph C, replaces the removed material and ceases disabling access to it not less than 10, nor more than 14, business days following receipt of the counter notice, unless its designated agent first receives notice from the person who submitted the notification under subsection C1C that such person has filed an action seeking a court order to restrain the subscriber from engaging in infringing activity relating to the material on the service provider's system or network. Paragraph 3. Contents of counter notification. To be effective under this subsection, a counter notification must be a written communication provided to the service provider's designated agent that includes substantially the following. Subparagraph A. A physical or electronic signature of the subscriber. Subparagraph B. Identification of the material that has been removed or to which access has been disabled and the location at which the material appeared before it was removed or access to it was disabled. Subparagraph C. A statement under penalty of perjury that the subscriber has a good faith belief that the material was removed or disabled as a result of mistake or misidentification of the material to be removed or disabled. Subparagraph D. The subscriber's name, address, and telephone number, and a statement that the subscriber consents to the jurisdiction of Federal District Court for the judicial district in which the address is located, or if the subscriber's address is outside of the United States, for any judicial district in which the service provider may be found, and that the subscriber will accept service of process from the person who provided notification under subsection C1C or an agent of such person. Paragraph 4. Limitation on other liability. A service provider's compliance with paragraph 2 shall not subject the service provider to liability for copyright infringement with respect to the material identified in the notice provided under subsection C1C. Subsection H. Subpoena to identify infringer. Paragraph 1. Request. A copyright owner or a person authorized to act on the owner's behalf may request the clerk of any United States District Court to issue a subpoena to a service provider for identification of an alleged infringer in accordance with this subsection. Paragraph 2. Contents of request. The request may be made by filing with the clerk. Subparagraph A. A copy of a notification described in subsection C3A. Subparagraph B. A proposed subpoena. And subparagraph C. A sworn declaration to the effect that the purpose for which the subpoena is sought is to obtain the identity of an alleged infringer and that such information will only be used for the purpose of protecting rights under this title. Paragraph 3. Contents of subpoena. The subpoena shall authorize and order the service provider receiving the notification and the subpoena to expeditiously disclose to the copyright owner or person authorized by the copyright owner information sufficient to identify the alleged infringer of the material described in the notification, to the extent such information is available to the service provider. Paragraph 4. Basis for granting subpoena. If the notification filed satisfies the provisions of subsection C3A, the proposed subpoena is in proper form, and the accompanying declaration is properly executed, the clerk shall expeditiously issue and sign the proposed subpoena and return it to the requester for delivery to the service provider. Paragraph 5. Actions of service provider receiving subpoena. Upon receipt of the issued subpoena, either accompanying or subsequent to the receipt of a notification described in subsection C3A, the service provider shall expeditiously disclose to the copyright owner or person authorized by the copyright owner the information required by the subpoena, notwithstanding any other provision of law and regardless of whether the service provider responds to the notification. Paragraph 6. Rules applicable to subpoena. Unless otherwise provided by this section or by applicable rules of the court, the procedure for issuance and delivery of the subpoena and the remedies for non-compliance with the subpoena shall be governed to the greatest extent practicable by those provisions of the Federal Rules of Civil Procedure governing the issuance, service, and enforcement of a subpoena ducis tecum. Subsection I. Conditions for eligibility. Paragraph 1. Accommodation of technology. The limitations on liability established by this section shall apply to a service provider only if the service provider, subparagraph A, has adopted and reasonably implemented and informs subscribers and account holders of the service provider system or network of a policy that provides for the termination in appropriate circumstances of subscribers and account holders of the service provider system or network who are repeat infringers, and subparagraph B accommodates and does not interfere with standard technical measures. Paragraph 2. Definition. As used in this subsection, the term standard technical measures means technical measures that are used by copyright owners to identify or protect copyrighted works, and subparagraph A have been developed pursuant to a broad consensus of copyright owners and service providers in an open, fair, voluntary, multi-industry standards process. Subparagraph B are available to any person on reasonable and non-discriminatory terms, and subparagraph C do not impose substantial costs on service providers or substantial burdens on their systems or networks. Subsection J. Injunctions. The following rules shall apply in the case of any application for an injunction under Section 502 against a service provider that is not subject to monetary remedies under this section. Paragraph 1. Scope of relief. Subparagraph A. With respect to conduct other than that which qualifies for the limitation on remedies set forth in subsection A, the court may grant injunctive relief with respect to a service provider only in one or more of the following forms. Clause 1. An order restraining the service provider from providing access to infringing material or activity residing at a particular online site on the provider's system or network. Clause 2. An order restraining the service provider from providing access to a subscriber or account holder of the service provider's system or network who is engaging in infringing activity and is identified in the order, by terminating the accounts of the subscriber or account holder that are specified in the order. Clause 3. Such other injunctive relief as the court may consider necessary to prevent or restrain infringement of copyrighted material specified in the order of the court at a particular online location, if such relief is the least burdensome to the service provider among the forms of relief comparably effective for that purpose. Subparagraph B. If the service provider qualifies for the limitation on remedies described in subsection A, the court may only grant injunctive relief in one or both of the following forms. Clause 1. An order restraining the service provider from providing access to a subscriber or account holder of the service provider's system or network who is using the provider's service to engage in infringing activity and is identified in the order, by terminating the accounts of the subscriber or account holder that are specified in the order. Clause 2. An order restraining the service provider from providing access by taking reasonable steps specified in the order to block access to a specific identified online location outside the United States. Paragraph 2. Considerations. The court, in considering the relevant criteria for injunctive relief under applicable law, shall consider. Subparagraph A. Whether such an injunction, either alone or in combination with other such injunctions issued against the same service provider under this subsection, would significantly burden either the provider or the operation of the provider's system or network. Subparagraph B, the magnitude of the harm likely to be suffered by the copyright owner in the digital network environment if steps are not taken to prevent or restrain the infringement. Subparagraph C, whether implementation of such an injunction would be technically feasible and effective and would not interfere with access to non-infringing material at other online locations. And subparagraph D, whether other less burdensome and comparably effective means of preventing or restraining access to the infringing material are available. Paragraph 3, notice and ex parte orders. Injunctive relief under this subsection shall be available only after notice to the service provider and an opportunity for the service provider to appear are provided, except for orders ensuring the preservation of evidence or other orders having no material adverse effect on the operation of the service provider's communications network. Subsection K, definitions. Paragraph 1, service provider. Subparagraph A. As used in subsection A, the term service provider means an entity offering the transmission, routing, or providing of connections for digital online communications between or among points specified by a user of material of the user's choosing, without modification to the content of the material as sent or received. Subparagraph B, as used in this section other than subsection A, the term service provider means a provider of online services or network access, or the operator of facilities therefore, and includes an entity described in subparagraph A. Paragraph 2, monetary relief. As used in this section, the term monetary relief means damages, costs, attorney's fees, and any other form of monetary payment. Subsection L, other defenses not affected. The failure of a service provider's conduct to qualify for limitation of liability under this section shall not bear adversely upon the consideration of a defense by the service provider, that the service provider's conduct is not infringing under this title or any other defense. Subsection M, protection of privacy. Nothing in this section shall be construed to condition the applicability of subsections A through D on. Paragraph 1. A service provider monitoring its service or affirmatively seeking facts indicating infringing activity, except to the extent consistent with a standard technical measure complying with the provisions of subsection I or. Paragraph 2. A service provider gaining access to, removing, or disabling access to material in cases in which such conduct is prohibited by law. Subsection N, construction. Subsections A, B, C, and D describe separate and distinct functions for purposes of applying this section. Whether a service provider qualifies for the limitation on liability in any one of those subsections shall be based solely on the criteria in that subsection, and shall not affect a determination of whether that service provider qualifies for the limitations on liability under any other such subsection. Section 513, determination of reasonable license fees for individual proprietors. In the case of any performing rights society subject to a consent decree which provides for the determination of reasonable license rates or fees to be charged by the performing rights society, notwithstanding the provisions of that consent decree, an individual proprietor who owns or operates fewer than 7 non-publicly traded establishments in which non-dramatic musical works are performed publicly, and who claims that any license agreement offered by that performing rights society is unreasonable in its license rate or fee as to that individual proprietor, shall be entitled to determination of a reasonable license rate or fee as follows. Paragraph 1. The individual proprietor may commence such proceeding for determination of a reasonable license rate or fee by filing an application in the applicable district court under paragraph 2 that a rate disagreement exists and by serving a copy of the application on the performing rights society. Such proceeding shall commence in the applicable district court within 90 days after the service of such copy, except that such 90-day requirement shall be subject to the administrative requirements of the court. Paragraph 2. The proceeding under paragraph 1 shall be held at the individual proprietor's election in the judicial district of the district court with jurisdiction over the applicable consent decree, or in that place of holding court of a district court that is the seat of the federal circuit, other than the Court of Appeals for the federal circuit, in which the proprietor's establishment is located. Paragraph 3. Such proceeding shall be held before the judge of the court with jurisdiction over the consent decree governing the performing rights society. At the discretion of the court, the proceeding shall be held before a special master or magistrate judge appointed by such judge. Should that consent decree provide for the appointment of an advisor or advisors to the court for any purpose, any such advisor shall be the special master so named by the court. Paragraph 4. In any such proceeding, the industry rate shall be presumed to have been reasonable at the time it was agreed to or determined by the court. Such presumption shall in no way affect a determination of whether the rate is being correctly applied to the individual proprietor. Paragraph 5. Pending the completion of such proceeding, the individual proprietor shall have the right to perform publicly the copyrighted musical compositions in the repertoire of the Performing Rights Society by paying an interim license rate or fee into an interest-bearing escrow account with the clerk of the court, subject to retroactive adjustment when a final rate or fee has been determined, in an amount equal to the industry rate, or in the absence of an industry rate, the amount of the most recent license rate or fee agreed to by the parties. Paragraph 6. Any decision rendered in such proceeding by a special master or magistrate judge named under paragraph 3 shall be reviewed by the judge of the court with jurisdiction over the consent decree governing the Performing Rights Society. Such proceeding, including such review, shall be concluded within 6 months after its commencement. Paragraph 7. Any such final determination shall be binding only as to the individual proprietor commencing the proceeding, and shall not be applicable to any other proprietor or any other Performing Rights Society. And the Performing Rights Society shall be relieved of any obligation of non-discrimination among similarly situated music users that may be imposed by the consent decree governing its operations. Paragraph 8. An individual proprietor may not bring more than one proceeding provided for in this section for the determination of a reasonable license rate or fee under any license agreement with respect to any one Performing Rights Society. Paragraph 9. For purposes of this section, the term industry rate means the license fee a Performing Rights Society has agreed to with, or which has been determined by the court, for a significant segment of the music user industry to which the individual proprietor belongs. Section 601 repealed. Public Law 111-295, Section 4, Subsection A, December 9, 2010, 124 Statutes at Large, 31080. Section 602. Infringing importation or exportation of copies or phonorecords. Subsection A. Infringing importation or exportation. Paragraph 1. Importation. Importation into the United States without the authority of the owner of copyright under this title of copies or phonorecords of a work that have been acquired outside the United States is an infringement of the exclusive right to distribute copies or phonorecords under Section 106, actionable under Section 501. Paragraph 2. Importation or exportation of infringing items. Importation into the United States or exportation from the United States without the authority of the owner of copyright under this title of copies or phonorecords, the making of which either constituted an infringement of copyright or which would have constituted an infringement of copyright if this title had been applicable, is an infringement of the exclusive right to distribute copies or phonorecords under Section 106, actionable under Sections 501 and 506. Paragraph 3. Exceptions. This subsection does not apply to Subparagraph A. Importation or exportation of copies or phonorecords under the authority or for the use of the government of the United States or of any state or political subdivision of a state, but not including copies or phonorecords for use in schools, or copies of any audiovisual work imported for purposes other than archival use. Subparagraph B. Importation or exportation for the private use of the importer or exporter and not for distribution, by any person with respect to no more than one copy or phonorecord of any one work at any one time, or by any person arriving from outside the United States or departing from the United States with respect to copies or phonorecords forming part of such person's personal baggage, or Subparagraph C. Importation by or for an organization operated for scholarly, educational, or religious purposes and not for private gain, with respect to no more than one copy of an audiovisual work solely for its archival purposes, and no more than 5 copies or phonorecords of any other work for its library lending or archival purposes, unless the importation of such copies or phonorecords is part of an activity consisting of systematic reproduction or distribution, engaged in by such organization in violation of the provisions of Section 108, subsection G, paragraph 2. Subsection B. Import prohibition. In a case where the making of the copies or phonorecords would have constituted an infringement of copyright if this title had been applicable, their importation is prohibited. In a case where the copies or phonorecords were lawfully made, United States Customs and Border Protection has no authority to prevent their importation. In either case, the Secretary of the Treasury is authorized to prescribe, by regulation, a procedure under which any person claiming an interest in the copyright in a particular work may, upon payment of a specified fee, be entitled to notification by United States Customs and Border Protection of the importation of articles that appear to be copies or phonorecords of the work. Section 603. Importation prohibitions, enforcement and disposition of excluded articles. Subsection A. The Secretary of the Treasury and the United States Postal Service shall separately or jointly make regulations for the enforcement of the provisions of this title prohibiting importation. Subsection B. These regulations may require, as a condition for the exclusion of articles under Section 602, Paragraph 1, that the person seeking exclusion obtain a court order enjoining importation of the articles, or Paragraph 2, that the person seeking exclusion furnish proof, of a specified nature, and in accordance with prescribed procedures, that the copyright in which such person claims an interest is valid, and that the importation would violate the prohibition in Section 602. The person seeking exclusion may also be required to post a surety bond for any injury that may result if the detention or exclusion of the articles proves to be unjustified. Subsection C. Articles imported in violation of the importation prohibitions of this title are subject to seizure and forfeiture in the same manner as property imported in violation of the customs revenue laws. Forfeited articles shall be destroyed as directed by the Secretary of the Treasury or the court, as the case may be. Section 701. The Copyright Office. General responsibilities and organization. Subsection A. All administrative functions and duties under this title, except as otherwise specified, are the responsibility of the Register of Copyrights as Director of the Copyright Office of the Library of Congress. The Register of Copyrights, together with the subordinate officers and employees of the Copyright Office, shall be appointed by the Librarian of Congress, and shall act under the Librarian's general direction and supervision. Subsection B. In addition to the functions and duties set out elsewhere in this chapter, the Register of Copyrights shall perform the following functions. Paragraph 1. Advise Congress on national and international issues relating to copyright, other matters arising under this title, and related matters. Paragraph 2. Provide information and assistance to federal departments and agencies and the judiciary on national and international issues relating to copyright, other matters arising under this title, and related matters. Paragraph 3. Participate in meetings of international intergovernmental organizations and meetings with foreign government officials relating to copyright, other matters arising under this title, and related matters, including as a member of United States delegations as authorized by the appropriate executive branch authority. Paragraph 4. Conduct studies and programs regarding copyright, other matters arising under this title, and related matters, the administration of the Copyright Office or any function vested in the Copyright Office by law, including educational programs conducted cooperatively with foreign intellectual property offices and international intergovernmental organizations. Paragraph 5. Perform such other functions as Congress may direct, or as may be appropriate in furtherance of the functions and duties specifically set forth in this title. Subsection C. The Register of Copyrights shall adopt a seal to be used on and after January 1, 1978, to authenticate all certified documents issued by the Copyright Office. Subsection D. The Register of Copyrights shall make an annual report to the Librarian of Congress of the work and accomplishments of the Copyright Office during the previous fiscal year. The annual report of the Register of Copyrights shall be published separately and as a part of the annual report of the Librarian of Congress. Subsection E. Except as provided by Section 706, Subsection B, and the regulations issued thereunder, all actions taken by the Register of Copyrights under this title are subject to the provisions of the Administrative Procedure Act of June 11, 1946, as amended c. 324, 60 Statutes at Large 237, Title 5, United States Code, Chapter 5, Subchapter 2, and Chapter 7. Subsection F. The Register of Copyrights shall be compensated at the greater of the rate of pay in effect for Level 3 of the Executive Schedule under Section 5314 of Title 5, or the maximum annual rate of basic pay payable under Section 53337 of such title for positions at agencies with a performance appraisal system certified under Section 5337. Substat D of such title. The Librarian of Congress shall establish not more than 4 positions for Associate Registers of Copyrights in accordance with the recommendations of the Register of Copyrights. The librarian shall make appointments to such positions after consultation with the Register of Copyrights. The rate of basic pay for each Associate Register of Copyrights shall be fixed in accordance with Section 5376 of Title 5. Section 702. Copyright Office Regulations. The Register of Copyrights is authorized to establish regulations not inconsistent with law for the administration of the functions and duties made the responsibility of the Register under this title. All regulations established by the Register under this title are subject to the approval of the Librarian of Congress. Section 703. Effective date of actions in Copyright Office. In any case in which time limits are prescribed under this title for the performance of an action in the Copyright Office, and in which the last day of the prescribed period falls on a Saturday-Sunday holiday, or other non-business day within the District of Columbia or the federal government, the action may be taken on the next succeeding business day and is effective as of the date when the period expired. Section 704. Retention and disposition of articles deposited in Copyright Office. Subsection A. Upon their deposit in the Copyright Office under Sections 407 and 408, all copies, phonorecords, and identifying material, including those deposited in connection with claims that have been refused registration, are the property of the United States government. Subsection B. In the case of published works, all copies, phonorecords, and identifying material deposited are available to the Library of Congress for its collections or for exchange or transfer to any other library. In the case of unpublished works, the library is entitled, under regulations that the Register of Copyrights shall prescribe, to select any deposits for its collections or for transfer to the National Archives of the United States or to a federal record center, as defined in Section 2901 of Title 44. Subsection C. The Register of Copyrights is authorized for specific or general categories of works to make a facsimile reproduction of all or any part of the material deposited under Section 408, and to make such reproduction a part of the Copyright Office records of the registration before transferring such material to the Library of Congress as provided by subsection B, or before destroying or otherwise disposing of such material as provided by subsection D. Subsection D. Deposits not selected by the library under subsection B, or identifying portions or reproductions of them, shall be retained under the control of the Copyright Office, including retention in government storage facilities, for the longest period considered practicable and desirable by the Register of Copyrights and the Librarian of Congress. After that period, it is within the joint discretion of the Register and the Librarian to order their destruction or other disposition. But in the case of unpublished works, no deposit shall be knowingly or intentionally destroyed or otherwise disposed of during its term of copyright, unless a facsimile reproduction of the entire deposit has been made a part of the Copyright Office records, as provided by subsection C. Subsection E. The depositor of copies, phonorecords, or identifying material under Section 408, or the copyright owner of record, may request retention under the control of the Copyright Office of one or more of such articles for the full term of copyright in the work. The Register of Copyrights shall prescribe, by regulation, the conditions under which such requests are to be made and granted, and shall fix the fee to be charged under Section 738, subsection A, if the request is granted. Section 705. Copyright Office Records: Preparation, Maintenance, Public Inspection, and Searching. Subsection A. The Register of Copyrights shall ensure that records of deposits, registrations, recordations, and other actions taken under this title are maintained, and that indexes of such records are prepared. Subsection B. Such records and indexes, as well as the articles deposited in connection with completed copyright registrations and retained under the control of the Copyright Office, shall be open to public inspection. Subsection C. Upon request and payment of the fee specified by Section 708, the Copyright Office shall make a search of its public records, indexes, and deposits, and shall furnish a report of the information they disclose with respect to any particular deposits, registrations, or recorded documents. Section 706. Copies of Copyright Office records. Subsection A. Copies may be made of any public records or indexes of the Copyright Office. Additional certificates of copyright registration and copies of any public records or indexes may be furnished upon request and payment of the fees specified by Section 708. Subsection B. Copies or reproductions of deposited articles retained under the control of the Copyright Office shall be authorized or furnished only under the conditions specified by the Copyright Office regulations. Section 707. Copyright Office Forms and Publications. Subsection A. Catalog of copyright entries. The Register of Copyrights shall compile and publish at periodic intervals catalogs of all copyright registrations. These catalogs shall be divided into parts in accordance with the various classes of works, and the Register has discretion to determine, on the basis of practicability and usefulness, the form and frequency of publication of each particular part. Subsection B. Other publications. The Register shall furnish, free of charge upon request, application forms for copyright registration and general informational material in connection with the functions of the Copyright Office. The Register also has the authority to publish compilations of information, bibliographies, and other material he or she considers to be of value to the public. Subsection C. Distribution of publications. All publications of the Copyright Office shall be furnished to depository libraries as specified under Section 1019(5) of Title 44, and aside from those furnished free of charge, shall be offered for sale to the public at prices based on the cost of reproduction and distribution. Section 708. Copyright Office Fees. Subsection A. Fees. Fees shall be paid to the Register of Copyrights. Paragraph 1. On filing each application under Section 408 for registration of a copyright claim or for a supplementary registration, including the issuance of a certificate of registration if registration is made. Paragraph 2. On filing each application for registration of a claim for renewal of a subsisting copyright under Section 304, subsection A, including the issuance of a certificate of registration if registration is made. Paragraph 3. For the issuance of a receipt for a deposit under Section 407. Paragraph 4. For the recordation, as provided by Section 205, of a transfer of copyright ownership or other document. Paragraph 5. For the filing under Section 115, subsection B, of a notice of intention to obtain a compulsory license. Paragraph 6. For the recordation under Section 302, subsection C, of a statement revealing the identity of an author of an anonymous or pseudonymous work, or for the recordation under Section 302, subsection D, of a statement relating to the death of an author. Paragraph 7. For the issuance under Section 706 of an additional certificate of registration. Paragraph 8. For the issuance of any other certification. Paragraph 9. For the making and reporting of a search as provided by Section 705 and for any related services. Paragraph 10. On filing a statement of account based on secondary transmissions of primary transmissions pursuant to Section 119 or 122, and Paragraph 11. On filing a statement of account based on secondary transmissions of primary transmissions pursuant to Section 111. The Register is authorized to fix fees for other services, including the cost of preparing copies of Copyright Office records, whether or not such copies are certified based on the cost of providing the service. Fees established under paragraphs 10 and 11 shall be reasonable and may not exceed one-half of the cost necessary to cover reasonable expenses incurred by the Copyright Office for the collection and administration of the statements of account and any royalty fees deposited with such statements. Subsection B, adjustment of fees. The Register of Copyrights may, by regulation, adjust the fees for the services specified in paragraphs 1 through 9 of subsection A in the following manner. Paragraph 1. The Register shall conduct a study of the costs incurred by the Copyright Office for the registration of claims, the recordation of documents, and the provision of services. The study shall also consider the timing of any adjustment in fees and the authority to use such fees consistent with the budget. Paragraph 2. The Register may, on the basis of the study under paragraph 1 and subject to paragraph 5, adjust fees to not more than that necessary to cover the reasonable costs incurred by the Copyright Office for the services described in paragraph 1, plus a reasonable inflation adjustment to account for any estimated increase in costs. Paragraph 3. Any fee established under paragraph 2 shall be rounded off to the nearest dollar, or for a fee less than $12, rounded off to the nearest 50 cents. Paragraph 4. Fees established under this subsection shall be fair and equitable and give due consideration to the objectives of the copyright system. Paragraph 5. If the Register determines under paragraph 2 that fees should be adjusted, the Register shall prepare a proposed fee schedule and submit the schedule with the accompanying economic analysis to the Congress. The fees proposed by the Register may be instituted after the end of 120 days after the schedule is submitted to the Congress unless, within that 120-day period, a law is enacted stating in substance that the Congress does not approve the schedule. Subsection C. The fees prescribed by or under this section are applicable to the United States government and any of its agencies, employees, or officers, but the Register of Copyrights has discretion to waive the requirement of this subsection in occasional or isolated cases involving relatively small amounts. Subsection D, paragraph 1. Except as provided in paragraph 2, all fees received under this section shall be deposited by the Register of Copyrights in the Treasury of the United States and shall be credited to the appropriations for necessary expenses of the Copyright Office. Such fees that are collected shall remain available until expended. The Register may, in accordance with regulations that he or she shall prescribe, refund any sum paid by mistake or in excess of the fee required by this section. Paragraph 2. In the case of fees deposited against future services, the Register of Copyrights shall request the Secretary of the Treasury to invest in interest-bearing securities in the United States Treasury any portion of the fees that, as determined by the Register, is not required to meet current deposit account demands. Funds from such portion of fees shall be invested in securities that permit funds to be available to the Copyright Office at all times if they are determined to be necessary to meet current deposit account demands. Such investments shall be in public debt securities with maturities suitable to the needs of the Copyright Office, as determined by the Register of Copyrights, and bearing interest at rates determined by the Secretary of the Treasury, taking into consideration current market yields on outstanding marketable obligations of the United States of comparable maturities. Paragraph 3. The income on such investments shall be deposited in the Treasury of the United States and shall be credited to the appropriations for necessary expenses of the Copyright Office. Subsection E, paragraph 1. In this subsection, the term covered competition means subparagraph A, an art competition sponsored by the Congressional Institute that is open only to high school students, or subparagraph B, the competition established under Section 3 of House Resolution 77, 113th Congress, agreed to February 26, 2013. Paragraph 2. With respect to a work that wins a covered competition, the Register of Copyrights, subparagraph A, shall waive the requirement under subsection A1 with respect to an application for registration of a copyright claim for that work, if that application is submitted to the Copyright Office not later than the last day of the calendar year following the year in which the work claimed by the application wins the covered competition, referred to in this paragraph as the covered year. And subparagraph B may waive a fee described in subparagraph A for an application submitted after the end of the covered year if the fee would have been waived under that subparagraph had the application been submitted before the last day of the covered year. Section 709. Delay in delivery caused by disruption of postal or other services. In any case in which the Register of Copyrights determines, on the basis of such evidence as the Register may, by regulation, require that a deposit, application, fee, or any other material to be delivered to the Copyright Office by a particular date would have been received in the Copyright Office in due time, except for a general disruption or suspension of postal or other transportation or communication services, the actual receipt of such material in the Copyright Office within 1 month after the date on which the Register determines that the disruption or suspension of such services has terminated shall be considered timely. Section 710. Emergency Relief Authority. Subsection A. Emergency Action. If, on or before December 31, 2021, the Register of Copyrights determines that a national emergency declared by the President under the National Emergencies Act, Title 50, United States Code, Section 1601 and following, generally disrupts or suspends the ordinary functioning of the copyright system under this title or any component thereof, including on a regional basis, the Register may, on a temporary basis, toll, waive, adjust, or modify any timing provision, including any deadline or effective period, except as provided in subsection C or procedural provision contained in this title or chapters 2 or 3 of Title 37, Code of Federal Regulations, for no longer than the Register reasonably determines to be appropriate to mitigate the impact of the disruption caused by the national emergency. In taking such action, the Register shall consider the scope and severity of the particular national emergency and its specific effect with respect to the particular provision, and shall tailor any remedy accordingly. Subsection B. Notice and effect. Any action taken by the Register in response to a national emergency pursuant to subsection A shall not be subject to Section 701, subsection E, or subchapter 2 of Chapter 5 of Title 5 United States Code and Chapter 7 of Title 5 United States Code. The provision of general public notice detailing the action being taken by the Register in response to the national emergency under subsection A is sufficient to effectuate such action. The Register may make such action effective both prospectively and retroactively in relation to a particular provision, and as the Register determines to be appropriate based on the timing, scope, and nature of the public emergency. But any action by the Register may only be retroactive with respect to a deadline that is not already passed before the declaration described in subsection A. Subsection C. Statement required. Except as provided in subsection D, not later than 20 days after taking any action that results in a provision being modified for a cumulative total of longer than 120 days, the Register shall submit to Congress a statement detailing the action taken, the relevant background, and rationale for the action. Subsection D. Exceptions. The authority of the Register to act under subsection A does not extend provisions under this title requiring the commencement of an action or proceeding in federal court within a specified period of time, except that if the Register adjusts the license availability date defined in Section 115, subsection E, paragraph 15, such adjustment shall not affect the ability to commence actions for any claim of infringement of exclusive rights provided by paragraphs 1 and 3 of Section 106 against a digital music provider arising from the unauthorized reproduction or distribution of a musical work by such digital music provider in the course of engaging in covered activities that accrued after January 1st. 2018, provided that such action is commenced within the time periods prescribed under Section 115, subsection D, paragraph 10, subparagraph at C, clause I, or 115 D10C2 as calculated from the adjusted license availability date. If the Register adjusts the license availability date, the Register must provide the statement to Congress under subsection C at the same time as the public notice of such adjustment with a detailed explanation of why such adjustment is needed. Subsection E. Copyright term exception. The authority of the Register to act under subsection A does not extend to provisions under Chapter 3, except Section 304, subsection C, or Section 1401, subsection A, paragraph 2. Subsection F. Other laws. Notwithstanding Section 301 of the National Emergencies Act, Title 50, United States Code, Section 1631, the authority of the Register under subsection A is not contingent on a specification made by the President under such section or any other requirement under that Act, other than the emergency declaration under Section 201, subsection A of such Act, Title 50, United States Code, Section 161, subsection A. The authority described in this section supersedes the authority of Title II of the National Emergencies Act, Title 50, United States Code, Section 1621 and following. Section 801, Copyright Royalty Judges, Appointment and Functions. Subsection A. Appointment. The Librarian of Congress shall appoint 3 full-time copyright royalty judges and shall appoint one of the 3 as the chief copyright royalty judge. The Librarian shall make appointments to such positions after consultation with the Register of Copyrights. Subsection B. Functions. Subject to the provisions of this chapter, the functions of the copyright royalty judges shall be as follows. Paragraph 1. To make determinations and adjustments of reasonable terms and rates of royalty payments as provided in Sections 112E, 114, 115, 116, 118, 119, and 1004. Paragraph 2. To make determinations concerning the adjustment of the copyright royalty rates under Section 111 solely in accordance with the following provisions. Subparagraph A. The rates established by Section 111, subsection D, paragraph 1, subparagraph B may be adjusted to reflect Clause 1, national monetary inflation or deflation, or Clause 2, changes in the average rates charged cable subscribers for the basic service of providing secondary transmissions to maintain the real constant dollar level of the royalty fee per subscriber, which existed as of the date of October 19, 1976, except that Subclause 1. If the average rates charged cable system subscribers for the basic service of providing secondary transmissions are changed so that the average rates exceed national monetary inflation, no change in the rates established by Section 111, subsection D. Paragraph 1, subparagraph B shall be permitted, and Subclause 2, no increase in the royalty fee shall be permitted based on any reduction in the average number of distant signal equivalents per subscriber. The copyright royalty judges may consider all factors relating to the maintenance of such level of payments, including, as an extenuating factor, whether the industry has been restrained by subscriber rate regulating authorities from increasing the rates for the basic service of providing secondary transmissions. Subparagraph B. In the event that the rules and regulations of the Federal Communications Commission are amended at any time after April 15, 1976, to permit the carriage by cable systems of additional television broadcast signals beyond the local service area of the primary transmitters of such signals, the royalty rates established by Section 111, subsection D, paragraph 1, subparagraph B may be adjusted to ensure that the rates for the additional distance signal equivalents resulting from such carriage are reasonable in the light of the changes effected by the amendment to such rules and regulations. In determining the reasonableness of rates proposed following an amendment of Federal Communications Commission rules and regulations, the copyright royalty judges shall consider, among other factors, the economic impact on copyright owners and users, except that no adjustment in royalty rates shall be made under this subparagraph with respect to any distance signal equivalent or fraction thereof represented by Clause 1. Carriage of any signal permitted under the rules and regulations of the Federal Communications Commission in effect on April 15, 1976, or the carriage of a signal of the same type, that is, independent network, or non-commercial, educational, substituted for such permitted signal, or Clause 2. A television broadcast signal first carried after April 15, 1976, pursuant to an individual waiver of the rules and regulations of the Federal Communications Commission, as such rules and regulations were in effect on April 15, 1976. Subparagraph C. In the event of any change in the rules and regulations of the Federal Communications Commission, with respect to syndicated and sports program exclusivity after April 15, 1976, the rates established by Section 111, subsection D, paragraph 1. Subparagraph B may be adjusted to assure that such rates are reasonable in light of the changes to such rules and regulations, but any such adjustment shall apply only to the affected television broadcast signals carried on those systems affected by the change. Subparagraph D. The gross receipts limitations established by Section 111, subsection D, paragraph 1. Subparagraph C and D shall be adjusted to reflect national monetary inflation or deflation or changes in the average rates charged cable system subscribers for the basic service of providing secondary transmissions to maintain the real constant dollar value of the exemption provided by such section, and the royalty rate specified therein shall not be subject to adjustment. Paragraph 3, subparagraph A. To authorize the distribution under Sections 111, 119, and 1007 of those royalty fees collected under Sections 111, 119, and 1005, as the case may be, to the extent that the copyright royalty judges have found that the distribution of such fees is not subject to controversy. Subparagraph B. In cases where the copyright royalty judges determine that controversy exists, the copyright royalty judges shall determine the distribution of such fees, including partial distributions, in accordance with Section 111, 119, or 1007, as the case may be. Subparagraph C. Notwithstanding Section 804, subsection B, paragraph 8, the copyright royalty judges, at any time after the filing of claims under Section 111, 119, or 1007 may, upon motion of one or more of the claimants, and after publication in the Federal Register of a request for responses to the motion from interested claimants, make a partial distribution of such fees if, based upon all responses received during the 30-day period beginning on the date of such publication, the copyright royalty judges conclude that no claimant entitled to receive such fees has stated a reasonable objection to the partial distribution, and all such claimants. Clause 1. Agree to the partial distribution. Clause 2. Sign an agreement obligating them to return any excess amounts to the extent necessary to comply with the final determination on the distribution of the fees made under subparagraph B. Clause 3. File the agreement with the copyright royalty judges, and Clause 4. Agree that such funds are available for distribution. Subparagraph D. The copyright royalty judges and any other officer or employee acting in good faith in distributing funds under subparagraph C shall not be held liable for the payment of any excess fees under subparagraph C. The copyright royalty judges shall, at the time the final determination is made, calculate any such excess amounts. Paragraph 4. To accept or reject royalty claims filed under Sections 111, 119, and 1007 on the basis of timeliness or the failure to establish the basis for a claim. Paragraph 5. To accept or reject rate adjustment petitions as provided in Section 804 and petitions to participate as provided in Section 803, subsection B 1 and 2. Paragraph 6. To determine the status of a digital audio recording device or a digital audio interface device under Sections 1002 and 1003, as provided in Section 101.10. Paragraph 7. Subparagraph A. To adopt as a basis for statutory terms and rates or as a basis for the distribution of statutory royalty payments, an agreement concerning such matters reached among some or all of the participants in a proceeding at any time during the proceeding, except that Clause 1. The copyright royalty judges shall provide to those that would be bound by the terms, rates, or other determinations set by any agreement in a proceeding to determine royalty rates an opportunity to comment on the agreement, and shall provide to participants in the proceeding under Section 803, subsection B, paragraph 2, that would be bound by the terms, rates, or other determinations set by the agreement an opportunity to comment on the agreement and object to its adoption as a basis for statutory terms and rates, and Clause 2. The copyright royalty judges may decline to adopt the agreement as a basis for statutory terms and rates for participants that are not parties to the agreement. If any participant described in Clause I objects to the agreement and the copyright royalty judges conclude, based on the record before them if one exists, that the agreement does not provide a reasonable basis for setting statutory terms or rates. Subparagraph B. License agreements voluntarily negotiated pursuant to Section 112, subsection E, paragraph 5, 114F, 2, 115C3 EI, 116C, or 18B2D2 that do not result in statutory terms and rates shall not be subject to clauses I and 2 of subparagraph A. Subparagraph C. Interested parties may negotiate and agree to, and the copyright royalty judges may adopt, an agreement that specifies as terms notice and record-keeping requirements that apply in lieu of those that would otherwise apply under regulations. Paragraph 8. To determine the administrative assessment to be paid by digital music providers under Section 115, subsection D. The provisions of Section 115, subsection D shall apply to the conduct of proceedings by the copyright royalty judges under Section 115, subsection D, and not the procedures described in this section, or Section 803, 804, or 805. Paragraph 9. To perform other duties as assigned by the Register of Copyrights within the Library of Congress, except as provided in Section 802, subsection G, at times when copyright royalty judges are not engaged in performing the other duties set forth in this section. Subsection C. Rulings. The copyright royalty judges may make any necessary procedural or evidentiary rulings in any proceeding under this chapter, and may, before commencing a proceeding under this chapter, make any such rulings that would apply to the proceedings conducted by the copyright royalty judges. Subsection D. Administrative support. The Librarian of Congress shall provide the copyright royalty judges with the necessary administrative services related to proceedings under this chapter. Subsection E. Location in Library of Congress. The offices of the copyright royalty judges and staff shall be in the Library of Congress. Subsection F. Effective date of action. On and after the date of the enactment of the Copyright Royalty and Distribution Reform Act of 2004, in any case in which time limits are prescribed under this title for performance of an action with or by the copyright royalty judges, and in which the last day of the prescribed period falls on a Saturday, Sunday, holiday, or other non-business day within the District of Columbia or the federal government, the action may be taken on the next succeeding business day, and is effective as of the date when the period expired. Section 802, Copyright Royalty Judgeships, Staff. Subsection A. Qualifications of copyright royalty judges. Paragraph 1. In general, each copyright royalty judge shall be an attorney who has at least 7 years of legal experience. The chief copyright royalty judge shall have at least 5 years of experience in adjudications, arbitrations, or court trials. Of the other 2 copyright royalty judges, one shall have significant knowledge of copyright law, and the other shall have significant knowledge of economics. An individual may serve as a copyright royalty judge only if the individual is free of any financial conflict of interest under subsection H. Paragraph 2. Definition. In this subsection, the term adjudication has the meaning given that term in Section 551 of Title V, but does not include mediation. Subsection B. Staff. The chief copyright royalty judge shall hire full-time staff members to assist the copyright royalty judges in performing their functions. Subsection C. Terms. The individual first appointed as the chief copyright royalty judge shall be appointed to a term of 6 years, and of the remaining individuals first appointed as copyright royalty judges, one shall be appointed to a term of 4 years, and the other shall be appointed to a term of 2 years. Thereafter, the terms of succeeding copyright royalty judges shall each be 6 years. An individual serving as a copyright royalty judge may be reappointed to subsequent terms. The term of a copyright royalty judge shall begin when the term of the predecessor of that copyright royalty judge ends. When the term of office of a copyright royalty judge ends, the individual serving that term may continue to serve until a successor is selected. Subsection D. Vacancies or incapacity. Paragraph 1. Vacancies. If a vacancy should occur in the position of copyright royalty judge, the Librarian of Congress shall act expeditiously to fill the vacancy, and may appoint an interim copyright royalty judge to serve until another copyright royalty judge is appointed under this section. An individual appointed to fill the vacancy occurring before the expiration of the term for which the predecessor of that individual was appointed shall be appointed for the remainder of that term. Paragraph 2. Incapacity. In the case in which a copyright royalty judge is temporarily unable to perform his or her duties, the Librarian of Congress may appoint an interim copyright royalty judge to perform such duties during the period of such incapacity. Subsection E. Compensation. Paragraph 1. Judges. The chief copyright royalty judge shall receive compensation at the rate of basic pay payable for level AL1 for administrative law judges pursuant to Section 5372, subsection B of Title V. And each of the other 2 copyright royalty judges shall receive compensation at the rate of basic pay payable for level AL-2 for administrative law judges, pursuant to such section. The compensation of the copyright royalty judges shall not be subject to any regulations adopted by the Office of Personnel Management pursuant to its authority under Section 5376, subsection B, paragraph 1 of Title V. Paragraph 2. Staff members. Staff members appointed under subsection B shall be compensated at a rate not more than the basic rate of pay payable for level 10 of GS 15 of the general schedule. Paragraph 3. Locality pay. All rates of pay referred to under this subsection shall include locality pay. Subsection F. Independence of copyright royalty judge. Paragraph 1. In making determinations. Subparagraph A in general. Subsection I. Subject to subparagraph B and clause 2 of this subparagraph, the copyright royalty judges shall have full independence in making determinations concerning adjustments and determinations of copyright royalty rates and terms. The distribution of copyright royalties, the acceptance or rejection of royalty claims, rate adjustment petitions, and petitions to participate in issuing other rulings under this title. Except that the copyright royalty judges may consult with the Register of Copyrights on any matter other than a question of fact. Subsection 2. One or more copyright royalty judges may, or by motion to the copyright royalty judges, any participant in a proceeding may, request from the Register of Copyrights an interpretation of any material questions of substantive law that relate to the construction of provisions of this title and arise in the course of the proceeding. Any request for a written interpretation shall be in writing and on the record, and reasonable provision shall be made to permit participants in the proceeding to comment on the material questions of substantive law in a manner that minimizes duplication and delay. Except as provided in subparagraph B, the Register of Copyrights shall deliver to the copyright royalty judges a written response within 14 days after the receipt of all briefs and comments from the participants. The copyright royalty judges shall apply the legal interpretation embodied in the response of the Register of Copyrights if it is timely delivered, and the response shall be included in the record that accompanies the final determination. The authority under this clause shall not be construed to authorize the Register of Copyrights to provide an interpretation of questions of procedure before the copyright royalty judges. The ultimate adjustments and determinations of copyright royalty rates and terms, the ultimate distribution of copyright royalties, or the acceptance or rejection of royalty claims, rate adjustment petitions, or petitions to participate in a proceeding. Subparagraph B. Novel questions. Subsection I. In any case in which a novel material question of substantive law concerning an interpretation of those provisions of this title that are the subject of the proceeding is presented, the copyright royalty judges shall request a decision of the Register of Copyrights in writing to resolve such novel question. Reasonable provision shall be made for comment on such request by the participants in the proceeding in such a way as to minimize duplication and delay. The Register of Copyrights shall transmit his or her decision to the copyright royalty judges within 30 days after the Register of Copyrights receives all of the briefs or comments of the participants. Such decision shall be in writing and included by the copyright royalty judges in the record that accompanies their final determination. If such a decision is timely delivered to the copyright royalty judges, the copyright royalty judges shall apply the legal determinations embodied in the decision of the Register of Copyrights in resolving material questions of substantive law. Subsection 2 in clause I. A novel question of law is a question of law that has not been determined in prior decisions, determinations, and rulings described in Section 803, subsection A. Subparagraph C. Consultation. Notwithstanding the provisions of subparagraph A, the copyright royalty judges shall consult with the Register of Copyrights with respect to any determination or ruling that would require that any act be performed by the Copyright Office, and any such determination or ruling shall not be binding upon the Register of Copyrights. Subparagraph D. Review of legal conclusions by the Register of Copyrights. The Register of Copyrights may review for legal error the resolution by the copyright royalty judges of a material question of substantive law under this title that underlies or is contained in a final determination of the copyright royalty judges. If the Register of Copyrights concludes, after taking into consideration the views of the participants in the proceeding, that any resolution reached by the copyright royalty judges was in material error, the Register of Copyrights shall issue a written decision correcting such legal error, which shall be made part of the record of the proceeding. The Register of Copyrights shall issue such written decision not later than 60 days after the date on which the final determination by the copyright royalty judges is issued. Additionally, the Register of Copyrights shall cause to be published in the Federal Register such written decision, together with a specific identification of the legal conclusion of the copyright royalty judges that is determined to be erroneous. As to conclusions of substantive law involving an interpretation of the statutory provisions of this title, the decision of the Register of Copyrights shall be binding as precedent upon the copyright royalty judges in subsequent proceedings under this chapter. When a decision has been rendered pursuant to this subparagraphic, the Register of Copyrights may, on the basis of and in accordance with such decision, intervene as of right in any appeal of a final determination of the copyright royalty judges pursuant to Section 803, subsection D in the United States Court of Appeals for the District of Columbia Circuit. If, prior to intervening in such an appeal, the Register of Copyrights gives notification to, and undertakes to consult with, the Attorney General with respect to such intervention, and the Attorney General fails, within a reasonable period after receiving such notification, to intervene in such appeal, the Register of Copyrights may intervene in such appeal in his or her own name, by any attorney designated by the Register of Copyrights for such purpose. Intervention by the Register of Copyrights in his or her own name shall not preclude the Attorney General from intervening on behalf of the United States in such an appeal as may be otherwise provided or required by law. Subparagraph E. Effect on judicial review. Nothing in this section shall be interpreted to alter the standard applied by a court in reviewing legal determinations involving an interpretation or construction of the provisions of this title, or to affect the extent to which any construction or interpretation of the provisions of this title shall be accorded deference by a reviewing court. Paragraph 2. Performance appraisals. Subparagraph A. In general, notwithstanding any other provision of law or any regulation of the Library of Congress, and subject to subparagraph B, the copyright royalty judges shall not receive performance appraisals. Subparagraph B. Relating to sanction or removal. To the extent that the Librarian of Congress adopts regulations under subsection H relating to the sanction or removal of a copyright royalty judge, and such regulations require documentation to establish the cause of such sanction or removal, the copyright royalty judge may receive an appraisal related specifically to the cause of the sanction or removal. Subsection G. Inconsistent duties barred. No copyright royalty judge may undertake duties that conflict with his or her duties and responsibilities as a copyright royalty judge. Subsection H. Standards of conduct. The Librarian of Congress shall adopt regulations regarding the standards of conduct, including financial conflict of interest and restrictions against ex parte communications, which shall govern the copyright royalty judges in the proceedings under this chapter. Subsection I. Removal or sanction. The Librarian of Congress may sanction or remove a copyright royalty judge for violation of the standards of conduct adopted under subsection H, misconduct, neglect of duty, or any disqualifying physical or mental disability. Any such sanction or removal may be made only after notice and opportunity for a hearing, but the Librarian of Congress may suspend the copyright royalty judge during the pendency of such hearing. The Librarian shall appoint an interim copyright royalty judge during the period of any such suspension. Section 803. Proceedings of Copyright Royalty Judges. Subsection A. Proceedings. Paragraph 1. In general, the copyright royalty judges shall act in accordance with this title, and to the extent not inconsistent with this title, in accordance with subchapter 2 of Chapter 5 of Title 5, in carrying out the purposes set forth in Section 801. The copyright royalty judges shall act in accordance with regulations issued by the copyright royalty judges and the Librarian of Congress, and on the basis of a written record, prior determinations and interpretations of the Copyright Royalty Tribunal, Librarian of Congress, the Register of Copyrights, Copyright Arbitration Royalty Panels, to the extent those determinations are not inconsistent with a decision of the Librarian of Congress or the Register of Copyrights, and the copyright royalty judges, to the extent those determinations are not inconsistent with a decision of the Register of Copyrights that was timely delivered to the copyright royalty judges pursuant to Section 802, subsection F, paragraph 1, subparagraph A or B, or with a decision of the Register of Copyrights pursuant to Section 802, subsection F, paragraph 1, subparagraph D, under this chapter, and decisions of the Court of Appeals under this chapter before, on, or after the effective date of the Copyright Royalty and Distribution Reform Act of 2004. Paragraph 2. Judges acting as panel and individually. The copyright royalty judges shall preside over hearings and proceedings under this chapter en banc. The chief copyright royalty judge may designate a copyright royalty judge to preside individually over such collateral and administrative proceedings, and over such proceedings under paragraphs 1 through 5 of subsection B, as the chief judge considers appropriate. Paragraph 3. Determinations. Final determinations of the copyright royalty judges in proceedings under this chapter shall be made by majority vote. A copyright royalty judge dissenting from the majority on any determination under this chapter may issue his or her dissenting opinion, which shall be included with the determination. Subsection B. Procedures. Paragraph 1. Initiation. Subparagraph A. Call for petitions to participate. Subsection I. The copyright royalty judges shall cause to be published in the Federal Register notice of commencement of proceedings under this chapter, calling for the filing of petitions to participate in a proceeding under this chapter for the purpose of making the relevant determination under Section 111, 112, 114, 115, 116, 118, 119, 2004, or 107, as the case may be. Subclause 1. Promptly upon a determination made under Section 804, subsection A. Subclause 2. By no later than January 5th of a year specified in paragraph 2 of Section 804, subsection B for the commencement of proceedings. Subclause 3. By no later than January 5th of a year specified in subparagraph A or B of paragraph 3 of Section 804, subsection B for the commencement of proceedings, or as otherwise provided in subparagraph A or C of such paragraph for the commencement of proceedings. Subclause 4. As provided under Section 804, subsection B, paragraph 8, or Subclause 5. By no later than January 5th of a year specified in any other provision of Section 804, subsection B for the filing of petitions for the commencement of proceedings, if a petition has not been filed by that date, except that the publication of notice requirement shall not apply in the case of proceedings under Section 111 that are scheduled to commence in 2005. Subsection 2. Petitions to participate shall be filed by no later than 30 days after publication of notice of commencement of a proceeding under Clause I, except that the copyright royalty judges may, for substantial good cause shown, and if there is no prejudice to the participants that have already filed petitions, accept late petitions to participate at any time up to the date that is 90 days before the date on which participants in the proceeding are to file their written direct statements. Notwithstanding the preceding sentence, petitioners whose petitions are filed more than 30 days after publication of notice of commencement of a proceeding are not eligible to object to a settlement reached during the voluntary negotiation period under paragraph 3, and any objection filed by such a petitioner shall not be taken into account by the copyright royalty judges. Subparagraph B. Petitions to participate. Each petition to participate in a proceeding shall describe the petitioner's interest in the subject matter of the proceeding. Parties with similar interests may file a single petition to participate. Paragraph 2. Participation in general. Subject to paragraph 4, a person may participate in a proceeding under this chapter, including through the submission of briefs or other information, only if subparagraph A. That person has filed a petition to participate in accordance with paragraph 1, either individually or as a group under paragraph 1b. Subparagraph B. The copyright royalty judges have not determined that the petition to participate is facially invalid. Subparagraph C. The copyright royalty judges have not determined, sua sponte or on the motion of another participant in the proceeding, that the person lacks a significant interest in the proceeding, and subparagraph D. The petition to participate is accompanied by either Clause 1. In a proceeding to determine royalty rates, a filing fee of $150, or Clause 2. In a proceeding to determine distribution of royalty fees, Subclause 1, a filing fee of $150, or Subclause 2, a statement that the petitioner, individually or as a group, will not seek a distribution of more than $1,000, in which case the amount distributed to the petitioner shall not exceed $1,000. Paragraph 3. Voluntary negotiation period. Subparagraph A. Commencement of proceedings. Clause 1. Rate adjustment proceeding. Promptly after the date for filing of petitions to participate in a proceeding, the copyright royalty judges shall make available to all participants in the proceeding a list of such participants and shall initiate a voluntary negotiation period among the participants. Clause 2. Distribution proceeding. Promptly after the date for filing of petitions to participate in a proceeding to determine the distribution of royalties, the copyright royalty judges shall make available to all participants in the proceeding a list of such participants. The initiation of a voluntary negotiation period among the participants shall be set at a time determined by the copyright royalty judges. Subparagraph B. Length of proceedings. The voluntary negotiation period initiated under subparagraph A shall be 3 months. Subparagraph C. Determination of subsequent proceedings. At the close of the voluntary negotiation proceedings, the copyright royalty judges shall, if further proceedings under this chapter are necessary, determine whether and to what extent paragraphs 4 and 5 will apply to the parties. Paragraph 4. Small claims procedure in distribution proceedings. Subparagraph A. In general. If, in a proceeding under this chapter to determine the distribution of royalties, the contested amount of a claim is $10,000 or less, the copyright royalty judges shall decide the controversy on the basis of the filing of the written direct statement by the participant, the response by any opposing participant, and one additional response by each such party. Subparagraph B. Bad faith inflation of claim. If the copyright royalty judges determine that a participant asserts in bad faith an amount in controversy in excess of $10,000 for the purpose of avoiding a determination under the procedure set forth in subparagraph A, the copyright royalty judges shall impose a fine on that participant in an amount not to exceed the difference between the actual amount distributed and the amount asserted by the participant. Paragraph 5. Paper proceedings. The copyright royalty judges in proceedings under this chapter may decide sua sponte or upon motion of a participant to determine issues on the basis of the filing of the written direct statement by the participant, the response by any opposing participant, and one additional response by each such participant. Prior to making such decision to proceed on such a paper record only, the copyright royalty judges shall offer to all parties to the proceeding the opportunity to comment on the decision. The procedure under this paragraph. Subparagraph A shall be applied in cases in which there is no genuine issue of material fact, there is no need for evidentiary hearings, and all participants in the proceeding agree in writing to the procedure, and subparagraph B may be applied under such other circumstances as the copyright royalty judges consider appropriate. Paragraph 6. Regulations. Subparagraph A. In general. The copyright royalty judges may issue regulations to carry out their functions under this title. All regulations issued by the copyright royalty judges are subject to the approval of the Librarian of Congress and are subject to judicial review pursuant to Chapter 7 of Title 5, except as set forth in subsection D. Not later than 120 days after copyright royalty judges or interim copyright royalty judges, as the case may be, are first appointed after the enactment of the Copyright Royalty and Distribution Reform Act of 2004. Such judges shall issue regulations to govern proceedings under this chapter. Subparagraph B. Interim regulations. Until regulations are adopted under subparagraph A, the copyright royalty judges shall apply the regulations in effect under this chapter on the day before the effective date of the Copyright Royalty and Distribution Reform Act of 2004. To the extent such regulations are not inconsistent with this chapter, except that functions carried out under such regulations by the Librarian of Congress, the Register of Copyrights, or copyright arbitration royalty panels that, as of such date of enactment, are to be carried out by the copyright royalty judges under this chapter, shall be carried out by the copyright royalty judges under such regulations. Subparagraph C requirements. Regulations issued under subparagraph A shall include the following. Clause 1. The written direct statements and written rebuttal statements of all participants in a proceeding under paragraph 2 shall be filed by a date specified by the copyright royalty judges, which in the case of written direct statements, may be not earlier than 4 months and not later than 5 months, after the end of the voluntary negotiation period under paragraph 3. Notwithstanding the preceding sentence, the copyright royalty judges may allow a participant in a proceeding to file an amended written direct statement based on new information received during the discovery process, within 15 days after the end of the discovery period specified in Clause 4. Clause 2, Subclause 1. Following the submission to the copyright royalty judges of written direct statements and written rebuttal statements by the participants in a proceeding under paragraph 2, the copyright royalty judges, after taking into consideration the views of the participants in the proceeding, shall determine a schedule for conducting and completing discovery. Subparagraph 2. In this chapter, the term written direct statements means witness statements, testimony, and exhibits to be presented in the proceedings, and such other information that is necessary to establish terms and rates, or the distribution of royalty payments, as the case may be, as set forth in regulations issued by the copyright royalty judges. Subsection 3. Hearsay may be admitted in proceedings under this chapter to the extent deemed appropriate by the copyright royalty judges. Subsection 4. Discovery in connection with written direct statements shall be permitted for a period of 60 days, except for discovery ordered by the copyright royalty judges in connection with the resolution of motions, orders, and disputes pending at the end of such period. The copyright royalty judges may order a discovery schedule in connection with written rebuttal statements. Subsection V. Any participant under paragraph 2 in a proceeding under this chapter to determine royalty rates may request of an opposing participant non-privileged documents directly related to the written direct statement or written rebuttal statement of that participant. Any objection to such a request shall be resolved by a motion or request to compel production made to the copyright royalty judges in accordance with regulations adopted by the copyright royalty judges. Each motion or request to compel discovery shall be determined by the copyright royalty judges or by a copyright royalty judge when permitted under subsection A2. Upon such motion, the copyright royalty judges may order discovery pursuant to regulations established under this paragraph. Subsection V, Subclause 1. Any participant under paragraph 2 in a proceeding under this chapter to determine royalty rates may, by means of written motion or on the record, request of an opposing participant or witness other relevant information and materials if, absent the discovery sought, the copyright royalty judge's resolution of the proceeding would be substantially impaired. In determining whether discovery will be granted under this clause, the copyright royalty judges may consider: Item AA, whether the burden or expense of producing the requested information or materials outweighs the likely benefit, taking into account the needs and resources of the participants, the importance of the issues at stake, and the probative value of the requested information or materials in resolving such issues. Item B, whether the requested information or materials would be unreasonably cumulative or duplicative, or are obtainable from another source that is more convenient, less burdensome, or less expensive, and Item C, whether the participant seeking discovery has had ample opportunity by discovery in the proceeding or by other means to obtain the information sought. Subparagraph 2. This clause shall not apply to any proceeding scheduled to commence after December 31, 2010. Subsection 7. In a proceeding under this chapter to determine royalty rates, the participants entitled to receive royalties shall collectively be permitted to take no more than 10 depositions and secure responses to no more than 25 interrogatories. And the participants obligated to pay royalties shall collectively be permitted to take no more than 10 depositions and secure responses to no more than 25 interrogatories. The copyright royalty judges shall resolve any disputes among similarly aligned participants to allocate the number of depositions or interrogatories permitted under this clause. Subsection 8. The rules and practices in effect on the day before the effective date of the Copyright Royalty and Distribution Reform Act of 2004 relating to discovery and proceedings under this chapter to determine the distribution of royalty fees shall continue to apply to such proceedings on and after such effective date. Subsection 9. In proceedings to determine royalty rates, the copyright royalty judges may issue a subpoena commanding a participant or witness to appear and give testimony, or to produce and permit inspection of documents or tangible things, if the copyright royalty judge's resolution of the proceeding would be substantially impaired by the absence of such testimony or production of documents or tangible things. Such subpoena shall specify with reasonable particularity the materials to be produced or the scope and nature of the required testimony. Nothing in this clause shall preclude the copyright royalty judges from requesting the production by a non-participant of information or materials relevant to the resolution by the copyright royalty judges of a material issue of fact. Subsection X. The copyright royalty judges shall order a settlement conference among the participants in the proceeding to facilitate the presentation of offers of settlement among the participants. The settlement conference shall be held during a 21-day period following the 60-day discovery period specified in Clause 4 and shall take place outside the presence of the copyright royalty judges. Subsection 11. No evidence, including exhibits, may be submitted in the written direct statement or written rebuttal statement of a participant without a sponsoring witness, except where the copyright royalty judges have taken official notice, or in the case of incorporation by reference of past records or for good cause shown. Subsection C. Determination of copyright royalty judges. Paragraph 1. Timing. The copyright royalty judges shall issue their determination in a proceeding not later than 11 months after the conclusion of the 21-day settlement conference period under subsection B6CX, but, in the case of a proceeding to determine successors to rates or terms that expire on a specified date, in no event later than 15 days before the expiration of the then current statutory rates and terms. Paragraph 2. Rehearings. Subparagraph A. In general. The copyright royalty judges may, in exceptional cases, upon motion of a participant in a proceeding under subsection B2, order a rehearing after the determination in the proceeding is issued under paragraph 1, on such matters as the copyright royalty judges determine to be appropriate. Subparagraph B. Timing for filing motion. Any motion for a rehearing under subparagraph A may only be filed within 15 days after the date on which the copyright royalty judges deliver to the participants in the proceeding their initial determination. Subparagraph C. Participation by opposing party not required. In any case in which a rehearing is ordered, any opposing party shall not be required to participate in the rehearing, except that non-participation may give rise to the limitations with respect to judicial review provided for in subsection D1. Subparagraph D. No negative inference. No negative inference shall be drawn from lack of participation in a rehearing. Subparagraph E. Continuity of rates and terms. Subsection I. If the decision of the copyright royalty judges on any motion for a rehearing is not rendered before the expiration of the statutory rates and terms that were previously in effect, in the case of a proceeding to determine successors to rates and terms that expire on a specified date, then, Subclause 1, the initial determination of the copyright royalty judges that is the subject of the rehearing motion shall be effective as of the day following the date on which the rates and terms that were previously in effect expire, and Subclause 2, in the case of a proceeding under Section 114, subsection F, paragraph 1, subparagraph C, royalty rates and terms shall, for purposes of Section 114, subsection F, paragraph 3, subparagraph B, be deemed to have been set at those rates and terms contained in the initial determination of the copyright royalty judges that is the subject of the rehearing motion as of the date of that determination. Subsection 2. The pendency of a motion for a rehearing under this paragraph shall not relieve persons obligated to make royalty payments who would be affected by the determination on that motion from providing the statements of account and any reports of use, to the extent required, and paying the royalties required under the relevant determination or regulations. Subsection 3. Notwithstanding Clause 2, whenever royalties described in Clause 2 are paid to a person other than the Copyright Office, the entity designated by the copyright royalty judges to which such royalties are paid by the copyright user, and any successor thereto, shall, within 60 days after the motion for rehearing is resolved, or, if the motion is granted, within 60 days after the rehearing is concluded, return any excess amounts previously paid to the extent necessary to comply with the final determination of royalty rates by the copyright royalty judges. Any underpayment of royalties resulting from a rehearing shall be paid within the same period. Paragraph 3. Contents of determination. A determination of the copyright royalty judges shall be supported by the written record, and shall set forth the findings of fact relied on by the copyright royalty judges. Among other terms adopted in a determination, the copyright royalty judges may specify notice and record-keeping requirements of users of the copyrights at issue that apply in lieu of those that would otherwise apply under regulations. Paragraph 4. Continuing jurisdiction. The copyright royalty judges may issue an amendment to a written determination to correct any technical or clerical errors in the determination or to modify the terms, but not the rates, of royalty payments in response to unforeseen circumstances that would frustrate the proper implementation of such determination. Such amendment shall be set forth in a written addendum to the determination that shall be distributed to the participants of the proceeding and shall be published in the Federal Register. Paragraph 5. Protective order. The copyright royalty judges may issue such orders as may be appropriate to protect confidential information, including orders excluding confidential information from the record of the determination that is published or made available to the public, except that any terms or rates of royalty payments or distributions may not be excluded. Paragraph 6. Publication of determination. By no later than the end of the 60-day period provided in Section 802, subsection F, paragraph 1, subparagraph D, the Librarian of Congress shall cause the determination, and any corrections thereto, to be published in the Federal Register. The Librarian of Congress shall also publicize the determination and corrections in such other manner as the librarian considers appropriate, including, but not limited to, publication on the Internet. The Librarian of Congress shall also make the determination, corrections, and the accompanying record available for public inspection and copying. Paragraph 7. Late payment. A determination of the copyright royalty judges may include terms with respect to late payment, but in no way shall such terms prevent the copyright holder from asserting other rights or remedies provided under this title. Subsection D. Judicial Review. Paragraph 1. Appeal. Any determination of the copyright royalty judges under subsection C may, within 30 days after the publication of the determination in the Federal Register, be appealed to the United States Court of Appeals for the District of Columbia Circuit by any aggrieved participant in the proceeding under subsection B2 who fully participated in the proceeding and who would be bound by the determination. Any participant that did not participate in a rehearing may not raise any issue that was the subject of that rehearing at any stage of judicial review of the hearing determination. If no appeal is brought within that 30-day period, the determination of the copyright royalty judges shall be final, and the royalty fee or determination with respect to the distribution of fees, as the case may be, shall take effect as set forth in paragraph 2. Paragraph 2. Effective rates. Subparagraph A. Expiration on specified date. When this title provides that the royalty rates and terms that were previously in effect are to expire on a specified date, any adjustment or determination by the copyright royalty judges of successor rates and terms for an ensuing statutory license period shall be effective as of the day following the date of expiration of the rates and terms that were previously in effect, even if the determination of the copyright royalty judges is rendered on a later date. A licensee shall be obligated to continue making payments under the rates and terms previously in effect until such time as rates and terms for the successor period are established. Whenever royalties pursuant to this section are paid to a person other than the Copyright Office, the entity designated by the copyright royalty judges to which such royalties are paid by the copyright user, and any successor thereto, shall, within 60 days after the final determination of the copyright royalty judges establishing rates and terms for a successor period, or the exhaustion of all rehearings or appeals of such determination, if any, return any excess amounts previously paid to the extent necessary to comply with the final determination of royalty rates. Any underpayment of royalties by a copyright user shall be paid to the entity designated by the copyright royalty judges within the same period. Subparagraph B. Other cases. In cases where rates and terms have not, prior to the inception of an activity, been established for that particular activity under the relevant license, such rates and terms shall be retroactive to the inception of activity under the relevant license covered by such rates and terms. In other cases where rates and terms do not expire on a specified date, successor rates and terms shall take effect on the first day of the second month that begins after the publication of the determination of the copyright royalty judges in the Federal Register, except as otherwise provided in this title, or by the copyright royalty judges, or as agreed by the participants in a proceeding that would be bound by the rates and terms. Except as otherwise provided in this title, the rates and terms, to the extent applicable, shall remain in effect until such successor rates and terms become effective. Subparagraph C. Obligation to make payments. Clause 1. The pendency of an appeal under this subsection shall not relieve persons obligated to make royalty payments under Section 111, 112, 114, 115, 116, 118, 119, or 1003, who would be affected by the determination on appeal, from Subclause 1, providing the applicable statements of account and reports of use, and Subclause 2, paying the royalties required under the relevant determination or regulations. Clause 2, notwithstanding Clause I, whenever royalties described in Clause I are paid to a person other than the Copyright Office, the entity designated by the copyright royalty judges to which such royalties are paid by the copyright user, and any successor thereto, shall within 60 days after the final resolution of the appeal, return any excess amounts previously paid and interest thereon, if ordered pursuant to paragraph 3, to the extent necessary to comply with the final determination of royalty rates on appeal. Any underpayment of royalties resulting from an appeal and interest thereon, if ordered pursuant to paragraph 3, shall be paid within the same period. Paragraph 3. Jurisdiction of court. Section 706 of Title V shall apply with respect to review by the Court of Appeals under this subsection. If the court modifies or vacates a determination of the copyright royalty judges, the court may enter its own determination with respect to the amount or distribution of royalty fees and costs, and order the repayment of any excess fees, the payment of any underpaid fees, and the payment of interest pertaining respectively thereto, in accordance with its final judgment. The court may also vacate the determination of the copyright royalty judges and remand the case to the copyright royalty judges for further proceedings in accordance with subsection A. Subsection E. Administrative matters. Paragraph 1. Deduction of costs of Library of Congress and Copyright Office from filing fees. Subparagraph A. Deduction from filing fees. The Librarian of Congress may, to the extent not otherwise provided under this title, deduct from the filing fees collected under subsection B for a particular proceeding under this chapter the reasonable costs incurred by the Librarian of Congress, the Copyright Office, and the copyright royalty judges in conducting that proceeding, other than the salaries of the copyright royalty judges and the staff members appointed under Section 802, subsection B. Subparagraph B. Authorization of appropriations. There are authorized to be appropriated such sums as may be necessary to pay the costs incurred under this chapter, not covered by the filing fees collected under subsection B. All funds made available pursuant to this subparagraph shall remain available until expended. Paragraph 2. Positions required for administration of compulsory licensing. Section 307 of the Legislative Branch Appropriations Act, 1994, shall not apply to employee positions in the Library of Congress that are required to be filled in order to carry out Section 111, 112, 114, 115, 116, 118, or 119 or Chapter 10. Section 804, Institution of Proceedings. Subsection A. Filing of petition. With respect to proceedings referred to in paragraphs 1 and 2 of Section 801, subsection B concerning the determination or adjustment of royalty rates as provided in sections 111, 112, 114, 115, 116, 108, 119, and 1004. During the calendar years specified in the schedule set forth in subsection B, any owner or user of a copyrighted work whose royalty rates are specified by this title or are established under this chapter before or after the enactment of the Copyright Royalty and Distribution Reform Act of 2004 may file a petition with the copyright royalty judges declaring that the petitioner requests a determination or adjustment of the rate. The copyright royalty judges shall make a determination as to whether the petitioner has such a significant interest in the royalty rate in which a determination or adjustment is requested. If the copyright royalty judges determine that the petitioner has such a significant interest, the copyright royalty judges shall cause notice of this determination, with the reasons for such determination to be published in the Federal Register, together with the notice of commencement of proceedings under this chapter. With respect to proceedings under paragraph 1 of Section 801, subsection B concerning the determination or adjustment of royalty rates as provided in sections 112 and 114, during the calendar year specified in the schedule set forth in subsection B, the copyright royalty judges shall cause notice of commencement of proceedings under this chapter to be published in the Federal Register as provided in Section 803, subsection B, paragraph 1, subparagraph A. Subsection B. Timing of proceedings. Paragraph 1, Section 111 Proceedings, subparagraph A. A petition described in subsection A to initiate proceedings under Section 801, subsection B, paragraph 2, concerning the adjustment of royalty rates under Section 111, to which subparagraph A or D of Section 801, subsection B, paragraph 2 applies, may be filed during the year 2015 and in each subsequent fifth calendar year. Subparagraph B. In order to initiate proceedings under Section 801, subsection B, paragraph 2 concerning the adjustment of royalty rates under Section 111 to which paragraph B or C of Section 801, subsection B, paragraph 2 applies. Within 12 months after an event described in either of those subsections, any owner or user of a copyrighted work whose royalty rates are specified by Section 111, or by a rate established under this chapter before or after the enactment of the Copyright Royalty and Distribution Reform Act of 2004, may file a petition with the copyright royalty judges declaring that the petitioner requests an adjustment of the rate. The copyright royalty judges shall then proceed as set forth in subsection A of this section. Any change in royalty rates made under this chapter pursuant to this subparagraph may be reconsidered in the year 2015, and each fifth calendar year thereafter, in accordance with the provisions in Section 801, subsection B, paragraph 2, subparagraph B or C, as the case may be. A petition for adjustment of rates established by Section 111, subsection D, paragraph 1, subparagraph B as a result of a change in the rules and regulations of the Federal Communications Commission shall set forth the change on which the petition is based. Subparagraph C. Any adjustment of royalty rates under Section 111 shall take effect as of the first accounting period commencing after the publication of the determination of the copyright royalty judges in the Federal Register, or on such other date as is specified in that determination. Paragraph 2. Certain Section 112 proceedings. Proceedings under this chapter shall be commenced in the year 2007 to determine reasonable terms and rates of royalty payments for the activities described in Section 112, subsection E, Paragraph 1 relating to the limitation on exclusive rights specified by Section 114, subsection D, Paragraph 1, subparagraph C, Clause 4, to become effective on January 1, 2009. Such proceedings shall be repeated in each subsequent fifth calendar year. Paragraph 3, Section 114 and corresponding 112 proceedings. Subparagraph A, for eligible non-subscription services and new subscription services. Proceedings under this chapter shall be commenced as soon as practicable after the date of enactment of the Copyright Royalty and Distribution Reform Act of 2004 to determine reasonable terms and rates of royalty payments under Sections 114 and 112 for the activities of eligible non-subscription transmission services and new subscription services, to be effective for the period beginning on January 1, 2006 and ending on December 31, 2010. Such proceedings shall next be commenced in January 2009 to determine reasonable terms and rates of royalty payments to become effective on January 1, 2011. Thereafter, such proceedings shall be repeated in each subsequent 5th calendar year. Subparagraph B for pre-existing subscription and satellite digital audio radio services. Proceedings under this chapter shall be commenced in January 2006 to determine reasonable terms and rates of royalty payments under sections 114 and 112 for the activities of pre-existing subscription services, to be effective during the period beginning on January 1, 2008 and ending on December 31, 2012, and pre-existing satellite digital audio radio services, to be effective during the period beginning on January 1, 2007 and ending on December 31, 2012. Such proceedings shall next be commenced in 2011 to determine reasonable terms and rates of royalty payments, to become effective on January 1, 2013. Thereafter, such proceedings shall be repeated in each subsequent 5th calendar year, except that subsection I. With respect to pre-existing subscription services, the terms and rates finally determined for the rate period ending on December 31, 2022, shall remain in effect through December 31, 2027. And there shall be no proceeding to determine terms and rates for pre-existing subscription services for the period beginning on January 1, 2023 and ending on December 31, 2027. And 2. With respect to pre-existing satellite digital audio radio services, the terms and rates set forth by the copyright royalty judges on December 14, 2017 in their initial determination for the rate period ending on December 31, 2022 shall be in effect through December 31, 2027. Without any change based on a rehearing under Section 803, subsection C, paragraph 2, and without the possibility of appeal under Section 803, subsection D. And there shall be no proceeding to determine terms and rates for pre-existing satellite digital audio radio services for the period beginning on January 1, 2023, and ending on December 31, 2027. Subparagraph C, Clause 1. Notwithstanding any other provision of this chapter, this subparagraph shall govern proceedings commenced pursuant to Section 114, subsection F, paragraph 1, subparagraph C concerning new types of services. Subsection 2. Not later than 30 days after a petition to determine rates and terms for a new type of service is filed by any copyright owner of sound recordings or such new type of service, indicating that such new type of service is or is about to become operational. The copyright royalty judges shall issue a notice for a proceeding to determine rates and terms for such service. Subsection 3. The proceedings shall follow the schedule set forth in subsections B, C, and D of Section 803, except that Subclause 1. The determination shall be issued by not later than 24 months after the publication of the notice under Clause 2, and Subclause 2. The decision shall take effect as provided in subsections C2 and D2 of Section 803 and Section 114, subsection F, paragraph 3, subparagraph B, Clause 2 and C. Subsection 4. The rates and terms shall remain in effect for the period set forth in Section 114, subsection F, paragraph 1, subparagraph C. Paragraph 4. Section 115 Proceedings. A petition described in subsection A to initiate proceedings under Section 801, subsection B, paragraph 1 concerning the adjustment or determination of royalty rates as provided in Section 115 may be filed in the year 2006 and in each subsequent 5th calendar year, or at such other times as the parties have agreed under Section 115, subsection C. Paragraph 3, subparagraph B and C. Paragraph 5. Section 116 Proceedings. Subparagraph A. A petition described in subsection A to initiate proceedings under Section 801. Substock B concerning the determination of royalty rates and terms as provided in Section 116 may be filed at any time within 1 year after negotiated licenses authorized by Section 116 are terminated or expire and are not replaced by subsequent agreements. Subparagraph B. If a negotiated license authorized by Section 116 is terminated or expires and is not replaced by another such license agreement which provides permission to use a quantity of musical works not substantially smaller than the quantity of such works performed on coin-operated phonorecord players during the 1-year period ending March 1989, the copyright royalty judges shall, upon petition filed under paragraph 1, within 1 year after such termination or expiration, commence a proceeding to promptly establish an interim royalty rate or rates for the public performance by means of a coin-operated phono record player of non-dramatic musical works, embodied in phono records which had been subject to the terminated or expired negotiated license agreement. such rate or rates shall be the same as the last such rate or rates, and shall remain in force until the conclusion of proceedings by the copyright royalty judges, in accordance with Section 803, to adjust the royalty rates applicable to such works, or until superseded by a new negotiated license agreement, as provided in Section 116, subsection B. Paragraph 6. Section 118 Proceedings. A petition described in subsection A to initiate proceedings under Section 801, subsection B. Paragraph 1 concerning the determination of reasonable terms and rates of royalty payments as provided in Section 118 may be filed in the year 2006 and in each subsequent 5th calendar year. Paragraph 7. Section 1004 Proceedings. A petition described in subsection A to initiate proceedings under Section 801, subsection B, paragraph 1 concerning the adjustment of reasonable royalty rates under Section 1004 may be filed as provided in Section 1004, subsection A, paragraph 3. Paragraph 8. Proceedings concerning distribution of royalty fees. With respect to proceedings under Section 801, subsection B, paragraph 3 concerning the distribution of royalty fees in certain circumstances under Section 111, 119, or 1007, the copyright royalty judges shall, upon a determination that a controversy exists concerning such distribution, cause to be published in the Federal Register notice of commencement of proceedings under this chapter. Section 805. General Rule for Voluntarily Negotiated Agreements. Any rates or terms under this title that Paragraph 1 are agreed to by participants to a proceeding under Section 803, subsection B, paragraph 3. Paragraph 2 are adopted by the copyright royalty judges as part of a determination under this chapter, and Paragraph 3 are in effect for a period shorter than would otherwise apply under a determination pursuant to this chapter, shall remain in effect for such period of time as would otherwise apply under such determination, except that the copyright royalty judges shall adjust the rates pursuant to the voluntary negotiations to reflect national monetary inflation during the additional period the rates remain in effect. Section 901. Definitions. Subsection A, as used in this chapter. Paragraph 1. A semiconductor chip product is the final or intermediate form of any product. Subparagraph A, having two or more layers of metallic, insulating, or semiconductor material, deposited or otherwise placed on, or etched away or otherwise removed from, a piece of semiconductor material in accordance with a predetermined pattern. And subparagraph B, intended to perform electronic circuitry functions. Paragraph 2. A mask work is a series of related images, however fixed or encoded. Subparagraph A, having or representing the predetermined three-dimensional pattern of metallic, insulating, or semiconductor material present or removed from the layers of a semiconductor chip product. And subparagraph B, in which series the relation of the images to one another is that each image has the pattern of the surface of one form of the semiconductor chip product. Paragraph 3. A mask work is fixed in a semiconductor chip product when its embodiment in the product is sufficiently permanent or stable to permit the mask work to be perceived or reproduced from the product for a period of more than transitory duration. Paragraph 4. To distribute means to sell or to lease, bail, or otherwise transfer, or to offer to sell, lease, bail, or otherwise transfer. Paragraph 5. To commercially exploit a mask work is to distribute to the public for commercial purposes a semiconductor chip product embodying the mask work, except that such term includes an offer to sell or transfer a semiconductor chip product only when the offer is in writing and occurs after the mask work is fixed in the semiconductor chip product. Paragraph 6. The owner of a mask work is the person who created the mask work, the legal representative of that person, if that person is deceased or under a legal incapacity, or a party to whom all the rights under this chapter of such person or representative are transferred in accordance with Section 903, subsection B, except that, in the case of a work made within the scope of a person's employment, the owner is the employer for whom the person created the mask work, or a party to whom all the rights under this chapter of the employer are transferred in accordance with Section 903, subsection B. Paragraph 7. An innocent purchaser is a person who purchases a semiconductor chip product in good faith and without having notice of protection with respect to the semiconductor chip product. Paragraph 8. Having notice of protection means having actual knowledge that, or reasonable grounds to believe that, a mask work is protected under this chapter. And Paragraph 9. An infringing semiconductor chip product is a semiconductor chip product which is made, imported, or distributed in violation of the exclusive rights of the owner of a mask work under this chapter. Subsection B. For purposes of this chapter, the distribution or importation of a product incorporating a semiconductor chip product as a part thereof is a distribution or importation of that semiconductor chip product. Section 902. Subject matter of protection. Subsection A, paragraph 1. Subject to the provisions of subsection B, a mask work fixed in a semiconductor chip product by or under the authority of the owner of the mask work is eligible for protection under this chapter if subparagraph A, on the date on which the mask work is registered under Section 908 or is first commercially exploited anywhere in the world, whichever occurs first, the owner of the mask work is a national or domiciliary of the United States, Clause 2. A national, domiciliary, or sovereign authority of a foreign nation that is a party to a treaty affording protection to mask works to which the United States is also a party, or 3. A stateless person, wherever that person may be domiciled. Subparagraph B, the mask work is first commercially exploited in the United States, or Subparagraph C, the mask work comes within the scope of a presidential proclamation issued under paragraph 2. Paragraph 2. Whenever the president finds that a foreign nation extends to mask works of owners who are nationals or domiciliaries of the United States protection, A, on substantially the same basis as that on which the foreign nation extends protection to mask works of its own nationals and domiciliaries and mask works first commercially exploited in that nation. Or B, on substantially the same basis as provided in this chapter, the President may by proclamation extend protection under this chapter to mask works I of owners who are on the date on which the mask works are registered under Section 908. Or the date on which the mask works are first commercially exploited anywhere in the world, whichever occurs first, nationals, domiciliaries, or sovereign authorities of that nation, or two which are first commercially exploited in that nation. The President may revise, suspend, or revoke any such proclamation or impose any conditions or limitations on protection extended under any such proclamation. Subsection B, protection under this chapter shall not be available for a mask work that paragraph 1 is not original, or paragraph 2 consists of designs that are staple, commonplace, or familiar in the semiconductor industry, or variations of such designs combined in a way that, considered as a whole, is not original. Subsection C. In no case does protection under this chapter for a mask work extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Section 903. Ownership, transfer, licensing, and recordation. Subsection A. The exclusive rights in a mask work subject to protection under this chapter belong to the owner of the mask work. Subsection B. The owner of the exclusive rights in a mask work may transfer all of those rights, or license all or less than all of those rights, by any written instrument signed by such owner or a duly authorized agent of the owner. Such rights may be transferred or licensed by operation of law, may be bequeathed by will, and may pass as personal property by the applicable laws of intestate succession. Subsection C, paragraph 1. Any document pertaining to a mask work may be recorded in the Copyright Office if the document filed for recordation bears the actual signature of the person who executed it, or if it is accompanied by a sworn or official certification that it is a true copy of the original signed document. The Register of Copyrights shall, upon receipt of the document and the fee specified pursuant to Section 908, subsection D, record the document and return it with a certificate of recordation. The recordation of any transfer or license under this paragraph gives all persons constructive notice of the facts stated in the recorded document concerning the transfer or license. Paragraph 2. In any case in which conflicting transfers of the exclusive rights in a mask work are made, the transfer first executed shall be void as against the subsequent transfer which is made for a valuable consideration and without notice of the first transfer, unless the first transfer is recorded in accordance with paragraph 1 within 3 months after the date on which it is executed, but in no case later than the day before the date of such subsequent transfer. Subsection D. Mask works prepared by an officer or employee of the United States government as part of that person's official duties are not protected under this chapter. But the United States government is not precluded from receiving and holding exclusive rights in mask works transferred to the government under subsection B. Section 904. Duration of protection. Subsection A. The protection provided for a mask work under this chapter shall commence on the date on which the mask work is registered under Section 908, or the date on which the mask work is first commercially exploited anywhere in the world, whichever occurs first. Subsection B, subject to subsection C and the provisions of this chapter, the protection provided under this chapter to a mask work shall end 10 years after the date on which such protection commences under subsection A. Subsection C, all terms of protection provided in this section shall run to the end of the calendar year in which they would otherwise expire. Section 905. Exclusive rights in mask works. The owner of a mask work provided protection under this chapter has the exclusive rights to do and to authorize any of the following. Paragraph 1. To reproduce the mask work by optical, electronic, or any other means. Paragraph 2. To import or distribute a semiconductor chip product in which the mask work is embodied. And Paragraph 3. To induce or knowingly to cause another person to do any of the acts described in paragraphs 1 and 2. Section 906. Limitation on exclusive rights, reverse engineering, first sale. Subsection A, notwithstanding the provisions of Section 905, it is not an infringement of the exclusive rights of the owner of a mask work for Paragraph 1. A person to reproduce the mask work solely for the purpose of teaching, analyzing, or evaluating the concepts or techniques embodied in the mask work or the circuitry, logic flow, or organization of components used in the mask work. Or Paragraph 2. A person who performs the analysis or evaluation described in Paragraph 1 to incorporate the results of such conduct in an original mask work which is made to be distributed. Subsection B. Notwithstanding the provisions of Section 905, subsection 2, the owner of a particular semiconductor chip product made by the owner of the mask work or by any person authorized by the owner of the mask work may import, distribute, or otherwise dispose of or use, but not reproduce, that particular semiconductor chip product without the authority of the owner of the mask work. Section 907. Limitation on exclusive rights, innocent infringement. Subsection A, notwithstanding any other provision of this chapter, an innocent purchaser of an infringing semiconductor chip product. Paragraph 1. Shall incur no liability under this chapter with respect to the importation or distribution of units of the infringing semiconductor chip product that occurs before the innocent purchaser has notice of protection with respect to the mask work embodied in the semiconductor chip product. And paragraph 2. Shall be liable only for a reasonable royalty on each unit of the infringing semiconductor chip product that the innocent purchaser imports or distributes after having notice of protection with respect to the mask work embodied in the semiconductor chip product. Subsection B, the amount of the royalty referred to in subsection A, paragraph 2 shall be determined by the court in a civil action for infringement unless the parties resolve the issue by voluntary negotiation, mediation, or binding arbitration. Subsection C, the immunity of an innocent purchaser from liability referred to in subsection A, paragraph 1, and the limitation of remedies with respect to an innocent purchaser referred to in subsection A, paragraph 2 shall extend to any person who directly or indirectly purchases an infringing semiconductor chip product from an innocent purchaser. Subsection D. The provisions of subsections A, B, and C apply only with respect to those units of an infringing semiconductor chip product that an innocent purchaser purchased before having notice of protection with respect to the mask work embodied in the semiconductor chip product. Section 908. Registration of claims of protection. Subsection A. The owner of a mask work may apply to the Register of Copyrights for registration of a claim of protection in a mask work. Protection of a mask work under this chapter shall terminate if application for registration of a claim of protection in the mask work is not made as provided in this chapter within 2 years after the date on which the mask work is first commercially exploited anywhere in the world. Subsection B. The Register of Copyrights shall be responsible for all administrative functions and duties under this chapter, except for Section 708. The provisions of Chapter 7 of this title relating to the general responsibilities, organization, regulatory authority, actions, records, and publications of the Copyright Office shall apply to this chapter, except that the Register of Copyrights may make such changes as may be necessary in applying those provisions to this chapter. Subsection C. The application for registration of a mask work shall be made on a form prescribed by the Register of Copyrights. Such form may require any information regarded by the Register as bearing upon the preparation or identification of the mask work, the existence or duration of protection of the mask work under this chapter, or ownership of the mask work. The application shall be accompanied by the fee set pursuant to subsection D and the identifying material specified pursuant to such subsection. Subsection D. The Register of Copyrights shall by regulation set reasonable fees for the filing of applications to register claims of protection in mask works under this chapter, and for other services relating to the administration of this chapter or the rights under this chapter, taking into consideration the cost of providing those services, the benefits of a public record, and statutory fee schedules under this title. The Register shall also specify the identifying material to be deposited in connection with the claim for registration. Subsection E. If the Register of Copyrights, after examining an application for registration, determines, in accordance with the provisions of this chapter, that the application relates to a mask work which is entitled to protection under this chapter, then the Register shall register the claim of protection and issue to the applicant a certificate of registration of the claim of protection under the seal of the Copyright Office. The effective date of registration of a claim of protection shall be the date on which an application, deposit of identifying material, and fee, which are determined by the Register of Copyrights or by a court of competent jurisdiction to be acceptable for registration of the claim, have all been received in the Copyright Office. Subsection F. In any action for infringement under this chapter, the certificate of registration of a mask work shall constitute prima facie evidence one of the facts stated in the certificate, and 2, that the applicant issued the certificate has met the requirements of this chapter and the regulations issued under this chapter with respect to the registration of claims. Subsection G. Any applicant for registration under this section who is dissatisfied with the refusal of the Register of Copyrights to issue a certificate of registration under this section may seek judicial review of that refusal by bringing an action for such review in an appropriate United States District Court not later than 60 days after the refusal. The provisions of Chapter 7 of Title 5 shall apply to such judicial review. The failure of the Register of Copyrights to issue a certificate of registration within 4 months after an application for registration is filed shall be deemed to be a refusal to issue a certificate of registration for purposes of this subsection and Section 910. Substact B, paragraph 2, except that upon a showing of good cause, the District Court may shorten such 4-month period. Section 909, Mask Work Notice. Subsection A. The owner of a mask work provided protection under this chapter may affix notice to the mask work and to masks and semiconductor chip products embodying the mask work in such manner and location as to give reasonable notice of such protection. The Register of Copyrights shall prescribe by regulation, as examples, specific methods of affixation and positions of notice for purposes of this section, but these specifications shall not be considered exhaustive. The affixation of such notice is not a condition of protection under this chapter, but shall constitute prima facie evidence of notice of protection. Subsection B. The notice referred to in subsection A shall consist of: Paragraph 1. The words mask work, the symbol M or the symbol M, the letter M in a circle, and Paragraph 2. The name of the owner or owners of the mask work or an abbreviation by which the name is recognized or is generally known. Section 910. Enforcement of exclusive rights. Subsection A. Except as otherwise provided in this chapter, any person who violates any of the exclusive rights of the owner of a mask work under this chapter by conduct in or affecting commerce shall be liable as an infringer of such rights. As used in this subsection, the term any person includes any state, any instrumentality of a state, and any officer or employee of a state or instrumentality of a state acting in his or her official capacity. Any state and any such instrumentality, officer, or employee shall be subject to the provisions of this chapter in the same manner and to the same extent as any non-governmental entity. Subsection B, Paragraph 1. The owner of a mask work protected under this chapter, or the exclusive licensee of all rights under this chapter with respect to the mask work, shall, after a certificate of registration of a claim of protection in that mask work has been issued under Section 908, be entitled to institute a civil action for any infringement with respect to the mask work which is committed after the commencement of protection of the mask work under Section 904, Subsection A, Paragraph 2. In any case in which an application for registration of a claim of protection in a mask work and the required deposit of identifying material and fee have been received in the Copyright Office in proper form and registration of the mask work has been refused, the applicant is entitled to institute a civil action for infringement under this chapter with respect to the mask work if notice of the action, together with a copy of the complaint, is served on the Register of Copyrights. In accordance with the Federal Rules of Civil Procedure, the Register may, at his or her option, become a party to the action with respect to the issue of whether the claim of protection is eligible for registration by entering an appearance within 60 days after such service. But the failure of the Register to become a party to the action shall not deprive the court of jurisdiction to determine that issue. Subsection C, Paragraph 1. The Secretary of the Treasury and the United States Postal Service shall separately or jointly issue regulations for the enforcement of the rights set forth in Section 905 with respect to importation. These regulations may require, as a condition for the exclusion of articles from the United States, that the person seeking exclusion take any one or more of the following actions. Subparagraph A. Obtain a court order enjoining or an order of the International Trade Commission under Section 337 of the Tariff Act of 1930 excluding importation of the articles. Subparagraph B. Furnish proof that the mask work involved is protected under this chapter and that the importation of the articles would infringe the rights in the mask work under this chapter. Subparagraph C. Post a surety bond for any injury that may result if the detention or exclusion of the articles proves to be unjustified. Paragraph 2. Articles imported in violation of the rights set forth in Section 905 are subject to seizure and forfeiture in the same manner as property imported in violation of the customs laws. Any such forfeited articles shall be destroyed as directed by the Secretary of the Treasury or the court, as the case may be, except that the articles may be returned to the country of export whenever it is shown to the satisfaction of the Secretary of the Treasury that the importer had no reasonable grounds for believing that his or her acts constituted a violation of the law. Section 9011. Civil Actions. Subsection A. Any court having jurisdiction of a civil action arising under this chapter may grant temporary restraining orders, preliminary injunctions, and permanent injunctions on such terms as the court may deem reasonable to prevent or restrain infringement of the exclusive rights in a mask work under this chapter. Subsection B. Upon finding an infringer liable to a person entitled under Section 910, subsection B, Paragraph 1, to institute a civil action for an infringement of any exclusive right under this chapter, the court shall award such person actual damages suffered by the person as a result of the infringement. The court shall also award such person the infringer's profits that are attributable to the infringement and are not taken into account in computing the award of actual damages. In establishing the infringer's profits, such person is required to present proof only of the infringer's gross revenue, and the infringer is required to prove his or her deductible expenses and the elements of profit attributable to factors other than the mask work. Subsection C. At any time before final judgment is rendered, a person entitled to institute a civil action for infringement may elect, instead of actual damages and profits as provided by subsection B, an award of statutory damages for all infringements involved in the action, with respect to any one mask work for which any one infringer is liable individually, or for which any two or more infringers are liable jointly and severally. in an amount not more than $250,000 as the court considers just. Subsection D, an action for infringement under this chapter shall be barred unless the action is commenced within 3 years after the claim accrues. Subsection E, paragraph 1. At any time while an action for infringement of the exclusive rights in a mask work under this chapter is pending, the court may order the impounding, on such terms as it may deem reasonable, of all semiconductor chip products, and any drawings, tapes, masks, or other products by means of which such products may be reproduced that are claimed to have been made, imported, or used in violation of those exclusive rights. Insofar as practicable, applications for orders under this paragraph shall be heard and determined in the same manner as an application for a temporary restraining order or preliminary injunction. Paragraph 2. As part of a final judgment or decree, the court may order the destruction or other disposition of any infringing semiconductor chip products and any masks, tapes, or other articles by means of which such products may be reproduced. Subsection F. In any civil action arising under this chapter, the court in its discretion may allow the recovery of full costs, including reasonable attorney's fees, to the prevailing party. Subsection G, paragraph 1. Any state, any instrumentality of a state, and any officer or employee of a state, or instrumentality of a state acting in his or her official capacity, shall not be immune, under the 11th Amendment of the Constitution of the United States or under any other doctrine of sovereign immunity, from suit in federal court by any person, including any governmental or non-governmental entity, for a violation of any of the exclusive rights of the owner of a mask work under this chapter, or for any other violation under this chapter. Paragraph 2. In a suit described in paragraph 1 for a violation described in that paragraph. Remedies, including remedies both at law and in equity, are available for the violation to the same extent as such remedies are available for such a violation in a suit against any public or private entity other than a state, instrumentality of a state, or officer or employee of a state acting in his or her official capacity. Such remedies include actual damages and profits under subsection B, statutory damages under subsection C, impounding and disposition of infringing articles under subsection E, and costs and attorney's fees under subsection F. Section 912. Relation to other laws. Subsection A. Nothing in this chapter shall affect any right or remedy held by any person under chapters 1 through 8 or 10 of this title, or under Title 35. Subsection B, except as provided in Section 908, subsection B of this title, references to this title or Title 17 in chapters 1 through 8 or 10 of this title shall be deemed not to apply to this chapter. Subsection C. The provisions of this chapter shall preempt the laws of any state to the extent those laws provide any rights or remedies with respect to a mask work which are equivalent to those rights or remedies provided by this chapter, except that such preemption shall be effective only with respect to actions filed on or after January 1, 1986. Subsection D. Notwithstanding subsection C, nothing in this chapter shall detract from any rights of a mask work owner, whether under federal law exclusive of this chapter or under the common law or the statutes of a state, heretofore or hereafter declared or enacted, with respect to any mask work first commercially exploited before July 1, 1983. Section 913. Transitional Provisions. Subsection A. No application for registration under Section 908 may be filed, and no civil action under Section 910 or other enforcement proceeding under this chapter may be instituted until 60 days after the date of the enactment of this chapter. Subsection B. No monetary relief under Section 911 may be granted with respect to any conduct that occurred before the date of the enactment of this chapter, except as provided in subsection D. Subsection C. Subject to subsection A. The provisions of this chapter apply to all mask works that are first commercially exploited or are registered under this chapter, or both, on or after the date of the enactment of this chapter. Subsection D, paragraph 1. Subject to subsection A, protection is available under this chapter to any mask work that was first commercially exploited on or after July 1, 1983, and before the date of the enactment of this chapter. If a claim of protection in the mask work is registered in the Copyright Office before July 1, 1985, under Section 908. Paragraph 2. In the case of any mask work described in paragraph 1 that is provided protection under this chapter, infringing semiconductor chip product units manufactured before the date of the enactment of this chapter may, without liability under sections 910 or 9111, be imported into or distributed in the United States, or both, until 2 years after the date of registration of the mask work under section 908, but only if the importer or distributor, as the case may be, first pays or offers to pay the reasonable royalty referred to in Section 907, subsection A, paragraph 2 to the mask work owner, on all such units imported or distributed or both after the date of the enactment of this chapter. Paragraph 3. In the event that a person imports or distributes infringing semiconductor chip product units described in paragraph 2 of this subsection without first paying or offering to pay the reasonable royalty specified in such paragraph, or if the person refuses or fails to make such payment, the mask work owner shall be entitled to the relief provided in sections 911 and 911. Section 914. International Transitional Provisions. Subsection A. Notwithstanding the conditions set forth in subparagraphs A and C of Section 902, subsection A, paragraph 1 with respect to the availability of protection under this chapter to nationals, domiciliaries, and sovereign authorities of a foreign nation, the Secretary of Commerce may, upon the petition of any person, or upon the Secretary's own motion, issue an order extending protection under this chapter to such foreign nationals, domiciliaries, and sovereign authorities if the Secretary finds. Paragraph 1. That the foreign nation is making good faith efforts and reasonable progress toward. Subparagraph A. Entering into a treaty described in Section 900 A2, subsection A, paragraph 1, subparagraph A, or. Subparagraph B. Enacting or implementing legislation that would be in compliance with subparagraph A or B of Section 902, subsection A, paragraph 2, and paragraph 2, that the nationals, domiciliaries, and sovereign authorities of the foreign nation and persons controlled by them are not engaged in the misappropriation or unauthorized distribution or commercial exploitation of mask works, and paragraph 3, that issuing the order would promote the purposes of this chapter in international comity with respect to the protection of mask works. Subsection B. While an order under subsection A is in effect with respect to a foreign nation, no application for registration of a claim for protection in a mask work under this chapter may be denied solely because the owner of the mask work is a national, domiciliary, or sovereign authority of that foreign nation, or solely because the mask work was first commercially exploited in that foreign nation. Subsection C. Any order issued by the Secretary of Commerce under subsection A shall be effective for such period as the Secretary designates in the order, except that no such order may be effective after the date on which the authority of the Secretary of Commerce terminates under subsection E. The effective date of any such order shall also be designated in the order. In the case of an order issued upon the petition of a person, such effective date may be no earlier than the date on which the Secretary receives such petition. Subsection D, paragraph 1. Any order issued under this section shall terminate if. Subparagraph A, the Secretary of Commerce finds that any of the conditions set forth in paragraphs 1, 2, and 3 of subsection A no longer exist, or subparagraph B. Mask works of nationals, domiciliaries, and sovereign authorities of that foreign nation, or mask works first commercially exploited in that foreign nation become eligible for protection under subparagraph A or C of Section 902, subsection A, paragraph 1. Paragraph 2. Upon the termination or expiration of an order issued under this section, registrations of claims of protection in mask works made pursuant to that order shall remain valid for the period specified in Section 904. Subsection E. The authority of the Secretary of Commerce under this section shall commence on the date of the enactment of this chapter, and shall terminate on July 1, 1995. Subsection F, paragraph 1. The Secretary of Commerce shall promptly notify the Register of Copyrights and the committees on the Judiciary of the Senate and the House of Representatives of the issuance or termination of any order under this section, together with a statement of the reasons for such action. The Secretary shall also publish such notification and statement of reasons in the Federal Register. Paragraph 2. 2 years after the date of the enactment of this chapter, the Secretary of Commerce, in consultation with the Register of Copyrights, shall transmit to the committees on the Judiciary of the Senate and the House of Representatives a report on the actions taken under this section and on the current status of international recognition of mask work protection. The report shall include such recommendations for modifications of the protection accorded under this chapter to mask works owned by nationals, domiciliaries, or sovereign authorities of foreign nations as the Secretary, in consultation with the Register of Copyrights, considers would promote the purposes of this chapter and international comity with respect to mask work protection. Not later than July 1, 1994, the Secretary of Commerce, in consultation with the Register of Copyrights, shall transmit to the committees on the Judiciary of the Senate and the House of Representatives a report updating the matters contained in the report transmitted under the preceding sentence. Section 1001. Definitions. As used in this chapter, the following terms have the following meanings. Paragraph 1. A digital audio copied recording is a reproduction in a digital recording format of a digital musical recording, whether that reproduction is made directly from another digital musical recording or indirectly from a transmission. Paragraph 2. A digital audio interface device is any machine or device that is designed specifically to communicate digital audio information and related interface data to a digital audio recording device through a non-professional interface. Paragraph 3. A digital audio recording device is any machine or device of a type commonly distributed to individuals for use by individuals, whether or not included with or as part of some other machine or device, the digital recording function of which is designed or marketed for the primary purpose of, and that is capable of, making a digital audio copied recording for private use except for subparagraph A, professional model products, and subparagraph B, dictation machines, answering machines, and other audio recording equipment that is designed and marketed primarily for the creation of sound recordings resulting from the fixation of non-musical sounds. Paragraph 4, subparagraph A. A digital audio recording medium is any material object in a form commonly distributed for use by individuals that is primarily marketed or most commonly used by consumers for the purpose of making digital audio copied recordings by use of a digital audio recording device. Subparagraph B. Such term does not include any material object. Clause 1. That embodies a sound recording at the time it is first distributed by the importer or manufacturer, or Clause 2. That is primarily marketed and most commonly used by consumers either for the purpose of making copies of motion pictures or other audiovisual works, or for the purpose of making copies of non-musical literary works, including computer programs or databases. Paragraph 5. Subparagraph A. A digital musical recording is a material object. Clause 1, in which are fixed, in a digital recording format, only sounds and material statements or instructions incidental to those fixed sounds, if any, and Clause 2, from which the sounds and material can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Subparagraph B. A digital musical recording does not include a material object. Clause 1, in which the fixed sounds consist entirely of spoken word recordings, or Clause 2, in which one or more computer programs are fixed, except that a digital musical recording may contain statements or instructions constituting the fixed sounds and incidental material, and statements or instructions to be used directly or indirectly in order to bring about the perception, reproduction, or communication of the fixed sounds and incidental material. Subparagraph C. For purposes of this paragraph. Clause 1. A spoken word recording is a sound recording in which are fixed only a series of spoken words, except that the spoken words may be accompanied by incidental musical or other sounds, and Clause 2. The term incidental means related to and relatively minor by comparison. Paragraph 6. Distribute means to sell, lease, or assign a product to consumers in the United States, or to sell, lease, or assign a product in the United States for ultimate transfer to consumers in the United States. Paragraph 7. An interested copyright party is Subparagraph A. The owner of the exclusive right under Section 106, Substact 1 of this title to reproduce a sound recording of a musical work that has been embodied in a digital musical recording or analog musical recording lawfully made under this title that has been distributed. Subparagraph B. The legal or beneficial owner of, or the person that controls, the right to reproduce in a digital musical recording or analog musical recording a musical work that has been embodied in a digital musical recording or analog musical recording lawfully made under this title that has been distributed. Subparagraph C. Featured recording artist who performs on a sound recording that has been distributed, or Subparagraph D. Any association or other organization. Clause 1. Representing persons specified in Subparagraph A, B, or C, or Clause 2. Engaged in licensing rights in musical works to music users on behalf of writers and publishers. Paragraph 8. To manufacture means to produce or assemble a product in the United States. A manufacturer is a person who manufactures. Paragraph 9. A music publisher is a person that is authorized to license the reproduction of a particular musical work in a sound recording. Paragraph 10. A professional model product is an audio recording device that is designed, manufactured, marketed, and intended for use by recording professionals in the ordinary course of a lawful business, in accordance with such requirements as the Secretary of Commerce shall establish by regulation. Paragraph 11. The term serial copying means the duplication in a digital format of a copyrighted musical work or sound recording from a digital reproduction of a digital musical recording. The term digital reproduction of a digital musical recording does not include a digital musical recording as distributed by authority of the copyright owner for ultimate sale to consumers. Paragraph 12. The transfer price of a digital audio recording device or a digital audio recording medium. Subparagraph A is subject to Subparagraph B. Clause 1. In the case of an imported product, the actual entered value at United States Customs, exclusive of any freight, insurance, and applicable duty, and Clause 2. In the case of a domestic product, the manufacturer's transfer price, FOB the manufacturer, and exclusive of any direct sales taxes or excise taxes incurred in connection with the sale, and Subparagraph B. Shall, in a case in which the transferor and transferee are related entities or within a single entity, not be less than a reasonable arm's length price under the principles of the regulations adopted pursuant to Section 482 of the Internal Revenue Code of 1986, or any successor provision to such section. Paragraph 13. A writer is the composer or lyricist of a particular musical work. Section 1002. Incorporation of copying controls. Subsection A. Prohibition on importation, manufacture, and distribution. No person shall import, manufacture, or distribute any digital audio recording device or digital audio interface device that does not conform to. Paragraph 1. The Serial Copy Management System. Paragraph 2. A system that has the same functional characteristics as the serial copy management system and requires that copyright and generation status information be accurately sent, received, and acted upon between devices using the system's method of serial copying regulation and devices using the serial copy management system, or Paragraph 3. Any other system certified by the Secretary of Commerce as prohibiting unauthorized serial copying. Subsection B. Development of verification procedure. The Secretary of Commerce shall establish a procedure to verify upon the petition of an interested party that a system meets the standards set forth in subsection A, paragraph 2. Subsection C. Prohibition on circumvention of the system. No person shall import, manufacture, or distribute any device, or offer or perform any service, the primary purpose or effect of which is to avoid, bypass, remove, deactivate, or otherwise circumvent any program or circuit which implements, in whole or in part, a system described in subsection A. Subsection D. Encoding of information on digital musical recordings. Paragraph 1. Prohibition on encoding inaccurate information. No person shall encode a digital musical recording of a sound recording with inaccurate information relating to the category code, copyright status, or generation status of the source material for the recording. Paragraph 2. Encoding of copyright status not required. Nothing in this chapter requires any person engaged in the importation or manufacture of digital musical recordings to encode any such digital musical recording with respect to its copyright status. Subsection E. Information accompanying transmissions in digital format. Any person who transmits or otherwise communicates to the public any sound recording in digital format is not required under this chapter to transmit or otherwise communicate the information relating to the copyright status of the sound recording. Any such person who does transmit or otherwise communicate such copyright status information shall transmit or communicate such information accurately. Section 1003. Obligation to make royalty payments. Subsection A. Prohibition on importation and manufacture. No person shall import into and distribute or manufacture and distribute any digital audio recording device or digital audio recording medium unless such person records the notice specified by this section and subsequently deposits the statements of account and applicable royalty payments for such device or medium specified in Section 1004. Subsection B. Filing of notice. The importer or manufacturer of any digital audio recording device or digital audio recording medium within a product category or utilizing a technology with respect to which such manufacturer or importer has not previously filed a notice under this subsection, shall file with the Register of Copyrights a notice with respect to such device or medium, in such form and content as the Register shall prescribe by regulation. Subsection C. Filing of quarterly and annual statements of account. Paragraph 1. Generally, any importer or manufacturer that distributes any digital audio recording device or digital audio recording medium that it manufactured or imported shall file with the Register of Copyrights, in such form and content as the Register shall prescribe by regulation, such quarterly and annual statements of account, with respect to such distribution as the Register shall prescribe by regulation. Paragraph 2. Certification, verification, and confidentiality. Each such statement shall be certified as accurate by an authorized officer or principal of the importer or manufacturer. The Register shall issue regulations to provide for the verification and audit of such statements and to protect the confidentiality of the information contained in such statements. Such regulations shall provide for the disclosure in confidence of such statements to interested copyright parties. Paragraph 3. Royalty payments. Each such statement shall be accompanied by the royalty payments specified in Section 1004. Section 1004. Royalty payments. Subsection A. Digital audio recording devices. Paragraph 1. Amount of payment. The royalty payment due under Section 1003 for each digital audio recording device imported into and distributed in the United States or manufactured and distributed in the United States shall be 2% of the transfer price. Only the first person to manufacture and distribute or import and distribute such device shall be required to pay the royalty with respect to such device. Paragraph 2. Calculation for devices distributed with other devices. With respect to a digital audio recording device first distributed in combination with one or more devices, either as a physically integrated unit or as separate components, the royalty payment shall be calculated as follows. Subparagraph A. If the digital audio recording device and such other devices are part of a physically integrated unit, the royalty payment shall be based on the transfer price of the unit, but shall be reduced by any royalty payment made on any digital audio recording device included within the unit that was not first distributed in combination with the unit. Subparagraph B. If the digital audio recording device is not part of a physically integrated unit and substantially similar devices have been distributed separately at any time during the preceding 4 calendar quarters, the royalty payment shall be based on the average transfer price of such devices during those 4 quarters. Subparagraph C. If the digital audio recording device is not part of a physically integrated unit and substantially similar devices have not been distributed separately at any time during the preceding 4 calendar quarters, the royalty payment shall be based on a constructed price reflecting the proportional value of such device to the combination as a whole. Paragraph 3. Limits on royalties. Notwithstanding paragraph 1 or 2, the amount of the royalty payment for each digital audio recording device shall not be less than $1 nor more than the royalty maximum. The royalty maximum shall be $8 per device, except that in the case of a physically integrated unit containing more than one digital audio recording device, the royalty maximum for such unit shall be $12. During the 6th year after the effective date of this chapter, and not more than once each year thereafter, any interested copyright party may petition the copyright royalty judges to increase the royalty maximum and, If more than 20% of the royalty payments are at the relevant royalty maximum, the copyright royalty judges shall prospectively increase such royalty maximum with the goal of having no more than 10% of such payments at the new royalty maximum. However, the amount of any such increase as a percentage of the royalty maximum shall in no event exceed the percentage increase in the Consumer Price Index during the period under review. Subsection B. Digital audio recording media. The royalty payment due under Section 1003 for each digital audio recording medium imported into and distributed in the United States or manufactured and distributed in the United States shall be 3% of the transfer price. Only the first person to manufacture and distribute or import and distribute such medium shall be required to pay the royalty with respect to such medium. Section 1005. Deposit of royalty payments and deduction of expenses. The Register of Copyrights shall receive all royalty payments deposited under this chapter, and, after deducting the reasonable costs incurred by the Copyright Office under this chapter, shall deposit the balance in the Treasury of the United States as offsetting receipts in such manner as the Secretary of the Treasury directs. All funds held by the Secretary of the Treasury shall be invested in interest-bearing United States securities for later distribution with interest under Section 1007. The Register may, in the Register's discretion, 4 years after the close of any calendar year, close out the royalty payments account for that calendar year, and may treat any funds remaining in such account and any subsequent deposits that would otherwise be attributable to that calendar year as attributable to the succeeding calendar year. Section 1006. Entitlement to royalty payments. Subsection A. Interested copyright parties. The royalty payments deposited pursuant to Section 1005 shall, in accordance with the procedures specified in Section 1007, be distributed to any interested copyright party. Paragraph 1. Whose musical work or sound recording has been. Subparagraph A. Embodied in a digital musical recording or an analog musical recording lawfully made under this title that has been distributed, and Subparagraph B. Distributed in the form of digital musical recordings or analog musical recordings, or disseminated to the public in transmissions during the period to which such payments pertain, and Paragraph 2. Who has filed a claim under Section 1007. Subsection B. Allocation of royalty payments to groups. The royalty payments shall be divided into two funds as follows. Paragraph 1. The Sound Recordings Fund. 662, 3% of the royalty payments shall be allocated to the Sound Recordings Fund. 25.8% of the royalty payments allocated to the Sound Recordings Fund shall be placed in an escrow account managed by an independent administrator, jointly appointed by the interested copyright parties described in Section 1001, subsection 7, Paragraph A, and the American Federation of Musicians, or any successor entity, to be distributed to non-featured musicians whether or not members of the American Federation of Musicians or any successor entity who have performed on sound recordings distributed in the United States. 138% of the royalty payments allocated to the Sound Recordings Fund shall be placed in an escrow account managed by an independent administrator jointly appointed by the interested copyright parties described in Section 1001, subsection 7, Paragraph A, and the American Federation of TV and Radio Artists, or any successor entity, to be distributed to non-featured vocalists, whether or not members of the American Federation of Television and Radio Artists, or any successor entity, who have performed on sound recordings distributed in the United States. 40% of the remaining royalty payments in the Sound Recordings Fund shall be distributed to the interested copyright parties described in Section 1001, subsection 7, paragraph C, and 60% of such remaining royalty payments shall be distributed to the interested copyright parties described in Section 1001, subsection 7, paragraph A. Paragraph 2. The Musical Works Fund. Subparagraph A, 331/3% of the royalty payments shall be allocated to the Musical Works Fund for distribution to interested copyright parties described in Section 1001, subsection 7, paragraph B. Subparagraph B, clause 1. Music publishers shall be entitled to 50% of the royalty payments allocated to the Musical Works Fund. Subsection 2. Writers shall be entitled to the other 50% of the royalty payments allocated to the Musical Works Fund. Subsection C. Allocation of royalty payments within groups. If all interested copyright parties within a group specified in subsection B do not agree on a voluntary proposal for the distribution of the royalty payments within each group, the copyright royalty judges shall, pursuant to the procedures specified under Section 1007, subsection C, allocate royalty payments under this section based on the extent to which during the relevant period. Paragraph 1. For the Sound Recordings Fund. Each sound recording was distributed in the form of digital musical recordings or analog musical recordings, and Paragraph 2. For the Musical Works Fund. Each musical work was distributed in the form of digital musical recordings or analog musical recordings or disseminated to the public in transmissions. Section 1007. Procedures for distributing royalty payments. Subsection A. Filing of claims and negotiations. Paragraph 1. Filing of claims. During the first 2 months of each calendar year, Every interested copyright party seeking to receive royalty payments to which such party is entitled under Section 1006 shall file with the copyright royalty judges a claim for payments collected during the preceding year in such form and manner as the copyright royalty judges shall prescribe by regulation. Paragraph 2. Negotiations. Notwithstanding any provision of the antitrust laws, for purposes of this section, interested copyright parties within each group specified in Section 1006, subsection B may agree among themselves to the proportionate division of royalty payments, may lump their claims together and file them jointly or as a single claim, or may designate a common agent, including any organization described in Section 1001, subsection 7, paragraph D, to negotiate or receive payment on their behalf, except that no agreement under this subsection may modify the allocation of royalties specified in Section 1006, subsection B. Subsection B. Distribution of payments in the absence of a dispute. After the period established for the filing of claims under subsection A in each year, the copyright royalty judges shall determine whether there exists a controversy concerning the distribution of royalty payments under Section 1006, subsection C. If the copyright royalty judges determine that no such controversy exists, the copyright royalty judges shall, within 30 days after such determination, authorize the distribution of the royalty payments as set forth in the agreements regarding the distribution of royalty payments entered into pursuant to subsection A. The Librarian of Congress shall, before such royalty payments are distributed, deduct the reasonable administrative costs incurred under this section. Subsection C. Resolution of disputes. If the copyright royalty judges find the existence of a controversy, the copyright royalty judges shall, pursuant to Chapter 8 of this title, conduct a proceeding to determine the distribution of royalty payments. During the pendency of such a proceeding, the copyright royalty judges shall withhold from distribution an amount sufficient to satisfy all claims with respect to which a controversy exists, but shall, to the extent feasible, authorize the distribution of any amounts that are not in controversy. The Librarian of Congress shall, before such royalty payments are distributed, deduct the reasonable administrative costs incurred under this section. Section 1008. Prohibition on certain infringement actions. No action may be brought under this title alleging infringement of copyright based on the manufacture, importation, or distribution of a digital audio recording device, a digital audio recording medium, an analog recording device, or an analog recording medium, or based on the non-commercial use by a consumer of such a device or medium for making digital musical recordings or analog musical recording. Section 1009. Civil remedies. Subsection A. Civil actions. Any interested copyright party injured by a violation of Section 1002 or 1003 may bring a civil action in an appropriate United States District Court against any person for such violation. Subsection B. Other civil actions. Any person injured by a violation of this chapter may bring a civil action in an appropriate United States District Court for actual damages incurred as a result of such violation. Subsection C. Powers of the Court. In an action brought under subsection A, the Court. Paragraph 1. May grant temporary and permanent injunctions on such terms as it deems reasonable to prevent or restrain such violation. Paragraph 2. In the case of a violation of Section 1002, or in the case of an injury resulting from a failure to make royalty payments required by Section 1003, shall award damages under subsection D. Paragraph 3. In its discretion may allow the recovery of costs by or against any party other than the United States or an officer thereof, and Paragraph 4. In its discretion may award a reasonable attorney's fee to the prevailing party. Subsection D. Award of damages. Paragraph 1. Damages for Section 1002 or 1003 violations. Subparagraph A. Actual damages. Subsection I. In an action brought under subsection A, if the court finds that a violation of Section 1002 or 1003 has occurred, the court shall award to the complaining party its actual damages if the complaining party elects such damages at any time before final judgment is entered. Subsection 2. In the case of Section 1003, actual damages shall constitute the royalty payments that should have been paid under Section 1004 and deposited under Section 1005. In such a case, the court, in its discretion, may award an additional amount of not to exceed 50% of the actual damages. Subparagraph B. Statutory damages for Section 1002 violations. Clause 1. Device. A complaining party may recover an award of statutory damages for each violation of Section 1002, subsection A or C in the sum of not more than $2,500 per device involved in such violation, or per device on which a service prohibited by Section 1002, substag C has been performed as the court considers just. Clause 2. Digital musical recording. A complaining party may recover an award of statutory damages for each violation of Section 1002, subsection D in the sum of not more than $25 per digital musical recording involved in such violation, as the court considers just. Clause 3. Transmission. A complaining party may recover an award of damages for each transmission or communication that violates Section 1002, subsection E in the sum of not more than $10,000, as the court considers just. Paragraph 2. Repeated violations. In any case in which the court finds that a person has violated Section 1002 or 1003 within 3 years after a final judgment against that person for another such violation was entered, the court may increase the award of damages to not more than double the amounts that would otherwise be awarded under Paragraph 1, as the court considers just. Paragraph 3. Innocent violations of Section 1002. The court, in its discretion, may reduce the total award of damages against a person violating Section 1002 to a sum of not less than $250 in any case in which the court finds that the violator was not aware and had no reason to believe that its acts constituted a violation of Section 1002. Subsection E. Payment of damages. Any award of damages under subsection D shall be deposited with the register pursuant to Section 1005 for distribution to interested copyright parties, as though such funds were royalty payments made pursuant to Section 1003. Subsection F. Impounding of articles. At any time while an action under subsection A is pending, the court may order the impounding on such terms as it deems reasonable of any digital audio recording device, digital musical recording, or device specified in Section 1002. Substract C that is in the custody or control of the alleged violator, and that the court has reasonable cause to believe does not comply with or was involved in a violation of Section 1002. Subsection G. Remedial modification and destruction of articles. In an action brought under subsection A, the court may, as part of a final judgment or decree finding a violation of Section 1002, order the remedial modification or the destruction of any digital audio recording device, digital musical recording, or device specified in Section 1002, subsection C that Paragraph 1 does not comply with or was involved in a violation of Section 1002, and Paragraph 2 is in the custody or control of the violator, or has been impounded under subsection F. Section 10,1010. Determination of certain disputes. Subsection A. Scope of determination. Before the date of first distribution in the United States of a digital audio recording device or a digital audio interface device, any party manufacturing, importing, or distributing such device, and any interested copyright party may mutually agree to petition the copyright royalty judges to determine whether such device is subject to Section 1002 or the basis on which royalty payments for such device are to be made under Section 1003. Subsection B. Initiation of proceedings. The parties under subsection A shall file the petition with the copyright royalty judges requesting the commencement of a proceeding. Within 2 weeks after receiving such a petition, the chief copyright royalty judge shall cause notice to be published in the Federal Register of the initiation of the proceeding. Subsection C. Stay of judicial proceedings. Any civil action brought under Section 1009 against a party to a proceeding under this section shall, on application of one of the parties to the proceeding, be stayed until completion of the proceeding. Subsection D. Proceeding. The copyright royalty judges shall conduct a proceeding with respect to the matter concerned, in accordance with such procedures as the copyright royalty judges may adopt. The copyright royalty judges shall act on the basis of a fully documented written record. Any party to the proceeding may submit relevant information and proposals to the copyright royalty judges. The parties to the proceeding shall each bear their respective costs of participation. Subsection E. Judicial review. Any determination of the copyright royalty judges under subsection D may be appealed by a party to the proceeding in accordance with Section 883, subsection D of this title. The pendency of an appeal under this subsection shall not stay the determination of the copyright royalty judges. If the court modifies the determination of the copyright royalty judges, the court shall have jurisdiction to enter its own decision in accordance with its final judgment. The court may further vacate the determination of the copyright royalty judges and remand the case for proceedings as provided in this section. Section 1101. Unauthorized fixation and trafficking in sound recordings and music videos. Subsection A. Unauthorized acts. Anyone who, without the consent of the performer or performers involved. Paragraph 1. Fixes the sounds or sounds and images of a live musical performance in a copy or phonorecord, or reproduces copies or phonorecords of such a performance from an unauthorized fixation. Paragraph 2. Transmits or otherwise communicates to the public the sounds or sounds and images of a live musical performance, or Paragraph 3. Distributes or offers to distribute, sells or offers to sell, rents or offers to rent, or traffics in any copy or phonorecord fixed as described in Paragraph 1, regardless of whether the fixations occurred in the United States, shall be subject to the remedies provided in Sections 502 through 505 to the same extent as an infringer of copyright. Subsection B. Definition. In this section, the term traffic has the same meaning as in Section 2320, subsection E of Title 18. Subsection C. Applicability. This section shall apply to any act or acts that occur on or after the date of the enactment of the Uruguay Round Agreements Act. Subsection D. State law, not preempted. Nothing in this section may be construed to annul or limit any rights or remedies under the common law or statutes of any state. Section 1201. Circumvention of copyright protection systems. Subsection A. Violations regarding circumvention of technological measures. 1A. No person shall circumvent a technological measure that effectively controls access to a work protected under this title. The prohibition contained in the preceding sentence shall take effect at the end of the 2-year period beginning on the date of the enactment of this chapter. Subparagraph B. The prohibition contained in subparagraph A shall not apply to persons who are users of a copyrighted work, which is in a particular class of works, if such persons are, or are likely to be in the succeeding 3-year period, adversely affected by virtue of such prohibition in their ability to make non-infringing uses of that particular class of works under this title, as determined under subparagraph C. Subparagraph C. During the 2-year period described in subparagraph A, and during each succeeding 3-year period, the Librarian of Congress, upon the recommendation of the Register of Copyrights, who shall consult with the Assistant Secretary for Communications and Information of the Department of Commerce, and report and comment on his or her views in making such recommendation, shall make the determination in a rulemaking proceeding for purposes of subparagraph B of whether persons who are users of a copyrighted work are, or are likely to be in the succeeding 3-year period, adversely affected by the prohibition under subparagraph A in their ability to make non-infringing uses under this title of a particular class of copyrighted works. In conducting such rulemaking, the librarian shall examine: Clause 1. The availability for use of copyrighted works. Clause 2. The availability for use of works for nonprofit archival, preservation, and educational purposes. Clause 3. The impact that the prohibition on the circumvention of technological measures applied to copyrighted works has on criticism, comment, news reporting, teaching, scholarship, or research. Clause 4. The effect of circumvention of technological measures on the market for or value of copyrighted works. And Clause 5. Such other factors as the librarian considers appropriate. Subparagraph D. The librarian shall publish any class of copyrighted works for which the librarian has determined, pursuant to the rulemaking conducted under subparagraph C, that non-infringing uses by persons who are users of a copyrighted work are, or are likely to be, adversely affected, and the prohibition contained in subparagraph A shall not apply to such users with respect to such class of works for the ensuing 3-year period. Subparagraph E. Neither the exception under subparagraph B from the applicability of the prohibition contained in subparagraph A, nor any determination made in a rulemaking conducted under subparagraph C, may be used as a defense in any action to enforce any provision of this title other than this paragraph. Paragraph 2. No person shall manufacture, import, offer to the public, provide, or otherwise traffic in any technology, product, service, device, component, or part thereof, that subparagraph A is primarily designed or produced for the purpose of circumventing a technological measure that effectively controls access to a work protected under this title. Subparagraph B has only limited commercially significant purpose or use other than to circumvent a technological measure that effectively controls access to a work protected under this title, or subparagraph C is marketed by that person or another acting in concert with that person's knowledge for use in circumventing a technological measure that effectively controls access to a work protected under this title. Paragraph 3. As used in this subsection, subparagraph A, to circumvent a technological measure means to descramble a scrambled work, to decrypt an encrypted work, or otherwise to avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. And subparagraph B. A technological measure effectively controls access to a work if the measure in the ordinary course of its operation requires the application of information or a process or a treatment with the authority of the copyright owner to gain access to the work. Subsection B. Additional violations. Paragraph 1. No person shall manufacture, import, offer to the public, provide, or otherwise traffic in any technology, product, service, device, component, or part thereof, that subparagraph A is primarily designed or produced for the purpose of circumventing protection afforded by a technological measure that effectively protects a right of a copyright owner under this title in a work or a portion thereof. Subparagraph B has only limited commercially significant purpose or use other than to circumvent protection afforded by a technological measure that effectively protects a right of a copyright owner under this title in a work or a portion thereof. Or subparagraph C is marketed by that person or another acting in concert with that person's knowledge for use in circumventing protection afforded by a technological measure that effectively protects a right of a copyright owner under this title in a work or a portion thereof. Paragraph 2. As used in this subsection, subparagraph A, to circumvent protection afforded by a technological measure means avoiding, bypassing, removing, deactivating, or otherwise impairing a technological measure. And subparagraph B. A technological measure effectively protects a right of a copyright owner under this title if the measure in the ordinary course of its operation prevents, restricts, or otherwise limits the exercise of a right of a copyright owner under this title. Subsection C. Other rights, etc. Not affected. Paragraph 1. Nothing in this section shall affect rights, remedies, limitations, or defenses to copyright infringement, including fair use, under this title. Paragraph 2. Nothing in this section shall enlarge or diminish vicarious or contributory liability for copyright infringement in connection with any technology, product, service, device, component, or part thereof. Paragraph 3. Nothing in this section shall require that the design of or design and selection of parts and components for a consumer electronics, telecommunications, or computing product provide for a response to any particular technological measure, so long as such part or component, or the product in which such part or component is integrated, does not otherwise fall within the prohibitions of subsection A, paragraph 2, or B1. Paragraph 4. Nothing in this section shall enlarge or diminish any rights of free speech or the press for activities using consumer electronics, telecommunications, or computing products. Subsection D. Exemption for nonprofit libraries, archives, and educational institutions. Paragraph 1. A nonprofit library, archives, or educational institution which gains access to a commercially exploited copyrighted work solely in order to make a good faith determination of whether to acquire a copy of that work for the sole purpose of engaging in conduct permitted under this title shall not be in violation of subsection A. Paragraph 1, subparagraph A. A copy of a work to which access has been gained under this paragraph. Subparagraph A may not be retained longer than necessary to make such good faith determination, and subparagraph B may not be used for any other purpose. Paragraph 2. The exemption made available under paragraph 1 shall only apply with respect to a work when an identical copy of that work is not reasonably available in another form. Paragraph 3. A nonprofit library, archives, or educational institution that willfully for the purpose of commercial advantage or financial gain violates paragraph 1. Subparagraph A shall for the first offense be subject to the civil remedies under section 1203, and subparagraph B shall for repeated or subsequent offenses, in addition to the civil remedies under section 1203, forfeit the exemption provided under paragraph 1. Paragraph 4. This subsection may not be used as a defense to a claim under subsection A, paragraph 2, or B, nor may this subsection permit a nonprofit library, archives, or educational institution to manufacture, import, offer to the public, provide, or otherwise traffic in any technology, product, service, component, or part thereof which circumvents a technological measure. Paragraph 5. In order for a library or archives to qualify for the exemption under this subsection, the collections of that library or archives shall be: subparagraph A, open to the public, or subparagraph B, available not only to researchers affiliated with the library or archives or with the institution of which it is a part, but also to other persons doing research in a specialized field. Subsection E, law enforcement, intelligence, and other government activities. This section does not prohibit any lawfully authorized investigative, protective, information security, or intelligence activity of an officer, agent, or employee of the United States, a state, or a political subdivision of a state, or a person acting pursuant to a contract with the United States, a state, or a political subdivision of a state. For purposes of this subsection, the term information security means activities carried out in order to identify and address the vulnerabilities of a government computer, computer system, or computer network. Subsection F, reverse engineering, paragraph 1. Notwithstanding the provisions of subsection A, paragraph 1, subparagraph A, a person who has lawfully obtained the right to use a copy of a computer program may circumvent a technological measure that effectively controls access to a particular portion of that program for the sole purpose of identifying and analyzing those elements of the program that are necessary to achieve interoperability of an independently created computer program with other programs, and that have not previously been readily available to the person engaging in the circumvention, to the extent any such acts of identification and analysis do not constitute infringement under this title. Paragraph 2. Notwithstanding the provisions of subsections A, paragraph 2, and B, a person may develop and employ technological means to circumvent a technological measure or to circumvent protection afforded by a technological measure, in order to enable the identification and analysis under paragraph 1, or for the purpose of enabling interoperability of an independently created computer program with other programs, if such means are necessary to achieve such interoperability, to the extent that doing so does not constitute infringement under this title. Paragraph 3. The information acquired through the acts permitted under paragraph 1 and the means permitted under paragraph 2 may be made available to others if the person referred to in paragraph 1 or 2, as the case may be, provides such information or means solely for the purpose of enabling interoperability of an independently created computer program with other programs, and to the extent that doing so does not constitute infringement under this title or violate applicable law other than this section. Paragraph 4. For purposes of this subsection, the term interoperability means the ability of computer programs to exchange information, and of such programs mutually to use the information which has been exchanged. Subsection G. Encryption research. Paragraph 1. Definitions. For purposes of this subsection, subparagraph A. The term encryption research means activities necessary to identify and analyze flaws and vulnerabilities of encryption technologies applied to copyrighted works. If these activities are conducted to advance the state of knowledge in the field of encryption technology or to assist in the development of encryption products. And subparagraph B. The term encryption technology means the scrambling and descrambling of information using mathematical formulas or algorithms. Paragraph 2. Permissible acts of encryption research. Notwithstanding the provisions of subsection A, paragraph 1, subparagraph A, It is not a violation of that subsection for a person to circumvent a technological measure as applied to a copy, phonorecord, performance, or display of a published work in the course of an act of good faith encryption research if, subparagraph A, the person lawfully obtained the encrypted copy, phonorecord, performance, or display of the published work. Subparagraph B, such act is necessary to conduct such encryption research. Subparagraph C, the person made a good faith effort to obtain authorization before the circumvention. And subparagraph D, such act does not constitute infringement under this title or a violation of applicable law other than this section, including Section 1030 of Title 18 and those provisions of Title 18 amended by the Computer Fraud and Abuse Act of 1986. Paragraph 3. Factors in determining exemption. In determining whether a person qualifies for the exemption under Paragraph 2, the factors to be considered shall include: Subparagraph A. Whether the information derived from the encryption research was disseminated, and if so, whether it was disseminated in a manner reasonably calculated to advance the state of knowledge or development of encryption technology, versus whether it was disseminated in a manner that facilitates infringement under this title or a violation of applicable law other than this section, including a violation of privacy or breach of security. Subparagraph B, whether the person is engaged in a legitimate course of study, is employed, or is appropriately trained or experienced in the field of encryption technology. And subparagraph C, whether the person provides the copyright owner of the work to which the technological measure is applied with notice of the findings and documentation of the research and the time when such notice is provided. Paragraph 4. Use of technological means for research activities. Notwithstanding the provisions of subsection A, paragraph 2, it is not a violation of that subsection for a person to: Subparagraph A, develop and employ technological means to circumvent a technological measure for the sole purpose of that person performing the acts of good faith encryption research described in paragraph 2. And subparagraph B, provide the technological means to another person with whom he or she is working collaboratively for the purpose of conducting the acts of good faith encryption research described in paragraph 2, or for the purpose of having that other person verify his or her acts of good faith encryption research described in paragraph 2. Paragraph 5, report to Congress. Not later than 1 year after the date of the enactment of this chapter. The Register of Copyrights and the Assistant Secretary for Communications and Information of the Department of Commerce shall jointly report to the Congress on the effect this subsection has had on: Subparagraph A, encryption research and the development of encryption technology. Subparagraph B, the adequacy and effectiveness of technological measures designed to protect copyrighted works. And subparagraph C, protection of copyright owners against the unauthorized access to their encrypted copyrighted works. The report shall include legislative recommendations, if any. Subsection H, exceptions regarding minors. In applying subsection A to a component or part, the court may consider the necessity for its intended and actual incorporation in a technology, product, service, or device, which: Paragraph 1, does not itself violate the provisions of this title, and Paragraph 2, has the sole purpose to prevent the access of minors to material on the Internet. Subsection I, protection of personally identifying information. Paragraph 1, circumvention permitted. Notwithstanding the provisions of subsection A, paragraph 1, subparagraph A, it is not a violation of that subsection for a person to circumvent a technological measure that effectively controls access to a work protected under this title if: Subparagraph A, the technological measure or the work it protects contains the capability of collecting or disseminating personally identifying information reflecting the online activities of a natural person who seeks to gain access to the work protected. Subparagraph B, in the normal course of its operation, the technological measure or the work it protects collects or disseminates personally identifying information about the person who seeks to gain access to the work protected, without providing conspicuous notice of such collection or dissemination to such person, and without providing such person with the capability to prevent or restrict such collection or dissemination. Subparagraph C, the act of circumvention has the sole effect of identifying and disabling the capability described in subparagraph A, and has no other effect on the ability of any person to gain access to any work. And subparagraph D, the act of circumvention is carried out solely for the purpose of preventing the collection or dissemination of personally identifying information about a natural person who seeks to gain access to the work protected, and is not in violation of any other law. Paragraph 2, in applicability to certain technological measures. This subsection does not apply to a technological measure or a work it protects that does not collect or disseminate personally identifying information, and that is disclosed to a user as not having or using such capability. Subsection J, security testing. Paragraph 1, definition. For purposes of this subsection, the term security testing means accessing a computer system, or computer network solely for the purpose of good faith testing, investigating, or correcting a security flaw or vulnerability, with the authorization of the owner or operator of such computer system or computer network. Paragraph 2, permissible acts of security testing. Notwithstanding the provisions of subsection A, paragraph 1, subparagraph A, it is not a violation of that subsection for a person to engage in an act of security testing if such act does not constitute infringement under this title or a violation of applicable law other than this section, including Section 203 of Title 18 and those provisions of Title 18 amended by the Computer Fraud and Abuse Act of 1986. Paragraph 3. Factors in determining exemption. In determining whether a person qualifies for the exemption under Paragraph 2, the factors to be considered shall include: Subparagraph A. Whether the information derived from the security testing was used solely to promote the security of the owner or operator of such computer system, or computer network, or shared directly with the developer of such computer system, or computer network, and subparagraph B. Whether the information derived from the security testing was used or maintained in a manner that does not facilitate infringement under this title or a violation of applicable law other than this section, including a violation of privacy or breach of security. Paragraph 4. Use of technological means for security testing. Notwithstanding the provisions of subsection A, paragraph 2, it is not a violation of that subsection for a person to develop, produce, distribute, or employ technological means for the sole purpose of performing the acts of security testing described in subsection 2, provided such technological means does not otherwise violate section A, subsection 2. Subsection K. Certain analog devices and certain technological measures. Paragraph 1. Certain analog devices. Subparagraph A. Effective 18 months after the date of the enactment of this chapter, no person shall manufacture, import, offer to the public, provide, or otherwise traffic in any. Clause 1. VHS format analog video cassette recorder, unless such recorder conforms to the automatic gain control copy control technology. Clause 2. 8mm format analog video cassette camcorder, unless such camcorder conforms to the automatic gain control technology. Clause 3. Beta format analog video cassette recorder, unless such recorder conforms to the automatic gain control copy control technology, except that this requirement shall not apply until there are 1,000 beta format analog video cassette recorders sold in the United States in any one calendar year after the date of the enactment of this chapter. Clause 4. 8mm format analog video cassette recorder that is not an analog video cassette camcorder, unless such recorder conforms to the automatic gain control copy control technology, except that this requirement shall not apply until there are 20,000 such recorders sold in the United States in any one calendar year after the date of the enactment of this chapter. Or, Clause 5, analog video cassette recorder that records using an NTSC format video input, and that is not otherwise covered under clauses 1 through 4, unless such device conforms to the automatic gain control copy control technology. Subparagraph B. Effective on the date of the enactment of this chapter, no person shall manufacture, import, offer to the public, provide, or otherwise traffic in. Clause 1. Any VHS format analog video cassette recorder or any 8mm format analog video cassette recorder, if the design of the model of such recorder has been modified after such date of enactment, so that a model of recorder that previously conformed to the automatic gain control copy control technology no longer conforms to such technology. Or, Clause 2. Any VHS format analog video cassette recorder or any 8mm format analog video cassette recorder that is not an 8mm analog video cassette camcorder, if the design of the model of such recorder has been modified after such date of enactment so that a model of recorder that previously conformed to the 4-line color stripe copy control technology no longer conforms to such technology. Manufacturers that have not previously manufactured or sold a VHS format analog video cassette recorder or an 8mm format analog cassette recorder shall be required to conform to the 4-line color stripe copy control technology in the initial model of any such recorder manufactured after the date of the enactment of this chapter, and thereafter to continue conforming to the 4-line color stripe copy control technology. For purposes of this subparagraph, an analog video cassette recorder conforms to the 4-line color stripe copy control technology if it records a signal that, when played back by the playback function of that recorder in the normal viewing mode, exhibits, on a reference display device, a display containing distracting visible lines through portions of the viewable picture. Paragraph 2. Certain encoding restrictions. No person shall apply the automatic gain control copy control technology or color stripe copy control technology to prevent or limit consumer copying, except such copying. Subparagraph A. Of a single transmission, or specified group of transmissions, of live events, or of audiovisual works for which a member of the public has exercised choice in selecting the transmission, including the content of the transmissions or the time of receipt of such transmissions, or both, and as to which such member is charged a separate fee for each such transmission or specified group of transmission. Subparagraph B. From a copy of a transmission of a live event or an audiovisual work, if such transmission is provided by a channel or service where payment is made by a member of the public for such channel or service in the form of a subscription fee that entitles the member of the public to receive all of the programming contained in such channel or service. Subparagraph C. From a physical medium containing one or more pre-recorded audiovisual works, or Subparagraph D. From a copy of a transmission described in subparagraph A, or from a copy made from a physical medium described in subparagraph C. In the event that a transmission meets both the conditions set forth in subparagraph A and those set forth in subparagraph B, the transmission shall be treated as a transmission described in subparagraph A. Paragraph 3. Inapplicability. This subsection shall not. Subparagraph A. Require any analog video cassette camcorder to conform to the automatic gain control copy control technology with respect to any video signal received through a camera lens. Subparagraph B. Apply to the manufacture, importation, offer for sale, provision of, or other trafficking in any professional analog video cassette recorder, or subparagraph C. Apply to the offer for sale or provision of, or other trafficking in any previously owned analog video cassette recorder if such recorder was legally manufactured and sold when new and not subsequently modified in violation of paragraph 1. Subparagraph B. Paragraph 4. Definitions for purposes of this subsection. Subparagraph A. An analog video cassette recorder means a device that records, or a device that includes a function that records, on electromagnetic tape in an analog format the electronic impulses produced by the video and audio portions of a TV program, motion picture, or other form of audiovisual work. Subparagraph B. An analog video cassette camcorder means an analog video cassette recorder that contains a recording function that operates through a camera lens and through a video input that may be connected with a TV or other video playback device. Subparagraph C. An analog video cassette recorder conforms to the automatic gain control copy control technology if it: Clause 1 detects one or more of the elements of such technology and does not record the motion picture or transmission protected by such technology, or Clause 2 records a signal that, when played back, exhibits a meaningfully distorted or degraded display. Subparagraph D. The term professional analog video cassette recorder means an analog video cassette recorder that is designed, manufactured, marketed, and intended for use by a person who regularly employs such a device for a lawful business or industrial use, including making, performing, displaying, distributing, or transmitting copies of motion pictures on a commercial scale. Subparagraph E. The terms VHS format, 8mm format, beta format, automatic gain control copy control technology, color stripe copy control technology, 4-line version of the color stripe copy control technology, and NTSC have the meanings that are commonly understood in the consumer electronics and motion picture industries as of the date of the enactment of this chapter. Paragraph 5. Violations. Any violation of paragraph 1 of this subsection shall be treated as a violation of subsection B, paragraph 1 of this section. Any violation of paragraph 2 of this subsection shall be deemed an act of circumvention for the purposes of section 1203, subsection C, paragraph 3, subparagraph A of this chapter. Section 1202. Integrity of copyright management information. Subsection A. False copyright management information. No person shall knowingly and with the intent to induce, enable, facilitate, or conceal infringement. Paragraph 1. Provide copyright management information that is false, or Paragraph 2. Distribute or import for distribution copyright management information that is false. Subsection B. Removal or alteration of copyright management information. No person shall, without the authority of the copyright owner or the law. Paragraph 1. Intentionally remove or alter any copyright management information. Paragraph 2. Distribute or import for distribution copyright management information knowing that the copyright management information has been removed or altered without authority of the copyright owner or the law. Or Paragraph 3. Distribute, import for distribution or publicly perform works, copies of works, or phonorecords, knowing that copyright management information has been removed or altered without authority of the copyright owner or the law. Knowing, or with respect to civil remedies under section 1203, having reasonable grounds to know that it will induce, enable, facilitate, or conceal an infringement of any right under this title. Subsection C. Definition. As used in this section, the term copyright management information means any of the following information conveyed in connection with copies or phonorecords of a work or performances or displays of a work, including in digital form, except that such term does not include any personally identifying information about a user of a work or of a copy, phonorecord, performance, or display of a work. Paragraph 1. The title and other information identifying the work, including the information set forth on a notice of copyright. Paragraph 2. The name of and other identifying information about the author of a work. Paragraph 3. The name of and other identifying information about the copyright owner of the work, including the information set forth in a notice of copyright. Paragraph 4. With the exception of public performances of works by radio and television broadcast stations, the name of and other identifying information about a performer whose performance is fixed in a work other than an audiovisual work. Paragraph 5. With the exception of public performances of works by radio and television broadcast stations. In the case of an audiovisual work, the name of and other identifying information about a writer, performer, or director who is credited in the audiovisual work. Paragraph 6. Terms and conditions for use of the work. Paragraph 7. Identifying numbers or symbols referring to such information or links to such information. Paragraph 8. such other information as the Register of Copyrights may prescribe by regulation, except that the Register of Copyrights may not require the provision of any information concerning the user of a copyrighted work. Subsection D, law enforcement, intelligence, and other government activities. This section does not prohibit any lawfully authorized investigative, protective information security, or intelligence activity of an officer, agent, or employee of the United States, a state, or a political subdivision of a state, or a person acting pursuant to a contract with the United States, a state, or a political subdivision of a state. For purposes of this subsection, the term information security means activities carried out in order to identify and address the vulnerabilities of a government computer, computer system, or computer network. Subsection E, limitations on liability. Paragraph 1. Analog transmissions. In the case of an analog transmission, a person who is making transmissions in its capacity as a broadcast station or as a cable system, or someone who provides programming to such station or system, shall not be liable for a violation of subsection B if subparagraph A, avoiding the activity that constitutes such violation is not technically feasible or would create an undue financial hardship on such person, and subparagraph B, such person did not intend, by engaging in such activity, to induce, enable, facilitate, or conceal infringement of a right under this title. Paragraph 2. Digital transmissions. Subparagraph A. If a digital transmission standard for the placement of copyright management information for a category of works is set in a voluntary consensus standard setting process involving a representative cross-section of broadcast stations or cable systems and copyright owners of a category of works that are intended for public performance by such stations or systems, a person identified in paragraph 1 shall not be liable for a violation of subsection B with respect to the particular copyright management information addressed by such standard if Clause 1. The placement of such information by someone other than such person is not in accordance with such standard, and Clause 2. The activity that constitutes such violation is not intended to induce, enable, facilitate, or conceal infringement of a right under this title. Subparagraph B. Until a digital transmission standard has been set pursuant to subparagraph A with respect to the placement of copyright management information for a category of works, a person identified in paragraph 1 shall not be liable for a violation of subsection B with respect to such copyright management information if the activity that constitutes such violation is not intended to induce, enable, facilitate, or conceal infringement of a right under this title, and if Clause 1. The transmission of such information by such person would result in a perceptible visual or oral degradation of the digital signal, or Clause 2. The transmission of such information by such person would conflict with Subclause 1, an applicable government regulation relating to transmission of information in a digital signal. Subclause 2, an applicable industry-wide standard relating to the transmission of information in a digital signal that was adopted by a voluntary consensus standards body prior to the effective date of this chapter, or Subclause 3, an applicable industry-wide standard relating to the transmission of information in a digital signal that was adopted in a voluntary consensus standard setting process open to participation by a representative cross-section of broadcast stations or cable systems and copyright owners of a category of works that are intended for public performance by such stations or system. Paragraph 3. Definitions, as used in this subsection. Subparagraph A. The term broadcast station has the meaning given that term in Section 3 of the Communications Act of 1934, Title 47, United States Code, Section 153, and Subparagraph B. The term cable system has the meaning given that term in Section 602 of the Communications Act of 1934, Title 47, United States Code, Section 522. Section 1203. Civil remedies. Subsection A. Civil actions. Any person injured by a violation of Section 1201 or 1202 may bring a civil action in an appropriate United States District Court for such violation. Subsection B. Powers of the court. In an action brought under subsection A, the court, Paragraph 1, may grant temporary and permanent injunctions on such terms as it deems reasonable to prevent or restrain a violation, but in no event shall impose a prior restraint on free speech or the press protected under the First Amendment to the Constitution. Paragraph 2. At any time while an action is pending, may order the impounding, on such terms as it deems reasonable, of any device or product that is in the custody or control of the alleged violator, and that the court has reasonable cause to believe was involved in a violation. Paragraph 3. May award damages under subsection C. Paragraph 4. In its discretion may allow the recovery of costs by or against any party other than the United States or an officer thereof. Paragraph 5. In its discretion may award reasonable attorney's fees to the prevailing party. And Paragraph 6. May, as part of a final judgment or decree finding a violation, order the remedial modification or the destruction of any device or product involved in the violation that is in the custody or control of the violator or has been impounded under Paragraph 2. Subsection C. Award of damages. Paragraph 1. In general, except as otherwise provided in this title, a person committing a violation of Section 1201 or 1202 is liable for either Subparagraph A, the actual damages and any additional profits of the violator as provided in paragraph 2, or subparagraph B, statutory damages as provided in paragraph 3. Paragraph 2, actual damages. The court shall award to the complaining party the actual damages suffered by the party as a result of the violation, and any profits of the violator that are attributable to the violation and are not taken into account in computing the actual damages, if the complaining party elects such damages at any time before final judgment is entered. Paragraph 3, statutory damages, subparagraph A. At any time before final judgment is entered, a complaining party may elect to recover an award of statutory damages for each violation of Section 1201 in the sum of not less than $200 or more than $2,500 per act of circumvention, device, product, component, offer, or performance of service as the court considers just. Subparagraph B. At any time before final judgment is entered, a complaining party may elect to recover an award of statutory damages for each violation of Section 1202 in the sum of not less than $2,500 or more than $25,000. Paragraph 4. Repeated violations. In any case in which the injured party sustains the burden of proving, and the court finds that a person has violated Section 1201 or 1202 within 3 years after a final judgment was entered against the person for another such violation, the court may increase the award of damages up to triple the amount that would otherwise be awarded, as the court considers just. Paragraph 5. Innocent violations. Subparagraph A in general. The court in its discretion may reduce or remit the total award of damages in any case in which the violator sustains the burden of proving, and the court finds that the violator was not aware and had no reason to believe that its acts constituted a violation. Subparagraph B. Nonprofit library, archives, educational institutions, or public broadcasting entities. Clause 1. Definition. In this subparagraph, the term public broadcasting entity has the meaning given such term under Section 118, subsection F. Clause 2. In general, in the case of a nonprofit library, archives, educational institution, or public broadcasting entity, the court shall remit damages in any case in which the library, archives, educational institution, or public broadcasting entity sustains the burden of proving, and the court finds that the library, archives, educational institution, or public broadcasting entity was not aware and had no reason to believe that its acts constituted a violation. Section 1204. Criminal offenses and penalties. Subsection A in general. Any person who violates Section 1201 or 1202 willfully and for purposes of commercial advantage or private financial gain. Paragraph 1 shall be fined not more than $500,000 or imprisoned for not more than 5 years, or both, for the first offense. And Paragraph 2 shall be fined not more than $1 million or imprisoned for not more than 10 years, or both, for any subsequent offense. Subsection B. Limitation for nonprofit library, archives, educational institution, or public broadcasting entity. Subsection A shall not apply to a nonprofit library, archives, educational institution, or public broadcasting entity as defined under Section 118, subsection F. Subsection C. Statute of limitations. No criminal proceeding shall be brought under this section unless such proceeding is commenced within 5 years after the cause of action arose. Section 1205. Savings Clause. Nothing in this chapter abrogates, diminishes, or weakens the provisions of, nor provides any defense or element of mitigation in a criminal prosecution or civil action under any federal or state law that prevents the violation of the privacy of an individual in connection with the individual's use of the Internet. Section 1301. Designs protected. Subsection A. Designs protected. Paragraph 1. In general. The designer or other owner of an original design of a useful article which makes the article attractive or distinctive in appearance to the purchasing or using public may secure the protection provided by this chapter upon complying with and subject to this chapter. Paragraph 2. Vessel features. The design of a vessel hull, deck, or combination of a hull and deck, including a plug or mold, is subject to protection under this chapter notwithstanding Section 1302, subsection 4. Paragraph 3. Exceptions. Department of Defense rights in a registered design under this chapter, including the right to build to such registered design, shall be determined solely by operation of Subchapter 1 of Chapter 275 of Title 10, or by the instrument under which the design was developed for the United States government. Subsection B. Definitions. For the purpose of this chapter, the following terms have the following meanings. Paragraph 1. A design is original if it is the result of the designer's creative endeavor that provides a distinguishable variation over prior work pertaining to similar articles which is more than merely trivial and has not been copied from another source. Paragraph 2. A useful article is a vessel hull or deck, including a plug or mold, which in normal use has an intrinsic utilitarian function that is not merely to portray the appearance of the article or to convey information. An article which normally is part of a useful article shall be deemed to be a useful article. Paragraph 3. A vessel is a craft. Subparagraph A. That is designed and capable of independently steering a course on or through water through its own means of propulsion. And subparagraph B. That is designed and capable of carrying and transporting one or more passengers. Paragraph 4. A hull is the exterior frame or body of a vessel, exclusive of the deck, superstructure, masts, sails, yards, rigging, hardware, fixtures, and other attachments. Paragraph 5. A plug means a device or model used to make a mold for the purpose of exact duplication, regardless of whether the device or model has an intrinsic utilitarian function that is not only to portray the appearance of the product or to convey information. Paragraph 6. A mold means a matrix or form in which a substance for material is used, regardless of whether the matrix or form has an intrinsic utilitarian function that is not only to portray the appearance of the product or to convey information. Paragraph 7. A deck is the horizontal surface of a vessel that covers the hull, including exterior cabin and cockpit surfaces, and exclusive of masts, sails, yards, rigging, hardware, fixtures, and other attachments. Section 1302. Designs not subject to protection. Protection under this chapter shall not be available for a design that is. Paragraph 1. Not original. Paragraph 2. Staple or commonplace, such as a standard geometric figure, a familiar symbol, an emblem or a motif, or another shape, pattern, or configuration, which has become standard, common, prevalent, or ordinary. Paragraph 3. Different from a design excluded by paragraph 2 only in insignificant details or in elements which are variants commonly used in the relevant trades. Paragraph 4. Dictated solely by a utilitarian function of the article that embodies it, or Paragraph 5. Embodied in a useful article that was made public by the designer or owner in the United States or a foreign country more than 2 years before the date of the application for registration under this chapter. Section 1303. Revisions, adaptations, and rearrangements. Protection for a design under this chapter shall be available notwithstanding the employment in the design of subject matter excluded from protection under Section 1302 if the design is a substantial revision, adaptation, or rearrangement of such subject matter. Such protection shall be independent of any subsisting protection in subject matter employed in the design, and shall not be construed as securing any right to subject matter excluded from protection under this chapter or as extending any subsisting protection under this chapter. Section 1304. Commencement of protection. The protection provided for a design under this chapter shall commence upon the earlier of the date of publication of the registration under Section 1313, subsection A, or the date the design is first made public as defined by Section 1313, subsection B. Section 1305. Term of protection. Subsection A, in general, subject to subsection B, the protection provided under this chapter for a design shall continue for a term of 10 years beginning on the date of the commencement of protection under Section 1304. Subsection B, expiration. All terms of protection provided in this section shall run to the end of the calendar year in which they would otherwise expire. Subsection C, termination of rights. Upon expiration or termination of protection in a particular design under this chapter, all rights under this chapter in the design shall terminate, regardless of the number of different articles in which the design may have been used during the term of its protection. Section 1306, design notice. Subsection A, contents of design notice. Paragraph 1. Whenever any design for which protection is sought under this chapter is made public under Section 1310, subsection B, the owner of the design shall, subject to the provisions of Section 1007, mark it or have it marked legibly with a design notice consisting of subparagraph A, the words protected design, the abbreviation PROT-DES, or the letter D with a circle, or the symbol D. Subparagraph B, the year of the date on which protection for the design commenced, and subparagraph C, the name of the owner, an abbreviation by which the name can be recognized, or a generally accepted alternative designation of the owner. Any distinctive identification of the owner may be used for purposes of subparagraph C if it has been recorded by the administrator before the design marked with such identification is registered. Paragraph 2. After registration, the registration number may be used instead of the elements specified in subparagraphs B and C of paragraph 1. Subsection B, location of notice. The design notice shall be so located and applied as to give reasonable notice of design protection, while the useful article embodying the design is passing through its normal channels of commerce. Subsection C, subsequent removal of notice. When the owner of a design has complied with the provisions of this section, protection under this chapter shall not be affected by the removal, destruction, or obliteration by others of the design notice on an article. Section 1337. Effect of omission of notice. Subsection A, actions with notice. Except as provided in subsection B, the omission of the notice prescribed in Section 1306 shall not cause loss of the protection under this chapter, or prevent recovery for infringement under this chapter against any person who, after receiving written notice of the design protection, begins an undertaking leading to infringement under this chapter. Subsection B, actions without notice. The omission of the notice prescribed in Section 130.06 shall prevent any recovery under Section 1323 against a person who began an undertaking leading to infringement under this chapter before receiving written notice of the design protection. No injunction shall be issued under this chapter with respect to such undertaking unless the owner of the design reimburses that person for any reasonable expenditure or contractual obligation in connection with such undertaking that was incurred before receiving written notice of the design protection. As the court in its discretion direct, the burden of providing written notice of design protection shall be on the owner of the design. Section 1308, Exclusive Rights. The owner of a design protected under this chapter has the exclusive right to: Paragraph 1. Make, have made, or import, for sale or for use in trade, any useful article embodying that design, and Paragraph 2. Sell or distribute for sale or for use in trade any useful article embodying that design. Section 1309, Infringement. Subsection A, Acts of Infringement. Except as provided in subsection B, it shall be infringement of the exclusive rights in a design protected under this chapter for any person, without the consent of the owner of the design within the United States and during the term of such protection. 2. Paragraph 1. Make, have made, or import, for sale or for use in trade, any infringing article as defined in subsection E, or Paragraph 2. Sell or distribute for sale or for use in trade any such infringing article. Subsection B, Acts of Sellers and Distributors. A seller or distributor of an infringing article who did not make or import the article shall be deemed to have infringed on a design protected under this chapter only if that person. Paragraph 1. Induced or acted in collusion with a manufacturer to make, or an importer to import, such article, except that merely purchasing or giving an order to purchase such article in the ordinary course of business shall not of itself constitute such inducement or collusion, or Paragraph 2. Refused or failed upon the request of the owner of the design to make a prompt and full disclosure of that person's source of such article, and that person orders or reorders such article after receiving notice by registered or certified mail of the protection subsisting in the design. Subsection C, Acts without knowledge. It shall not be infringement under this section to make, have made, import, sell, or distribute any article embodying a design which was created without knowledge that a design was protected under this chapter and was copied from such protected design. Subsection D, Acts in ordinary course of business. A person who incorporates into that person's product of manufacture an infringing article acquired from others in the ordinary course of business, or who, without knowledge of the protected design embodied in an infringing article, makes or processes the infringing article for the account of another person in the ordinary course of business, shall not be deemed to have infringed the rights in that design under this chapter, except under a condition contained in paragraph 1 or 2 of subsection B. Accepting an order or reorder from the source of the infringing article shall be deemed ordering or reordering within the meaning of subsection B, paragraph 2. Subsection E, infringing article defined. As used in this section, an infringing article is any article the design of which has been copied from a design protected under this chapter without the consent of the owner of the protected design. An infringing article is not an illustration or picture of a protected design in an advertisement, book, periodical, newspaper, photograph, broadcast, motion picture, or similar medium. A design shall not be deemed to have been copied from a protected design if it is original and not substantially similar in appearance to a protected design. Subsection F, establishing originality. The party to any action or proceeding under this chapter who alleges rights under this chapter in a design shall have the burden of establishing the design's originality whenever the opposing party introduces an earlier work, which is identical to such design, or so similar as to make prima facie showing that such design was copied from such work. Subsection G, reproduction for teaching or analysis. It is not an infringement of the exclusive rights of a design owner for a person to reproduce the design in a useful article or in any other form, solely for the purpose of teaching, analyzing, or evaluating the appearance, concepts, or techniques embodied in the design, or the function of the useful article embodying the design. Section 1310, application for registration. Subsection A, time limit for application for registration. Protection under this chapter shall be lost if application for registration of the design is not made within 2 years after the date on which the design is first made public. Subsection B, when design is made public. A design is made public when an existing useful article embodying the design is anywhere publicly exhibited, publicly distributed, or offered for sale or sold to the public by the owner of the design or with the owner's consent. Subsection C, application by owner of design. Application for registration may be made by the owner of the design. Subsection D, contents of application. The application for registration shall be made to the administrator and shall state: Paragraph 1. The name and address of the designer or designers of the design. Paragraph 2. The name and address of the owner if different from the designer. Paragraph 3. The specific name of the useful article embodying the design. Paragraph 4. The date, if any, that the design was first made public, if such date was earlier than the date of the application. Paragraph 5. Affirmation that the design has been fixed in a useful article. And Paragraph 6. such other information as may be required by the administrator. The application for registration may include a description setting forth the salient features of the design, but the absence of such a description shall not prevent registration under this chapter. Subsection E. Sworn statement. The application for registration shall be accompanied by a statement under oath by the applicant or the applicant's duly authorized agent or representative, setting forth to the best of the applicant's knowledge and belief. Paragraph 1. That the design is original and was created by the designer or designers named in the application. Paragraph 2. That the design has not previously been registered on behalf of the applicant or the applicant's predecessor in title, and Paragraph 3. That the applicant is the person entitled to protection and to registration under this chapter. If the design has been made public with the design notice prescribed in Section 1306, the statement shall also describe the exact form and position of the design notice. Subsection F. Effective errors. Paragraph 1. Error in any statement or assertion as to the utility of the useful article named in the application under this section, the design of which is sought to be registered, shall not affect the protection secured under this chapter. Paragraph 2. Errors in omitting a joint designer or in naming an alleged joint designer shall not affect the validity of the registration, or the actual ownership or the protection of the design, unless it is shown that the error occurred with deceptive intent. Subsection G. Design made in scope of employment. In a case in which the design was made within the regular scope of the designer's employment, and individual authorship of the design is difficult or impossible to ascribe, and the application so states, the name and address of the employer for whom the design was made may be stated instead of that of the individual designer. Subsection H. Pictorial representation of design. The application for registration shall be accompanied by 2 copies of a drawing or other pictorial representation of the useful article embodying the design, having 1 or more views adequate to show the design in a form and style suitable for reproduction, which shall be deemed a part of the application. Subsection I. Design in more than one useful article. If the distinguishing elements of a design are in substantially the same form in different useful articles, the design shall be protected as to all such useful articles when protected as to one of them, but not more than 1 registration shall be required for the design. Subsection J. Application for more than one design. More than one design may be included in the same application under such conditions as may be prescribed by the administrator. For each design included in an application, the fee prescribed for a single design shall be paid. Section 1311. Benefit of earlier filing date in foreign country. An application for registration of a design filed in the United States by any person who has, or whose legal representative or predecessor or successor in title has, previously filed an application for registration of the same design in a foreign country, which extends to designs of owners who are citizens of the United States or to applications filed under this chapter. Similar protection to that provided under this chapter shall have that same effect as if filed in the United States on the date on which the application was first filed in such foreign country. If the application in the United States is filed within 6 months after the earliest date on which any such foreign application was filed. Section 1312. Oaths and acknowledgments. Subsection A. In general, oaths and acknowledgments required by this chapter. Paragraph 1. May be made. Subparagraph A. Before any person in the United States authorized by law to administer oaths, or Subparagraph B. When made in a foreign country, before any diplomatic or consular officer of the United States authorized to administer oaths, or before any official authorized to administer oaths in the foreign country concerned, whose authority shall be proved by a certificate of a diplomatic or consular officer of the United States, and Paragraph 2 shall be valid if they comply with the laws of the state or country where made. Subsection B. Written declaration in lieu of oath. Paragraph 1. The administrator may by rule prescribe that any document which is to be filed under this chapter in the office of the administrator, and which is required by any law, rule, or other regulation to be under oath, may be subscribed to by a written declaration in such form as the administrator may prescribe, and such declaration shall be in lieu of the oath otherwise required. Paragraph 2. Whenever a written declaration under Paragraph 1 is used, the document containing the declaration shall state that willful false statements are punishable by fine or imprisonment, or both, pursuant to Section 1001 of Title 18, and may jeopardize the validity of the application or document or a registration resulting therefrom. Section 1313. Examination of application and issue or refusal of registration. Subsection A. Determination of registrability of design, registration. Upon the filing of an application for registration in proper form under Section 1310, and upon payment of the fee prescribed under Section 1316, the administrator shall determine whether or not the application relates to a design which on its face appears to be subject to protection under this chapter, and if so, the registrar shall register the design. Registration under this subsection shall be announced by publication. The date of registration shall be the date of publication. Subsection B. Refusal to register, reconsideration. If, in the judgment of the administrator, the application for registration relates to a design which on its face is not subject to protection under this chapter, The administrator shall send to the applicant a notice of refusal to register and the grounds for the refusal. Within 3 months after the date on which the notice of refusal is sent, the applicant may, by written request, seek reconsideration of the application. After consideration of such a request, the administrator shall either register the design or send to the applicant a notice of final refusal to register. Subsection C. Application to cancel registration. Any person who believes he or she is or will be damaged by a registration under this chapter may, upon payment of the prescribed fee, apply to the administrator at any time to cancel the registration on the ground that the design is not subject to protection under this chapter, stating the reasons for the request. Upon receipt of an application for cancellation, the administrator shall send to the owner of the design, as shown in the records of the office of the administrator, a notice of the application. And the owner shall have a period of 3 months after the date on which such notice is mailed in which to present arguments to the administrator for support of the validity of the registration. The administrator shall also have the authority to establish, by regulation, conditions under which the opposing parties may appear and be heard in support of their arguments. If, after the periods provided for the presentation of arguments have expired, the administrator determines that the applicant for cancellation has established that the design is not subject to protection under this chapter, the administrator shall order the registration stricken from the record. Cancellation under this subsection shall be announced by publication, and notice of the administrator's final determination with respect to any application for cancellation shall be sent to the applicant and to the owner of record. Costs of the cancellation procedure under this subsection shall be borne by the non-prevailing party or parties, and the administrator shall have the authority to assess and collect such costs. Section 1314. Certification of registration. Certificates of registration shall be issued in the name of the United States under the seal of the office of the administrator and shall be recorded in the official records of the office. The certificate shall state the name of the useful article, the date of filing of the application, the date of registration, and the date the design was made public, if earlier than the date of filing of the application, and shall contain a reproduction of the drawing or other pictorial representation of the design. If a description of the salient features of the design appears in the application, the description shall also appear in the certificate. A certificate of registration shall be admitted in any court as prima facie evidence of the facts stated in the certificate. Section 1315. Publication of announcements and indexes. Subsection A. Publications of the administrator. The administrator shall publish lists and indexes of registered designs and cancellations of designs, and may also publish the drawings or other pictorial representations of registered designs for sale or other distribution. Subsection B. File of representatives of registered designs. The administrator shall establish and maintain a file of the drawings or other pictorial representations of registered designs. The file shall be available for use by the public under such conditions as the administrator may prescribe. Section 1316. Fees. The administrator shall, by regulation, set reasonable fees for the filing of applications to register designs under this chapter, and for other services relating to the administration of this chapter, taking into consideration the cost of providing these services and the benefit of a public record. Section 1317. Regulations. The administrator may establish regulations for the administration of this chapter. Section 1318. Copies of records. Upon payment of the prescribed fee, any person may obtain a certified copy of any official record of the office of the administrator that relates to this chapter. That copy shall be admissible in evidence with the same effect as the original. Section 1319. Correction of errors in certificates. The administrator may, by a certificate of correction under seal, correct any error in a registration incurred through the fault of the office, or upon payment of the required fee. Any error of a clerical or typographical nature occurring in good faith, but not through the fault of the office. Such registration, together with the certificate, shall thereafter have the same effect as if it had been originally issued in such corrected form. Section 1320. Ownership and transfer. Subsection A. Property right in design. The property right in a design subject to protection under this chapter shall vest in the designer, the legal representatives of a deceased designer, or of one under legal incapacity. The employer for whom the designer created the design in the case of a design made within the regular scope of the designer's employment, or a person to whom the rights of the designer or of such employer have been transferred. The person in whom the property right is vested shall be considered the owner of the design. Subsection B. Transfer of property right. The property right in a registered design, or a design for which an application for registration has been, or may be filed, may be assigned, granted, conveyed, or mortgaged by an instrument in writing, signed by the owner, or may be bequeathed by will. Subsection C. Oath or acknowledgement of transfer. An oath or acknowledgement under Section 13 shall be prima facie evidence of the execution of an assignment, grant, conveyance, or mortgage under subsection B. Subsection D. Recordation of transfer. An assignment, grant, conveyance, or mortgage under subsection B shall be void as against any subsequent purchaser or mortgagee for a valuable consideration. unless it is recorded in the office of the administrator within 3 months after its date of execution or before the date of such subsequent purchase or mortgage. Section 1321. Remedy for infringement. Subsection A in general. The owner of a design is entitled, after issuance of a certificate of registration of the design under this chapter, to institute an action for any infringement of the design. Subsection B. Review of refusal to register. Paragraph 1. Subject to Paragraph 2, the owner of a design may seek judicial review of a final refusal of the administrator to register the design under this chapter by bringing a civil action, and may in the same action, if the court adjudges the design subject to protection under this chapter, enforce the rights in that design under this chapter. Paragraph 2. The owner of a design may seek judicial review under this section if Subparagraph A. The owner has previously duly filed and prosecuted to final refusal an application in proper form for registration of the design. Subparagraph B. The owner causes a copy of the complaint in the action to be delivered to the administrator within 10 days after the commencement of the action. And Subparagraph C. The defendant has committed acts in respect to the design which would constitute infringement with respect to a design protected under this chapter. Subsection C. Administrator as party to action. The administrator may, at the administrator's option, become a party to the action with respect to the issue of registrability of the design claim by entering an appearance within 60 days after being served with the complaint. But the failure of the administrator to become a party shall not deprive the court of jurisdiction to determine that issue. Subsection D. Use of arbitration to resolve dispute. The parties to an infringement dispute under this chapter, within such time as may be specified by the administrator by regulation, may determine the dispute or any aspect of the dispute by arbitration. Arbitration shall be governed by Title IX. The parties shall give notice of any arbitration award to the administrator, and such award shall, as between the parties to the arbitration, be dispositive of the issues to which it relates. The arbitration award shall be unenforceable until such notice is given. Nothing in this subsection shall preclude the administrator from determining whether a design is subject to registration in a cancellation proceeding under Section 1313, subsection C. Section 1322. Injunctions. Subsection A in general. A court having jurisdiction over actions under this chapter may grant injunctions in accordance with the principles of equity to prevent infringement of a design under this chapter, including in its discretion, prompt relief by temporary restraining orders and preliminary injunctions. Subsection B. Damages for injunctive relief wrongfully obtained. A seller or distributor who suffers damage by reason of injunctive relief wrongfully obtained under this section has a cause of action against the applicant for such injunctive relief and may recover such relief as may be appropriate, including damages for lost profits, cost of materials, loss of goodwill, and punitive damages in instances where the injunctive relief was sought in bad faith, and, unless the court finds extenuating circumstances, reasonable attorney's fees. Section 1323. Recovery for infringement. Subsection A. Damages. Upon a finding for the claimant in an action for infringement under this chapter, the court shall award the claimant damages adequate to compensate for the infringement. In addition, the court may increase the damages to such amount, not exceeding $50,000 or $1 per copy, whichever is greater, as the court determines to be just. The damages awarded shall constitute compensation and not a penalty. The court may receive expert testimony as an aid to the determination of damages. Subsection B. Infringer's profits. As an alternative to the remedies provided in subsection A, the court may award the claimant the infringer's profits resulting from the sale of the copies, if the court finds that the infringer's sales are reasonably related to the use of the claimant's design. In such a case, the claimant shall be required to prove only the amount of the infringer's sales, and the infringer shall be required to prove its expenses against such sales. Subsection C. Statute of limitations. No recovery under subsection A or B shall be had for any infringement committed more than 3 years before the date on which the complaint is filed. Subsection D. Attorney's fees. In an action for infringement under this chapter, the court may award reasonable attorney's fees to the prevailing party. Subsection E. Disposition of infringing and other articles. The court may order that all infringing articles and any plates, molds, patterns, models, or other means specifically adapted for making the articles be delivered up for destruction or other disposition as the court may direct. Section 1324. Power of court over registration. In any action involving the protection of a design under this chapter, the court, when appropriate, may order registration of a design under this chapter or the cancellation of such a registration. Any such order shall be certified by the court to the administrator, who shall make an appropriate entry upon the record. Section 1325. Liability for action on registration fraudulently obtained. Any person who brings an action for infringement knowing that registration of the design was obtained by a false or fraudulent representation materially affecting the rights under this chapter shall be liable in the sum of $10 or such part of that amount as the court may determine. That amount shall be to compensate the defendant and shall be charged against the plaintiff and paid to the defendant in addition to such costs and attorney's fees of the defendant as may be assessed by the court. Section 1326. Penalty for false marking. Subsection A, in general. Whoever, for the purpose of deceiving the public, marks upon, applies to, or uses in advertising, in connection with an article made, used, distributed, or sold, a design which is not protected under this chapter, a design notice specified in section 1-06, or any other words or symbols importing that the design is protected under this chapter, knowing that the design is not so protected, shall pay a civil fine of not more than $500 for each such offense. Subsection B, suit by private persons. Any person may sue for the penalty established by subsection A, in which event one half of the penalty shall be awarded to the person suing and the remainder shall be awarded to the United States. Section 1327, penalty for false representation. Whoever knowingly makes a false representation materially affecting the rights obtainable under this chapter for the purpose of obtaining registration of a design under this chapter shall pay a penalty of not less than $500 and not more than $1,000. And any rights or privileges that individual may have in the design under this chapter shall be forfeited. Section 1328, enforcement by Treasury and Postal Service. Subsection A, regulations. The Secretary of the Treasury and the United States Postal Service shall separately or jointly issue regulations for the enforcement of the rights set forth in section 1308 with respect to importation. Such regulations may require, as a condition for the exclusion of articles from the United States, that the person seeking exclusion take any one or more of the following actions. Paragraph 1. Obtain a court order enjoining, or an order of the International Trade Commission under Section 337 of the Tariff Act of 1930, excluding importation of the articles. Paragraph 2. Furnish proof that the design involved is protected under this chapter and that the importation of the articles would infringe the rights in the design under this chapter. Paragraph 3. Post a surety bond for any injury that may result if the detention or exclusion of the articles proves to be unjustified. Subsection B, seizure and forfeiture. Articles imported in violation of the rights set forth in section 13008 are subject to seizure and forfeiture in the same manner as property imported in violation of the customs laws. Any such forfeited articles shall be destroyed as directed by the Secretary of the Treasury or the court, as the case may be, except that the articles may be returned to the country of export whenever it is shown to the satisfaction of the Secretary of the Treasury that the importer had no reasonable grounds for believing that his or her acts constituted a violation of the law. Section 1329, relation to design patent law. The issuance of a design patent under Title 35 United States Code for an original design for an article of manufacture shall terminate any protection of the original design under this chapter. Section 1330, common law and other rights unaffected. Nothing in this chapter shall annul or limit. Paragraph 1, common law or other rights or remedies, if any, available to or held by any person with respect to a design which has not been registered under this chapter, or Paragraph 2. Any right under the trademark laws or any right protected against unfair competition. Section 1331. Administrator, Office of the Administrator. In this chapter, the Administrator is the Register of Copyrights, and the Office of the Administrator and the Office refer to the Copyright Office of the Library of Congress. Section 1332. No retroactive effect. Protection under this chapter shall not be available for any design that has been made public under Section 1310, subsection B, before the effective date of this chapter. Section 1401, unauthorized use of pre-1972 sound recordings. Subsection A, in general. Paragraph 1, unauthorized acts. Anyone who on or before the last day of the applicable transition period under Paragraph 2, and without the consent of the rights owner, engages in covered activity with respect to a sound recording fixed before February 15, 1972, shall be subject to the remedies provided in sections 502 through 505 and 1203 to the same extent as an infringer of copyright or a person that engages in unauthorized activity under Chapter 12. Paragraph 2. Term of prohibition. Subparagraph A, in general. The prohibition under Paragraph 1, Clause 1, subject to Clause 2, shall apply to a sound recording described in that paragraph. Subclause 1, through December 31st of the year that is 95 years after the year of first publication, and Subclause 2, for a further transition period as prescribed under subparagraph B of this paragraph, and Clause 2, shall not apply to any sound recording after February 15, 2067. Subparagraph B, transition periods. Clause 1, pre-1923 recordings. In the case of a sound recording first published before January 1st, 1923, the transition period described in subparagraph A, Clause 1, Subclause 2 shall end on December 31st of the year that is 3 years after the date of enactment of this section. Clause 2, 1923-1946 recordings. In the case of a sound recording first published during the period beginning on January 1st, 1923, and ending on December 31st, 1946, the transition period described in subparagraph A, Clause 1. Subclause 2 shall end on the date that is 5 years after the last day of the period described in subparagraph A, Clause 1, Subclause 1. Clause 3, 1947-1956 recordings. In the case of a sound recording first published during the period beginning on January 1, 1947 and ending on December 31, 1956, the transition period described in subparagraph A, Clause 1. Subclause 2 shall end on the date that is 15 years after the last day of the period described in subparagraph A, Clause 1, Subclause 1. Clause 4, post-1956 recordings. In the case of a sound recording fixed before February 15, 1972, that is not described in Clause 1, 2, or 3, the transition period described in subparagraph A, Clause 1, Subclause 2 shall end on February 15, 2067. Paragraph 3. Rule of construction. For the purposes of this subsection, the term anyone includes any state, any instrumentality of a state, and any officer or employee of a state or instrumentality of a state acting in the official capacity of the officer or employee as applicable. Subsection B. Certain authorized transmissions and reproduction. A public performance by means of a digital audio transmission of a sound recording fixed before February 15, 1972, or a reproduction in an ephemeral phonorecord or copy of a sound recording fixed before February 15, 1972, shall, for purposes of subsection A, be considered to be authorized and made with the consent of the rights owner if, paragraph 1, the transmission or reproduction would satisfy the requirements for statutory licensing under Section 112, subsection E, paragraph 1, or Section 114, subsection D, paragraph 2, or would be exempt under Section 104, subsection D, paragraph 1, as the case may be. If the sound recording were fixed on or after February 15, 1972, and paragraph 2, the transmitting entity pays the statutory royalty for the transmission or reproduction pursuant to the rates and terms adopted under Sections 112, subsection E, and 114, subsection F, and complies with other obligations. In the same manner as required by regulations adopted by the copyright royalty judges under Sections 112, subsection E, and 114, subsection F for sound recordings that are fixed on or after February 15, 1972, except in the case of a transmission that would be exempt under Section 114, subsection D, paragraph 1. Subsection C, certain non-commercial uses of sound recordings that are not being commercially exploited. Paragraph 1 in general. Non-commercial use of a sound recording fixed before February 15, 1972, that is not being commercially exploited by or under the authority of the rights owner shall not violate subsection A if. Subparagraph A. The person engaging in the non-commercial use, in order to determine whether the sound recording is being commercially exploited by or under the authority of the rights owner, makes a good faith, reasonable search for, but does not find the sound recording. Clause 1. In the records of schedules filed in the Copyright Office as described in subsection F, paragraph 5, subparagraph A, and Clause 2. On services offering a comprehensive set of sound recordings for sale or streaming. Subparagraph B. The person engaging in the non-commercial use files a notice identifying the sound recording and the nature of the use in the Copyright Office in accordance with the regulations issued under paragraph 3, subparagraph B, and subparagraph C. During the 90-day period beginning on the date on which the notice described in subparagraph B is indexed into the public records of the Copyright Office, the rights owner of the sound recording does not, in its discretion, opt out of the non-commercial use by filing notice thereof in the Copyright Office in accordance with the regulations issued under paragraph 5. Paragraph 2. Rules of construction. For purposes of this subsection. Subparagraph A. Merely recovering costs of production and distribution of a sound recording resulting from a use otherwise permitted under this subsection does not itself necessarily constitute a commercial use of the sound recording. Subparagraph B. The fact that a person engaging in the use of a sound recording also engages in commercial activities does not itself necessarily render the use commercial. And subparagraph C. The fact that a person files notice of a non-commercial use of a sound recording in accordance with the regulations issued under paragraph 3. Subparagraph B does not itself affect any limitation on the exclusive rights of a copyright owner described in section 107, 108, 109, 110, or 112, subsection F as applied to a claim under subsection A of this section pursuant to subsection F, paragraph 1. Subparagraph A of this section. Paragraph 3. Notice of covered activity. Not later than 180 days after the date of enactment of this section, the Register of Copyrights shall issue regulations that. Subparagraph A. Provide specific reasonable steps that, if taken by a filer, are sufficient to constitute a good faith, reasonable search under paragraph 1, subparagraph A to determine whether a recording is being commercially exploited, including the services that satisfy the good faith, reasonable search requirement under paragraph 1, subparagraph A for purposes of the safe harbor described in paragraph 4, subparagraph A, and subparagraph B, establish the form, content, and procedures for the filing of notices under paragraph 1, subparagraph B. Paragraph 4. Safe harbor. Subparagraph A in general. A person engaging in a non-commercial use of a sound recording otherwise permitted under this subsection who establishes that the person made a good faith, reasonable search under paragraph 1, Subparagraph A, without finding commercial exploitation of the sound recording by or under the authority of the rights owner, shall not be found to be in violation of subsection A. Subparagraph B, steps sufficient but not necessary. Taking the specific reasonable steps identified by the Register of Copyrights in the regulations issued under paragraph 3, subparagraph A, shall be sufficient but not necessary for a filer to satisfy the requirement to conduct a good faith. Reasonable search under paragraph 1, subparagraph A for purposes of subparagraph A of this paragraph. Paragraph 5. Opting out of covered activity. Subparagraph A in general. Not later than 180 days after the date of enactment of this section, the Register of Copyrights shall issue regulations establishing the form, content, and procedures for the rights owner of a sound recording that is the subject of a notice under paragraph 1. Subparagraph B2, in its discretion, file notice opting out of the covered activity described in the notice under paragraph 1. Subparagraph B, during the 90-day period beginning on the date on which the notice under paragraph 1. Subparagraph B is indexed into the public records of the Copyright Office. Subparagraph B, rule of construction. The fact that a rights holder opts out of a non-commercial use of a sound recording by filing notice thereof in the Copyright Office in accordance with the regulations issued under subparagraph A does not itself enlarge or diminish any limitation on the exclusive rights of a copyright owner described in section 107, 108, 109, 110, or 112. Subsection F as applied to a claim under subsection A of this section pursuant to subsection F, paragraph 1, subparagraph A of this section. Paragraph 6. Civil penalties for certain acts. Subparagraph A, filing of notices of non-commercial use. Any person who willfully engages in a pattern or practice of filing a notice of non-commercial use of a sound recording as described in paragraph 1, subparagraph B, fraudulently describing the use proposed, or knowing that the use proposed is not permitted under this subsection, shall be assessed a civil penalty in an amount that is not less than $250 and not more than $1,000 for each such notice, in addition to any other remedies that may be available under this title based on the actual use made. Subparagraph B, filing of opt-out notices. Clause 1 in general. Any person who files an opt-out notice as described in paragraph 1, subparagraph C, knowing that the person is not the rights owner or authorized to act on behalf of the rights owner of the sound recording to which the notice pertains, shall be assessed a civil penalty in an amount not less than $250 and not more than $1,000 for each such notice. Clause 2, pattern or practice. Any person who engages in a pattern or practice of making filings, as described in Clause 1, shall be assessed a civil penalty in an amount not less than $10,000 for each such filing. Subparagraph C, definition. For purposes of this paragraph, the term knowing. Clause 1 does not require specific intent to defraud, and Clause 2, with respect to information about ownership of the sound recording in question, means that the person, Subclause 1, has actual knowledge of the information. Subclause 2 acts in deliberate ignorance of the truth or falsity of the information, or Subclause 3 acts in grossly negligent disregard of the truth or falsity of the information. Subsection D, payment of royalties for transmissions of performances by direct licensing of statutory services. Paragraph 1, in general. A public performance by means of a digital audio transmission of a sound recording fixed before February 15, 1972, shall, for purposes of subsection A, be considered to be authorized and made with the consent of the rights owner if the transmission is made pursuant to a license agreement voluntarily negotiated at any time between the rights owner and the entity performing the sound recording. Paragraph 2. Payment of royalties to nonprofit collective under certain license agreements. Subparagraph A, licenses entered into on or after date of enactment. To the extent that a license agreement described in paragraph 1 entered into on or after the date of enactment of this section extends to a public performance by means of a digital audio transmission of a sound recording fixed before February 15, 1972, that meets the conditions of subsection B. Clause 1. The licensee shall, with respect to such transmission, pay to the collective designated to distribute receipts from the licensing of transmissions in accordance with section 114, subsection F, 50% of the performance royalties for that transmission due under the license, and Clause 2. The royalties paid under Clause 1 shall be fully credited as payments due under the license. Subparagraph B. Certain agreements entered into before enactment. To the extent that a license agreement described in paragraph 1 entered into during the period beginning on January 1 of the year in which this section is enacted and ending on the day before the date of enactment of this section, or a settlement agreement with a pre-existing satellite digital audio radio service, as defined in section 114, subsection J, entered into during the period beginning on January 1, 2015, and ending on the day before the date of enactment of this section, extends to a public performance by means of a digital audio transmission of a sound recording fixed before February 15, 1972, that meets the conditions of subsection B. Clause 1. The rights owner shall, with respect to such transmission, pay to the collective designated to distribute receipts from the licensing of transmissions in accordance with section 114, subsection F, an amount that is equal to the difference between Subclause 1. 50% of the difference between Item AA, the rights owner's total gross performance royalty fee receipts or settlement monies received for all such transmissions covered under the license or settlement agreement, as applicable, and Item B, the rights owner's total payments for outside legal expenses, including any payments of third-party claims that are directly attributable to the license or settlement agreement, as applicable, and Subclause 2, the amount of any royalty receipts or settlement monies under the agreement that are distributed by the rights owner to featured and non-featured artists before the date of enactment of this section, and Clause 2, the royalties paid under Clause 1 shall be fully credited as payments due under the license or settlement agreement, as applicable. Paragraph 3. Distribution of royalties and settlement monies by collective. The collective described in paragraph 2 shall, in accordance with subparagraphs B through D of section 114, subsection G, paragraph 2, and paragraphs 5 and 6 of section 114, subsection G, distribute the royalties or settlement monies received under paragraph 2 under a license or settlement described in paragraph 2, which shall be the only payments to which featured and non-featured artists are entitled by virtue of the transmissions described in paragraph 2, except for settlement monies described in paragraph 2 that are distributed by the rights owner to featured and non-featured artists before the date of enactment of this section. Paragraph 4. Payment of royalties under license agreements entered before enactment or not otherwise described in paragraph 2. Subparagraph A in general. To the extent that a license agreement described in paragraph 1 entered into before the date of enactment of this section, or any other license agreement not as described in paragraph 2, extends to a public performance by means of a digital audio transmission of a sound recording fixed before February 15, 1972, that meets the conditions of subsection B. The payments made by the licensee pursuant to the license shall be made in accordance with the agreement. Subparagraph B. Additional payments not required. To the extent that a licensee has made or will make in the future payments pursuant to a license as described in subparagraph A, the provisions of paragraphs 2 and 3 shall not require any additional payments from, or additional financial obligations on the part of the licensee. Subparagraph C. Rule of construction. Nothing in this subsection may be construed to prohibit the collective designated to distribute receipts from the licensing of transmissions in accordance with section 114. Subsector F from administering royalty payments under any license not described in paragraph 2. Subsection E. Preemption with respect to certain past acts. Paragraph 1. In general. This section preempts any claim of common law copyright or equivalent right under the laws of any state arising from a digital audio transmission or reproduction that is made before the date of enactment of this section of a sound recording fixed before February 15, 1972, if subparagraph A. The digital audio transmission would have satisfied the requirements for statutory licensing under section 114, subsection D, paragraph 2, or been exempt under section 114, subsection D, paragraph 1. Or the reproduction would have satisfied the requirements of section 112, subsection E, paragraph 1, as the case may be, if the sound recording were fixed on or after February 15, 1972, and subparagraph B, either clause 1. Except in the case of a transmission that would have been exempt under section 114, subsection D, paragraph 1, not later than 270 days after the date of enactment of this section. The transmitting entity pays statutory royalties and provides notice of the use of the relevant sound recordings in the same manner as required by regulations adopted by the copyright royalty judges for sound recordings that are fixed on or after February 15, 1972, for all the digital audio transmissions and reproductions satisfying the requirements for statutory licensing under sections 112, subsection E, paragraph 1, and 114, subsection D, paragraph 2 during the 3 years before that date of enactment, or clause 2. An agreement voluntarily negotiated between the rights owner and the entity performing the sound recording, including a litigation settlement agreement entered into before the date of enactment of this section, authorizes or waives liability for any such transmission or reproduction, and the transmitting entity has paid for and reported such digital audio transmission under that agreement. Paragraph 2. Rule of construction for common law copyright. For purposes of paragraph 1, a claim of common law copyright or equivalent right under the laws of any state includes a claim that characterizes conduct subject to that paragraph as an unlawful distribution, act of record piracy, or similar violation. Paragraph 3. Rule of construction for public performance rights. Nothing in this section may be construed to recognize or negate the existence of public performance rights in sound recordings under the laws of any state. Subsection F. Limitations on remedies. Paragraph 1. Fair use. Uses by libraries, archives, and educational institutions. Subparagraph A in general. The limitations on the exclusive rights of a copyright owner described in sections 107, 108, 109, 110, and 112, subsection F shall apply to a claim under subsection A with respect to a sound recording fixed before February 15, 1972. Subparagraph B. Rule of construction for section 108, subsection H. With respect to the application of section 108, subsection H to a claim under subsection A with respect to a sound recording fixed before February 15, 1972, the phrase during the last 20 years of any term of copyright of a published work in such section 108. Substag H shall be construed to mean at any time after the date of enactment of this section. Paragraph 2. Actions. The limitations on actions described in Section 507 shall apply to a claim under subsection A with respect to a sound recording fixed before February 15, 1972. Paragraph 3. Material online. Section 512 shall apply to a claim under subsection A with respect to a sound recording fixed before February 15, 1972. Paragraph 4. Principles of equity. Principles of equity apply to remedies for a violation of this section to the same extent as such principles apply to remedies for infringement of copyright. Paragraph 5. Filing requirement for statutory damages and attorney's fees. Subparagraph A. Filing of information on sound recordings. Clause 1. Filing requirement. Except in the case of a transmitting entity that has filed contact information for that transmitting entity under subparagraph B in any action under this section. An award of statutory damages or of attorney's fees under Section 504 or 505 may be made with respect to an unauthorized use of a sound recording under subsection A only if. Subclause 1. The rights owner has filed with the Copyright Office a schedule that specifies the title, artist, and rights owner of the sound recording and contains such other information as practicable as the Register of Copyrights prescribes by regulation. And Subclause 2. The use occurs after the end of the 90-day period beginning on the date on which the information described in Subclause 1 is indexed into the public records of the Copyright Office. Clause 2. Regulations. Not later than 180 days after the date of enactment of this section, the Register of Copyrights shall issue regulations that Subclause 1. Establish the form, content, and procedures for the filing of schedules under Clause 1. Subclause 2. Provide that a person may request that the person receive timely notification of a filing described in Subclause 1, and Subclause 3. Set forth the manner in which a person may make a request under Subclause 2. Subparagraph B. Filing of contact information for transmitting entities. Clause 1. Filing requirement. Not later than 30 days after the date of enactment of this section, the Register of Copyrights shall issue regulations establishing the form, content, and procedures for the filing of contact information by any entity that, as of the date of enactment of this section, performs a sound recording fixed before February 15, 1972, by means of a digital audio transmission. Clause 2. Time limit on filings. The Register of Copyrights may accept filings under Clause 1 only until the 180th day after the date of enactment of this section. Clause 3. Limitation on statutory damages and attorney's fees. Subclause 1. Limitation. An award of statutory damages or of attorney's fees under Section 504 or 505 may not be made against an entity that has filed contact information for that entity under Clause 1 with respect to an unauthorized use by that entity of a sound recording under subsection A if the use occurs before the end of the 90-day period, beginning on the date on which the entity receives a notice that Item AA is sent by or on behalf of the rights owner of the sound recording. Item B states that the entity is not legally authorized to use that sound recording under subsection A, and Item C identifies the sound recording in a schedule conforming to the requirements prescribed by the regulations issued under subparagraph A. Clause 2. Subclause 2. Undeliverable notices. In any case in which a notice under Subclause 1 is sent to an entity by mail or courier service and the notice is returned to the sender, because the entity either is no longer located at the address provided in the contact information filed under Clause 1 or has refused to accept delivery, or the notice is sent by electronic mail and is undeliverable, the 90-day period under Subclause 1 shall begin on the date of the attempted delivery. Subparagraph C, Section 412. Section 412 shall not limit an award of statutory damages under Section 504, subsection C, or attorney's fees under Section 505 with respect to a covered activity in violation of subsection A. Paragraph 6. Applicability of other provisions. Subparagraph A. In general, subject to subparagraph B, no provision of this title shall apply to or limit the remedies available under this section except as otherwise provided in this section. Subparagraph B. Applicability of definitions. Any term used in this section that is defined in Section 101 shall have the meaning given that term in Section 101. Subsection G. Application of Section 230 Safe Harbor. For purposes of Section 230 of the Communications Act of 1934, Title 47, United States Code, Section 230. Subsection A shall be considered to be a law pertaining to intellectual property under subsection E, paragraph 2 of such Section 230. Subsection H. Application to rights owners. Paragraph 1. Transfers. With respect to a rights owner described in subsection L, paragraph 2, subparagraph B. Subparagraph A. Subsections D and E of Section 201 and Section 204 shall apply to a transfer described in subsection L. Paragraph 2, subparagraph B to the same extent as with respect to a transfer of copyright ownership. And subparagraph B, notwithstanding Section 411, that rights owner may institute an action with respect to a violation of this section to the same extent as the owner of an exclusive right under a copyright may institute an action under Section 501, subsection B. Paragraph 2. Application of other provisions. The following provision shall apply to a rights owner under this section to the same extent as any copyright owner. Subparagraph A, Section 112, subsection E, paragraph 2. Subparagraph B, Section 112, subsection E, paragraph 7. Subparagraph C, Section 114, subsection E. Subparagraph D, Section 114, subsection H. Subsection I, ephemeral recordings. An authorized reproduction made under this section shall be subject to Section 112, subsection G, to the same extent as a reproduction of a sound recording fixed on or after February 15, 1972. Subsection J, rule of construction. A rights owner of, or featured recording artist who performs on, a sound recording under this chapter shall be deemed to be an interested copyright party, as defined in Section 1001, to the same extent as a copyright owner or featured recording artist under Chapter 10. Subsection K, treatment of states and state instrumentalities, officers, and employees. Any state and any instrumentality, officer, or employee described in subsection A, paragraph 3, shall be subject to the provisions of this section in the same manner and to the same extent as any non-governmental entity. Subsection L, definitions. In this section, paragraph 1, covered activity. The term covered activity means any activity that the copyright owner of a sound recording would have the exclusive right to do or authorize under Section 106 or 602, or that would violate Section 1201 or 1202, if the sound recording were fixed on or after February 15, 1972. Paragraph 2, rights owner. The term rights owner means subparagraph A, the person that has the exclusive right to reproduce a sound recording under the laws of any state as of the day before the date of enactment of this section, or subparagraph B, any person to which a right to enforce a violation of this section may be transferred in whole or in part after the date of enactment of this section under Clause 1, subsections D and E of Section 201, and Clause 2, Section 204. Section 1501, definitions. In this chapter, paragraph 1, the term claimant means the real party in interest that commences a proceeding before the Copyright Claims Board under Section 1506, subsection E, pursuant to a permissible claim of infringement brought under Section 1504. Subsection C, paragraph 1. Non-infringement brought under Section 1504, subsection C, paragraph 2, or misrepresentation brought under Section 1504, subsection C, paragraph 3. Paragraph 2. The term counterclaimant means a respondent in a proceeding before the Copyright Claims Board that subparagraph A asserts a permissible counterclaim under Section 1504, subsection C, paragraph 4 against the claimant in the proceeding, and subparagraph B is the real party in interest with respect to the counterclaim described in subparagraph A. Paragraph 3, the term party. Subparagraph A means a party and subparagraph B includes the attorney of a party as applicable, and paragraph 4. The term respondent means any person against whom a proceeding is brought before the Copyright Claims Board under Section 1506, subsection E, pursuant to a permissible claim of infringement, brought under Section 1504, subsection C, paragraph 1. Non-infringement brought under Section 1504, subsection C, paragraph 2, or misrepresentation brought under Section 1504, subsection C, paragraph 3. Section 1502, Copyright Claims Board. Subsection A in general. There is established in the Copyright Office the Copyright Claims Board, which shall serve as an alternative forum in which parties may voluntarily seek to resolve certain copyright claims regarding any category of copyrighted work, as provided in this chapter. Subsection B, officers and staff. Paragraph 1, Copyright Claims Officers. The Register of Copyrights shall recommend 3 full-time copyright claims officers to serve on the Copyright Claims Board in accordance with paragraph 3, subparagraph A. The officers shall be appointed by the Librarian of Congress to such positions after consultation with the Register of Copyrights. Paragraph 2, Copyright Claims Attorneys. The Register of Copyrights shall hire not fewer than 2 full-time copyright claims attorneys to assist in the administration of the Copyright Claims Board. Paragraph 3, Qualifications. Subparagraph A, Copyright Claims Officers. Clause 1. In general, each copyright claims officer shall be an attorney who has not fewer than 7 years of legal experience. Clause 2. Experience 2 of the copyright claims officers shall, subclause 1, have substantial experience in the evaluation, litigation, or adjudication of copyright infringement claims, and subclause 2, between those 2 officers have represented or presided over a diversity of copyright interests, including those of both owners and users of copyrighted works. Clause 3. Alternative dispute resolution. The copyright claims officer not described in Clause 2 shall have substantial familiarity with copyright law and experience in the field of alternative dispute resolution, including the resolution of litigation matters through that method of resolution. Subparagraph B. Copyright Claims Attorneys. Each copyright claims attorney shall be an attorney who has not fewer than 3 years of substantial experience in copyright law. Paragraph 4. Compensation. Subparagraph A. Copyright Claims Officers. Clause 1 definition. In this subparagraph, the term senior level employee of the federal government means an employee, other than an employee in the senior executive service, the position of whom is classified above GS 15 of the General Schedule. Clause 2 pay range. Each copyright claims officer shall be compensated at a rate of pay that is not less than the minimum and not more than the maximum rate of pay payable for senior level employees of the federal government, including locality pay, as applicable. Subparagraph B. Copyright claims attorneys. Each copyright claims attorney shall be compensated at a rate of pay that is not more than the maximum rate of pay payable for Level 10 of GS 15 of the General Schedule, including locality pay, as applicable. Paragraph 5. Terms. Subparagraph A. In general. Subject to subparagraph B, a copyright claims officer shall serve for a renewable term of 6 years. Subparagraph B. Initial terms. The terms for the first copyright claims officers appointed under this chapter shall be as follows. Clause 1. The first such copyright claims officer appointed shall be appointed for a term of 4 years. Clause 2. The second copyright claims officer appointed shall be appointed for a term of 5 years. Clause 3. The third copyright claims officer appointed shall be appointed for a term of 6 years. Paragraph 6. Vacancies and incapacity. Subparagraph A. Vacancy. Clause 1 in general. If a vacancy occurs in the position of a copyright claims officer, the Librarian of Congress shall, upon the recommendation of, and in consultation with, the Register of Copyrights, act expeditiously to appoint a copyright claims officer for that position. Clause 2. Vacancy before expiration. An individual appointed to fill a vacancy occurring before the expiration of the term for which the predecessor of the individual was appointed shall be appointed to serve a 6-year term. Subparagraph B. Incapacity. If a copyright claims officer is temporarily unable to perform the duties of the officer, the Librarian of Congress shall, upon recommendation of and in consultation with the Register of Copyrights, act expeditiously to appoint an interim copyright claims officer to perform such duties during the period of such incapacity. Paragraph 7. Sanction or removal. Subject to Section 1503, subsection B, the Librarian of Congress may sanction or remove a copyright claims officer. Paragraph 8. Administrative support. The Register of Copyrights shall provide the copyright claims officers and copyright claims attorneys with necessary administrative support, including technological facilities, to carry out the duties of the officers and attorneys under this chapter. Paragraph 9. Location of Copyright Claims Board. The offices and facilities of the copyright claims officers and copyright claims attorneys shall be located at the Copyright Office. Section 1503. Authority and duties of the Copyright Claims Board. Subsection A. Functions. Paragraph 1. Copyright Claims Officers. Subject to the provisions of this chapter and applicable regulations, the functions of the Copyright Claims Officers shall be as follows. Subparagraph A. To render determinations on the civil copyright claims, counterclaims, and defenses that may be brought before the officers under this chapter. Subparagraph B. To ensure that claims, counterclaims, and defenses are properly asserted and otherwise appropriate for resolution by the Copyright Claims Board. Subparagraph C. To manage the proceedings before the officers and render rulings pertaining to the consideration of claims, counterclaims, and defenses, including with respect to scheduling, discovery, evidentiary, and other matters. Subparagraph D. To request from participants and non-participants in a proceeding the production of information and documents relevant to the resolution of a claim, counterclaim, or defense. Subparagraph E. To conduct hearings and conferences. Subparagraph F. To facilitate the settlement by the parties of claims and counterclaims. Subparagraph G. 2. Clause 1 award monetary relief, and Clause 2 include in the determinations of the officers a requirement that certain activities under Section 1504, subsection E, paragraph 2 cease or be mitigated if the party to undertake the applicable measure has so agreed. Subparagraph H to provide information to the public concerning the procedures and requirements of the Copyright Claims Board. Subparagraph I to maintain records of the proceedings before the officers, certify official records of such proceedings as needed, and, as provided in Section 1506, subsection T, make the records in such proceedings available to the public. Subparagraph J to carry out such other duties as are set forth in this chapter. Subparagraph K, when not engaged in performing the duties of the officers set forth in this chapter, to perform such other duties as may be assigned by the Register of Copyrights. Paragraph 2. Copyright claims attorneys. Subject to the provisions of this chapter and applicable regulations, the functions of the copyright claims attorneys shall be as follows. Subparagraph A, to provide assistance to the copyright claims officers in the administration of the duties of those officers under this chapter. Subparagraph B, to provide assistance to members of the public with respect to the procedures and requirements of the Copyright Claims Board. Subparagraph C, to provide information to potential claimants contemplating bringing a permissible action before the Copyright Claims Board about obtaining a subpoena under Section 512, subsection H, for the sole purpose of identifying a potential respondent in such an action. Subparagraph D, when not engaged in performing the duties of the attorneys set forth in this chapter, to perform such other duties as may be assigned by the Register of Copyrights. Subsection B, independence and determination. Paragraph 1. In general, the Copyright Claims Board shall render the determinations of the board in individual proceedings independently on the basis of the records in the proceedings before it and in accordance with the provisions of this title, judicial precedent, and applicable regulations of the Register of Copyrights. Paragraph 2. Consultation. The copyright claims officers and copyright claims attorneys. Subparagraph A may consult with the Register of Copyrights on general issues of law, and subparagraph B, subject to section 1506, subsection X, may not consult with the Register of Copyrights with respect to Clause 1. The facts of any particular matter pending before the officers and the attorneys, or Clause 2. The application of law to the facts described in Clause 1. Paragraph 3. Performance appraisals. Notwithstanding any other provision of law or any regulation or policy of the Library of Congress or Register of Copyrights, any performance appraisal of a copyright claims officer or copyright claims attorney may not consider the substantive result of any individual determination reached by the Copyright Claims Board as a basis for appraisal, except to the extent that the result may relate to any actual or alleged violation of an ethical standard of conduct. Subsection C, direction by register. Subject to subsection B, the copyright claims officers and copyright claims attorneys shall, in the administration of their duties, be under the general direction of the Register of Copyrights. Subsection D, inconsistent duties barred. A copyright claims officer or copyright claims attorney may not undertake any duty that conflicts with the duties of the officer or attorney in connection with the Copyright Claims Board. Subsection E, recusal. A copyright claims officer or copyright claims attorney shall recuse himself or herself from participation in any proceeding with respect to which the copyright claims off EC or copyright claims attorney, as the case may be, has reason to believe that he or she has a conflict of interest. Subsection F, ex parte communications, except as may otherwise be permitted by applicable law. Any party to a proceeding before the Copyright Claims Board shall refrain from ex parte communications with the copyright claims officers and the Register of Copyrights concerning the substance of any active or pending proceeding before the Copyright Claims Board. Subsection G, judicial review. Actions of the copyright claims officers and Register of Copyrights under this chapter in connection with the rendering of any determination are subject to judicial review as provided under Section 1508, subsection C, and not under Chapter 7 of Title V. Section 1504, nature of proceedings. Subsection A, voluntary participation. Participation in a Copyright Claims Board proceeding shall be on a voluntary basis in accordance with this chapter, and the right of any party to instead pursue a claim, counterclaim, or defense in a district court of the United States, any other court, or any other forum, and to seek a jury trial shall be preserved. The rights, remedies, and limitations under this section may not be waived except in accordance with this chapter. Subsection B, statute of limitations. Paragraph 1. In general, a proceeding may not be maintained before the Copyright Claims Board unless the proceeding is commenced, in accordance with Section 1506, subsection E, before the Copyright Claims Board, not later than 3 years after the claim accrued. Paragraph 2. Tolling. Subject to Section 1507, subsection A, a proceeding commenced before the Copyright Claims Board shall toll the time permitted under Section 507. Substact B, for the commencement of an action on the same claim in a district court of the United States during the period in which the proceeding is pending. Subsection C, permissible claims, counterclaims, and defenses. The Copyright Claims Board may render determinations with respect to the following claims, counterclaims, and defenses, subject to such further limitations and requirements, including with respect to particular classes of works, as may be set forth in regulations established by the Register of Copyrights. Paragraph 1. A claim for infringement of an exclusive right in a copyrighted work provided under Section 106 by the legal or beneficial owner of the exclusive right at the time of the infringement, for which the claimant seeks damages, if any, within the limitations set forth in subsection E, paragraph 1. Paragraph 2. A claim for a declaration of non-infringement of an exclusive right in a copyrighted work provided under Section 106, consistent with Section 2001 of Title 28. Paragraph 3. A claim under Section 512, subsection F, for misrepresentation in connection with a notification of claimed infringement or a counter-notification seeking to replace removed or disabled material, except that any remedies relating to such a claim in a proceeding before the Copyright Claims Board shall be limited to those available under this chapter. Paragraph 4. A counterclaim that is asserted solely against the claimant in a proceeding. Subparagraph A, pursuant to which the counterclaimant seeks damages, if any, within the limitations set forth in subsection E, paragraph 1, and subparagraph B that Clause 1 arises under Section 106 or Section 512, subsection F, and out of the same transaction or occurrence that is the subject of a claim of infringement brought under paragraph 1, a claim of non-infringement brought under paragraph 2, or a claim of misrepresentation brought under paragraph 3, or Clause 2 arises under an agreement pertaining to the same transaction or occurrence that is the subject of a claim of infringement brought under paragraph 1, if the agreement could affect the relief awarded to the claimant. Paragraph 5. A legal or equitable defense under this title or otherwise available under law, in response to a claim or counterclaim asserted under this subsection. Paragraph 6. A single claim or multiple claims permitted under paragraph 1, 2, or 3 by one or more claimants against one or more respondents, but only if all claims asserted in any one proceeding arise out of the same allegedly infringing activity or continuous course of infringing activities and do not, in the aggregate, result in the recovery of such claim or claims for damages that exceed the limitations under subsection E, paragraph 1. Subsection D, excluded claims. The following claims and counterclaims are not subject to determination by the Copyright Claims Board. Paragraph 1. A claim or counterclaim that is not a permissible claim or counterclaim under subsection C. Paragraph 2. A claim or counterclaim that has been finally adjudicated by a court of competent jurisdiction or that is pending before a court of competent jurisdiction, unless that court has granted a stay to permit that claim or counterclaim to proceed before the Copyright Claims Board. Paragraph 3. A claim or counterclaim by or against a federal or state governmental entity. Paragraph 4. A claim or counterclaim asserted against a person or entity residing outside of the United States except in a case in which the person or entity initiated the proceeding before the Copyright Claims Board and is subject to counterclaims under this chapter. Subsection E, permissible remedies. Paragraph 1. Monetary recovery. Subparagraph A. Actual damages, profits, and statutory damages for infringement. With respect to a claim or counterclaim for infringement of copyright, and subject to the limitation on total monetary recovery under subparagraph D, the Copyright Claims Board may award either of the following. Clause 1. Actual damages and profits determined in accordance with Section 504, subsection B, with that award taking into consideration, in appropriate cases, whether the infringing party has agreed to cease or mitigate the infringing activity under paragraph 2. Clause 2. Statutory damages, which shall be determined in accordance with Section 504, subsection C, subject to the following conditions. Subclause 1, with respect to works timely registered under Section 412, so that the works are eligible for an award of statutory damages in accordance with that section. The statutory damages may not exceed $15,000 for each work infringed. Subclause 2, with respect to works not timely registered under Section 4112, but eligible for an award of statutory damages under this section, statutory damages may not exceed $7,500 per work infringed, or a total of $15,000 in any one proceeding. Subclause 3. The Copyright Claims Board may not make any finding that, or consider whether the infringement was committed willfully in making an award of statutory damages. Subclause 4. The Copyright Claims Board may consider as an additional factor in awarding statutory damages whether the infringer has agreed to cease or mitigate the infringing activity under paragraph 2. Subparagraph B. Election of damages. With respect to a claim or counterclaim of infringement at any time before final determination is rendered, and notwithstanding the schedule established by the Copyright Claims Board under Section 1506, subsection K, the claimant or counterclaimant shall elect Clause 1 to recover actual damages and profits or statutory damages under subparagraph A, or Clause 2 not to recover damages. Subparagraph C. Damages for other claims. Damages for claims and counterclaims other than infringement claims, such as those brought under Section 512, subsection F, shall be subject to the limitation under subparagraph D. Subparagraph D. Limitation on total monetary recovery. Notwithstanding any other provision of law, a party that pursues any one or more claims or counterclaims in any single proceeding before the Copyright Claims Board may not seek or recover in that proceeding a total monetary recovery that exceeds the sum of $30,000, exclusive of any attorney's fees and costs that may be awarded under Section 1506, subsection Y. Paragraph 2. Paragraph 2. Agreement to cease certain activity. In a determination of the Copyright Claims Board, the Board shall include a requirement to cease conduct if, in the proceeding relating to the determination. Subparagraph A. A party agrees. Clause 1. To cease activity that is found to be infringing, including removing or disabling access to or destroying infringing materials, or Clause 2. To cease sending a takedown notice or counter notice under Section 512 to the other party regarding the conduct at issue before the Board if that notice or counter notice was found to be a knowing material misrepresentation under Section 512, subsection F, and Subparagraph B. The agreement described in subparagraph A is reflected in the record for the proceeding. Paragraph 3. Attorney's fees and costs. Notwithstanding any other provision of law except in the case of bad faith conduct as provided in Section 1506, subsection Y, paragraph 2, the parties to proceedings before the Copyright Claims Board shall bear their own attorney's fees and costs. Subsection F. Joint and several liability. Parties to a proceeding before the Copyright Claims Board may be found jointly and severally liable if all such parties and relevant claims or counterclaims arise from the same activity or activity. Subsection G. Permissible number of cases. The Register of Copyrights may establish regulations relating to the permitted number of proceedings each year by the same claimant under this chapter, in the interests of justice and the administration of the Copyright Claims Board. Section 1505, Registration Requirement. Subsection A. Application or certificate A claim or counterclaim alleging infringement of an exclusive right in a copyrighted work may not be asserted before the Copyright Claims Board unless Paragraph 1. The legal or beneficial owner of the copyright has first delivered a completed application, a deposit, and the required fee for registration of the copyright to the Copyright Office. And Paragraph 2. A registration certificate has either been issued or has not been refused. Subsection B. Certificate of registration, notwithstanding any other provision of law. A claimant or counterclaimant in a proceeding before the Copyright Claims Board shall be eligible to recover actual damages and profits or statutory damages under this chapter for infringement of a work if the requirements of subsection A have been met, except that Paragraph 1. The Copyright Claims Board may not render a determination in the proceeding until Subparagraph A. A registration certificate with respect to the work has been issued by the Copyright Office, submitted to the Copyright Claims Board, and made available to the other parties to the proceeding, and Subparagraph B. The other parties to the proceeding have been provided an opportunity to address the registration certificate. Paragraph 2. If the proceeding may not proceed further because a registration certificate for the work is pending, the proceeding shall be held in abeyance pending submission of the certificate to the Copyright Claims Board, except that if the proceeding is held in abeyance for more than 1 year, the Copyright Claims Board may, upon providing written notice to the parties to the proceeding, and 30 days to the parties to respond to the notice, dismiss the proceeding without prejudice, and Paragraph 3. If the Copyright Claims Board receives notice that registration with respect to the work has been refused, the proceeding shall be dismissed without prejudice. Subsection C. Presumption. In a case in which a registration certificate shows that registration with respect to a work was issued not later than 5 years after the date of the first publication of the work, the presumption under Section 41(n), Substat C shall apply in a proceeding before the Copyright Claims Board in addition to relevant principles of law under this title. Subsection D. Regulations. In order to ensure that actions before the Copyright Claims Board proceed in a timely manner, the Register of Copyrights shall establish regulations allowing the Copyright Office to make a decision, on an expedited basis, to issue or deny copyright registration for an unregistered work that is at issue before the Board. Section 1506. Conduct of Proceedings. Subsection A in general. Paragraph 1. Applicable law. Proceedings of the Copyright Claims Board shall be conducted in accordance with this chapter and regulations established by the Register of Copyrights under this chapter, in addition to relevant principles of law under this title. Paragraph 2. Conflicting precedent. If it appears that there may be conflicting judicial precedent on an issue of substantive copyright law that cannot be reconciled, the Copyright Claims Board shall follow the law of the federal jurisdiction in which the action could have been brought if filed in a district court of the United States, or, if the action could have been brought in more than one such jurisdiction, the jurisdiction that the Copyright Claims Board determines has the most significant ties to the parties in conducted issue. Subsection B. Record. The Copyright Claims Board shall maintain records documenting the proceedings before the Board. Subsection C. Centralized process. Proceedings before the Copyright Claims Board shall, Paragraph 1, be conducted at the offices of the Copyright Claims Board without the requirement of in-person appearances by parties or others, and Paragraph 2, take place by means of written submissions, hearings, and conferences carried out through internet-based applications and other telecommunications facilities, except that in cases in which physical or other non-testimonial evidence material to a proceeding cannot be furnished to the Copyright Claims Board through available telecommunications facilities, the Copyright Claims Board may make alternative arrangements for the submission of such evidence that do not prejudice any other party to the proceeding. Subsection D. Representation. A party to a proceeding before the Copyright Claims Board may be, but is not required to be, represented by Paragraph 1. An attorney, or Paragraph 2. A law student who is qualified under applicable law governing representation by law students of parties in legal proceedings and who provides such representation on a pro bono basis. Subsection E. Commencement of proceeding. In order to commence a proceeding under this chapter, a claimant shall, subject to such additional requirements as may be prescribed in regulations established by the Register of Copyrights, file a claim with the Copyright Claims Board that, Paragraph 1, includes a statement of material facts in support of the claim. Paragraph 2 is certified under subsection Y, Paragraph 1, and Paragraph 3 is accompanied by a filing fee in such amount as may be prescribed in regulations established by the Register of Copyrights. Subsection F. Review of claims and counterclaims. Paragraph 1. Claims. Upon the filing of a claim under subsection E, the claim shall be reviewed by a copyright claims attorney to ensure that the claim complies with this chapter and applicable regulations, subject to the following. Subparagraph A. If the claim is found to comply, the claimant shall be notified regarding that compliance and instructed to proceed with service of the claim under subsection G. Subparagraph B. If the claim is found not to comply, the claimant shall be notified that the claim is deficient and be permitted to file an amended claim not later than 30 days after the date on which the claimant receives the notice, without the requirement of an additional filing fee. If the claimant files a compliant claim within that 30-day period, the claimant shall be so notified and be instructed to proceed with service of the claim. If the claim is refiled within that 30-day period and still fails to comply, the claimant shall again be notified that the claim is deficient and shall be provided a second opportunity to amend the claim not later than 30 days after the date of that second notice, without the requirement of an additional filing fee. If the claim is refiled again within that second 30-day period and is compliant, the claimant shall be so notified and shall be instructed to proceed with service of the claim. But if the claim still fails to comply, upon confirmation of such non-compliance by a copyright claims officer, the proceeding shall be dismissed without prejudice. The Copyright Claims Board shall also dismiss without prejudice any proceeding in which a compliant claim is not filed within the applicable 30-day period. Subparagraph C, Clause 1, subject to Clause 2 for purposes of this paragraph. A claim against an online service provider for infringement by reason of the storage of or referral or linking to infringing material that may be subject to the limitations on liabilities set forth in subsection B, C, or D of Section 512 shall be considered non-compliant unless the claimant affirms in the statement required under subsection E. Paragraph 1 of this section that the claimant has previously notified the service provider of the claimed infringement in accordance with subsection B, paragraph 2, subparagraph E, C3, or D3 of section 512 as applicable, and the service provider failed to remove or disable access to the material expeditiously upon the provision of such notice. Subsection 2. If a claim is found to be non-compliant under Clause 1, the Copyright Claims Board shall provide the claimant with information concerning the service of such a notice under the applicable provision of section 512. Paragraph 2. Counterclaims. Upon the filing and service of a counterclaim, the counterclaim shall be reviewed by a copyright claims attorney to ensure that the counterclaim complies with the provisions of this chapter and applicable regulation. If the counterclaim is found not to comply, the counterclaimant and the other parties to the proceeding shall be notified that the counterclaim is deficient, and the counterclaimant shall be permitted to file and serve an amended counterclaim not later than 30 days after the date of such notice. If the counterclaimant files and serves a compliant counterclaim within that 30-day period, the counterclaimant and such other parties shall be so notified. If the counterclaim is refiled and served within that 30-day period but still fails to comply, the counterclaimant and such other parties shall again be notified that the counterclaim is deficient, and the counterclaimant shall be provided a second opportunity to amend the counterclaim not later than 30 days after the date of the second notice. If the counterclaim is refiled and served again within that second 30-day period and is compliant, the counterclaimant and such other parties shall be so notified, but if the counterclaim still fails to comply, upon confirmation of such noncompliance by a copyright claims officer, the counterclaim, but not the proceeding, shall be dismissed without prejudice. Paragraph 3. Dismissal for unsuitability. The Copyright Claims Board shall dismiss a claim or counterclaim without prejudice if upon reviewing the claim or counterclaim, or at any other time in the proceeding, the Copyright Claims Board concludes that the claim or counterclaim is unsuitable for determination by the Copyright Claims Board, including on account of any of the following. Subparagraph A. The failure to join a necessary party. Subparagraph B. The lack of an essential witness, evidence, or expert testimony. Subparagraph C. The determination of a relevant issue of law or fact that could exceed either the number of proceedings the Copyright Claims Board could reasonably administer, or the subject matter competence of the Copyright Claims Board. Subsection G. Service of notice and claims. In order to proceed with a claim against a respondent, a claimant shall, not later than 90 days after receiving notification under subsection F to proceed with service, file with the Copyright Claims Board proof of service on the respondent. In order to effectuate service on a respondent, the claimant shall cause notice of the proceeding and a copy of the claim to be served on the respondent, either by personal service or pursuant to a waiver of personal service, as prescribed in regulations established by the Register of Copyrights. Such regulations shall include the following requirements. Paragraph 1. The notice of the proceeding shall adhere to a prescribed form and shall set forth the nature of the Copyright Claims Board and proceeding, the right of the respondent to opt out, and the consequences of opting out and not opting out, including a prominent statement that, by not opting out within 60 days after receiving the notice, the respondent. Subparagraph A loses the opportunity to have the dispute decided by a court created under Article 3 of the Constitution of the United States, and subparagraph B waives the right to a jury trial regarding the dispute. Paragraph 2. The copy of the claim served on the respondent shall be the same as the claim that was filed with the Copyright Claims Board. Paragraph 3. Personal service of a notice and claim may be effected by an individual who is not a party to the proceeding and is older than 18 years of age. Paragraph 4. An individual other than a minor or incompetent individual may be served by. Subparagraph A. Complying with state law for serving a summons in an action brought in courts of general jurisdiction in the state where service is made. Subparagraph B. Delivering a copy of the notice and claim to the individual personally. Subparagraph C. Leaving a copy of the notice and claim at the individual's dwelling or usual place of abode with someone of suitable age and discretion who resides there. Or subparagraph D. Delivering a copy of the notice and claim to an agent designated by the respondent to receive service of process, or, if not so designated, an agent authorized by appointment or by law to receive service of process. Paragraph 5. Subparagraph A. A corporation, partnership, or unincorporated association that is subject to suit in courts of general jurisdiction under a common name shall be served by delivering a copy of the notice and claim to its service agent. If such service agent has not been designated, service shall be accomplished. Clause 1. By complying with state law for serving a summons in an action brought in courts of general jurisdiction in the state where service is made, or Clause 2. By delivering a copy of the notice and claim to an officer, a managing or general agent, or any other agent authorized by appointment or by law to receive service of process in an action brought in courts of general jurisdiction in the state where service is made, and if the agent is one authorized by statute and the statute so requires, by also mailing a copy of the notice and claim to the respondent. Subparagraph B. A corporation, partnership, or unincorporated association that is subject to suit in courts of general jurisdiction under a common name may elect to designate a service agent to receive notice of a claim against it before the Copyright Claims Board, by complying with requirements that the Register of Copyrights shall establish by regulation. The Register of Copyrights shall maintain a current directory of service agents that is available to the public for inspection, including through the Internet, and may require such corporations, partnerships, and unincorporated associations designating such service agents to pay a fee to cover the costs of maintaining the directory. Paragraph 6. In order to request a waiver of personal service, the claimant may notify a respondent by first-class mail or by other reasonable means that a proceeding has been commenced. Such notice to be made in accordance with regulations established by the Register of Copyrights, subject to the following. Subparagraph A. Any such request shall be in writing, shall be addressed to the respondent, and shall be accompanied by a prescribed notice of the proceeding, a copy of the claim as filed with the Copyright Claims Board, a prescribed form for waiver of personal service, and a prepaid or other means of returning the form without cost. Subparagraph B. The request shall state the date on which the request is sent and shall provide the respondent a period of 30 days, beginning on the date on which the request is sent, to return the waiver form signed by the respondent. The signed waiver form shall, for purposes of this subsection, constitute acceptance and proof of service as of the date on which the waiver is signed. Paragraph 7. Subparagraph A. A respondent's waiver of personal service shall not constitute a waiver of the respondent's right to opt out of the proceeding. Subparagraph B. A respondent who timely waives personal service under paragraph 6 and does not opt out of the proceeding shall be permitted a period of 30 days, in addition to the period otherwise permitted under the applicable procedures of the Copyright Claims Board, to submit a substantive response to the claim, including any defenses and counterclaims. Paragraph 8. A minor or an incompetent individual may only be served by complying with state law for serving a summons or like process on such an individual in an action brought in the courts of general jurisdiction of the state where service is made. Paragraph 9. Service of a claim and waiver of personal service may only be effected within the United States. Subsection H. Notification by Copyright Claims Board. The Register of Copyrights shall establish regulations providing for a written notification to be sent by, or on behalf of, the Copyright Claims Board to notify the respondent of a pending proceeding against the respondent, as set forth in those regulations, which shall, Paragraph 1. Include information concerning the respondent's right to opt out of the proceeding, the consequences of opting out and not opting out, and a prominent statement that by not opting out within 60 days after the date of service under subsection G, the respondent loses the opportunity to have the dispute decided by a court created under Article 3 of the Constitution of the United States and waives the right to a jury trial regarding the dispute. And Paragraph 2. Be in addition to and separate and apart from the notice requirements under subsection G. Subsection I. Opt-out procedure. Upon being properly served with a notice and claim, a respondent who chooses to opt out of the proceeding shall have a period of 60 days, beginning on the date of service, in which to provide written notice of such choice to the Copyright Claims Board, in accordance with regulations established by the Register of Copyrights. If proof of service has been filed by the claimant and the respondent does not submit an opt-out notice to the Copyright Claims Board within that 60-day period, the proceeding shall be deemed an active proceeding and the respondent shall be bound by the determination in the proceeding to the extent provided under Section 1507, subsection A. If the respondent opts out of the proceeding during that 60-day period, the proceeding shall be dismissed without prejudice, except that in exceptional circumstances and upon written notice to the claimant, the Copyright Claims Board may extend that 60-day period in the interest of justice. Subsection J. Service of other documents. Documents submitted or relied upon in a proceeding other than the notice and claim shall be served in accordance with regulations established by the Register of Copyrights. Subsection K. Scheduling. Upon confirmation that a proceeding has become an active proceeding, the Copyright Claims Board shall issue a schedule for the future conduct of the proceeding. The schedule shall not specify a time that a claimant or counterclaimant is required to make an election of damages that is inconsistent with Section 1504, subsection E. A schedule issued by the Copyright Claims Board may be amended by the Copyright Claims Board in the interests of justice. Subsection L. Conferences. One or more copyright claims officers may hold a conference to address case management or discovery issues in a proceeding, which shall be noted upon the record of the proceeding and may be recorded or transcribed. Subsection M. Party submissions. A proceeding of the Copyright Claims Board may not include any formal motion practice, except that, subject to applicable regulations and procedures of the Copyright Claims Board. Paragraph 1. The parties to the proceeding may make requests to the Copyright Claims Board to address case management and discovery matters, and submit responses thereto. And Paragraph 2. The Copyright Claims Board may request or permit parties to make submissions addressing relevant questions of fact or law, or other matters, including matters raised sua sponte by the Copyright Claims Officers, and offer responses thereto. Subsection N. Discovery. Discovery in a proceeding shall be limited to the production of relevant information and documents, written interrogatories, and written requests for admission, as provided in regulations established by the Register of Copyrights, except that. Paragraph 1. Upon the request of a party, and for good cause shown, the Copyright Claims Board may approve additional relevant discovery on a limited basis, in particular matters, and may request specific information and documents from participants in the proceeding and voluntary submissions from non-participants consistent with the interests of justice. Paragraph 2. Upon the request of a party and for good cause shown, the Copyright Claims Board may issue a protective order to limit the disclosure of documents or testimony that contain confidential information. And Paragraph 3. After providing notice and an opportunity to respond, and upon good cause shown, the Copyright Claims Board may apply an adverse inference with respect to disputed facts against a party who has failed to timely provide discovery materials in response to a proper request for materials that could be relevant to such fact. Subsection O. Evidence. The Copyright Claims Board may consider the following types of evidence in a proceeding, and such evidence may be admitted without application of formal rules of evidence. Paragraph 1. Documentary and other non-testimonial evidence that is relevant to the claims, counterclaims, or defenses in the proceeding. Paragraph 2. Testimonial evidence submitted under penalty of perjury in written form or in accordance with subsection P, limited to statements of the parties and non-expert witnesses, that is relevant to the claims, counterclaims, and defenses in a proceeding, except that, in exceptional cases, expert witness testimony or other types of testimony may be permitted by the Copyright Claims Board for good cause shown. Subsection P. Hearings. The Copyright Claims Board may conduct a hearing to receive oral presentations on issues of fact or law from parties and witnesses to a proceeding, including oral testimony, subject to the following. Paragraph 1. Any such hearing shall be attended by not fewer than 2 of the Copyright Claims Officers. Paragraph 2. The hearing shall be noted upon the record of the proceeding and, subject to Paragraph 3, may be recorded or transcribed as deemed necessary by the Copyright Claims Board. Paragraph 3. A recording or transcript of the hearing shall be made available to any Copyright Claims Officer who is not in attendance. Subsection Q. Voluntary dismissal. Paragraph 1. By claimant. Upon the written request of a claimant that is received before a respondent files a response to the claim in a proceeding, the Copyright Claims Board shall dismiss the proceeding or a claim or respondent as requested without prejudice. Paragraph 2. By counterclaimant. Upon written request of a counterclaimant that is received before a claimant files a response to the counterclaim, the Copyright Claims Board shall dismiss the counterclaim, such dismissal to be without prejudice. Paragraph 3. Class actions. Any party in an active proceeding before the Copyright Claims Board who receives notice of a pending or putative class action arising out of the same transaction or occurrence, in which that party is a class member, may request in writing dismissal of the proceeding before the Board. Upon notice to all claimants and counterclaimants, the Copyright Claims Board shall dismiss the proceeding without prejudice. Subsection R. Settlement. Paragraph 1. In general, at any time in an active proceeding, some or all of the parties may. Subparagraph A. Jointly request a conference with a Copyright Claims Officer for the purpose of facilitating settlement discussions, or Subparagraph B. Submit to the Copyright Claims Board an agreement providing for settlement and dismissal of some or all of the claims and counterclaims in the proceeding. Paragraph 2. Additional request. A submission under Paragraph 1, Subparagraph B may include a request that the Copyright Claims Board adopt some or all of the terms of the party's settlement in a final determination in the proceeding. Subsection S. Factual findings. Subject to Subsection N, Paragraph 3, the Copyright Claims Board shall make factual findings based upon a preponderance of the evidence. Subsection T. Determinations. Paragraph 1. Nature and contents. A determination rendered by the Copyright Claims Board in a proceeding shall. Subparagraph A. Be reached by a majority of the Copyright Claims Board. Subparagraph B. Be in writing and include an explanation of the factual and legal basis of the determination. Subparagraph C. Set forth any terms by which a respondent or counterclaim respondent has agreed to cease infringing activity under Section 5-04, Subsection E, Paragraph 2. Subparagraph D. To the extent requested under Subsection R, Paragraph 2, set forth the terms of any settlement agreed to under Subsection R, Paragraph 1, and Subparagraph E. Include a clear statement of all damages and other relief awarded, including under Subparagraph C and D. Paragraph 2. Dissent. A Copyright Claims Officer who dissents from a decision contained in a determination under Paragraph 1 may append a statement setting forth the grounds for that dissent. Paragraph 3. Publication. Each final determination of the Copyright Claims Board shall be made available on a publicly accessible website. The Register shall establish regulations with respect to the publication of other records and information relating to such determinations, including the redaction of records to protect confidential information that is the subject of a protective order under subsection N, paragraph 2. Paragraph 4. Freedom of Information Act. All information relating to proceedings of the Copyright Claims Board under this chapter is exempt from disclosure to the public under Section 552, subsection B, paragraph 3 of Title V, except for determinations records, and information published under paragraph 3. Subsection U. Respondent's default. If a proceeding has been deemed an active proceeding but the respondent has failed to appear or has ceased participating in the proceeding, as demonstrated by the respondent's failure without justifiable cause to meet one or more deadlines or requirements set forth in the schedule adopted by the Copyright Claims Board under subsection K, the Copyright Claims Board may enter a default determination, including the dismissal of any counterclaim asserted by the respondent, as follows and in accordance with such other requirements as the Register of Copyrights may establish by regulation. Paragraph 1. The Copyright Claims Board shall require the claimant to submit relevant evidence and other information in support of the claimant's claim and any asserted damages, and, upon review of such evidence and any other requested submissions from the claimant, shall determine whether the materials so submitted are sufficient to support a finding in favor of the claimant under applicable law, and if so, the appropriate relief and damages, if any, to be awarded. Paragraph 2. If the Copyright Claims Board makes an affirmative determination under paragraph 1, the Copyright Claims Board shall prepare a proposed default determination and shall provide written notice to the respondent at all addresses, including email addresses, reflected in the records of the proceeding before the Copyright Claims Board, of the pendency of a default determination by the Copyright Claims Board, and of the legal significance of such determination. Such notice shall be accompanied by the proposed default determination and shall provide that the respondent has a period of 30 days, beginning on the date of the notice, to submit any evidence or other information in opposition to the proposed default determination. Paragraph 3. If the respondent responds to the notice provided under paragraph 2 within the 30-day period provided in such paragraph, the Copyright Claims Board shall consider the respondent's submissions and, after allowing the other parties to address such submissions, maintain or amend its proposed determination as appropriate, and the resulting determination shall not be a default determination. Paragraph 4. If the respondent fails to respond to the notice provided under paragraph 2, the Copyright Claims Board shall proceed to issue the default determination as a final determination. Thereafter, the respondent may only challenge such determination to the extent permitted under Section 1508, subsection C, except that, before any additional proceedings are initiated under Section 1508, the Copyright Claims Board may, in the interests of justice, vacate the default determination. Subsection 5. Claimant's failure to proceed. Paragraph 1. Failure to complete service. If a claimant fails to complete service on a respondent within the 90-day period required under subsection G, the Copyright Claims Board shall dismiss that respondent from the proceeding without prejudice. If a claimant fails to complete service on all respondents within that 90-day period, the Copyright Claims Board shall dismiss the proceeding without prejudice. Paragraph 2. Failure to prosecute. If a claimant fails to proceed in an active proceeding as demonstrated by the claimant's failure, without justifiable cause, to meet one or more deadlines or requirements set forth in the schedule adopted by the Copyright Claims Board under subsection K, the Copyright Claims Board may, upon providing written notice to the claimant in a period of 30 days, beginning on the date of the notice, to respond to the notice, and after considering any such response, issue a determination dismissing the claimant's claims, which shall include an award of attorney's fees and costs, if appropriate, under subsection Y, paragraph 2. Thereafter, the claimant may only challenge such determination to the extent permitted under Section 1508, subsection C, except that, before any additional proceedings are initiated under Section 1508, the Copyright Claims Board may, in the interests of justice, vacate the determination of dismissal. Subsection W. Request for reconsideration. A party may, not later than 30 days after the date on which the Copyright Claims Board issues a final determination in a proceeding under this chapter, submit a written request for reconsideration of, or an amendment to, such determination if the party identifies a clear error of law or fact material to the outcome, or a technical mistake. After providing the other parties an opportunity to address such request, the Copyright Claims Board shall either deny the request or issue an amended final determination. Subsection X. Review by Register. If the Copyright Claims Board denies a party a request for reconsideration of a final determination under subsection W, that party may, not later than 30 days after the date of such denial, request review of the final determination by the Register of Copyrights in accordance with regulations established by the Register. Such request shall be accompanied by a reasonable filing fee as provided in such regulations. The review by the Register shall be limited to consideration of whether the Copyright Claims Board abused its discretion in denying reconsideration of the determination. After providing the other parties an opportunity to address the request, the Register shall either deny the request for review or remand the proceeding to the Copyright Claims Board for reconsideration of issues specified in the remand and for issuance of an amended final determination. Such amended final determination shall not be subject to further consideration or review other than under Section 1508, subsection C. Subsection Y. Conduct of parties and attorneys. Paragraph 1. Certification. The Register of Copyrights shall establish regulations requiring certification of the accuracy and truthfulness of statements made by participants in proceedings before the Copyright Claims Board. Paragraph 2. Bad faith conduct. Notwithstanding any other provision of law, in any proceeding in which a determination is rendered, and it is established that a party pursued a claim, counterclaim, or defense for a harassing or other improper purpose, or without a reasonable basis in law or fact, then, unless inconsistent with the interests of justice, the Copyright Claims Board shall in such determination award reasonable costs and attorney's fees to any adversely affected party in an amount of not more than $5,000, except that. Subparagraph A. If an adversely affected party appeared pro se in the proceeding, the award to that party shall be for costs only, in an amount of not more than $2,500, and subparagraph B. In extraordinary circumstances, such as where a party has demonstrated a pattern or practice of bad faith conduct as described in this paragraph, the Copyright Claims Board may, in the interests of justice, award costs and attorney's fees in excess of the limitations under this paragraph. Paragraph 3. Additional penalty. If the board finds that on more than one occasion within a 12-month period a party pursued a claim, counterclaim, or defense before the Copyright Claims Board for a harassing or other improper purpose, or without a reasonable basis in law or fact, that party shall be barred from initiating a claim before the Copyright Claims Board under this chapter for a period of 12 months beginning on the date on which the board makes such a finding. Any proceeding commenced by that party that is still pending before the board when such a finding is made shall be dismissed without prejudice, except that, if a proceeding has been deemed active under subsection I, the proceeding shall be dismissed under this paragraph only if the respondent provides written consent thereto. Subsection Z. Regulations for smaller claims. The Register of Copyrights shall establish regulations to provide for the consideration and determination, by not fewer than one copyright claims officer, of any claim under this chapter in which total damages sought do not exceed $5,000, exclusive of attorney's fees and costs. A determination issued under this subsection shall have the same effect as a determination issued by the entire Copyright Claims Board. Item AA. Opt-out for libraries and archives. Paragraph 1. In general, the Register of Copyrights shall establish regulations allowing for a library or archives that does not wish to participate in proceedings before the Copyright Claims Board to preemptively opt out of such proceedings. Paragraph 2. Procedures. The regulations established under Paragraph 1 shall. Subparagraph A. Set forth procedures for preemptively opting out of proceedings before the Copyright Claims Board, and subparagraph B. Require that the Copyright Office compile and maintain a publicly available list of the libraries and archives that have successfully opted out of proceedings in accordance with the procedures described in subparagraph A. Paragraph 3. No fee or renewal required. The Register of Copyrights may not. Subparagraph A. Charge a library or archives a fee to preemptively opt out of proceedings under this subsection, or subparagraph B. Require a library or archives to renew a decision to preemptively opt out of proceedings under this subsection. Paragraph 4. Definitions. For purposes of this subsection, the terms library and archives mean any library or archives, respectively, that qualifies for the limitations on exclusive rights under Section 108. Section 5107. Effective proceeding. Subsection A. Determination. Subject to the reconsideration and review processes provided under subsections W and X of Section 1506 and Section 15008, subsection C, the issuance of a final determination by the Copyright Claims Board in a proceeding, including a default determination or determination based on a failure to prosecute, shall solely with respect to the parties to such determination preclude relitigation before any court or tribunal or before the Copyright Claims Board of the claims and counterclaims asserted and finally determined by the board, and may be relied upon for such purpose in a future action or proceeding arising from the same specific activity or activities, subject to the following. Paragraph 1. A determination of the Copyright Claims Board shall not preclude litigation or relitigation as between the same or different parties before any court or tribunal or the Copyright Claims Board of the same or similar issues of fact or law in connection with claims or counterclaims not asserted or not finally determined by the Copyright Claims Board. Paragraph 2. A determination of ownership of a copyrighted work for purposes of resolving a matter before the Copyright Claims Board may not be relied upon and shall not have any preclusive effect in any other action or proceeding before any court or tribunal, including the Copyright Claims Board. Paragraph 3. Except to the extent permitted under this subsection and Section 1508, any determination of the Copyright Claims Board may not be cited or relied upon as legal precedent in any other action or proceeding before any court or tribunal, including the Copyright Claims Board. Subsection B. Class actions not affected. Paragraph 1. In general, a proceeding before the Copyright Claims Board shall not have any effect on a class action proceeding in a district court of the United States, and Section 1509. Subsector A shall not apply to a class action proceeding in a district court of the United States. Paragraph 2. Notice of class action. Any party to an active proceeding before the Copyright Claims Board who receives notice of a pending class action, arising out of the same transaction or occurrence as the proceeding before the Copyright Claims Board, in which the party is a class member shall either Subparagraph A. Opt out of the class action, in accordance with regulations established by the Register of Copyrights, or Subparagraph B. Seek dismissal under Section 1506, Subsection Q, Paragraph 3 of the proceeding before the Copyright Claims Board. Subsection C. Other materials in proceeding. Except as permitted under this section and Section 1508, a submission or statement of a party or witness made in connection with a proceeding before the Copyright Claims Board, including a proceeding that is dismissed, may not be cited or relied upon in, or serve as the basis of any action or proceeding concerning rights or limitations on rights under this title before any court or tribunal, including the Copyright Claims Board. Subsection D. Applicability of Section 512, Subsection G. A claim or counterclaim before the Copyright Claims Board that is brought under Subsection C, Paragraph 1 or C4 of Section 1504, or brought under Subsection C, Paragraph 6 of Section 1504, and that relates to a claim under Subsection C. Paragraph 1 or C4 of such section qualifies as an action seeking an order to restrain a subscriber from engaging in infringing activity under Section 512, Subsection G, Paragraph 2, Subparagraph C if Paragraph 1. Notice of the commencement of the Copyright Claims Board proceeding is provided by the claimant to the service provider's designated agent before the service provider replaces the material following receipt of a counter notification under Section 512. Subsect G and Paragraph 2. The claim brought alleges infringement of the material identified in the notification of claimed infringement under Section 512, Subsection C, Paragraph 1, Subparagraph C. Subsection E. Failure to assert counterclaim. The failure or inability to assert a counterclaim in a proceeding before the Copyright Claims Board shall not preclude the assertion of that counterclaim in a subsequent court action or proceeding before the Copyright Claims Board. Subsection F. Opt-out or dismissal of party. If a party has timely opted out of a proceeding under Section 1506, Subsection I, or is dismissed from a proceeding before the Copyright Claims Board issues a final determination in the proceeding, the determination shall not be binding upon and shall have no preclusive effect with respect to that party. Section 1508, Review and Confirmation by District Court. Subsection A in general. In any proceeding in which a party has failed to pay damages, or has failed otherwise to comply with the relief awarded in a final determination of the Copyright Claims Board, including a default determination or a determination based on a failure to prosecute, the aggrieved party may, not later than 1 year after the date on which the final determination is issued, any reconsideration by the Copyright Claims Board or review by the Register of Copyrights is resolved, or an amended final determination is issued, whichever occurs last, apply to the United States District Court for the District of Columbia or any other appropriate district court of the United States for an order confirming the relief awarded in the final determination and reducing such award to judgment. The court shall grant such order and direct entry of judgment unless the determination is or has been vacated, modified, or corrected under subsection C. If the United States District Court for the District of Columbia or other district court of the United States, as the case may be, issues an order confirming the relief awarded by the Copyright Claims Board, the court shall impose on the party who failed to pay damages or otherwise comply with the relief the reasonable expenses required to secure such order, including attorney's fees that were incurred by the aggrieved party. Subsection B. Filing Procedures. Paragraph 1. Application to confirm determination. Notice of the application under subsection A for confirmation of a determination of the Copyright Claims Board and entry of judgment shall be provided to all parties to the proceeding before the Copyright Claims Board that resulted in the determination, in accordance with the procedures applicable to service of a motion in the District Court of the United States where the application is made. Paragraph 2. Contents of application. The application under subsection A shall include the following. Subparagraph A. A certified copy of the final or amended final determination of the Copyright Claims Board, as reflected in the records of the Copyright Claims Board, following any process of reconsideration or review by the Register of Copyrights, to be confirmed and rendered to judgment. Subparagraph B. A declaration by the applicant, under penalty of perjury. Clause 1. That the copy is a true and correct copy of such determination. Clause 2. Stating the date the determination was issued. Clause 3. Stating the basis for the challenge under subsection C, paragraph 1, and Clause 4. Stating whether the applicant is aware of any other proceedings before the court concerning the same determination of the Copyright Claims Board. Subsection C. Challenges to the determination. Paragraph 1. Basis for challenge. Not later than 90 days after the date on which the Copyright Claims Board issues a final or amended final determination in a proceeding, or not later than 90 days after the date on which the Register of Copyrights completes any process of reconsideration or review of the determination, whichever occurs later, a party may seek an order from a district court of the United States vacating, modifying or correcting the determination of the Copyright Claims Board in the following cases. Subparagraph A. If the determination was issued as a result of fraud, corruption, misrepresentation, or other misconduct. Subparagraph B. If the Copyright Claims Board exceeded its authority or failed to render a final determination concerning the subject matter at issue. Subparagraph C. In the case of a default determination or determination based on a failure to prosecute, if it is established that the default or failure was due to excusable neglect. Paragraph 2. Procedure to challenge. Subparagraph A. Notice of application. Notice of the application to challenge a determination of the Copyright Claims Board shall be provided to all parties to the proceeding before the Copyright Claims Board, in accordance with the procedures applicable to service of a motion in the court where the application is made. Subparagraph B. Staying of proceedings. For purposes of an application under this subsection, any judge who is authorized to issue an order to stay the proceedings in another action brought in the same court may issue an order to be served with the notice of application. Staying proceedings to enforce the award while the challenge is pending. Section 1509, Relationship to other district court actions. Subsection A. Stay of district court proceedings. Subject to Section 1507, Subsection B. A district court of the United States shall issue a stay of proceedings or such other relief as the court determines appropriate with respect to any claim brought before the court that is already the subject of a pending or active proceeding before the Copyright Claims Board. Subsection B. Alternative dispute resolution process. A proceeding before the Copyright Claims Board under this chapter shall qualify as an alternative dispute resolution process under Section 651 of Title 28 for purposes of referral of eligible cases by district courts of the United States upon the consent of the parties. Section 1510, Implementation by Copyright Office. Subsection A. Regulations. Paragraph 1. Implementation generally. The Register of Copyrights shall establish regulations to carry out this chapter. Such regulations shall include the fees prescribed under subsections E and X of Section 1506. The authority to issue such fees shall not limit the authority of the Register of Copyrights to establish fees for services under Section 708. All fees received by the Copyright Office in connection with the activities under this chapter shall be deposited by the Register of Copyrights and credited to the appropriations for necessary expenses of the office in accordance with Section 708. Subtype D. In establishing regulations under this subsection, the Register of Copyrights shall provide for the efficient administration of the Copyright Claims Board and for the ability of the Copyright Claims Board to timely complete proceedings instituted under this chapter, including by implementing mechanisms to prevent harassing or improper use of the Copyright Claims Board by any party. Paragraph 2. Limits on monetary relief. Subparagraph A in general. Subject to subparagraph B, not earlier than 3 years after the date on which Copyright Claims Board issues the first determination of the Copyright Claims Board, the Register of Copyrights may, in order to further the goals of the Copyright Claims Board, conduct a rulemaking to adjust the limits on monetary recovery or attorneys' fees and costs that may be awarded under this chapter. Subparagraph B. Effective date of adjustment. Any rule under subparagraph A that makes an adjustment shall take effect at the end of the 120-day period beginning on the date on which the Register of Copyrights submits the rule to Congress, and only if Congress does not, during that 120-day period, enact a law that provides in substance that Congress does not approve the rule. Subsection B. Necessary facilities. Subject to applicable law, the Register of Copyrights may retain outside vendors to establish internet-based, teleconferencing, and other facilities required to operate the Copyright Claims Board. Subsection C. Fees. Any filing fees, including the fee to commence a proceeding under Section 1506, subsection E, shall be prescribed in regulations established by the Register of Copyrights. The sum total of such filing fees shall be in an amount of not less than $100, may not exceed the cost of filing an action in a district court of the United States, and shall be fixed in amounts that further the goals of the Copyright Claims Board. Section 1511. Funding. There are authorized to be appropriated such sums as may be necessary to pay the costs incurred by the Copyright Office under this chapter that are not covered by fees collected for services rendered under this chapter, including the costs of establishing and maintaining the Copyright Claims Board and its facilities.